approach the dais. If you have any questions, please raise your hand, and one of us, the Sergeant at Arms, would kindly assist you. Thank you very much for your kind cooperation. Chair, we're ready to begin.
Good morning and welcome to the meeting of the Committee on Rules, Privileges, and Elections. I'm City Council Member Keith Powers, chair of this committee. Before we begin, I'd like to introduce the other members of the committee who are present here today. We're joined by Speaker Adrian Adams, Councilmember Justin Branning, Councilmember Shekhar Krishnan, Councilmember Gail Brewer, Councilmember Amanda Farias, Councilmember Crystal Hudson, Councilmember Selvina Brooks Powers, Councilmember Palladino, Councilmember Ariola, Councilmember Aviles, Councilmember Salam, Councilmember Osei, Councilmember Joseph, Councilmember De La Rosa, our public advocate, Jamani Williams, Councilmember Sandy Nurse, Councilmember Chris Marte, Councilmember Camilla Hanks, and I am sure we'll be joined by more. And we love Diana Ayala, who is also here too. Please throw him out. Throw him out. All right, we're going to move on with the hearing. Just a quiet day here at City Hall today. Yes. We will, and you thought you were going to be the biggest celebrity here today. Yeah, not here for you. Of course, I'm going to ask everyone to please respect this hearing. If you are disrespectful, we will ask you to leave, and if you are not willing, we will ask the security to escort you. This is a long hearing that we're going to have here today, so please be respectful of each other as we would all expect. We'll move on. Before we start, we're also joined by Councilmember Rivera here as well. I want to acknowledge the staff here today who helped put together today's hearing. I want to acknowledge the counsel to the committee, Jeff Campagna, the committee staff that worked on today's hearing, Chief Ethics Counsel Pearl Moore, Director of Investigations, Francesca Della Vecchia, Deputy Director of Investigations, Alicia Vassell. I want to also thank my staff, Haley Brundage and Ben Jacobs, who are here today, and all the other staff who helped to prepare for today's hearing. Today, the committee will consider the nomination of Randy Mastro for appointment to the position of Corporation Counsel. Before we start, I want to recognize Speaker Adrian Adams to make an opening statement.
Thank you very much, Chair Powers, and good morning, everyone. Thank you so much for being here this morning. I want to thank and acknowledge all of the members of the Committee on Rules, Privileges, and Elections for convening today's hearing on the nomination of Randy Mastro for the position of Corporation Counsel. The role of Corporation Counsel is a prestigious and powerful position in our city government. To serve the public at this level is a great privilege. It's based on qualifications, attributes, and many aspects of a nominee's record. Being a qualified attorney and litigator is not the full breadth of qualifications required for this critical position. There are many experienced and effective lawyers in our great city, but any prospective corporation counsel must meet a high standard of commitment to public service and justice. They also need New Yorkers' trust and must be accountable to the public and the many officials represented by the law department. They must be able to confidently lead the more than 800 attorneys and support staff of the law department. They must faithfully represent all of us, the entire city, the council, agencies, and other elected officials. The reason that our city charter was revised to require this position to ensure Corporation Counsel does not prioritize the mayor or any single official over the city's interests and justice. This issue was a central concern with past corporation counsels. We consider the context of this history and the weight of our responsibility to strengthen democratic governance as we approach this hearing. Our goal today is to evaluate the nominee's record and determine whether they meet the high standards and public trust required of this critical position. The due diligence taken in this process is what New Yorkers deserve and should be required for a position of such great authority, mercy, and good governance. To demonstrate they meet these requirements. As a council, we take this responsibility very seriously because our job is to make city government more responsive to the needs of all New Yorkers. Leadership matters, especially when city leaders are responsible for providing services that New Yorkers rely upon for their safety and well-being. These decisions are too important to take place behind closed doors, outside of the public view. Ultimately, a transparent process like the one we're undergoing today strengthens accountability and trust in our government. As a council, it is our responsibility to be good stewards of this city. It is our duty to critically examine appointees, their character, their qualifications, and their record so that we can ensure we have the best person for the job. It is also our responsibility to ensure nominees' records are consistent with the values of our city. As the city's top attorney, the Corporation Counsel must have a strong record of championing what New Yorkers hold dear, including equity and justice. It's critical that they be someone the public can trust to put the people first, which means that their record of fighting for the people, for standing up for workers' rights, and pursuing racial equality and justice must be uncompromising. Their commitment to working for solutions New Yorkers desperately need, like affordable housing, safeguards for climate change and disasters, and protections for workers, should be crystal clear. There is too much on the line for New Yorkers and our collective future to accept anything less. This role and any top position in government is not entitled to anyone. Make no mistake about it. It is a privilege. Women and people of color know this to be true. Rarely, if ever, have we been considered entitled to top positions. In fact, entitlement has often kept those who look like us from accessing such valuable opportunities. Our women majority and historically diverse council inherently understands this. We were elected by New Yorkers in every neighborhood of this city. We represent their diverse interests, and we prioritize the diversity that our representation reflects. It is our duty to thoroughly examine nominees. Mr. Mastro, I look forward to hearing from you today in our exchange regarding your record, qualifications, and experiences in consideration of your nominee as Corporation Counsel. Thank you very much. I turn it back over to our chair.
Thank you, Madam Speaker. Before we move forward, I want to summarize the powers and duties of the Corporation Counsel before I introduce the candidate. Pursuant to Sections 31 and 391 of the New York City Charter, and by letter dated July 30th, 2024, Mayor Eric Adams requested the Council's advice and consent in relation to his nomination of Randy Mastro for appointment to be the Corporation Counsel. The New York City Charter designates the Corporation Counsel as the attorney and counsel for the city and all city agencies. The Corporation Counsel, and by extension of the Law Department, is granted the power to conduct all the legal business of the City of New York. Further, the Corporation Counsel has the right to bring or defend any legal action in local, state, or federal courts. The Law Department is comprised of approximately 850 attorneys who specialize in all the areas of law necessary to conduct the legal business of the city. The Law Department includes specialists in a wide range of fields of litigation, land use, ethics, professional responsibility, contracts, administrative law, juvenile delinquency, and legislative interpretation, just to name a few. They represent the city, elected officials, and city agencies with all legal issues that they confront. If the Council grants its advice and consent, Mr. Mastro will be appointed Corporation Counsel and will serve an indefinite term at a salary of $253,000. Mr. Mastro has joined us today. Congratulations on your nomination. He is a partner currently at the law firm of King & Spalding. Previously, he was a partner at the firm of Gibson, Dunn & Crutcher. He's held several roles in government, first in the United States Attorney's Office, and then as Chief of Staff, and later as Deputy Mayor to Mayor Giuliani, and as Chair of the Charter Revision Commission and Task Force on Bilingual Education under Mayor Giuliani. Before we begin, and Mr. Mastro will offer you an opportunity to offer an opening statement, I'd ask the council to administer the affirmation.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this committee and in answer to all council member questions?
I do.
Thank you, Mr. Mastro. I'll never recognize you to make an offer to offer an opening statement.
Thank you. Madam Speaker, Chair Powers, Rules Committee members, other members of the council, public advocate, thank you for affording me this opportunity to present my qualifications to become corporation counsel and my vision for the law department. I am a passionate advocate in the courtroom and a proud New Yorker. I am honored to have this opportunity of a lifetime to use the power of the law to do public good and improve New Yorkers' lives. While I served in city government before, this is the one job I aspired to do, and I have been training for it my entire career. In public service for more than a decade as a deputy mayor and a federal prosecutor. In private practice, devoting hundreds of hours a year, year after year, to pro bono work and community service, including as chair of Citizens Union, the gold standard for good government in our city, and as vice chair of the Legal Aid Society, which does more for the indigent than any other organization I know of. First, I want to thank all of those publicly supporting me, now 100-fold, many of whom you will hear directly from later today. I also enjoy the unanimous support of editorial boards who have weighed in. When has that ever happened before in New York City? I'm humbled to know all of them care so much that they are here today to speak out. I especially want to thank my wife, Janine, a doctor scientist at Memorial Sloan Kettering who does groundbreaking cancer research, and my daughter, Ariana, an MBA student at Wharton who comes out of the not-for-profit world. They're both here supporting me now, and they know firsthand the sacrifices public service entails. The last time I was in government, in the 90s, our family had to have round-the-clock police protection because I received mob death threats. I'm also extremely grateful to have the support of so many in the legal community, including former U.S. Attorney General Loretta Lynch, SEC Chair and U.S. Attorney Mary Jo White, Homeland Security Secretary Jay Johnson, and top New York judges like Jonathan Lippman, Carmen Saparik, Rolando Acosto, and David Sachs, who you'll hear from later. It's a veritable who's who of the New York bar. That should tell you something. It includes the Corporation Counsel from the Dinkins, Bloomberg, and de Blasio administrations, one of whom, Victor Kovner, who you will hear from later today, said on behalf of all of them that I have virtually unmatched relevant experience and possess the character and dedication to serve with distinction. At the outset, let me set the record straight. I'm a lifelong Democrat who's represented mostly Democrats, including Bill Thompson, Betsy Gottbaum, Bill de Blasio, and Letitia James. As deputy mayor in the 1990s, I took on organized crime in the Fulton Fish Market and the private carding industry and lived to tell the tale, and won for our city. I implemented the most sweeping domestic partnership protections for same-sex couples in the country at the time. And I worked constructively with elected Democrats and labor unions, many of whom vouch for me today, including former Governor David Patterson, who is here to support me, and you'll hear from later, City Council Speaker Peter Vallone, and Michael Mulgrew of the UFT, Randy Weingarten of the AFT, and the leaders of the UFA, sanitation workers, Teamsters Local 237, and the Building and Construction Trades Council. In private practice, I've successfully represented firm clients, sometimes in controversial cases. But that's what litigators do, zealously and ethically advocate for firm clients. My personal values are reflected in the extensive pro bono work I have done, including representing peaceful racial justice protesters in Lafayette Square assaulted by federal authorities in June 2020 in the wake of George Floyd's murder, supporting LGBTQ plus rights and same-sex marriage in the U.S. Supreme Court, convincing the U.S. Supreme Court to reopen houses of worship closed by Governor Cuomo during COVID, blocking the state's onerous disclosure requirements on good government groups that chilled free speech, getting 70 million generous Americans donated after 9/11 released to fallen firefighter heroes' families, and winning reinstatement for a black teacher, Janet Morgan, who you'll hear from later, fired for giving her class an assignment on racism in an historic ruling establishing teachers' academic freedom rights. I hope to bring many more such cases and move more of the law department's resources into affirmative litigation as head of that 800-lawyer team. Of course, defending our city and protecting the public fisc will be a priority. But just as importantly, a priority of mine will be to bring cases to protect and expand New Yorkers' civil rights, constitutional rights, racial justice, social justice, workers' rights, tenants' rights, consumer protection, and environmental protection, as well as to promote public safety, going after guns, drugs, gangs, organized crime, and illegal smoke shops. I'm known as a happy warrior, now ready to fight for the rights of all New Yorkers. It matters who your lawyer is. The counsel has its priorities. Some now in the New York Court of Appeals, where I have argued many times and won. And many say our democracy is on the ballot this presidential election year. Whatever the outcome, I'll stand up for our city. I want to share with you something about my background that informs my values. Like so many of you, I'm the grandson of immigrants. They came to this country from Italy through Ellis Island. My father dreamed of becoming a teacher. He had to drop out of grad school to come home to save the family shoe store business. Supported so many of his relatives, his mother, his sister, when his dad tragically and suddenly died of a heart attack. But my father continued to pursue his dream while running that shoe store and supporting his family, going to NYU at night and simultaneously teaching political science at a local college. He exemplified the best in American values, an immigrant's tale of hard work, perseverance, and fulfilling one's dreams. And although he's no longer with us, and I miss him every day, he inspires me every day to pursue my dreams, which I'm doing here today. I have met with most of you. I've offered to meet with every council member. And I believe if you get to know me, you will want to work with me because I get results, and now I'll get them for you. You won't have to fill out any forms to meet with me because we do best for our city working together. On issues so many of you told me at our meetings you care about, I care about them too and have a proven track record of addressing them. On women's rights, I've worked with Legal Momentum, NARAL, Sanctuary for Families, as a board member and pro bono advocate for victims of domestic violence. And in the late 80s, I prosecuted Randall Terry and Operation Rescue, that virulent anti-abortion group, fining them and enjoining them from blocking access to abortion clinics. On LGBTQ plus rights and the rights of same-sex couples, I worked with Lambda, the Empire State Pride Agenda, Stonewall Veterans, and Freedom to Marry to advance within government and on a pro bono basis the rights of same-sex couples and the LGBTQ plus community. On immigrants' rights, the Charter Revision Commission I chaired made the Mayor's Office of Immigrant Affairs a permanent charter agency and enshrined in our city's constitution the city's commitment to immigrants to ensure them access to city services without fear of reprisal. On homeless services, when Bowery Residents Committee, one of our city's leading homeless services providers, faced an existential crisis that it had to win from NIMBYs trying to shut down its flagship Chelsea facility. Its executive director, Muzzy Rosenblatt, who you'll hear from later today, turned to me to be BRC's zealous advocate, and we prevailed, saving that organization. On tenants' rights, as a legal aid vice chair and board member, I raised literally millions of dollars for that organization to support tenants' rights. And as a federal prosecutor, when the city couldn't evict drug dealers from public housing, we used federal forfeiture laws to remove them, to the cheers of tenants. On education, I've served on the boards of CUNY, Literacy Design Collaborative, YMCA of Greater New York, Children's Museum Manhattan, Jewish Children's Museum, and Hale House. And I did pro bono cases with the UFT to reduce class size. On civil rights, racial justice, diversity. In addition to my other pro bono cases, I took on Mayor Bloomberg on term limits, resulting in more diverse city office holders today, including the more diverse city council that exists today. In private practice, I led my law firm's New York litigation group from 0 diverse partners to more than 30% women and other diverse partners. And inclusion and diversity will continue to be a priority of mine. On environmental protection, as deputy mayor, I designed and implemented the plan to close the Fresh Kills landfill, ensuring a more equitable, environmentally sound system for disposing of city waste. And in private practice, I've held government accountable to do full environmental reviews and protect environmental justice communities. On workers' rights, as a federal prosecutor, I brought groundbreaking cases requiring direct rank and file elections by union members of their top officers. As deputy mayor, I worked so constructively with unions that they chose in record numbers to cross over and endorse our administration for re-election, including DC 37. And on public safety and gun control, over my career as a federal prosecutor and deputy mayor, I faced down organized crime and won. In our administration, major crime fell by more than 50% and the murder rate by 70%. And the Charter Revision Commission I chaired banned guns and increased penalties for possession near schools. To those who say they consider my nomination to be controversial, I understand them to be questioning a few of the hundreds, if not thousands, of cases I've taken on in private practice. Not my qualifications for this job or my abilities as a lawyer. Within the legal community, I'm described by our trade press, the American Lawyer, as, quote, one of the most respected lawyers in the country, end quote. And I enjoyed widespread support among elected Democrats and unions with whom I worked as deputy mayor. Indeed, I'm supported or have represented every Democrat candidate for mayor from 2001 to the present. That should also tell you something. In fact, when I left City Hall in mid-1998, the New York Times quoted a colleague describing me as, quote, the administration's conscience, end quote. And the Daily News ran an editorial praising me for doing, quote, the seemingly impossible, and saying the contributions I made to the city I served so well will last a lifetime. Now I'll be able to make more such contributions. Let me address the real elephant in the room. To those who say I'll just be the mayor's lawyer, they obviously don't know me. I am my own man. I've stood up to organized crime, mayors, governors, and even presidents when they got it wrong, and won. And I brought lawsuits directly contrary to the positions of this administration. So you don't have to guess whether I'll stand up. I already have. I've been described as fearless, tenacious, courageous, and I'll stand up for what is right, representing the entire city, including the city council. I've read press reports relating my nomination to larger issues between the mayor and the council. Whatever their differences, I am here as a nominee for a legal position and to present my qualifications on the merits. I pledge to represent both the council and the administration with professionalism, integrity, and respect, and to bring both sides of the hall together to find common ground as I did as deputy mayor, only this time representing both. So I hope and pray this council will recognize the value of having me as your lawyer and representing you and our city as a whole in ways that will be truly innovative and transformative. In your own lives, you'd need a lawyer. You'd want the best qualified attorney to represent you, one with a proven track record of success. Our city deserves no less. Paraphrasing a president who inspired me in my youth, I come here today asking not what our city can do for me, but what I can do for our city. I stand ready to serve this city that I love and to give back. And I vow, if afforded this opportunity, I will make all of you proud of what we accomplish together. Speaker Adams, Chair Powers, respectfully, may I make one request before we continue? I will, of course, remain here for the entire hearing, and I look forward to hearing what everyone has to say, and it's meaningful to me. But I hope after hearing from the public, you will afford me the opportunity to respond briefly to what is said here while it is fresh and we're all here together. That will complete the circle and I think be the most helpful way to conclude this public hearing. I would really appreciate that opportunity. Thank you.
Thank you, Mr. Mastro. It would be out of our normal procedure to have somebody testify at the end again, but we'll, for the time being, move forward with the first round. And
I really appreciate it. This is unprecedented in so many ways, but I would really appreciate it, and I thank you for your consideration.
Thank you. I also want to recognize we're being joined by Councilmember Gennaro, Councilmember Sanchez, Councilmember Ressler, and Councilmember Feliz. Before we begin our questions, I also want to make sure everyone understands the purpose of today's hearing and the procedures that we'll be following for the rest of the hearing. The purpose of this hearing is to hear from the nominee, to examine his record, and to determine whether they have demonstrated the commitment towards justice worthy of the privilege and trust to lead the law department in representing this city. Corporation Counsel must have the faith and trust of officials throughout our government, including, of course, the City Council, Public Advocate, Controller, Borough Presidents, Mayor, and the hundreds of attorneys and staff of the Law Department, as well as the diverse people of New York City. There must be trust that the person in this position will represent the public interests of all New Yorkers and prioritize the pursuit of justice over politics, and today's hearing can help us transparently make that assessment. Now that you've given an opportunity to make a statement, we'll also, as we discussed, be hearing from members of the public after the council members have an opportunity to ask their questions. Before public testimony, council members will be allowed to ask and speak to and ask questions of the nominee. And I also want to do some housekeeping on the processes and expectations. As chair, I'll be recognizing members to address the nominee, starting with members of the committee and followed by other council members. We will afford flexibility to members on their first round of questioning. After that, after the first round has been completed, we will have a second round, which each member will be limited to 5 minutes. We also want to, of course, ensure that whenever a council member is recognized, the time belongs to that member. They can use that time to make statements, ask questions, and reclaim their time from the nominee or the public at any time. We ask people do not interrupt each other, and we request that people are answering the questions that are asked of them. After all members have an opportunity to address and question the nominee will be excused, and we'll welcome and encourage you to stay, as I think you have already committed to do so, and then head into the public portion of the hearing. I want to thank everyone who is here today for attending the important hearing and participating in this public process. If you have not yet and you wish to testify, you can fill out an appearance form with the Sergeant at Arms and indicate whether you will be testifying in favor of or in opposition to the candidate. Members of the public may also participate in this hearing by registering on the council's website at council.nyc.gov/testify. We ask members of the public who are here with us remain silent during those proceedings. We've already had one that did not. So we'll ask you to refrain from applause or other audible reactions. I'll start with my own questions before recognizing the speaker and other members for turns to ask questions. And I should note, we can't offer another opportunity to testify, but you are offered an opportunity to amend your testimony within 72 hours if you'd like to submit or amend or adjust your testimony. I want to jump into a number of questions. I will take a few minutes, but since we have such a long hearing, I want to offer the opportunity for everyone to testify. I wanted to pull one quote from your testimony here. You won't have to fill out a form to meet with me. Is that a promise?
That is an absolute promise, and I have told many of you that when we have met, I am your lawyer. You will be on speed dial to me. I will always have an open door, no matter what any of you have said about me in the past or say about me in the future. I am there to serve you.
Okay. I want to ask a few questions related to some information that you provided to us up front before the hearing. We had asked you to provide, to answer some questions, pre-hearing questions. You provided some documentation, and we had asked for some additional documentation. Before that, we asked you to provide a list of all instances in which you have represented a client in a cause of action against the city, the name of the client, a summary of the cause of action, and the final disposition of the matter. We received a list of clients and cause of action, but I don't believe we'd received the rest of the information. I wanted to ask if you're planning to update that information to us, and if so, what a timeline for that would be.
Yep. Mr. Chair, I did supplement the responses. You asked me to go back in my career, any case I'd ever had representing a client against the city. I went back to the late 80s, early 90s when I represented, Roland Eanes, a black newspaper delivery man who'd been falsely arrested for criminal trespass in the lobby of a building because white tenants complained against him, and I got him acquitted. And I thought I provided all of that information going back over the course of my career, but to the extent there's any additional information you would like me to provide, I will definitely do that. I am an open book.
I think we had asked for some information related to the final disposition of those matters and citations to the final decision. I don't think we had received that. So are you committing that you will provide that to us after the hearing?
I'm committing I will do that. It's all a matter of public record. I did give the names of the cases. And over the past 10 years, any cases I brought against the city, I provided that detailed information. But I will go back to my days as a young pup lawyer and give you every detail.
Got it. Are there any cases, to your full knowledge, that that should be on the list that you haven't provided to us?
Again, I left my former law firm 2 years ago and joined King & Spalding, so I don't have access to my old files, so I was going on memory, and I made that clear.
Sure.
So it is possible that there would have been one or more that I didn't recall over a 40-year career. I intended to be complete, but it is possible that there are others, and I'd be happy to,
I think the question is to your knowledge.
To my, to the best of my recollection.
Okay.
I think I listed over 20 cases.
Got it. Okay. In your private practice, you've represented a wide range of clients. We have obviously many of them in the information you provided, and many that have challenged decisions to our city or state government. We're in receipt of a letter that you authored to the Conflict of Interest Board on April 23rd, 2024, seeking guidance to them about how to deal with your current and former employers, and a response letter from the Conflict of Interest Board dated a week later, April 30th, providing guidance and assistance to you regarding your current and past employment. COIB stated in their guidance letter, you'd be required to recuse yourself from any matters involving Gibson, Dunn, and Crutcher, including but not limited to receiving emails or participating in conference calls, may not attend meetings regarding these matters, and may not receive copies of the documents relevant to these matters. They also added that you must be recused, as described above, at the city from any matter involving King & Spalding, including any matter in which King & Spalding is representing a party. Before I ask my question, I just want for clarification, can you just state your relationship with King & Spalding and your relationship with Gibson, Dunn, and Crutcher?
I was a partner at Gibson, Dunn & Crutcher for 25 years, both before and after my tenure in city government in the mid to late 90s, and left that partnership approximately 2 years ago, and I'm now a partner at King & Spalding.
Okay. And if you are nominated, will your relationship with those firms continue? I assume you will cease to be employed there, but what will be your relationship with them if you are corporation counsel?
I have no current relationship with Gibson Dunn, and I would be resigning from the King & Spalding partnership if I were fortunate enough to have this opportunity to serve.
Okay. And do you agree with the findings of the letter from the
I offered to do exactly what they said I should do before they ruled, and I will, of course, abide by that guidance. And, of course, I respect the Conflicts Board.
Understood. And the letter that they provided is a form, they've stated it is not a formal opinion of the Conflict of Interest Board. It's providing information and guidance to you. I think it's from the Deputy Counsel. Have you sought out a formal opinion from the Conflict of Interest Board on any of those matters? In terms of the full board?
Not beyond the guidance that was given, because I offered going in and told your counsel's office as well that I will be recusing myself from anything that has to do with Gibson, Dunn, or King and Spalding.
Understand. And so is there a plan to seek out a formal opinion to provide a more comprehensive opinion evaluation? Are you going to, I'm trying to understand your recusal process with your prior firms. You'll follow the letter that is provided to you on April 30th from the Conflict of Interest Board?
Absolutely, and if there's a need for further guidance, I've done this before. I will get that guidance and follow that guidance to the letter.
Okay. The guidance letter states, I think, fairly clearly that you're to recuse yourself from matters with your past and current employers. Have you sought any guidance? It noticeably is absent on your present or past clients, and was wondering if you had sought out guidance on whether a recusal would be necessary for, let's say, your present clients who might be challenging the city of New York.
The ruling didn't reach present clients who I'd no longer be representing, but I did represent to the Conflicts Board that any matter for a current client that involved the city in any way, I would be recusing myself from. If the situation arises that a former client is appearing before the city, I'll seek further guidance from the Conflicts Board to the extent that seems appropriate and warranted, and of course follow any such advice.
Okay. So, for example, you currently represent a coalition of condo owners, co-op owners challenging a law the City Council passed. We commonly refer to as Local Law 97. In that particular instance, would you recuse yourself from working on that case, meeting with the client, participating in conference calls or emails?
Of course. Any current matter that I have that involves the city in any way, even if the city isn't a direct party, like congestion pricing, not a direct party in my case, but I would be recusing myself. This is, of course, what I would do.
Okay. And what is the statute of limitations on when you would be recusing yourself from a client that's in the past or in present?
Well, as I understand the limitation or the recusal, it's for the duration of the matter. And then, depending upon the nature of a subsequent matter, may require further guidance or recusal, but that would depend on the nature of the matter.
And can you just discuss with us the process on how that determination will be made? I mean, COIB has clearly outlined in their letter that you should not be, you should be recusing yourself when you have business with your former or past employer. Feels pretty open and shut on that one. But in the case where there's a present client, maybe with a different attorney, what would be the process of seeking or determining, I should say, when you need to recuse yourself from a case?
These are ethics issues that lawyers have to deal with all the time as to when they have a conflict or should recuse themselves. I err on the side of recusal or seeking the guidance on whether I should recuse. So if it's a matter unrelated to anything that was the subject of litigation that I was directly handling, but it's the same client on a different matter, I would, in all likelihood, go back to the Conflicts Board and ask for guidance on whether I should recuse myself.
Okay. You said in all likelihood. What would be instances where you wouldn't do that?
Something could be so unrelated to any work we ever did together, or they could be part of a large coalition where they play a minor role or something like that. But I would err on the side of seeking guidance from the Conflicts Board, and if it is more of a comfort to this council, I would do that on any matter where they appeared.
And is there necessary recusal related to a specific category? For instance, if using a similar example of a condo association in Brooklyn were to bring a case related to similar to the one you have on Local 97 that mirrored or resembled the case that you've presently represent a client on, how would you handle that?
I would recuse myself on any case involving challenges to Local Law 97.
Okay, understood. Just taking another example, you're currently the counsel of record in a case, GMAX managing against the state of New York, which they petitioned the Supreme Court to take up. The case challenges specific provisions of the Housing Stability and Tenant Protection Act of 2019. If your case that your client brings forward were accepted, or in any instance where it's working through the courts, the City of New York, I believe, would likely file an amicus brief in opposition to that case, as it's done in other cases as well. In the past, that brief has been filed, and the front page usually has the name of the corporation counsel on it. In this case, the attorney record for this client, who is currently you, would then be the corporation counsel for the City of New York filing an amicus brief in that case. Is that a direct conflict?
I would be recusing myself from any matter where the city was involved in the amendments to the rent control law. Just to be clear, Chair Powers, in that case, I represented small landlords who challenged a certain of the 2019 amendments to the rent control law, but we said in the very first paragraph of our appellate brief to the Second Circuit and to the Supreme Court that we agreed with rent control. We were not challenging rent control writ large. We support rent control, but certain retroactive amendments where small landlords had made tenant improvements for which historically they were entitled to some credit over a period of years were retroactively changed, where their rights to move back into their own properties to live had been retroactively changed. It was a very limited constitutional challenge, but I would recuse myself anyway. The city was did not end up being a party on the merits in the GMAX case, but if the city wants to file an amicus brief, I would recuse myself from that, and God bless the city. I have always supported rent control. This was to address a unique problem limited to small landlords and the draconian effects of certain amendments retroactively applied to them, and we told that to the court, that we support rent control, but the effects of some of these amendments was just too much for these small landlords.
Okay, and there are instances where the city has filed a brief in I think the CHIPS case against the City of New York, and I'm sure others as well.
Yes, which was a challenge to rent control writ large, which we did not support, we do not support.
Good, appreciate it.
I would never support that.
Okay, I appreciate that. A couple, it's just to go through this, we've talked about congestion pricing. It sounds like some of the cases rent stabilization, local law 97. Are there other areas right now where you feel you would need to make a recusal based on your current practice?
Well, we did talk about some of those cases on congestion pricing. I would recuse myself from the litigations in which the city is involved, but to be clear, so the council understands, that is a litigation on behalf of the governor of New Jersey and the state of New Jersey. That is an environmental challenge. The city is not a party to that litigation. It's an environmental challenge to the work done by the Federal Highway Administration and the MTA. It's actually a pro-environment case. It's about the inadequacy of the environmental review that was done by that federal agency and the MTA that didn't protect, that didn't adequately consider, didn't mitigate the adverse effects of congestion pricing on environmental justice communities in New Jersey, in Bayonne, in Newark, in East Orange, in all of Bergen County. There was no mitigation in that original plan for the adverse environmental impacts on those environmental justice communities, and that's what we challenge. It doesn't seek to stop congestion pricing from ever happening. It's to say, and I've done this in a number of cases, hold government accountable to do it right, to do full environmental reviews and protect environmental justice communities. And when you do it right, it will go forward. Governor Murphy has said he supports the general concept, but I would still recuse myself on any of the other cases. I know Staten Island has a case, and others have cases where the city is involved. I would recuse myself from those cases anyway.
I would contest that the legal argument being made by the state of New Jersey is motivated by their intention not to be in support of congestion pricing, whether it is about the EIS or not.
I can't speak to the governor's motivation. I can speak to, as a lawyer, the principled positions and arguments that I've made, and it's about protecting environmental justice communities and making sure they get mitigation for the obvious adverse environmental impacts that will occur from the
Understood.
rerouting of traffic through New Jersey.
Just to go back to the question asked, what are other areas where, as Corporation Counsel, at least in the short term, you would need like areas of practice where you might, or specific areas where you might be required to recuse yourself beyond the ones that we had mentioned?
I'm not sure. I would have to review the cases and whether they're still ongoing, but I did name 4 cases in the last decade, and in any of those I would recuse myself even if the city wasn't directly involved.
And I would know, like, those are big cases, and I might make the argument that we want a Corporation Counsel who can be fully working on, invested in those issues. As you know, it's your lawyer does matter. And so how do we move, as we move through the nomination process, address what are, I think, fairly substantial issues that the city of New York should be, I would argue, be participating in, or requiring your litigation skills and talent to help address what a challenge to New York City might be on those issues?
I'm really glad that you asked that question because I will acknowledge to you that some of these are, we're talking in 3 areas in particular, they are important issues. I certainly don't have any perception from the outside that the city has not been well represented in those areas. But I would say this, I think that's why it's so important to have a Corporation Counsel who understands when the city has an objective, a priority, a salutary purpose that even some of the litigants involved. In Local Law 97, my client said that they support carbon emission restrictions and reducing carbon emissions. In the GMAX case, my client said they support rent control. In congestion pricing, Governor Murphy says he supports the environmental aims.
Every single one of them has a lawsuit to prevent that action from happening.
And my point is this, I understand when the city gets it right, when the state gets it right, when the federal government gets it right, and I understand when things haven't been done quite right. And I believe I can play an even more important role in working with this council, having a dedicated team from Corp Counsel help you with drafting your legislation, creating the record that will ensure that litigation like the ones I have sometimes participated in to hold government accountable, will not be successful, that you will achieve your objectives and they will be beyond challenge in court. It's really important that you have a Corp Counsel who comes out of that background and understands how to protect your interests and your objectives from potential litigation.
But Mr. Redger, would you agree that litigation is a strategy to prevent outcomes or delay outcomes, even if you state in your mission statement that you agree with a certain issue? I'm not saying you are doing this, I'm saying, but often it's a strategy utilized in order to prevent something from happening. So regardless of whatever the mission statement is of any organization or group, litigation is part of a strategy to delay an outcome or prevent an outcome.
I couldn't accept such a broad proposition unless you look at the specific facts and the specific parties involved. I can only tell you this, the small landlords, in the cases, the Condo Co-op Association and Local Law 97 case, the small landlords in the GMAX case, they do believe in those principles. In those small condos and co-ops, they spent tens of thousands of dollars to reduce carbon emissions and succeeded in the years preceding the new law. And they're concerned about the effects of the new law when they invested in complying with the old law. Same thing in the GMAX case about retroactive amendments. My point being this, one size doesn't fit all. You have to look at the facts of each case, but let's assume that there are cases like you're talking about where litigation is a strategy. All the more reason why you need a Corp Counsel who understands that and is proactive in advance, helping you as a council draft your legislation, create the administrative record that supports it so that when these cases go to court, and there are some parties who do what you suggest, Chair Powers, we will be ahead of the curve and defeat them promptly and quickly and achieve your objectives. That's what I do as a lawyer. That's the value I bring to the table, understanding those issues, having litigated them, and understanding your priorities. I live to serve your priorities, your policy objectives, and I will make sure that we are in the best position to defend you in court because I've been there and I know what it takes to challenge the city and I know what it takes to protect the city, and I will protect you.
Okay, thank you, Mr. Mastro. I'm just in respect of time. I'll come back with for further round of questions. We're now going to go to the speaker for a round of questions.
Thank you.
Thank you very much, Chair, and thank you once again, Mr. Mastro, for your testimony thus far. I'm going to be speaking from a couple of different perspectives. I first want to go into the role of Corporation Counsel. Under the city charter, the Corporation Counsel is the attorney for the city, including its elected officials, agencies, and most important for us here, the Corporation Counsel is charged to represent the people of the city and the best interests of the city as a whole. As the city's attorney, the Corporation Counsel is lawyer to not only the mayor, but all of the other branches and offices of government, including the council, comptroller, public advocate, and borough presidents, and must have the independence to determine what is in the best interest of the city as opposed to one particular official or branch of city government. Throughout your career in city government, all of which took place during the Giuliani administration, there was immense antagonism to the council, but also to other city elected officials, most notably the office of the public advocate. Given this history and your role as one of the highest ranking officials in that administration, how can this council trust that you will faithfully represent the interests of all of the city's officers, not just the mayors?
Madam Speaker, I respectfully disagree with the characterization, but it's not just me disagreeing with the characterization. It's former City Council Speaker Peter Vallone, who says, quote, Randy Mastro is an excellent lawyer who knows right from wrong, and he would be an excellent corporation counsel. Mark,
That's not my question, sir.
okay, but you said there was terrible animosity.
That's not my
towards the
question,
council.
though.
Okay, I'm sorry.
I'm asking you
Yeah.
how the council can trust that you will faithfully represent the interests of all the city's officers and not just the mayor. That's coming from you.
Okay, thank you. You hopefully know and will hear from some former city councilman today, actually the respect that I had and how well I worked with the council when I was deputy mayor in charge of intergovernmental relations. So you know there is a track record of me with Speaker Vallone, his senior staff, and the council members, some of whom will testify here today, about how constructively I worked with the council when I was deputy mayor responsible for only one side of the hall. Now let me be clear on issues that you can take to the bank about why I will be an independent force for good representing this council in ways that no corp council ever has before. On affirmative litigation, how does that work? That works because I work with each of you, all 51 of you, to identify cases of concern in your districts on civil rights, constitutional rights, tenants' rights, workers' rights, consumer protection, environmental protection, and then we bring those cases, closing illegal smoke shops, going after gun violence, gang violence, drugs. I work with each of you as corp counsel and have a dedicated larger team to bring those cases.
But Mr. Mastro, respectfully, you are projecting into the future. I'm trying to lay a groundwork for historical perspective here before we get into a projection of the future. And my question was very specific. It had to do with your work and your career in city government in the past. That did take place under the Giuliani administration, and that had a climate of antagonism toward the council and other elected officials and other members of government. The question once again was, given that history, how can the council trust that you will faithfully represent the interests of all of the city's officers and not just the mayors from a historical perspective?
Okay. Madam Speaker, respectfully, from a historical perspective, I was actually known as the person in City Hall who developed constructive working relationships with the council and with other elected officials. That's why every major Democratic elected official from my generation, Billy Thompson, Betsy Gottbaum, Mark Green, Freddie Ferrer, Peter Vallone, have endorsed my candidacy because they know how constructively I personally worked with the council to achieve a sweeping legislative agenda to go after organized crime at the Fulton Fish Market, private carding industry, to make domestic partnership rights for same-sex couples the most sweeping protections in the country. I did that. I always had an open door, and I always reached across the aisle and across the hall. So the historical perspective you're describing is not how elected Democrats experienced me when I was the deputy mayor in charge of intergovernmental affairs. You will hear from some of them today. I had a track record of reaching across the aisle. I built bridges. I had an open door where we mediated disputes and we didn't end up in court. And I believe that track record is something that I can help bring the two sides of the hall together. So, Madam Speaker, I respect the question you're asking, and I was only in City Hall for a little over 4 years, not the entirety of the Giuliani administration, but my record is clear. I reached across the aisle. I had open doors. I had open doors to everyone, even if they didn't get along with the mayor, and we got things done with the council.
Speaking of a track record, once again, respectfully, Mr. Mastro, the track record shows that you have called the Office of the Public Advocate a left-wing radical and fighting to cut that position out of the line of succession. Is that true?
Well, actually, again, Mark Green supports me right now, and we've submitted that.
That's not the question, Mr. Mastro. We understand your endorsements.
Yes.
The people that support you have made their voices very clear to this council.
Thank you, Your Honor. Thank you, Your Honor. The issue that you're raising has to do with a charter revision where the mayor wanted to eliminate the public advocate from the line of succession. In that context, I chaired that commission. But actually what I did historically, and I think it's why Mark...
What was your perspective?
My perspective was, and this eventually happened in the Bloomberg administration when Betsy Gottbaum was the public advocate, also here supporting me. But when that proposal was made by the mayor to change the line of succession during the mayor's term, I stood up to Rudy Giuliani. My charter revision commission that I chaired said no, we did not do that. We said we would not do that while he was mayor and while Mark Green was public advocate, that had to await a future generation. That's the fact, Madam Speaker. And I think that shows you can count on me to stand up to mayors and count on me to stand up for the council and other elected officials. So we did not change the charter in that respect, and I refused to put on the ballot changing the line of succession to eliminate Mark Green from succeeding Rudy Giuliani. We said that was a future issue and should go on the ballot only to happen prospectively after everyone had left office. And eventually, Mayor Bloomberg made the same proposal and did that to Betsy Gottbaum.
Okay, I still don't think that my question, which was really specific, was addressed, but we're going to move on. The Corporation Counsel must carefully and transparently explain to elected officials the potential negative long-term consequences to the city or their respective governmental entity of making a particular argument or taking a particular action. To fulfill their duty, the Corporation Counsel must prioritize the long-term institutional interests of the city, advise against organizational wrongdoing, report internal wrongdoing to appropriate authorities, and screen claims and legal arguments made against and for the city. They fail in their duties when they do not adequately advise city officials and agencies on how a short-term legal battle might affect the city's long-term interests. Similarly, it would be a failure to decline to report and appropriately act in response to organizational wrongdoing. Of course, this form of legal representation is in stark contrast to the type practiced in the private sector, where aggressively zealous representation of individual interests is expected. Once again, given your history of loyal service to Mr. Giuliani in your public service career and your career in the private sector aggressively representing individual private interests that often conflicted with the city's long-term institutional interests, how can this council entrust in you the long-term institutional interests of the city?
I'm very glad you asked that, Madam Speaker, because the role of a lawyer litigating on behalf of clients in private practice is to represent them zealously and ethically and get the best results you can for them. And I'm known as a lawyer who's tenacious and successful in the courtroom. So I'm known as a bear in the courtroom, but I'm actually a teddy bear in real life. And I was honored to have the opportunity to meet with you prior to these hearings. I'm actually in government. My personal reputation, maybe not my old boss's, who wasn't the easiest guy to work with all the time, but my personal reputation was one of reaching across the aisle, building coalitions, reaching across the hall, getting things done, and working well with other members in government, and the different branches of government and the different offices of government. That's why they're all supporting me now. So we did a lot of positive things for the city. No one thought we could break organized crime stranglehold, the Fulton Fish Market private carding industry. No one thought we could pass the most sweeping domestic partnership protections in the country at the time for same-sex couples. No one thought we could close the Fresh Kills landfill and have a more environmentally sound policy. We did a lot of constructive things. No one thought we could move the illegal vendors off of 125th Street without violence and incident, and now have it be a thriving commercial center and those vendors in their own mart operating legally a few blocks away. There are so many positive things when I look back on my own time there, and so many relationships I built that I built because of the people who were supporting me today. So I understand the difference in the role. I understand what it is to build coalitions, to work with partners in government, and I have a proven track record of doing that. That's why every major elected Democrat in my era supports me now. That's why every Democrat who's been the nominee for mayor from 2001 to the present, I've either represented or supports me or both. I build bridges. I am a consensus builder. I am a communicator, and my goodness, Madam Speaker, right now, more than ever, we could use some communication in City Hall to build bridges, and I'm prepared to do that for both sides of the hall.
We just need you to put that microphone closer to you
I'm sorry.
so that everyone can hear you.
Okay.
You can just pull it
No
forward.
problem. I hope you could hear me, though. Thank you.
You can hear.
Thank you.
We want the public to
I
hear.
really appreciate it, Madam
All right.
Speaker.
In looking at the values of the Corporation Counsel, the Corporation Counsel is not only an attorney, but also a government official. Together, these duties require the person in this position to appropriately consider and respect the principles of democratic self-government and the rule of law. City government must serve all residents, whether or not they voted for us, or those who employ us, or whether or not they can vote at all. Government decisions have many implications and can affect the rights of people who lack access to decision makers. It is often a public servant and government lawyer's role to fairly articulate a decision's impact on those rights and interests. The Corporation Counsel must counsel not just to the letter of the law, but also on shared public values. While these values ultimately serve the long-term interests of the public and society, they may also conflict with existing law or the short-term interests of those in power. It is the Corporation Counsel, as the chief legal officer for the city, who can advise policymakers on the interests of groups not represented by majority or powerful political forces. Fritz Schwartz, former Corporation Counsel under Mayor Koch, and a respected architect of the current city charter, stated that, quote, "The interests of the city must be the touchstone," end quote. Implicit within the interests of the city, fundamentally the public interest, is the administration of justice. It is incumbent upon the Corporation Counsel to consider, advocate, and advise on the advancement of varying concepts of justice for the public interest. This council believes in an inherent and unique interest to govern impartially and see that justice shall be done. What about your professional history would give this council confidence? And you notice my line of questioning so far continues to say the same thing. It has to do with trust in you and the council putting its trust in you. What about your professional history would give this council confidence that you would put the best interests of the city and the administration of justice before the interests of the mayor?
What should give you confidence and trust in me is that when I served in city government before, I put my life on the line for this city. I faced death threats from the mob, 2.5 years of police protection, but it was the right thing to do to stand up to the mafia that had a stranglehold over the Fulton Fish Market and the private carding industry. I personally lobbied a Republican Catholic mayor and a Democrat Catholic speaker to pass the most sweeping domestic partnership protections for same-sex couples in the country. You think that was easy, but it was the right thing to do, and we got it done. And Madam Speaker, I can only tell you this. I have a long track record. It's not a few years, it's 30-plus years of standing up for civil rights, constitutional rights, racial justice, when Donald Trump, Bill Barr, and other federal authorities tear-gassed and rubber-bulleted peaceful racial justice protesters in June 2020 in the wake of George Floyd's murder. Okay. That was an atrocity. I stood up for justice, pro bono, and we pushed back the administration and got the Biden administration to impose protocols so that something like that never happens again. When Janet Morgan, who you'll hear from later, 30-plus years ago, got fired by the Malvern School District for giving her class an assignment on racism. She'd been out of work for 2 years. She had lost all of her money after mortgaging her home, and her old lawyers were going to withdraw. I stepped in 1990 to represent her pro bono. We got her job back. We got her back pay. We got a ruling from the Commissioner of Education that teachers have a right of academic freedom on such subjects, the first such ruling ever. I've been doing this for 30 to 40 years, standing up for civil rights, constitutional rights, and racial justice. I've been standing up for public safety to the point of literally putting my life on the line. And my word is my bond. And you were very wise to say before these hearings to the press that you should look at the overall view of my entire record. My entire career is standing up for those principles and the hundreds of hours a year that I've devoted to pro bono service and to community service like Citizens Union, the gold standard of good government, the Legal Aid Society. Madam Speaker, I don't ask you to trust me. I ask you to look at my entire record and ask yourself, when you look at that entire record and decades of commitment to pro bono service and community service, and when you listen to the speakers who will be here today, people you know and trust who vouch for me, and I know you've spoken to them, people you wouldn't expect, people I've represented. I represented Billy Thompson, Betsy Gottbaum, Bill de Blasio, Letitia James. These are all people who respect and trust me so much over the course of my career that they entrusted their sensitive matters to me, and I handled them pro bono, and I got them results. Madam Speaker, I will be the best lawyer you've ever worked with. Just give me that opportunity. I implore you. I pray you will. I know and respect you, and I look forward to representing you if afforded this opportunity. Thank you.
Thank you, Mr. Mastro. I want to delve more into how we can be assured that what happened with the law department during the Giuliani years will not happen under your watch. One specific example that I would like you to address was when in 1999, the Corporation Counsel stood next to then Mayor Giuliani and said that he had the right to stop duly appropriated funds from going to the Brooklyn Museum because he found an exhibit to be offensive. This was contrary to the position taken by the Brooklyn Borough President, the City Council Speaker, the Public Advocate, the city's Cultural Institution Group, a former corporation counsel who represented the city's cultural groups, and virtually every First Amendment expert in the city of New York. It also ended up being contrary to the position of the federal courts. And to quote someone who is vouching for you today, Victor Kovner, the former corporation counsel who gave this quote before the 2019 charter revision, quote, "I have to say, it was not the finest moment for the law department," end quote. How can we have confidence that the law department, under your leadership, would not take a legal position that is in conflict with the city's legal interests and averse to every involved city official other than the mayor, simply because the mayor wants the law department and the corporation counsel to take such a position?
I'm really glad you asked that. You can have confidence in that because that was not my time in City Hall. I was not in city government in 1999 when the Brooklyn Museum incident occurred, and I like to think, had I been there to counsel the mayor at that point in time, that never would have happened, just as some other issues that arose earlier about art exhibits. He did not take the kind of position that he took on the Brooklyn Museum. And I think you can have confidence, people who know me, people who've litigated with me and against me. Victor Kovner is here to speak today. He's one of 5 corporation counsel going back over 4 administrations who have endorsed my candidacy. And I did not agree with the Brooklyn Museum decision, and I would have counseled the mayor against it. And as a corporation counsel, I will stand up for what I think is right, and I will do the right thing. And if I don't think a position the mayor is taking is one that is legally defensible, I will tell that to the mayor, and we will not defend the mayor. You have conflicts with the mayor, and you have legislation where you have conflicts with the mayor. I think historically, corporation counsel has tended to almost always agree with the mayor. I will call the balls and strikes. I will give it straight. I will try to bring people together to see if we can find common ground. I think corporation counsel should be much more proactive that way so you avoid litigation. But I will call those balls and strikes, and I would not have advised the mayor or permitted the mayor to do what he did at the Brooklyn Museum. It would have been against my counsel.
Thank you very much. You've spoken a lot about pro bono work and your pro bono work. During your discussions with several council members, you discussed plans to develop a large-scale program for pro bono services from the city's legal community, contemplating in particular the participation of major law firms, often called big law. How do these large private law firms share the city's policies and preference for real inclusion and diversity, especially amongst their own leadership?
I'm really glad you asked that question.
You're glad that I'm asking all of my questions.
Yes, I am, and that should tell you something. I'm a happy warrior. Madam Speaker, involving large law firms to supplement the great workforce of the law department, I think is something that would be a plus. That ultimately directed by the city and Corp Counsel's office as to the direction of the litigation, but it's additional resources that we can bring to bear to the process. I'm committed to diversity and inclusion, and the law department should always reflect the diversity and be a representation of the community we serve. I have a proven track record of doing that in private practice myself, where I took my old law firm's New York litigation group from 0 diverse partners to over 30% women and other diverse partners by the time I left the firm, and I'm very proud of that. Private law firms making resources available for pro bono work, that would be at the direction of the law department. And I think that that's a supplementation to that workforce. I also think that in our recruiting, and recruiting a diverse team at Corp Counsel's office, extremely important. And the law department needs that kind of emphasis on recruiting. And with affirmative litigation being a hook, I think you are going to see a new energy of people at all levels. The young shining stars to more senior people who want to make a contribution to public service, coming into public service to do that. It will be exciting work, but always, always the team that we will have on the field, Madam Speaker, will reflect this great city of ours and be a diverse team, I assure you.
Mr. Mastro, in the 1980s, Alan Schwartz, Mayor Koch's first corporation counsel, established a program to serve as a bridge while the modern law department was being developed. This program allowed these large law firms opportunity to send their lawyers to get trial experience and other training on the city's time. While the city benefited from their services in the short term, the long-term benefits of that training, experience, and institutional knowledge went out the door to the benefit and windfall of private law firms. How will you ensure this benefits the law department rather than lead to weakening the law department?
Well, Madam Speaker, I think actually I have enormous respect for the law department. I was a consumer of the law department. I stand on the shoulders of giants if I'm fortunate to have this opportunity. But I think that the experience of lawyers in the law department who work really hard with those tens of thousands of defensive cases, to have additional resources, to have exposure and work with lawyers in the private sector, to get that more diverse experience, and to do that on affirmative cases where they are achieving civil rights and constitutional rights and social justice, where they are protecting public safety. I think the lawyers in the law department are going to love that. It's not going to take anything away from them. Right now, we're not doing a lot of affirmative litigation. We're doing some. There are cases like going after, our share of the opioid crisis money, like some tenants' rights cases for slumlords. We need to do many more of those. But they are few and far between. I want to see us do a lot of that kind of work. And if we do a lot of that kind of work, I think the people in the law department will not only be energized and inspired by the work, they will want to work with the broader team to achieve those objectives. It's remarkably inspiring. We did this when I was in the civil division at the U.S. Attorney's Office, and we brought cases against organized crime. We brought cases against drug dealers. We brought cases for consumer protection. You're going to hear from some of my former colleagues. We did groundbreaking work in so many of these areas, and it just jazzed us. It was inspiring. And we worked with outside counsel whenever we could to expand the team because we were achieving social justice and public safety. That's what I intend to do.
Mr. Mastro, why would your enthusiasm, though, not be more towards building up the municipal workforce?
It is, Your Honor. I think we have to make it a major priority, and I have said this, and I said it to you. We have to replenish the ranks. COVID took a heavy toll. We have to build up the law department again. There have been cuts and things like that. It's extremely important. But I think with a law department that does both the defensive cases, which is so much of its docket right now, and the opportunity to achieve social justice and to advance public safety, I think the people in the law department are going to love that. Of course I want to build up the municipal workforce. I want to come back to public service for all the right reasons, to do good, to improve people's lives, to use the law department and the power of the law to achieve social justice and public safety ends. If we do that, my God, the people in the law department are going to love that. I am a mentor. I am a trainer. I am a leader. I'm an inspirer. I've led large law firms. I've led large organizations. And priority number one is to have the best law department, to recruit at every level to bring in the best people. That's priority number one. And you do that because the work is so compelling.
Thank you. I just wanted to note that the gallery was chuckling at your reference to me as Your Honor. I happen to like it.
Then, Your Honor, I will continue doing it for as long as I can. Thank you.
It's fine.
Thank
It's
you.
fine. Madam Speaker will do. Thank you. This is my final line of questioning, Mr. Mastro, before I turn it over to my colleagues. In speaking of norms of democratic governance and separation of powers, this administration has shown a unique lack of respect for the separation of powers between government branches and democratic governance, taking some extraordinary actions to disregard duly passed laws by the Council and the executive branch's obligation to implement the laws. Most recently, the administration used the declaration of a state of emergency on the day before a law to ban solitary confinement was set to take effect simply to block it. The mayor called a state of emergency, quote, a tool in his toolbox, insinuating that declaring a state of emergency is an instrument of the executive branch to be used in the legislative process. Do you agree that the executive branch's role is to implement laws that are duly enacted?
Yes.
Do you want to explain that? Explain your yes, please.
I've answered this in writing to the council because a similar question was put to me in writing, and I said that best practice, best course, if the council passes a law, and I said this to a number of you when we met, best practice, the council passes a law or overrides a mayoral veto if the administration thinks that it is illegal. It's incumbent upon the administration to go to court to block that legislation and have it declared illegal. It's not to wait. It's not to wait to be sued. That's not the way I will conduct myself as Corporation Counsel. And when there are issues like this, I want to be crystal clear. I will be proactive in advance about trying to avoid the conflict as those issues are percolating, to see if there is common ground, and to try and bring the two sides of the whole together. I am a communicator, and I will do that. And I will do that in a way that Corp Counsel have never done before, because I will try to participate on the front end when conflicts are percolating up. But if they are at impasse, and you pass a law or override a veto, that's the law. And I will tell the administration that at that point the administration should be going to court, not ignoring the law. End of story.
Thank you. Would
Thank you.
Would you advise continuing with the current state of emergency and emergency order to block this particular law?
Madam Speaker, I'm not steeped. I'm aware that such an issue exists now. I'm not steeped in the issue, and the emergency executive authority, which I believe emanates from state law, but I certainly would make it a priority to review that issue and give my frank and honest assessment as soon as I'm fortunate enough to have this position. But I'm not steeped in that, and it would be irresponsible for me to opine off the cuff on a complicated issue like that. But I am telling you, I am committed to the rule of law. I've sued over the rule of law and enforcing the rule of law time and time again to hold government accountable to following the rule of law. And the rule of law is if you pass a law or override a veto, that is the law. And it's incumbent, if you disagree with that and think that it's not legal, to go to court to block it.
Okay. Mayor Adams has also made false accusations against the city's campaign finance board that apparently seeks to undermine the independent board's credibility by accusing it of leaking information that it released in response to a Freedom of Information request. Do you find this to be appropriate or inappropriate?
I'm not personally familiar with the issue you're describing, so I would have to understand more about it. But the way you have phrased it, leads to certain conclusions. But I've not studied the issue, and I'm not in a position. Again, I'm a responsible, ethical lawyer. I'm going to give you my best advice after I have studied an issue, and I'm going to give it to you straight. And if I agree with you, I'm going to tell you that, and if I disagree with you, I'm going to tell you that. But it's not something where, if I haven't studied the issue, I should be opining off the cuff.
Okay. What impact do you believe it has when the executive branch undermines independent government bodies or disregards principles of democratic governance?
Obviously, that's abhorrent to so many of us. And you can see in my own history, that entire record of mine, how often I have taken on government. I have stood up to mayors, to governors, even presidents, when they have not respected the rule of law and they have overreached, and I have won. So you don't have to guess how I feel about those issues. You know from my entire record.
Okay. Thank you.
Thank you.
I think I'm going to turn it over to my colleagues. I was going to take you back to my very first question that I still don't think was answered, but I think I'll just leave that.
Madam Speaker, when I review this record, I will try and answer it more precisely. I have enormous respect for you, and I want to make sure that all of your questions are answered. And as I said when we met, I will earn your trust, and I will be the best corporation counsel I can possibly be, working and having the honor of representing you. Thank you.
Thank you for your testimony.
Thank you, Your Honor. We'll now go to the Deputy Speaker Ayala, followed by Majority Whip Brooks Bowers.
Thank you, Chair. Before we begin, I just wanted to add that we do have all of the endorsements on file, and so I would rather not go through them individually, and I think that those folks that are here to speak on your behalf will have their opportunity to do that. We have a number of questions and a number of colleagues that have their own set of questions, and so we want to kind of run through this as efficiently and yet as quickly as possible without taking away from your responses. Mr. Mastro, I wanted to follow up on the chair's questions with one more about your background information. King and Spalding informed us that in 2022 you did some pro bono legal work for Mayor Adams' office. Can you tell us about the exact focus and subject of that work, its time and length, and how many hours?
It was actually in 2023, predominantly in 2023. It was relating to the migrant crisis, and without waiving privilege, I'm authorized to say it was for the city and the mayor's office, and without waiving privilege, I'm authorized to say that it related to ensuring that asylum seekers got their asylum applications heard in a timely manner, which hasn't been happening. That they could get work permits as quickly as possible, which hasn't been happening, and what federal resources might be available to help the city in the crisis. Those were the general subject matters on which we provided legal advice. There was no subsequent action or outcome to report, but that was the nature of the advice.
Okay, and how many hours and how long did you do this work?
It was over a period of months, and I don't know the hours.
2 months, 3 months, 6 months?
I would be guesstimating, but I would say it was over a 4 to 6 month period.
So that's a pretty substantial amount of time.
Council member, it was. It's one of hundreds of cases I work on, so I don't think the actual hours were that significant, but I don't know the exact number of hours.
Understood. Thank you for the response. Given your relationship with the mayor, given that your relationship with the mayor extended to doing legal work for his office, which had not been disclosed until we began asking questions for this hearing, how can you expect us to believe that you will not be partial to the mayor's office as corporation counsel?
Well, actually, I thought I was doing a public service by responding to the request to help. And I would think that all council members would share in the concern that asylum seekers get timely review of their asylum applications and that they get work permits so they can work.
Understood, but that's not the
here.
question. The question is, it was not reported until we started to ask questions.
Not with all due respect. There wasn't a question that asked me that. I was asked about cases I brought against the city. But I have, for
You didn't
almost
think it necessary to disclose that?
for every mayor, I have volunteered my time and done pro bono service for every mayor.
That's wonderful, but why not disclose it if you were the subject of?
It wasn't,
this
I
hearing.
would have been pleased to disclose it had I been asked. And of course, as soon as it came up, I gave this council a disclosure. But to me, it's an honor to serve the city. And we've had a migrant crisis, and I was honored to help. It's not a question of being beholden to the mayor. I did that work for the city and in conjunction with the law department.
Okay. We also asked you to list all political campaigns in which you have been involved, the name of the candidate and the office, the nature of your involvement. You responded that you worked on a pro bono basis for Rudy Giuliani in 1993's mayoral campaign and for his 2007 presidential campaign, but you did not say in what capacity. You weren't an ordinary volunteer on the 1993 campaign. You were legal counsel to the campaign, as the press release announcing your appointment to Mayor Giuliani's deputy mayor indicated. That's a sensitive position in a campaign, privy to confidential information, correct?
I provided pro bono counsel to the Giuliani campaign on issues relating to campaign
That's
finance.
not the question, Mr. Mastro.
I'm sorry.
I can repeat it if you'd like. You were legal counsel to the campaign, as the press release announcing your appointment indicated. That's a sensitive position in a campaign that is privy to confidential information. Is that correct?
It is correct that it's a sensitive position. I was explaining to you what legal counsel meant. My role was limited to representing the Giuliani, Badillo, and
Okay.
Alter campaigns on campaign
Just-
finance issues.
I'm just asking on this one. Okay.
Okay.
As you were also head of his transition team in 1993, you were also and you were also the head of his transition team in 1993 too, correct?
No, I was a deputy,
Deputy?
and I was involved in helping select a cabinet that was a fusion government and included many Democrats, including Debbie Wright, Ninfa Segarra, and others.
Okay. And in that role, is it correct that you were also involved in the hiring decisions for the mayor's commissioners, political appointments, and other staff?
Yes,
Okay. And when Rudy Giuliani ran for Senate in 2000, did you volunteer in that campaign in any way?
no.
What was your role in Giuliani's 2007 presidential campaign?
My role was being called upon by that campaign to do some press about his record as mayor. That's what my role was.
So, comms?
I wasn't a comms person. I volunteered some of my time to do some press interviews relating to his record as mayor.
Okay. In 1996, the New York Times reported that at the announcement of Mayor Giuliani making you deputy mayor of operations, you called Mr. Giuliani, and I quote, a role model and an inspiration, unquote. Is that correct?
It is correct that I used those words, and if you would like to know why I used those words, I will be happy to tell you.
I actually don't.
You don't want to know why I said that? You don't want to know, that he was a crusading U.S. attorney and we took on the mob in the U.S.
Opinions.
Attorney's office in here?
Your opinions, listen.
No, but you don't want to know that he stood up to the Reagan
But
administration
I would
on
like to
Social
move on,
Security
Mr.
benefits?
Mastro, you're out of turn.
No, I'm
moving
just
on,
trying to explain
New
why I
Yorkers-
said that.
New Yorkers need a corporation counsel who will advocate in their best interests, especially New Yorkers in the most vulnerable positions of society. Instead, Mr. Mastro, during your tenure as a high-profile litigator at two prominent firms, you have repeatedly chosen to represent clients who are unmistakably against the interests of the most vulnerable populations of the city and beyond. You have agreed to represent predatory clients who time and time again are fighting against the interests of vulnerable people, engaging in egregious civil and human rights violations, and seeking to overturn protections. We must ask ourselves at this council, why these clients seek your representation. Beyond your choice of clientele and how this reflects on your professional priorities, there are the arguments and tactics that you have used which we must evaluate in assessing your ability to make important decisions as corporation counsel for the City of New York. I'd like to talk about one of the most important, the most vulnerable groups in New York City, our unhoused population. comprised disproportionately of Black and Hispanic Latinx New Yorkers. According to the Coalition for the Homeless, in June 2024, 132,293 people slept each night in New York City shelters. Thousands more slept unsheltered in public spaces, and more than 200,000 people slept temporarily doubled up in the homes of others. That means that an estimated 350,000 people were unhoused this past June. Unhoused New Yorkers, like others in our city, need a corporation counsel that can and will be their advocate. So we turn to the Lucerne Hotel. In 2020, at the height of the pandemic, unhoused individuals were dying in crowded city shelters where they could not social distance. So the city, under the de Blasio administration, moved unhoused individuals into temporary single occupancy rooms to reduce the density of congregate settings in shelters during the pandemic and slow the spread of the COVID-19 pandemic, of COVID-19. One of those shelters was the Lucerne Hotel, located on Manhattan's Upper West Side. The city then announced plans to move those individuals in that shelter to another hotel in the financial district. Residents of the financial district subsequently brought litigation to stop this move. Mr. Mastro, for Gibson Dunn, as part of this litigation, you represented the West Side Community Organization Incorporated, comprised of residents of the Upper West Side who pressured the city to move the individuals out of the Lucerne. In fact, this organization, known for its anti-homeless views and NIMBYism, argued that the need for the unhoused individuals weren't met at the Lucerne Hotel and that their needs would be met elsewhere, could be met elsewhere, just not at the Upper West Side. In response to this litigation, the Department of Homeless Services issued a statement saying, quote, "New Yorkers experiencing homelessness are our neighbors, and the notion that they are not welcome in some neighborhoods for any reason is an affront to basic decency," unquote. By pursuing this litigation, you determined the city's efforts to create a safe environment for unhoused New Yorkers during the pandemic by pressuring the city to move 235 individuals from the Lucerne Hotel. Would you do that again?
There's a lot to unpack there, Council Member. Fact of the matter is that that's not a fair characterization of that litigation. I actually worked hand in glove with the progressive de Blasio administration and Steve Banks, the commissioner at the time, to find a better housing solution for the men at the Lucerne instead of being doubled up in single-room occupancy hotel without the social services and medical services they needed. The group that I represented I only agreed to represent that group because they committed they would work with the administration to find a better housing solution near the medical and social services that the men at the Lucerne needed, and in single-room occupancy, not doubled up in an SRO hotel. We didn't sue the city. We worked hand in glove with the city to achieve that. And in fact, I represented some of the men at the Lucerne who wanted to move. And today, we have more common understanding. We have more caring. I care about the homeless. I represented BRC to save that organization to continue to provide those services. And Councilwoman, the fact of the matter is that even today, a leader of the opposition, one of the men at Lucerne, Shams LeBaron, supports me for this position.
Okay, we understand. You have a lot of support in the room, and we will gladly hear from those folks, and that information is on record. I don't think that, this is a question of, whether or not you support individuals that are unhoused, but rather there was a situation that occurred that cried of NIMBYism, where you were the representative attorney. But I would like to move forward, Mr. Mastro. During this litigation, you hired private investigators disguised as plumbers who gained entry to the residence of a homeless activist. Once inside, investigators took a photo of the activist undressed and without his knowledge, and you decided to include that photo in documents submitted to the court. In fact, the activist attorney moved to strike this photo from the record, which you zealously opposed. In response to this shocking and unacceptable litigation tactic, the Department of Homeless Services commented that it was, quote, absolutely egregious invasion of his privacy, unquote, and the activist attorney argued that the only reason that it was included in the record was to, quote, harass, embarrass, and humiliate him publicly, unquote. Are these the sort of questionable litigation tactics that you'll be teaching law department attorneys?
Okay. Of course, the way you have framed the question doesn't capture what really was happening from a legal standpoint, so let me explain briefly.
The question here is, will you teach these, is this a tactic that you're going to be teaching attorneys?
Please, Councilwoman, when you ask me a question like that, you have to please give me the opportunity to respond. The fact of the matter was that standing was an issue in the case. Standing meaning legally that we had, when men moved out of the Lucerne, like some of the clients I represented who wanted to move downtown.
That's not the question, Mr. Mastro.
Please, Councilwoman. When they moved out of the Lucerne, you don't have standing to maintain the suit any longer. This individual had moved out of the Lucerne, so I had to prove that that individual had moved out of the Lucerne because it was a dispositive issue in the litigation. And at every phase in the courts, including that phase, the courts held that, yes, I was right in what I did in proving there was no standing. The case ended up being dismissed, challenging removing people from the Lucerne. And I don't think the Department of Homeless Services at that moment realized the context, the legal context in which that occurred. So all I am saying is that there was a legal obligation to prove that that individual no longer lived in the Lucerne.
I need to move on, Mr. Mastro.
Thank you, Counsel.
You know, can the public, I mean, having heard that, you know, I'm very disturbed by that. I'm very disturbed by that. You know, as I'm sitting here just rereading it, and I had that information prior to today. How do you expect the public to trust that you're going to conduct litigation on behalf of the city with integrity and protect the dignity and the privacy of unhoused New Yorkers after that type of incident occurred under your watch?
I respectfully suggest that everything I did was proper and ethical.
I mean,
because please, Councilwoman, because I had to prove he lacked standing.
Yeah.
But when the individual involved says, I understand, and I'm here to support you to become corporation counsel, I think that's a lot more meaningful than press releases that you're quoting from. So I care about the homeless.
I don't want to. I don't want to
care about the
I don't want to go,
homeless.
of course, because I really don't want to. I don't want to get into a back and forth about this. But I think that, you know, your record of accomplishments, I'm sure, you know, speaks of itself. But there's also a question of character, of moral character. There's also a question about tactic. There's also a question about what is legal, but should probably not be or should be handled differently. And I think that taking a photograph of an unhoused individual, you know, under false, well, firstly entering this person's place of residence under false pretenses, photographing this person, to me, is an unethical practice. And whether or not it was legal and whether or not the courts, I take that in high regard when I am making my decisions, because that's not the moral conduct that I uphold myself to, and I expect more from everyone else. But I'm going to move on because, again, like I said, we have a lot of questions.
I'm not going to be permitted to
I'm not
respond to
asking
that?
a question, Mr. Mastro, so I'm not asking you to respond to anything at this moment.
Okay.
And I want to talk about your record with respect to social services, and specifically for New York City's gay community and those living with HIV/AIDS. In your meetings with council members in advance of this hearing and in interviews with the press, you stated that you were proud of the Giuliani administration's support of gay rights. It's true that in 1998, Rudy Giuliani signed a law recognizing the rights of gay and lesbian people to form domestic partnerships, which the New York Times reported was at the time the urging of one of his best friends and biggest donors, and post-divorce roommate, openly gay car dealer Howard Capel. But when you began working at City Hall in 1994, there were other more pressing issues facing the gay community, namely AIDS, and the government's response to it failed. By 1993, HIV/AIDS diagnoses in New York were up to 12,833 per year. By 1994, AIDS deaths in New York were peaking at 8,334. The Department of AIDS Services, which has been established in 1985 to expedite health, housing, food, healthcare assistance to people living with HIV/AIDS, had a staff of around 704 who served 16,000 AIDS patients. At the time, gay people had no legal protections from employment or housing discrimination, and people with AIDS were often too sick to work. As Rudy Giuliani prepared to enter the mayor's office, he proposed drastically cutting the budget, if not eliminating the Department of AIDS Services entirely. Housing Works, a nonprofit service and advocacy organization founded in 1990 to provide housing and supportive services to low-income New Yorkers living with HIV and AIDS, objected. In conjunction with the AIDS activists like ACT UP, Housing Works used peaceful but well-publicized demonstrations and protests to call attention to the need for better HIV/AIDS policies and improvements to the mayor's Division of AIDS Services in New York City. When the group staged a protest, the administration positioned helicopters above and stationed snipers on top of City Hall. That survived budget cuts in 1994 budget, but come 1995, the Giuliani administration required people applying for AIDS-related services who were literally struggling to survive to go through the same months-long red tape process that able-bodied people go through to get public assistance. This callous policy was struck down by the Court of Appeals in 1999 in an opinion that found that the Giuliani administration created illegal obstacles for individuals living with HIV or AIDS to obtain public assistance. As Deputy Mayor of Operations, you oversaw the Mayor's Office of Contracts, which included the approval of city contracts. Subsequent to Housing Works' vigorous demonstrations, protests, and criticisms of former Mayor Giuliani and his HIV/AIDS policies, the city eliminated several contracts with Housing Works, which you approved, including non-renewal of Housing Works' AIDS housing contract, which helped house hundreds of New Yorkers living with HIV and AIDS. I would like to submit for the record the disposition of Randy Mastro and make particular reference to page 109, paragraphs 13 to 16. You were asked if, quote, there was a decision made, was there not, to refuse to renew Housing Works' scatter site contract in 1997, unquote. You admitted, quoted, quote, I allowed the decision to stand, unquote. At reference page 113, paragraph 13, and at reference page 116, paragraphs 17 through 19, you further stated, quote, while I would have had the authority to take a contrary review, I did not take a contrary review, unquote. There were many lawsuits brought against the Giuliani administration. In fact, Housing Works sued former Mayor Giuliani, yourself, and other high-ranking officials within the Giuliani administration for First Amendment violations and illegal retaliatory actions. The city paid Housing Works almost $5 million to settle the lawsuit, which was one of the largest settlements in a series of settlements made with a variety of groups and people who all complained that high-ranking officials like yourself in the Giuliani administration illegally retaliated against them for criticism. Why would we trust you to be a champion of civil rights and pro-gay rights in your role as Corporation Counsel when you have used your power to not uplift but instead allow the Giuliani administration to abuse some of the most vulnerable populations, individuals in New York City?
Okay. I did not do what you just described. I, along with others in the administration, including another Deputy Mayor, Fran Ryder, who you'll hear from later today, we actually advocated and stood up to preserve the Office of AIDS Services, to preserve funding for AIDS programs. And now let's talk about Housing Works. The commissioner at the time, Lillian Barrios Paoli, came to us and told us in 1997, Housing Works.
Mr. Mastro, that's not what the record. That is not what the record says. You were directly quoted.
Please, council member. Please
You were
let me
directly
answer the
quoted.
question. I'm just asking you to let me answer the question.
But you're not answering the question that I
I am,
asked.
please, council member. Lillian Barrios Paoli came to us, me, Fran, explained that Housing Works couldn't account for over $500,000 of the multi-million-dollar housing contract it had to provide housing for people with AIDS, and then refused to cooperate with the audit of where that money had gone. We gave them multiple opportunities to do that, but at the end of the day, Lillian said they refused, and we were left with no choice as people who are obligated, honor-bound to protect the public fisc. You think in 1997, a re-election year, I wanted to have a fight with Housing Works? So Lillian made the decision and the recommendation that the contracts should be terminated. I accepted the recommendation. I have great respect for Lillian Barrios Paoli, as does Fran. And we made that painfully. It was heartbreaking. I have friends, I have former partners who died from AIDS. I advocated for the rights of AIDS funding and AIDS patients in the Giuliani administration.
So you're saying that there was no retaliation?
Ma'am, please. That Housing Works litigation.
Miss, I rather miss.
Sorry.
Ma'am.
Sorry.
I don't-
Sorry, miss.
Or maybe
the-
council member, yeah.
The council member, sorry. I'd say Your Honor, but
No.
I've already given that title to one
We've
other.
been there.
I just want the record to reflect. To us, that was a heartbreaking situation. We didn't have any animus towards Housing Works. Housing Works thought and litigated over those issues. All three of us, Lilium, myself, and Fran, objected to a subsequent law department in a subsequent administration deciding to settle that case. I think it's a problem you council members have experienced too, where the law department settles cases. And I vow to you, you will never have, you will always be included in
Mr.
decisions
Mastro,
to
I
settle
appreciate
cases.
it. I'm not here to rewrite history. I'm here to just, I'm asking questions that are part of the record. This is
Yes.
public information
I
that has been
support
out there, and so I have no interest in rewriting history.
Yes,
I'm asking the question. So additionally, why should we trust that you will uphold the law for millions of New Yorkers and not act in retaliatory manner towards those who have angered the administration, and this is a really important question, or disagreed with you, when a federal judge found that in another case involving Housing Works, the Giuliani administration, which you were a high-ranking official in, broke the law and acted with, quote, retaliatory intent, unquote. Were you not the conscience of the administration? Yes or no question.
I was called the conscience of the administration by Deborah Wright.
Thank
And
you.
I
just needed a yes or no, sir.
Is there a question?
You have invited former Deputy Mayor Fran Ryder to testify today on your behalf. At the time that you were okayed the termination of Housing Works contracts, you were aware that Fran Ryder hated Housing Works and blamed
No.
them for how the other AIDS activists were portraying her.
Not
Why would you think that someone who advocated for terminating an AIDS charity contract would have received by this council as a compelling and credible character witness for you? And when were you trying to convince this council that you've always supported the gay community? Why would you ask her to come to testify on your behalf?
Well, that's not true, and Fran was a tireless advocate for the gay community and people from that community. And the fact of the matter is, I never retaliated against anyone about anything. And I never...
You were a high-ranking official.
Please, Councilwoman, please let me finish, okay? This is important because you've questioned my moral character and you've questioned whether I retaliated against people. And I never did that. No court has ever found that I did that. No court has ever questioned my moral character or integrity. The fact of the matter is I've stood up for homeless services.
You were a high-ranking official in the administration who had the authority to approve and disapprove contracts. So you were a part of these conversations, were you not, Mr. Mastro?
I have already testified.
The courts have already found in favor of Housing Works. There was a substantial, there was a lawsuit.
I have already testified that I advocated for rights in that community. I advocated for homeless rights, and I've done that in private practice. I think the entirety of my record reflects that I have had an unblemished record of ethics and integrity and practice in all phases of my career, and I have stood up for the civil rights of people in that community and for the civil rights of the homeless, and I've gone to court to vindicate them time and time again. So you have to look at one's entire record, and my entire record bespeaks of somebody who stood up for the homeless and someone who stood up for the LGBTQ plus community in the Supreme Court on multiple occasions. That's the record, Councilwoman.
Yeah. So, and with all due respect, we're talking about your witnesses, not your record. Why would
Fran Ryder was a tireless champion for the rights of the LGBTQ community and those who were suffering from AIDS.
Perfect. That's your, okay. That's what that's fine. That's your opinion. From unhoused individuals suffering from HIV/AIDS to unhoused men living in fear of contracting COVID in city shelters, you have fervently advocated against the best interests of the most vulnerable sectors of society. These New Yorkers needed support. They deserve to be treated with human decency and compassion. Instead, Mr. Mastro, they received the backlash of uncouth litigation tactics that you deployed, and they suffered as a result. We have to question how far you're willing to push the professional boundaries of Corporation Counsel. Based on your record, you failed to make vulnerable New Yorkers a priority. Why should New Yorkers expect that this will change now?
It's not a fair characterization of anything I ever did in practice. And the courts at every turn in regard to Lucerne agreed with me. And I have advocated for the rights of homeless organizations and the rights of the LGBTQ plus community repeatedly throughout my career. So that's why the council can have confidence that I will be a passionate advocate at Corp Counsel for those rights as well.
Thank you.
Thank you.
That is all, Mr. Chair.
Thank you very much.
Thank you. We're going to hear now from Majority Whip Brooks Powers, and will be followed by Councilmember Hudson and Ferris. Thanks.
Thank you, Chair, and thank you, Mr. Mastro, for your testimony and the opportunity to have met with you prior to today. So I want to start by talking about affirmative action rollbacks during the time. Are you with us?
Yes, please.
Okay, just wanted to make sure I have your
Thank you.
attention.
Thank you.
Okay. Wanted to talk about affirmative action rollback. So during the mayoral campaign preceding his election in 1993, Rudy Giuliani criticized the program created under Mayor David Dinkins, the first black mayor of the city of New York, which aimed to significantly boost the number of city contracts awarded to companies owned by minorities and women. In its first year, in 1992, the program increased the percentage of contracts awarded to such minority and women-owned companies to 17.5%, up from 9% in 1990. Mayor Dinkins had highlighted this program as one of his major achievements. In the very first month as mayor in January 1994, Rudy Giuliani took steps to roll back Mayor Dinkins' contracting equity efforts to assist women and minorities, including by eliminating this program in a move that was described as quote-unquote an economic lynching in Black Enterprise magazine. Within the next 6 months, Mayor Giuliani took yet another significant step in undermining Mayor Dinkins' efforts by even eliminating the city goal of awarding 20% of all city contracts to women-owned and minority-owned businesses. At that time, as the mayor's chief of staff, you conveyed that the city would no longer, quote-unquote, set arbitrary number goals. And in relation to a different program put forth by the mayor that purportedly could help minority and women-owned businesses, you stated, quote unquote, "We fully expect our program to be much more successful." However, approximately just 3 years later, in April 1997, when you were Deputy Mayor of Operations, Mayor Giuliani admitted that the city at that point no longer even kept track of how many city contracts were awarded to minority-owned businesses. Mr. Mastro, can you share exactly how you and Rudy Giuliani were working to address the disparity in business contracts received by minority and women-owned businesses during the years of 1994 to 1997, when it seems that the mayor's administration didn't think it was even important enough to keep track of basic data related to awarding such contracts?
I appreciate you asking that question. And while I was not the person in City Hall in either capacity, chief of staff or as deputy mayor for operations, responsible for the administration of the program, it was certainly my understanding and intent that the reforms we made in the program were intended to create economic opportunity for minority and women-owned businesses. Former Deputy Mayor Rudy Washington will be here to testify as well, and it was a program that he was involved in, so he may be able to address more specifically your questions. But my understanding is we made reforms that were intended to help minority and women-owned businesses, and certainly that would have been my intent. So I can't speak to what the quote you have from the mayor, but I can say what my personal intent and understanding was at an earlier point in the administration when we made certain reforms. So I appreciate the question, and that's my recollection.
And so you're saying that as chief of staff and as director of operations that you played no role at all in the rollbacks of this program?
I did not. As chief of staff, my role and of course the role of Chief of Staff differs from administration to administration, but as Chief of Staff, my role was the administration of the Mayor's office, the offices that were part of the Mayor's office. And as Deputy Mayor for Operations, my role was to oversee the operational agencies of city government, most of them, not all of them, not economic development, not community development, not small business administration. Those were other deputy mayors. As Deputy Mayor for Operations, I oversaw most of the operating agencies of the city, as well as intergovernmental budget, but not administering that program.
So let me ask you this. Let's continue on this path where you said that you were not responsible for it. I would imagine that based on some of the glowing comments that you've made publicly about Rudy Giuliani, that you agreed with the direction he was taking on the program? Or are you saying you did not agree with it?
I'm saying that what I remember about the reforms we made in the program, my understanding was it was intended to facilitate minority and women-owned business economic opportunities, not the way you have described it. So that was my understanding, but I was not responsible for administering the program, and I just want to be clear. I've talked about things from the Giuliani administration, and there were a lot of achievements, and I've talked about my own record in the Giuliani administration, but that is a program that I was not responsible for reforming or administering.
I mean, and I hear what you're saying. The only thing is factually that wasn't the case, that the changes that Rudy Giuliani made during that time, in fact, took away opportunities from women and minority-owned companies. And let me finish if I can. And you stayed. So if you didn't believe in the work that was being done, or you saw a negative result of a policy, you stayed. And so that's the concern that I have. And privately we spoke, and I was very clear in terms of how I feel about MWBEs, and I feel the city can always do more as it pertains to the participation, the utilization of minority and women-owned businesses. But this is an administration that one of the first actions that he took was to dismantle this very important program, and as a result of it, saw far less minority and women businesses receiving opportunities for contracts. So what is your take on that?
The fact that certain reforms were made to a program isn't dismantling. And the fact that the mayor, several years later, couldn't quote the statistics any longer, wasn't aware of the statistics any longer, doesn't mean the program wasn't still effective. And I didn't stay forever. I left shortly after the re-election. So, there are matters between me and the mayor. The reason why I'm a trusted counselor to mayors and speakers is because I maintain a confidence. But there are things in the Giuliani administration that I'm very proud of that we did. But this was not an area that I was responsible for, so I can't really speak to your questions, Councilwoman, but I appreciate the questions.
Well, I will say that while I understand you didn't stay there forever, you stayed there from 1994 to 1998, if I'm not mistaken.
June of '98, yes, Council.
Okay, and this happened at the start of his term in 1994. So there were still several years, and that was within this, frame of the administration's actions against this. But just going to the next question, if the Dinkins administration goal of 20% was an arbitrary number as it was framed as, what metrics did you and the Giuliani administration set?
I'm sorry?
What metrics did you and the Giuliani metrics set? Because at that time, it was stated that the goal of 20% was an arbitrary number. So I'd like to know what metrics were set to ensure that minority and women-owned businesses were able to have an opportunity of utilization.
Okay. Again, I wasn't responsible for administering, reforming or administering the program, so I'm not the one who can address those questions. Perhaps Deputy Mayor Washington can when he is here. But I personally was not responsible for administering or reforming the program, so I'm not in a position to know how to respond to your question in terms of the.
Well, as Chief of Staff, I'd like to know how you personally address this dynamic. So in the event that you were to be appointed as Corp Counsel and Mayor Adams decided to change some type of policy that was deemed racist or an economic lynching or something that was not in the best interest of New Yorkers, are you going to say that you will just stay there and stand by his side on that matter? Or
No.
are you going to do something? And I want to know, what did you do in your role as Chief of Staff?
The answer is no. I'm here to do something and stand up for our city. And as Corporation Counsel, I would be representing the entire city, and my portfolio would be particularly broad. But in terms of reviewing the legality of proposed actions and actions. But as Chief of Staff in that administration, actually the role was more limited. I was responsible for the immediate offices of City Hall. I was not responsible for any government agencies or the administration of any programs in government as Chief of Staff. I was not. And in certain administrations, the Chief of Staff's role has been limited like that. In other administrations, it's been broader. But my role was very limited, and I don't know that
Mastro?
what you are saying is true.
Mr. Mastro, did you have daily meetings with the mayor at in your role as Chief of Staff and/or Deputy Mayor for Operations?
There were daily morning meetings with senior staff, and I was considered senior staff.
Okay.
But I didn't meet daily one-on-one with the mayor. No, not as Chief of Staff or even as Deputy Mayor for Operations.
Going back to the question, what metrics were set? So you were a part of those meetings. I imagine you had the opportunity to opine on things that were being discussed. At that time, what metrics were set for this program?
Again, I appreciate the question, but I don't have a recollection 30 years later of whether I knew or participated in such a discussion. I wasn't the one who would have reformed or administered the program and set the metrics. So I can only answer you with my best recollection today. It was not in my portfolio, and I don't have a recollection of discussions about the program.
Mr. Mastro, around the time Mayor Giuliani made you Deputy Mayor of Operations in 1996, the New York Times reported you referring to Giuliani as a role model and an inspiration in your life and stating, quote unquote, "I'm very much looking forward to this challenge and very much looking forward to supporting the important mission and agenda that he has set for all of us," quote unquote. And also that you said, quote unquote, "So let's go forward and keep doing the good things we're doing." As Deputy Mayor for Operations, were you responsible for the contracts for the City of New York and approving any type of approval aspects of them?
There was a mayor's office of contracts and the commissioners of agencies responsible for administering the contracts, the ones who made recommendations to that office. There was at a very high level, a review function, but
A review function by you?
by the Mayor's Office of Contracts, which did report to my office, but there was
So reported to you?
rare. It was very rare that I got involved in an individual contract decision. And if I can just say, if you will please permit me, I wanted to explain what I meant by that quote, and I appreciate the opportunity to do that, because one has to put in context. The Rudy Giuliani of today is not the Rudy Giuliani of the mid-1990s. When Rudy Giuliani came into
I don't want to center this around Rudy Giuliani in that light. I want to be able to get through the rest of the questions because I know a lot of my colleagues still
but
have some
I
remaining
just wanted
questions.
to explain why.
We don't need to explain. I know who Rudy Giuliani is.
But
I don't need anyone to explain to me who he is.
This isn't about Rudy Giuliani.
With all due
This is about
respect, I'm
Randy
reclaiming
Mastro.
my time.
Yes, please, go ahead.
Thank you. Can you explain why you apparently were so looking forward to continuing to support Giuliani's despicable actions in dismantling the contracting equity efforts of the first black mayor of the city of New York, some of which was described, as I said before, as a quote-unquote economic lynching?
Okay. This is, I was proud to continue the historic reductions in crime. I was proud to continue the extraordinary job growth that occurred in the Giuliani administration. I was proud to continue the war on organized crime in which I put my life on the line. Those are the things that I was referring to. And I think I should point out that I have the support of many people from the Dinkins administration who say that I was the administration's conscience, who say that I was the person they could talk to and who would try to get things done. And I was a bridge. So I think that, you have to put all of this in perspective. I'm here as Randy Mastro, not as Rudy Giuliani, not as the mayor I served, or as the mayor I will serve, because I'm going to be serving the whole city. I'm here to present my credentials, and that's what I meant by I was proud that we had had such historic reductions in crime, such historic job growth, and that we took on organized crime
And
to the
also
point where I put my life on
as
the
well
line.
as historic dismantling of a program meant to lift up black and brown businesses.
I don't know that to be the case. That certainly wouldn't have been
But
my
it
personal
is the
intent.
case
But it wasn't a
statistically.
program that I administered.
But you
and-
were a part of the administration and you stayed for 3 additional years despite this.
Councilwoman, I'm just explaining to you what I meant by the quote and what my portfolio was. So,
Understood.
thank you.
Mr. Mastro, in light of what I have mentioned, how could the council possibly believe that you are truly committed to utilizing the office of the Corporation Counsel to further social justice as you have indicated?
Because I have a 40-year track record of bringing cases pro bono and otherwise, because I have a track record, including in city government, of protecting human rights, because I put my life on the line for this city, and I'm prepared, I would do it again. And I spent 2.5 years of my life under police protection so that the mob wouldn't kill me because of what I did for this city. So how do you know I have the courage and the character to do this job? You know it because I put my life on the line for this city, and I will do it again. Thank you.
I'm going to just move over now to affirmative action rollback as it pertains to employment and the Parks Department litigation, which I'm sure you're familiar with. So it's
I
been
am not,
reported-
actually. I didn't oversee the Parks Department either, so
We'll-
I'm
we'll
not
get-
familiar
we'll-
with it.
We'll get to that.
Okay.
It has been reported that during his first month in office in January 1994, Mayor Giuliani discarded the affirmative action plan in relation to city employment that had been city policy under Mayor Dinkins. Along with Giuliani's actions in dismantling the program for minority and women-owned businesses, among other things, in the very beginning of his term, such actions to dismantle the affirmative action initiative sent a message to his commissioners and administrators, according to award-winning journalist Jack Newfield, that, quote-unquote, no one would be looking over their shoulder on the issue of minority hiring, and that, quote-unquote, they could do whatever they wanted in that regard. Furthermore, it was reported in March 1996 that since the time Rudy Giuliani became mayor in January 1994, 4,632 fewer blacks worked in agencies under mayoral control. In contrast, white male employment has edged up by 387. The mayor has appointed 600 additional white officials and administrators. At the same time, the number of senior black officials had decreased by 258. In the mayor's office, 20 employees earn more than $100,000. One is African American. Fast forward to 2001, the U.S. Equal Employment Opportunity Commissions found in response to complaints filed by 20 black or Hispanic workers in the New York City Parks Department that there was quote-unquote reasonable cause to believe that the Parks Department under the Giuliani administration had engaged in unlawful discrimination on the basis of racial and national origin in assigning and promoting employees. Thereafter, the U.S. Department of Justice, represented by then Assistant U.S. Attorney Lisa Zornberg, who now is the mayor's lawyer, filed its own complaint in 2002 against the Parks Department, having determined that the EEOC complaint had merit. The Department of Justice complaint stated, among other things, that the Parks Department engages in a pattern of practice of discrimination against its black and Hispanic employees on the basis of their race and/or national origin in making promotion decisions. In making this assertion, the United States Department of Justice complaint included references to various incidents that were specifically alleged to have occurred between 1995 and 1998, during the time in which you were the chief of staff and at another point the deputy mayor for operations, in which all commissioners reported up to that role. The city eventually settled the federal case with the U.S. Department of Justice with certain changes to employment-related practices and with the Parks Department workers for more than $21 million. Mr. Mastro, as the supposed conscience of the administration and in light of the extensive history of egregious issues with creating a safe work environment for minority employees, how could the council possibly rely on you to lead the city entity with hundreds of employees from diverse backgrounds?
Well, I have to say, it's not accurate to say that the Parks Department reported to me. It did not. It reported to a different deputy mayor. So I was not personally involved in the day-to-day operations of the Parks Department, and I'm not familiar with that lawsuit which occurred.
You refer to yourself as the conscious, though.
I
the
did.
Administration.
I didn't actually. Deborah Wright, one of the most distinguished people who's ever served in city government. She served in the Dinkins administration. She served in the Giuliani administration, and then for decades, she headed Carver Bank in Harlem. She's the person who called me the conscience of the Giuliani administration. I was not responsible for the Parks Department, and I had a diverse staff. My staff was diverse. My chief of staff was a woman.
Mr. Mastro,
so please,
I just want to get to the next question.
Facts are facts, and the fact
Thank
of the
you,
matter
Mr.
is,
Mastro.
I have a long history
Mr.
of
Mastro,
emphasizing
I'm
diversity.
reclaiming my time. We're going to go to the next question.
Okay,
In light
but
of
I was going to emphasize my history of diversity.
In light of this extensive history of an administration for which you were so deeply involved, which seemed to be comfortable with allowing systemic racism to fester in city government employment, how can the council consider you to be credible when you say that you want to use this office of Corporation Counsel to further civil rights and employee rights?
It is neither a fair characterization, nor does that reflect my values and my own actions and my own history, because we seem to be stuck in the 1990s, and looking at my entire record, including that time in the 1990s, my entire record is one of someone who's been committed to inclusion and diversity, and someone who's been committed to standing up for civil rights, constitutional rights, racial justice, and social justice. So, you asked me, this council can have confidence in how I will conduct myself as Corporation Counsel based on my entire history and record as Randy Mastro, and as someone who has brought case after case, has served in community service at Citizens Union, legal aid, and otherwise fighting for civil rights, constitutional rights, racial justice, and social justice. Thank you.
Again, Mr. Mastro, the concern that I feel that I have and a number of my colleagues share is wanting to know that we would be having a corporation counsel that has the sensitivity to ensure that they stand up against racial discrimination, and also creating opportunities for qualified people in the workforce to be able to have upward mobility as well. The Giuliani administration was not necessarily known for that. I shared the numbers, and numbers don't lie. And, you know, in terms of the questions asked, I haven't gotten a clear idea of the metrics that was set during that administration, how you, while you said you were not the conscious, but someone else deemed you the conscious. You know, it's interesting that you don't feel that you were either, but wanting to know, like, what did you do? How did you stand up to that? The Corporation Counsel must not only seek justice on behalf of the City of New York, but also must operate an agency with hundreds of employees. And my concern with the nomination currently is that nothing in your background indicates that you will run an equitable and diverse agency, or that you understand what it means to do so this year, because I have not been clear through your responses of, in those moments, how you stood up in those moments as Chief of Staff or as the Deputy Mayor for Operations.
Mr. Mastro, I'll give you, we're going to go to the next one, but I'll give you an opportunity to respond to that.
Thank you. Why don't you ask the people who were serving in government or community leaders? Why don't you ask people like David Patterson? He'll testify here later. Billy Thompson, Reverend Sharpton. Why don't you ask people whether I was the person in City Hall who had an open door? And I don't describe myself as the conscience of the Giuliani administration. That was described by one of my Democrat black colleagues who I love like a sister. And I wear that as a badge of honor. And I have a record of standing up on these issues. Ask Janet Morgan when she's up here how I won her job back when she was a victim of racial discrimination. Ask Rashida Buchanan, one of the peaceful racial justice protesters who was assaulted at Lafayette Square Park. And why don't you ask my colleagues at Gibson Dunn, where I took a New York litigation group that had partnership that had no diverse partners at all when I went back, and over 30% women and other diverse partners by the time I left. I have that track record, Counsel.
But what
I have that track record.
And thank you for that, Mr. Mastro. But what I'm asking you is, in your role of Chief of Staff or Deputy Mayor for Operations, what did you do to address these matters at that time?
I did a tremendous amount. And there are many issues on which I and others in the administration spoke candidly and confidentially to the mayor. That's why I am a trusted advisor. But it's also the case, because you don't cite this, but if you looked at the press clips at the time, we had greater Hispanic representation at assistant commissioner and above levels in our administration than any administration in history up to that point in time. So there's a complete record to be looked at, and I just urge the council to consider my entire record over the course of my entire career, which is one of standing up for civil rights, constitutional rights, racial justice, and social justice. It's not 4 years, it's 40 years, council member. So I appreciate the questions. I appreciate why you're asking. I'm my own man. And I've stood up for those issues for 40 years.
Mr. Mastro, can I, before we move on, just ask a clarifying question?
Sure.
Can you describe, just understanding your role, as we're just questions are coming up, but what was in your portfolio as the Deputy Mayor of Operations and Chief of Staff? Can you give us a description of what was in your portfolio when you're the Deputy Mayor, what agencies, what responsibilities, and similarly for Chief of Staff?
Well, Chief of Staff, there were no operating agencies that reported to me. I was responsible for the offices of the Mayor's office. So it was a very limited portfolio.
Can you speak up a little bit?
I'm sorry.
Or move the mic. Yeah,
I'm not usually so soft-spoken. as Deputy Mayor for Operations, most of the city's operational agencies, but not all of them. The economic development and planning agencies and some related agencies reported to a particular deputy mayor. The social service agencies reported to another deputy mayor. And then there was a portfolio of other agencies under community development that included parks, cultural affairs, others that reported to another deputy mayor.
So just
And
to
the
clarify,
police department
your agencies as
would have
deputy
been the classic operational agencies like sanitation, DEP, and other core operational agencies of brick and mortar type agencies of city government. Do It, the other ones, I don't think it's called Do It anymore, but it was technology. Core operational agencies, other than the police and the fire department, which reported directly to the mayor.
Okay. And appointments too?
No.
Okay. We'll go now to Councilmember Hudson.
Thank you so much, Chair, and good afternoon, Mr. Mastro. It's good to see you again. Before I get into my formal remarks and some questions, I do want to just state for the public record, a lot of the references that you continue to refer to as being present, I know they'll testify later. I do think it's important that the public knows that several of those former council members you refer to on speaking on your behalf are current lobbyists with business before the city and business before the mayor. So I just wanted to make that point. Thank you for your participation in today's proceedings. I'd like to speak with you about your record on policing and police accountability. Among other work, the Law Department, and in particular its Special Federal Litigation Division, is responsible for defending NYPD officers against civil rights claims, including allegations of excessive use of force, unlawful arrest, and illegal search and seizure. The Corporation Counsel plays a vital role in assessing the cases where the city needs to admit its officers were at fault and must be held accountable, and conversely, the cases where the city and its officers acted justly and need to be defended with the full might of the department's resources. This calculation is not purely a legal one. There are times when the city could make a legal argument, but when taking fairness and equity into account, it should not, because it is not what justice requires. In making these calls, the Corporation Counsel needs to prioritize what is morally right for our city and our citizens over what is politically expedient. Making the right call requires an attorney with the highest ethical standards, someone who knows right from wrong and has a track record of making the morally right choice, even if it is a politically damaging one. Making the right call requires an attorney who understands that police violence is often the product of structural racism and causes generational trauma. Making the right call requires an attorney who understands that when given an opportunity to play a role in ending structural racism in our police force, they will do so. Making the right call requires an attorney who has demonstrated in his or her career that they have no tolerance for racial injustice or policing without accountability, and that they have stood boldly against those societal ills. You, Mr. Mastro, have a long record on these issues that the council and public can judge you on. Let's start in 1992. That year, Rudy Giuliani was in the midst of his first campaign for mayor. In the lead up to the 1993 election on September 16, 1992, Mr. Giuliani attended a protest at City Hall organized by the Police Benevolent Association. The PBA was protesting Mayor Dinkins' push for the Civilian Complaint Review Board to be comprised of all civilians, as well as the Mullen Commission that was investigating allegations of widespread corruption in the NYPD at that time. The protest turned into a riot when 10,000 mostly white off-duty police officers stormed, surrounded, and occupied City Hall. The rioters then marched to the Brooklyn Bridge, where they blocked traffic, jumped on cars, and frightened motorists. Reporters and bystanders were violently assaulted by the rioters, many who were carrying guns and drinking alcohol. It was one of the largest riots in our city's history. The riot was also filled with overt racism. Newsday described some of the racist conduct, noting that, quote, the cops held up several of the most crude drawings of Dinkins, black, performing perverted sex acts, end quote. Another officer shouted that, quote, now you got an N-word right inside City Hall. How do you like that? An N-word mayor, end quote. There were chants of, quote, the mayor's on crack, end quote, and signs calling the city's first black mayor a, quote, washroom attendant, end quote. In the middle of this chaos, Mr. Giuliani stood on a flatbed truck with a bullhorn and led chants. Mr. Giuliani attacked the Anti-Corruption Commission, which he said was solely created, quote, to protect David Dinkins' political ass, end quote. The NYPD had to send officers to stop the riot. And arriving at the scene at some point was then police officer Eric Adams as a non-participant in the riot. Adams told reporters that the riot was, quote, right out of the 1950s, a drunk, racist lynch mob storming City Hall and coming in here to get themselves an N-word, end quote. Mr. Giuliani's pivotal role in this racist riot was widely reported at the time, and I'll include in the record for this hearing those articles. Mr. Mastro, you served as Mr. Giuliani's counsel for that campaign. What role did you play in his participation in that riot, and did you condemn these remarks and racist rhetoric then, and do you now?
None. I wasn't involved in his campaign until 1993, and that does not reflect my values or anything I ever would have done or said.
Mr. Giuliani's own mayoral campaign knew his participation in the riot was a major liability and feared it would feed into the narrative that Mr. Giuliani was a racist, which I would certainly say now, given his more recent track record, has proven to be true. According to the Cato Institute, an internal vulnerability report titled the Rudolph Giuliani Vulnerability Study, prepared for the 1993 campaign, devoted more than 50 pages to the 1992 police riot under the all-caps heading, racist. The report recommended, and I quote, when dealing with direct questions about the police rally, Giuliani should acknowledge and criticize the underlying racial nature of the protest, end quote. However, Mr. Giuliani and the campaign never publicly denounced it, and he went on to unseat the city's first black mayor. Do you agree with this characterization of the riot as racist?
The way you have described it, I was not personally involved in that campaign in any way at that time, so I don't recall the specifics of it, but it certainly doesn't reflect my values or how I would have conducted myself.
How would you describe that riot, if not as racist?
I think that particular, as I recall historically, from over 30 years ago, I understand why it was so offensive. So I'm not here to condone or explain that action. I got involved in the campaign at a later point in time, and I think a lot of people in connection with that campaign regretted that rally happened.
Well, I would say that the gentleman who has nominated you for this position called it racist himself, as his firsthand experience was that it was so.
I understand.
And if the campaign admitted it to be racist in its internal vulnerability document, why didn't the campaign publicly denounce this racism?
I have no idea. I wasn't involved in the campaign at the time, as I said.
So you would have never pushed for there to be a public denouncement of the riot at any point when you joined the campaign?
It is not an issue that arose in the limited role I played as counsel for campaign finance issues.
Given Mr. Giuliani's role in one of the most public and overt displays of racism in the NYPD's history, was it the morally right choice for you to serve as his counsel and later in his administration?
I answered the call to public service because the city faced such enormous issues, such enormous crises at the time. Over 2,000 murders a year, hundreds of thousands of private sector jobs lost, a declining quality of life in every neighborhood of the city.
It's one thing to answer the call to public service in a government position. It's another thing to work for somebody's political campaign. So I will ask again, given Mr. Giuliani's role in one of the most public and overt displays of racism in the NYPD's history, was it the morally right choice for you to serve as his counsel and then later in his administration?
And I will answer again. I answered the call to public service. I served as a pro bono lawyer on campaign finance law issues only. And the positions that Rudy Giuliani took during that campaign in 1993, pro-choice, pro-gay rights, pro-immigrants' rights, pro-gun control, and a safer city with economic opportunity, those are things that I agreed with. And the city faced enormous problems. In 1993, given the 2,000 a year murder rate, job losses, declining quality of life, Time magazine calling us the rotting apple.
Okay,
I answered
thank
the
you.
call to public service to do good, to do something, and I did do something.
So
I
I'm
put
gonna
my
take-
life on the line for this
I'm
city.
reclaiming my time, thank you, and I'm going to take your answer as a yes. It was the morally right choice for you to serve as his counsel and
It
later in
wasn't-
his administration.
It wasn't a moral choice about that one event.
Well, that's
It
my
was
question, sir.
it
My
was-
question
I
is,
Counsel-
was it the morally right choice for you to serve as his counsel and later in his administration?
Councilwoman, I've already said that
You're evading
not-
my question. That's what you've said.
I'm not-
So I'm asking for a direct answer, and if you can't give it to me and you're not giving me a no, I'm going to take it as a yes.
Councilwoman, obviously, I agreed to serve, and I think my record in public service speaks of sacrifice and
If you're not going to give me a direct answer, I'm going to move on, okay? Let's fast forward a few years. Mr. Giuliani is elected mayor in November 1993. You become his chief of staff and later his deputy mayor of operations. You've said publicly that you are proud of the work you did for Mayor Giuliani and that one of the reasons you should become corporation counsel is specifically because of that work. As chief of staff and then deputy mayor for operations, you were responsible for all of the city's operating agencies, which may have included the NYPD, although you just stated that they reported directly to the mayor. You helped Mayor Giuliani make crucial decisions related to the operations of the NYPD and its officers. You met with the mayor and other top staff in the mornings to plan strategy and make decisions. No major decision involving the operations of the NYPD were made without your input. As we've already discussed at this hearing, you were so essential to Mayor Giuliani's work that some called you the, quote, conscience, end quote, for his administration. And you can't refer to somebody else's description of you as that without claiming it yourself. While you are proud of the Giuliani era, many New Yorkers, especially people of color, do not have the same fond memories of the NYPD under Giuliani. The executive director of the ACLU of New York summed up the views of many New Yorkers in a 2001 op-ed when she wrote the following, quote, "As mayor, Giuliani oversaw a policing regime repeatedly engaged in persecution and brutal assaults and killings of Black and Hispanic New Yorkers, using unlawful stop-and-frisk policies to jail Black and Hispanic New Yorkers in service of his broken windows policing. Every time the NYPD killed a Black man, Rudy Giuliani was right there, not only defending the police, but attacking the victim," end quote. This rise in hyper-aggressive policing led to a number of high-profile instances of police brutality against people of color and unjust police killings of civilians during the Giuliani administration. In 1994, Anthony Baez was choked to death by a police officer after the football he was playing with unintentionally hit an NYPD vehicle. That same year, 13-year-old Nicholas Hayward was shot and killed by an NYPD officer in his public housing development in Brooklyn. In 1995, NYPD officers fatally shot cousins Anthony Rosario and Hilton Vega in a hail of 28 bullets in the Bronx, with most shots fired into their backs. That same year, 16-year-old honors student Young Jin Huang was shot in the head and killed by a police officer in Sheepshead Bay, Brooklyn. My question for you is, how can someone who is proud to this day of the Giuliani administration's record and who played a pivotal role in its policing policies and practices truly understand the toll of police violence or engender confidence about police accountability, and further, admit to wrongdoing by the NYPD in similar cases of police brutality in the future?
I said that I was proud of my record in the Giuliani administration. I was not responsible for overseeing the police department. It reported directly to the mayor, but one has to look at the entire record. There also were historic reductions in crime during that period of time. I don't condone.
Those historic
I
records
don't
of crime
condone
going
Counsel-
down started in the
Counsel.
Dinkins administration, I will note for the record. But go ahead.
You are correct that in the last year of the Dinkins administration, which averaged over 2,000 murders a year, there was some crime reduction. and there was Safe Streets, Safe Cities, where Peter Vallone, working with Mayor Dinkins, got more cops approved for the NYPD. And I give credit to both of them for that. The over 50% reduction in major crime and the 70% reduction in
My
murder
question
rates.
wasn't about the reduction in crime, Mr. Mastro.
Please.
Should I repeat it?
No, please let me finish. I don't condone any of that police violence. In fact, as Corporation Counsel, I would want Corporation Counsel's office to play an even more proactive role, not just having risk management to review instances of police misconduct or allegations of brutality, but to do a deep dive at the outset, to try to have a dedicated team to do a deep dive at the outset to determine the merits of those cases and look at systemic reform and what needed to be done with those individual police or otherwise. So I think Corp Counsel's office can play a very constructive role in doing more than just risk management and what it's costing the city, and actually trying to get to the root causes and who's causing it, and to try to do something working with the police department and the rest of the administration in addressing those causes. So no, I don't condone those things. I never did condone those things. And the person you quoted from the Civil Liberties Union will tell you, if you speak to him, that I'm an excellent lawyer and he has a great deal of
I'm
respect
not questioning
for me.
your ability as a lawyer,
me.
nor did I say you condoned those actions.
Okay, as a
What
civil
I
liberties
asked
lawyer-
was, how would you engender confidence about police accountability and admit to wrongdoing by the NYPD in similar cases of police brutality in the future? Surely you can understand that New Yorkers who were here under the Giuliani times and remember those times specifically, and who were impacted directly by a lot of those policies and decisions and these particular events that I've outlined, might have some skepticism. So I'm asking, how do you provide confidence in your ability to those New Yorkers?
Sure. So I was attempting to answer your question, Councilwoman. I do have, the confidence and respect of civil liberties leaders like Norman Siegel, who I've done.
I'm asking about regular New Yorkers, not the people who are here to give
Let me please finish.
words on your behalf.
How can you have confidence in my abilities in this respect? I've already told you that I would do something transformative at Corp Counsel's office, which is to have a dedicated team to review those cases, do a deep dive, try to get to the root causes, not just evaluate them from a risk management standpoint. And you can have confidence because I've actually brought cases about police brutality, including in June 2020, when federal authorities, police and local police, assaulted peaceful racial justice protesters at Lafayette Square in the wake of George Floyd's murder.
Okay, I'm glad you
litigated those cases.
I'm glad you brought that up, because I do have a question about that and other pro bono work you've done. How do you reconcile that pro bono work that you've done in furtherance of racial justice against being the conscience of a mayoral administration that used racist and bigoted tactics to malign Black New Yorkers and New Yorkers of color? On the one hand, you're referring to your successes and your record of 30 years. On the other hand, you're telling us that you don't remember certain things from 30 years ago. And on the one hand, you're referring to pro bono cases that you litigated on behalf of racial justice, social justice. But on the other hand, you worked in administration that directly had a negative impact on Black and brown New Yorkers. So I'm asking you, how do you reconcile the two things? I don't need a whole long thing about it. I just want to know, how do you reconcile those two things? Because they're conflicting.
Please let me answer the
I would love it if you would actually answer my specific question.
I am council member, and the fact of the matter is that it's not reconciling something to recognize that I have these values within my administration. When I served in that administration, I was recognized as someone who advocated for similar values. That's why another member of that administration—
And you've also
Debbie
worked
Wright,
against those values.
Please. That's why another member of that administration, Debbie Wright, Democrat, blacks served in the Dinkins administration.
I don't need you to pull out every black person that can speak on your character, okay?
Please.
I'm asking you to answer a very specific question. There will be people here who will have their opportunity to give their account of their experiences with you, black, white, and otherwise. So I don't need you to give me a listing of every black person who supports you, every gay person who supports you, every woman who supports you. What I'm asking you is, when you have a whole list of cases that you've worked on to further social justice, and then you've worked in an administration that has discounted that work, how do you, Mr. Mastro, reconcile the two things?
In city government, I am trying to answer your question.
You're trying to talk around my question?
I'm not.
You're not answering my question.
Please let me answer your question.
Mr. Mastro, just give him an opportunity to answer the question.
I was also working for social justice in the Giuliani administration. That's why I spearheaded the passage of the most sweeping domestic partnership legislation for same-sex couples at the time. I did many things to advance social justice in the Giuliani administration, and that's why I was described the way I was by Debbie Wright. And the fact of the matter is that you have a 40-year career to know that I embody those values. And we are focusing only on a 4-year period of a 40-year career, and even then you have hard evidence of how I exemplified within the confines of being in a support position those values.
I think my colleagues and I have referenced the entirety of your 40-year career, not just 4 years, to be fair. In fiscal year 2023, New York City paid out $266.7 million in claims against the NYPD, an increase of 12% over fiscal year 2022, according to the New York City Comptroller. Do you believe that the Corporation Counsel or the city's law department, which settles these claims, has a role to play in attempting to reduce the amount of taxpayer dollars spent per annum on these types of cases?
Well, of course, I already alluded to this. If I am fortunate enough to assume this position, I will expand the team and the resources devoted to reviewing these cases, not just from a risk management standpoint on dollars paid out, but to, at inception, review those cases, those allegations, to try to get to the merits, try to get to the systemic causes, to prevent those kinds of things from continuing to occur. So I see Court Counsel playing a more proactive role in addressing police misconduct or police excessive force, and dealing with the police department and the rest of the administration to address those matters, not just looking at it as defending the incoming and determining the risk management and settling the cases, trying to get to the root causes, get ahead of it. So I actually intend to be a more proactive Corp Counsel in that regard than any Corp Counsel has ever been.
Thank you.
Thank you.
There were many instances of police brutality during the Giuliani administration, but I want to talk to you in detail about one particular incident under your watch as Deputy Mayor for Operations. In the summer of 1997, police officers in Brooklyn detained Haitian immigrant Abner Louima. An investigation of that arrest revealed that officers beat Mr. Louima with nightsticks in the squad car on the way to the precinct, and then when they arrived at the precinct, they continued to brutally beat him, knocked out his teeth, and sodomized him with a broom handle in the station house. This horrendous event took place in the midst of the Giuliani re-election campaign, and in response to the public outcry, Mayor Giuliani announced a new task force on police and community relations. The task force was filled with prominent civic and community leaders, experts, and elected officials, including a former police commissioner, the president of the New York Civil Liberties Union, and the executive directors of the Asian American Legal Defense Fund, Anti-Defamation League, and New York Urban League, to name a few. After almost 7 months of work, the task force generated 91 specific recommendations to the mayor and the NYPD to improve police community relations. By the time the task force released its recommendations, Mayor Giuliani had already been reelected, and he dismissed the task force and its work. Mayor Giuliani's dismissal of a prominent task force that he himself commissioned was so shocking that he called on you to do damage control in the press. Instead of standing up to champion deeply needed reforms, you instead told reporters that, quote, the mayor was underwhelmed by the task force report, and rightly so, end quote. Chair Powers, I now enter into the record the 1998 New York Times article that includes Mr. Mastro's views on the task force in question. You also complained that the task force did not follow its mandate. This complaint was astounding coming from you because the task force was completely staffed by the mayor's office, and as the deputy mayor for operations, you would have been the one to steer them in the right direction and produce recommendations that would have improved police-community relations. In the end, it was clear that Mr. Giuliani's task force was a political ploy to win votes instead of a good faith effort to try to reform the police following the brutalization of Abner Louima. This ploy left in place systemic policies and practices and a culture that would continue to allow New Yorkers to be harmed and unjustly killed by the police. Mr. Mastro, as the so-called conscience of the Giuliani administration, how do you reconcile that you squandered this opportunity to improve the NYPD, advance justice, and keep New Yorkers safe?
First of all, that horrific incident led to the creation of a special commission at the urging of a number of us in the administration, including myself. The mayor was not impressed with some of the ultimate recommendations, some of which included things like changing the name of a particular entity or taking away the right of police officers earned through collective bargaining and legislation to live outside of the city, which was, in the mayor's view, unrealistic. It was not uncommon for me as the deputy mayor to express the mayor's view publicly. I personally wanted to see such a commission and always supported doing more in terms of reform in the police department. I left the administration shortly thereafter, what you're quoting, but I can only say that I wish we had done better as an administration to address community concerns, to have better understanding with communities, to have had better police-community relations. And some of the recommendations of that task force were, in fact, ones that the police department internally continued to follow. But I will just say this, of all the things that I look back on, I wish we had developed better relationships with communities of color. And it's certainly something that in my own experience, I always had an open door and tried to encourage dialogue. I think that people from that period would tell you that. But you asked me the question, I give you the answer.
Thank you. After this, other New Yorkers would unjustly be killed by NYPD officers during the Giuliani administration. In 1999, an unarmed Amadou Diallo was shot and killed by officers in the infamous street crimes unit who discharged 41 shots. In 2000, undercover police officers shot and killed Patrick Dorismond, a father of 2 children. And to smear Mr. Dorismond in the middle of his U.S. Senate campaign, Mr. Giuliani released Dorismond's sealed juvenile delinquency records. I've named just a few individuals here, but there were countless instances of police violence that experts have concluded were the outgrowth of hyper-aggressive policing that Mr. Giuliani had instituted. While Mr. Giuliani has justified this brutality by saying it was a necessary cost to ensure public safety, we all now know better. Crime dropped nationwide during this period and had already been dropping in the city during the Dinkins administration, as I noted earlier. Despite all of this, you continued to remain in Mr. Giuliani's orbit even after you left his administration in 1998. You supported his 2008 campaign for president, and for decades you used your considerable legal talents to defend and champion, arguably, the one New Yorker who in modern times has had the worst record on police accountability. Mr. Mastro, aren't New Yorkers right to fear that you will always side with the powerful over marginalized communities and remain loyal to the person who puts you in power rather than to delivering justice?
No.
Okay. Thank you for your testimony. Our city has many capable, brilliant, and talented lawyers who would be willing and able to serve as our corporation counsel. The question before us today is not just about confirming a qualified attorney or a successful litigator. It is about confirming someone who has all of the skills, including the requisite track record of a commitment to justice and to the public good, to perform the job. Someone who will inspire trust and confidence in New Yorkers that they will do what's right and just for the public. Someone who will protect and represent New Yorkers, each and every one of us. Our city deserves someone who will represent our interests without question. And as evident in my line of questioning, my concern with your nomination is that many New Yorkers who suffered through the painful Giuliani years won't be comforted by placing the so-called conscience of that dark period at the helm of the law department and prioritize the principles of justice that is required of the Corporation Counsel. Thank you, Chair.
Thank you. We'll go to Councilmember Ressler for questions.
Thanks so much, Chair Powers and Speaker Adams. And thank you, Mr. Mastro, for being here today and patiently answering our many, many questions. I do want to just begin by commending you for your laudable pro bono work over many years, but I'm going to focus my questions today more on your paid clients. Firstly, a few questions relating to rent regulation. And this isn't intended to be a pop quiz, so feel free to just say you don't know. But do you know how many affordable homes, rent-regulated homes, were lost to vacancy decontrol?
I don't know the number.
277,000 apartments. Do you know how many New Yorkers, so just to give a sense, that was a fifth of what the rent-regulated housing stock was, gone, enough to house approximately 10% of the New York City population today. Do you know how many New Yorkers are currently rent burdened, or what percent of New Yorkers are currently rent burdened?
I don't know the current percentage. I haven't been in city government for 25 years.
Fair, but you pay close attention to these issues. You know, about a third of families in New York City pay over 50% of their income in rent. And just to give a sense, do you know the proximate census in our DHS, Department of Homeless Services shelter population today? We have about 80,000 New Yorkers that are sleeping in shelter tonight. So you stated that you've always supported rent control today in this hearing, but when you became Rudy Giuliani's chief of staff in 1994, one of the very first bills that came across the mayor's desk was Local Law Number 4, which expanded the state's 3-month vacancy decontrol pilot, making it permanent in New York City. I'd like to enter into the record the legislative history of Local Law 4. This bill was championed by the landlord lobby, the Rent Stabilization Association. RSA pushed Local Law 4 as an alternative to a bill that would have simply extended the rent stabilization law, as Jack Lynn explained in a memo to the mayor on which you were copied back in 1994. Mayor Giuliani, of course, signed the bill. Local Law 4 allowed landlords to set market rate rents on previously affordable rent-stabilized apartments. And as I mentioned, as a result, we lost 277,000 rent-stabilized homes in the ensuing 25 years. This would have been enough affordable housing units to house all of the population that's in shelter tonight 9 times over. Just think about that for a second. When you left the Giuliani administration in 1998, you joined the firm of Gibson, Dunn & Crutcher, and you began representing the RSA, again, the landlord lobby. How soon after returning to Gibson Dunn did you sign the Rent Stabilization Association as a client?
22 years later.
22 years after you left the Giuliani administration, you signed RSA as a client? So you left...
The RSA was not a client of mine until around 2019, 2020.
Okay. And so when...
And the legislation you referred to was passed by the city council.
Indeed, after making it through the state legislature, and Giuliani signed it into law. After we finally got rid of vacancy decontrol, thanks to the state legislature's work in 2019, protecting tenants in perpetuity to be in the rent stabilization system, your response was not to celebrate this victory for tenants. Of course, in 2021, you sued the state on behalf of a group of real estate companies, asking that the court strike down the New York State rent stabilization law. You lost at the district court, you appealed at the Second Circuit, and lost again. On April 18th, 2024, 4 months ago, after the mayor began floating your name for Corporation Counsel, you filed a petition for cert to the United States Supreme Court, asking the court not only to strike down the rent stabilization law, but also asking the court to overturn Penn Central, the landmark case that established the NYC Landmarks Law to not be a regulatory taking. I'd now submit for the record your petition for cert.
Do you want me to respond to that?
The question I'd like to ask is, you've mentioned today that your clients in this case are small landlords. Who is the client paying for your services in this litigation, and are there any other entities besides the named client contributing to the payments for these legal services?
In that case, it is known that the Rent Stabilization Association was involved in the case. I represented small landlords, and to be clear, we did not attack the rent stabilization law. The issue was narrow, and you put the petition into the record. So let's look at the petition, which says the plaintiffs do not challenge rent control and rent stabilization. Simply the amendments, some of the amendments in 2019 that retroactively changed the law and affected their rights. Specifically, their rights to reoccupy their own, these were small landlords who had only a few units, the right to reoccupy their own property. They no longer had the right to move back into their property, number one. Number two, they had invested tenant improvements, and under the existing law in which they made those investments to improve tenants' conditions, they had a right to a certain amount of credit over a period of years, and that was taken away from them retroactively. These were small landlords who were suffering, and we brought a very limited challenge, not against rent control or rent stabilization. We did not challenge them writ large, and that is not true for you to say that.
But, Mr. Mastro, yes or no, isn't it accurate that a potential implication of the GMAX case is that this extremely conservative, far-right Supreme Court could entirely eliminate rent regulation in New York City?
No, absolutely not, and you obviously are not reading the first paragraph of our petition to the Supreme Court, which is we're only seeking very narrow relief. It will not affect rent control or rent stabilization.
But
it
the
will,
Supreme Court
if we were
could have determined a different outcome.
Councilman Ressler, if we were successful in that case, it would mean that limited amendments which retroactively changed the law for small landlords who'd already invested in their properties, all right, they would be able to get the same credit for having improved tenant conditions that they used to get before. They would be able in a townhouse to move back into a floor of the townhouse when they had that right and it was retroactively taken away. Very limited relief. And we said that repeatedly to the Supreme Court and the lower courts. This
But by
does not
bringing the
jeopardize
subject of rent regulation to this
No.
extreme far-right conservative Supreme Court,
No.
we put the affordable housing of 2.2 million New Yorkers at risk. 1 million rent-regulated affordable apartments that we depend on as the linchpin for affordability in New York City that would upend how New Yorkers, and working-class New Yorkers, would no longer be able to live here without rent regulation.
Councilman,
And I am deeply concerned that you put forward a case that could have led to this far-right extremist Supreme Court making the wrong decision. And it may have not been the focus, the narrow focus that you were articulating today, but it was the risk that the case posed, and you know better.
Councilman, I do know better because I know what I asked for. And I know that the Supreme Court, just before we filed our petition, had rejected the efforts of other litigants to get rid of rent control and rent stabilization. And the Supreme Court said, no, we reject those petitions. They are too broad. And we said to the Supreme Court, we agree that's too broad. We agree with rent control and rent stabilization. We said it in the very first paragraph.
But this was the risk that you were taking.
We just asked for limited,
this Supreme Court
relief.
has made decision after decision that has not been a narrow ruling, but that has far-reaching consequences, including eliminating a woman's right to choose, right? And so this Supreme Court has been eliminating Chevron deference. We could go on and on and on where they have chosen to not act narrowly. And you put the affordability of New York City at risk in this case. I'd like to ask a few more questions about your clients.
Well, just so the record is clear, I did not do that. And please read the first paragraph of the petition, which says the plaintiffs do not challenge rent control and rent stabilization, period. End of story. Thank you.
Is it accurate, I'll make these a couple of yes or no's, is it accurate that a potential implication of your lawsuit against Local Law 97 is that the law could be completely undone?
It could be found to be, as sweeping as it is, preempted by state law. It could.
Yes or no, is it accurate that a potential implication of your congestion pricing lawsuit prior to Kathy Hochul's something or other is that you could have halted the implementation of congestion pricing altogether?
No.
your congestion pricing litigation could not have led to a halting of that policy?
No. Would you like to know why?
Please.
Okay, thank you. The lawsuit that we brought on behalf of the governor of New Jersey and New Jersey simply seeks a proper full environmental review of one-of-a-kind, unprecedented, congestion pricing scheme in this country, and that environmental justice communities be fully considered and mitigation measures provided for them before congestion pricing goes into effect. It will not prevent congestion pricing from going into effect. That's not my lawsuit. It's a lawsuit that some others in New York have brought. The lawsuit that I brought on behalf of the governor of New Jersey and the state of New Jersey is about protecting our environmental laws, making sure that federal and authorities and the MTA abide by their legal obligations under something called NEPA, National Environmental Protection Act, to provide for full environmental reviews and for commitment of mitigation to environmental justice communities like Newark and East Orange and Bayonne and Bergen County that will obviously be adversely affected by the diversion of traffic through those New Jersey communities. Yet the plan approved by the FHWA, federal agency, and the MTA provided no mitigation money whatsoever in the original proposal. It is about protecting environmental justice communities and full environmental review, which I would think environmentalists would applaud.
It did ultimately include investments in EJ communities as part of the final solution that had been agreed to by the MTA. But I think the overarching point here is that, some of the cases that you've discussed today, including in our back and forth regarding rent regulations, Local Law 97, are about technicalities, even minor issues. And that may be true, but the implications are not minor. The implications are the end of rent regulations as we know it, or the end of the most ambitious municipal climate legislation in the country. You've argued that we shouldn't judge you based on your paying clients because everyone deserves an attorney who will represent them zealously. And I agree with that. But we're not talking about representing clients in criminal court, and you don't have to represent every client in civil proceeding, especially as an attorney of your stature. You've chosen to take on these cases that could have such detrimental impact on life as we know it in New York City. So I guess just ask the question, why should we approve the nomination of a litigator who has actively worked to strike down tenant and environmental protections and other noble public policies here in New York City when we have qualified attorneys who have not been involved in paid legal work opposed to the public interest like you?
I have explained to you in 2 of those 3 cases the very narrow scope of the relief, that it goes to simply certain amendments applied retroactively, and that it goes to protecting environmental justice communities for which there was no mitigation originally and inadequate mitigation now. These are actually principles that everyone should care about. And on the 3rd case, it involves a preemption question because of the way Local Law 97 was drafted and crafted. And I have explained that I'm proud of the work I've done to hold government accountable at all levels, local, state, and federal, to do the right thing. And ultimately, these principles, protecting the environment, for having full environmental review and protection of environmental justice communities, not allowing laws to be applied retroactively when people have depended upon those laws and can ill afford otherwise. And in a circumstance like Local Law 97, where I said flat out on behalf of our clients, we support climate change legislation. We support improving the standards. But you have someone offering themselves as corporation counsel who understands when the government doesn't get it right, when legislation needs to be improved, and who will help you craft legislation so that a preemption argument can't be made, help you achieve those objectives, help you develop the administrative record in the legislative body to make sure that your legislation is unassailable when it gets to the courts. That's actually something that I'm uniquely well qualified to help this council do because of those experiences. These are not things that are anti-government. These are things that are pro-government and holding government accountable to get it right and now helping government to ensure that when it has laudable goals, that its goals will become law that is unassailable. I can help you do that.
Mr. Mastro,
Councilman, I will help you do that.
As recently as July, you filed paperwork relating to Local Law 97 in court that, as you testified today, could upend and overturn this legislation as we know it.
It could, but I could help you recraft that legislation so that it would be unassailable, and I wish you would let me.
To me, this isn't a laughing matter at all.
Please.
The future of our planet
I'm
is
not-
at stake. The future of
I'm
our
not
city is at
laughing.
stake.
Someone in
This
the
is
audience
the
is
most
laughing.
consequential law that we have enacted in the New York City Council in many years, and it will dramatically drive down our carbon emissions. And you have been the one working against it and fighting to overturn it. So, considering you've appeared in court multiple times since you've been mentioned as a potential nominee for this position against the law department, against the city's attorneys, do you think that you put those attorneys, the law department, in a difficult position to have to argue against their potential future boss? Furthermore, we've heard from several attorneys at the law department that are concerned about the tactics you have used against the city. They've noted that you're a win-at-all-costs attorney, or that's your mentality, and that they have found you to be highly combative. Is this the type of approach that we should expect from you should you be confirmed for this position at the helm of the law department?
I don't know that to be the case. I have many friends in the law department. I have enormous respect for them. But the fact of the matter is, when you are litigating against the government, where the legal standards are overwhelmingly in the government's favor, those are always uphill climbs. But the fact of the matter is, I have more than one speed. I recognize the difference in the roles, and I have great working relationships with lawyers in general. So no, I don't see it at all as an issue of lawyers in the law department fearing that I had a different position. We're all professionals. I've been a lawyer representing clients in private practice in litigation. I have great respect for the law department. I think most members of the law department have great respect for me. I wouldn't be pursuing this position if I didn't already appreciate and understand and value the lawyers of the law department and all the law department can do, and what more it can do for civil rights, constitutional rights, social justice, and public safety. We can do so much more. This is a unique opportunity to transform the law department and to get it right. Thank you.
Appreciate that. I'd like to just shift gears to another topic. Could you briefly explain your understanding of the process by which the law department determines whether or not to represent an employee accused of sexual harassment?
I have not been involved with the law department. I remember what the procedures were 25 plus years ago. I know there are protocols for doing that. I would want to review it when I get there. I would want to evaluate the protocols to see whether I think they're appropriate or not, and I would commit to do that, but I'm not familiar with the protocols.
Well, I'll tell you the upshot. The law department will determine if the employee was acting within the scope of his or her public employment and in the discharge of his or her duties, and was not in violation of any rule or regulation of his agency at the time of the alleged act or omission occurred. So, yes or no, is it correct that if the Corporation Counsel determines that an employee was acting outside the scope of their employment, the employee is not entitled to representation, as far as you understand?
I think as a general proposition, while each case depends upon its facts, I think that is correct.
Correct.
If the employee acted outside the scope of their employment, that would be different.
And yes or no, is it correct that the Corporation Counsel determines that an employee acting in violation of any rule or regulation at the time of the alleged incident, that employee is not entitled to representation?
Again, it depends upon the facts of each case, and we don't, in the context of potential civil representation or in the context of a criminal case, we don't prejudge the individual based on the allegations in a criminal or a civil complaint.
Of course, you don't prejudge. But if you believe
the fact of the matter is, these issues depend upon a deep dive factually. and I would want to review the law department's protocols to determine whether I thought they were appropriate, and I will reform them accordingly. But I don't believe
So let me
that
just
the
say
law
this.
department represents people who act outside the scope of their
Well, they're
employment.
certainly not supposed to. Do you believe that if reasonably verified, repeated sexual harassment is in violation of a rule or regulation of the city?
Obviously, sexual harassment is not something that's condoned by the city.
If appointed, would you agree to re-examine the current representation decisions to confirm that they meet the appropriate standard?
Yes.
When you were first approached by the Adams administration to ask if you were interested when were you first approached by the Adams administration to ask if you were interested in being considered for Corp Counsel?
Earlier this year.
Can you be more specific?
It was after the first of the year, probably more like February.
February.
But that's based on recollection. It's now been so long since word leaked that I was potentially being considered.
Well, you made it.
It
You
feels
made it to
like
this
a
stage in the
lifetime,
process.
ladies
It
and
is.
gentlemen.
I know it does. Have you had any conversations with the mayor or members of his team in the past 7-8 months about decisions regarding representation and provision of outside counsel?
None.
Would you consult?
I've never had a discussion with the mayor about any particular case or any particular representation at all.
Would you consult with the mayor when making determinations of when to provide external counsel for senior government officials?
The law department makes those determinations according to a protocol. It's not a question of consulting with any one individual.
What role do you believe the Corporation Counsel has in defending the mayor and members of administration for activities that fall outside of the reasonable expectation of work on behalf of the public interest?
I think we've already talked about this. If you acted outside the scope of your authority, that's not something that I understand typically Corporation Counsel would be involved in.
Well, I have to say plainly, of course, I'm concerned about the case of Tim Pearson in particular. There have been allegations of repeated sexual misconduct and harassment by him, by many colleagues who've worked with him in city government. There was an inadequate investigation, according to statements from the City Hall press office, and yet he is still in his job. He's still overseeing staff, including women. He's been provided with a white shoe attorney, outside counsel, at no expense to him. We, as taxpayers, are paying for it. And, you know, this, of course, has been widely reported to be the major, or one of the major issues that led to the discontinuation of public service for Judge Heinz Radix. So it is of grave concern to me how the mayor interfered in this case and insisted that outside counsel be provided to his friend, that an inadequate investigation occur, and that he's continued to serve in his job without any repercussions whatsoever. And I take you at your word that you said today, if confirmed, that you will review that case and that you will not consult with the mayor in determining whether outside counsel is appropriate. Did I get that right?
You do have that right, and I want to say I appreciate what you are saying. I'm not accepting the characterizations of certain issues or people. I have to steep myself in the issues and study them, but I just say this about the judge. I have enormous respect for the judge.
You and me both.
Appeared before her when she was a judge on the case to block the Bloomberg administration from expanding the Brooklyn House of Detention. Did that on behalf of Billy Thompson and Letitia James to block that decrepit facility from being expanded. And she was the judge who issued that order, so I have great respect for her.
I do as well, and as chair of the Governmental Operations Committee, we have oversight of the law department. I work closely with Judge Heinz Radix. She never had us fill out a form either. She was a great partner for our committee and for the council as a whole.
You'll be on speed dial to me, Councilman Ressler, and
you might regret that.
door will always be open. And to you, Councilman Hudson, no matter what you say.
You don't want to offer that. Let me just tell you that.
You've stated that you were honored to work. In the questions that Councilmember Hudson raised in particular, you underscored that you were honored to work for Mayor Rudy Giuliani, administration where you served in two of the most powerful positions in the office of the mayor. You were described as the voice of the administration, a key strategist, etc. You said that Rudy Giuliani established New York City as an international model for reform and the most restrained police department in America. We've heard a lot about your accomplishments in the Giuliani administration and the work that you're proud of, but are there major policy decisions and work of the Giuliani administration that you're not proud of? Decisions you fought against that you'd like to share with us today to demonstrate your independence that you've spoken to so much today?
I think I have already testified that, of course, there are such issues, and those are issues that a trusted counselor addresses in confidence with the principal and speaks with candor and confidence. That's what a trusted counselor and lawyer does. But I will say this, and I will repeat it again, and it came up with Councilwoman Hudson, because I've said it publicly before. I wish we had done more to improve relationships with communities of color, that we had communicated better, had more understanding. Communication, understanding. So many of the issues that arose, I wish we had done more in that regard, and that I always had an open door, but I was just one person. And the fact remains that there are so many misunderstandings even to this day. I wish we had done a better job. But with sensitivity and understanding and communication.
Mr. Mastro, the problematic relationships that the Giuliani administration had with communities of color were a direct result of the Giuliani administration's policies, right? Did you support the Giuliani administration's use of hyper-aggressive broken windows policing?
Well, I think that that's a characterization.
Just yes or no?
Windows. It's not a yes or no, because in certain respects, broken windows policing, which was practiced nationally in the mid-1990s, resulted not in incarceration, but people being in the system, and that sometimes led to breaking really shocking cases, serial rapist on the Upper East Side that I can recall, and other cases where the person, as a toll jumper, didn't go to prison, but was, in the system for having been a toll jumper. You can't, one size doesn't fit all. It's a question of implementation and how one does things. I'm not saying that everything was done perfectly, but I'm also not here to say anything other than there were tremendous reductions in crime during that period of time, and I think we have to understand historical context and how much good was done. And in taking on organized crime, which was my bailiwick, we had tremendous achievements against formidable odds where I'm lucky to be alive today.
With all due respect, it is disappointing that you're not prepared to go further than saying not everything was handled perfectly, and I'm going to maintain my private counsel from over a quarter century ago. There were serious policy, seriously problematic policies that were implemented by the Giuliani administration, and I wish, with a quarter century of perspective, you could speak more eloquently and directly to what was gotten wrong. The hyper-aggressive over-policing and broken windows mentality, the discriminatory use of stop and frisk, the fact that the Giuliani administration limited the ability of people with AIDS and HIV to access city benefits, the fact that the homeless population skyrocketed during the Giuliani administration, the cancellation of the Housing Works contracts that supported programs for the homeless and people with HIV/AIDS. I recognize that you have good work that you have done in your career that you can tout and be proud of, but I'm disappointed that the deeply problematic record of many of the Giuliani administration is not something that you're prepared to speak to in any meaningful way.
I think, Councilman, with all due respect, I think I am speaking to it in a meaningful way. I don't agree with some of your characterizations, but I have acknowledged I wish there are things we could have done better. And I am, at my core, I am a lawyer and a counselor. And lawyers and counselors counsel their clients, work with clients and public officials with whom they serve with relationships of trust and confidence. The fact that I might have done things differently 25 years later, a confidence is a confidence, just as I will keep the speaker's confidence when we speak in confidence if I'm fortunate enough to have this position. And I should say that looking at the totality of my career over 4 decades, to me, the focus on trying to get me say negative things about a mayor I served during a 4-year period in those 40 years, I'm not sure why that should so dominate these proceedings. I'm here to tell you I am ready to serve, and I have a 40-year record of advancing civil rights, constitutional rights, social justice, and public safety. And there are things in the Giuliani administration I'm proud of having done myself in my own record in the Giuliani administration.
But Mr. Mastro,
So
you were not a
thank you for
bystander.
that.
You were not a bystander in the Giuliani administration. You were not
I
a
didn't
mid-level
claim
official.
to be.
Nor have you claimed to be. You were one of the most senior handful of people in that administration, among the most powerful people that there were in City Hall for the years that you worked here. And I would have hoped, coming into the hearing today, as you try to persuade this City Council that you share our values, that you would have brought a more reflective perspective and taken more accountability for what the Giuliani administration got wrong in failing and in implementing such harmful policies to the most vulnerable New Yorkers. And I have to say, Mr. Mastro, you've said previously that you see a lot of similarities between the Giuliani and Adams administrations, and unfortunately, I do too. And I couldn't think of a more damning indictment. With that, I think I will give up the.
May I please?
You go.
Please.
Chair? Okay. I have not compared the Giuliani administration to other administrations, but to be clear, I'm here to talk about my own record and my own record in that administration. And my own record in that administration is reflected in what editorial boards and contemporaries who served with me in government from across the hall and throughout city government, elected Democrats, have said about me and my values. And it was the Daily News that wrote when I left City Hall, I did the virtually impossible, and the contributions I made to city government will last a lifetime. The Post, the Times, everyone praised my personal work in City Hall, and I don't want us to lose focus by focusing on certain issues that weren't necessarily in my portfolio, although I did have a significant role. But imagine, ladies and gentlemen, imagine how difficult it was for me, for my family, to face daily death threats because I had the guts to take on organized crime. For this city, the prior administration said they wouldn't take on because it was intractable. At the Fulton Fish Market, private carding industry and otherwise. Imagine the guts it took. In the 1990s, I stood up and advocated within that administration for victims of AIDS, having lost so many close to me from that scourge. And I stood up for the rights of the LGBTQ plus community at a time when that was not a popular position. And we got historic things done. We didn't cut, we expanded the rights of same-sex couples to an unprecedented extent in this city's history. And I stood up when it was wrong that Staten Island was bearing all of our solid waste. I stood up when on 125th Street a crisis was occurring.
Mastro, we're going to keep going to
Okay.
questions.
I'm just saying, please look at the totality of my record and then all the pro bono I have done over the years. I appreciate you acknowledging that, Councilman.
I do. I really do. I think you've done noble work over the course of your career. You fought for many causes that are worthy of admiration. And I also think that when you defend somebody, you go to extremes in doing so. And I am concerned that as Corporation Counsel, you would go to extremes in defending Eric Adams rather than the city of New York. And that is something that I'm hoping to hear more from you today as we make our decision.
I'm happy to tell you more right now.
We're going to move along.
I'm sorry.
It's okay. We have a long list of council members here. We want to make sure we are moving the hearing in the right direction. We're going to go now to Councilmember Farias, followed by Council. Well, we'll start there.
Great. That's Majority Leader Farias for the record. I want to start by continuing a few questions related to your answers to our pre-hearing questions, Mr. Mastro.
Sure, thank
You were a partner at Gibson, Dunn, and Crutcher from 1989 to 1993,
Yes.
and again from 1998 to 2022. We asked you
Partner
to,
in 93. I was at Gibson Dunn from 89 to 93. Partner in 93, then a partner when I returned.
Thank you for the clarification. We asked you to provide your compensation for the last 5 years you were there. You refused. You can answer this yes or no. You are aware that as a public official, your salary will be a matter of public record.
Yes, I am, and I did disclose that financial information to DOI. I understand it was made available to the council, and to be crystal clear, while I consider that to be confidential, private information, I will acknowledge that I'm going to be making a tremendous personal sacrifice
Sure.
by coming
All
here
of our
to
salaries
do-
are public record,
to
Mr.
do
Mastro.
this job, and I not only am prepared
Okay, I'm going to
make that
reclaim my
sacrifice.
time back. We do
I'm
not need
sorry.
the filibuster. I
Right.
would like to get through the
I'm-
questions.
I'm
We have
not
several
filibustering.
council
I'm just
members
trying
that
to-
still need to ask questions.
I'm just-
You are also aware that as a public officer with substantial policy discretion, you would be required to make public annual disclosures of all income sources and financial interests for yourself and your spouse.
Of course.
Great. That means if you're a part of any deferred compensation program at Gibson, Dunn, King, and Spalding, or from your city employment at the city, you will have to disclose that if you're appointed.
I will not have any such deferred compensation from my old firm or my present firm, which I would be resigning as a partner.
Okay, thank you. The council values transparency in all of our partners. Are you prepared to disclose all of your income and assets without obfuscation or delay if you become corporation counsel?
I already have disclosed all of my assets.
Okay, yes. During your time as a partner at Gibson Dunn, you served in many leadership positions, including chair of the litigation department, member of the executive committee, and even at one time, head of the New York office. Is that correct?
Yes, ma'am.
Typically, in 2021, you pursued the position of managing partner and chair of Gibson Dunn. Is that correct?
I was on the management committee of Gibson Dunn.
So is that a no that you were running for managing partner?
Oh, I'm sorry, that I ran for managing partner?
You pursued the position of managing partner.
Well, that's not actually accurate, but to the extent you're asking, we hadn't actually commenced a process of who should become the managing partner. A majority of the executive committee, when polled, thought that I should become the managing partner.
Okay, so
But
you
I
accept-
did not ever pursue the position, and I withdrew from any consideration.
Typically, to become managing partner requires the support of your peers and colleagues. Is that correct? And is it true that you were not chosen?
No, I just explained. The old managing partner polled the executive committee. A majority of the 1,000-share partners on that committee and others responded to him that I should be the next managing partner. But given my age, I ultimately withdrew from consideration, since typically managing partners were younger, and I was at that point in my 60s.
Okay. What is the current status of the dissolution of your relationship with Gibson Dunn?
I've already answered this question. I departed Gibson Dunn. It's a confidential matter, but there are issues relating to the terms of my departure.
And are you folks in arbitration right now?
It's a confidential arbitration, and as I've already informed the council, I'm only
Okay, thank you for the reiteration.
I'm only permitted to say that it involves the terms of my departure.
The law department is the city's law firm, employing approximately 850 lawyers and hundreds of other support staff. It is one of the biggest law offices in the city. Why shouldn't we scrutinize your departure from Gibson Dunn, given that it could relate to your former colleagues' lack of support for you leading the firm? After all, in this hearing, we are considering whether you should lead the city's law office.
Well, I led Gibson Dunn for 20 years and was on its executive committee and on its management committee for most of that time, and I led its litigation group, co-chaired that group to preeminence nationally. And you're going to hear from former colleagues from Gibson Dunn and current colleagues about what kind of leader I was at Gibson Dunn, including leading the New York litigation partnership to from 0 to more than 30% women and many diverse partners.
Sure. So why leave the law firm, if that's the case?
I'm sorry?
Why leave?
Because I hit age 65 and I was no longer in firm management. I don't, I've said that publicly. I looked forward to the unique opportunity to build something new, and that's what's some of the attraction of returning to city government, to do something transformative with the law department, to bring affirmative litigation, more of it, for the benefit of the city, civil rights, constitutional rights, social justice, public safety.
It seems like current and former city law department attorneys also have had doubts about your leadership and do not support you becoming corporation counsel. We have received several statements from several longtime current and former attorneys at the law department who provided their statements anonymously for fear of retribution by you based on some of the tactics you've employed. One stated, "I have a hard time thinking of a person more ill-suited for that position than Mr. Mastro. He has argued countless cases against the city, challenging its local laws and regulations as preempted by state or federal law or as otherwise unconstitutional. The through line being his view that local government should not be able to address the problems facing the city and its denizens, perhaps ever, if they adversely affect the bottom line of one of those clients." Another stated, "During my law department career, I litigated several cases against Randy Mastro. As far as I can recall, the city won most or all of them. He was always a difficult adversary, full of bluster, puffed up with self-importance, and disdainful of line of attorneys and their often winning legal arguments. While Randy certainly represented his clients zealously, he could also be overzealous, making highly questionable factual assertions and borderline frivolous legal arguments. It would be unsettling to see someone with Randy's values and his history of litigating against the city in high-profile cases becoming corporation counsel. Why should the council place extraordinary faith in the idea that all of these people, including those who have served the city's law department for decades collectively, are wrong?"
So it's hard to respond when you quote so-called anonymous sources, but I will say this. I've listed all the cases I brought against the city, and I won many of them. But leaving that aside, in the heat of litigation, sometimes people take things personally. I take nothing personally. I don't take your questions personally. I don't take anyone's questions personally on this council. And I think that I could produce dozens of people from the law department who would say how much they enjoyed working with me, and they do it on the record. So I have to say that it doesn't surprise me that one or more people in the heat of battle came away with less of a broader perspective, but in most of my litigation work, you develop relationships and bonds that go beyond just that litigation, and we're professionals. We respect each other. I respect the law department. I respected all of them, and that's why I would like to serve, because I think it's a great department.
Thank you. I mean, I'm sure many of us can aggregate a dossier of people that can be on either sides, but I think it's important for all of us to consider as many sides as possible coming into this.
A couple of anonymous people you're quoting, but go ahead, please.
There will be lots of folks testifying today, so I'm sure the anonymity of the two that I've given as an example are irrelevant.
Please go ahead.
It has been widely reported that Judge Hines Radix left her role as corporation counsel because she believed that the law department and city resources should not be used to defend a top associate of the mayor's against sexual assault and harassment allegations. Given that you are seeking this role at the mayor's nomination to replace Judge Hines Radix, it seems fair to believe that you think this is an appropriate role for the Corporation Council. How can we, as the first women majority legislative body of this city, believe that you can run an inclusive workplace that isn't hostile to women, given the controversy of a legal decision on gender-based harassment and violence that trues your nomination to replace someone whose principled legal position seemed unappreciated?
Well, I don't know any of that background that you are referring to, but I have a proven track record of diversity, including in my own law firm where, I took a litigation partnership in New York. We had no diverse partners, no women partners, and we were over 30% women and many diverse partners by the time I left.
Okay, we will continue on with the questions then so we can get to the rest of it. Judge Hines Radix wasn't the first or the last woman commissioner, mostly women of color who have left the Adams administration, including several alleged who have been pushed out. Why do you feel comfortable joining an administration as a white man to replace a woman of color in light of this track record of independent women commissioners and leaders outside of City Hall departing?
Well, I never thought of this as being about who I am. I thought of this about being about my qualifications to serve, no matter what.
But that is
race,
directly connected to
but
your
no matter-
experience,
no
right?
no matter what race,
Your lived
gender, or
experience and how
religion.
you get to move through the world. And upon reflection of coming into this position, replacing, under the circumstances, women of color are being replaced or pushed out.
What reflects my worldview is 40 years ago representing Janet Morgan, black school teacher who'd been improperly discharged and was the victim of racial discrimination and violated academic freedom. What shows who I am are the representation of peaceful racial justice protesters after George Floyd's murder in June 2020, most of whom were black.
I mean,
what represents my values
Respectfully,
is
I've-
what I
I've
have
heard you
done
here-
for the LGBTQ community.
Do you need a minute?
No,
Okay.
Please let me.
What
please
I'm
let me
saying to
explain
you is
my
you're
values.
sitting here, you're claiming that you've worked on expanding gender roles and all of those items, but really, like, are you comfortable with entering a space in an administration that is known to push out women of color? That's the question.
Yeah, I don't.
That's the value set question that I'm asking you.
I don't agree with the characterization. It's like the prior question you asked.
Okay.
I don't know that to be the case or that to be a fair characterization.
So do you believe that Judge Hines Radix is qualified to be corporation counsel? As a black woman, 34-year termed.
I already told you I have nothing but respect for Judge Radix. And I personally appeared before her. I respect her. This isn't about, this isn't about my views of her. I had nothing but respect for her.
And what about the acting corp counsel?
I have nothing but respect for her. She happens to be the daughter of one of the first mayors I voted for, Wilson Good, when I was a student in Philadelphia.
Okay. Let's move on from
Actually,
this.
he was the next elected
In the
mayor.
1990s.
He was the next elected mayor.
Mr. Mastro,
Yes,
we're going to move on.
sorry.
In the 1990s, there was a national right-wing movement aimed at dismantling bilingual education. By 1999, the movement made its way into New York City, and Mayor Giuliani formed the Mayor's Task Force on Bilingual Education, with the stated goal of making, quote, recommendations to the mayor and the Board of Education regarding the reform of bilingual education with an emphasis on intense English instruction for students who are not fluent in English, end quote. Mayor Giuliani named you as co-chair to this task force. Could you share with us what specific experience in bilingual education qualified you to serve as co-chair for the task force?
Well, I was co-chair of that task force with Harold Levy, the school's chancellor at the time, and I was honored to serve. I think that had more to do with, my administrative skills, but I was honored to serve with Harold. I also went on the board of CUNY, where I was confirmed by the state senate. So I had done work in the education space, and I cared about that issue. And Harold and I worked extremely closely together. Unfortunately, Harold passed away, or I think he would be here talking about how constructively
Okay,
we
so
worked
while
together.
serving as
Can I-
co-chair, you were rather vocal about the failure of bilingual education. In fact, though the final recommendations fell short of it, you advocated for the complete elimination of
I did
bilingual
not.
education in New
I
York
did
City
not.
schools.
Would you like to know what I
I'm going
advocated
to
for?
finish, and then I'll give you a moment to respond.
Please, thank you.
Supporters of bilingual classes argue that students who went through the program scored higher on standardized tests than did U.S.-born speakers. Your position was quite vocally opposed by prominent Latino civil rights organizations that saw Mayor Giuliani's antagonistic stance towards bilingual education as a xenophobic dog whistle designed to score political points with a certain subset of voters who support Giuliani's sought for his U.S. Senate run. Considering the pains taken by Giuliani to suppress the Latino vote back in '93, it is difficult to fathom that he had their best interests at heart during his tenure, particularly when it came to focusing significant resources to their education. Given the lack of experience in education and education policy, it would seem that Giuliani tabbed you as a chair to this commission because he trusted you most to get the job of dismantling a set of programs meant to serve the Latino community as well as other immigrant groups. Is that right?
No, and I have to explain because you have it completely wrong. The proposal that we made as a result of that commission's work was not a condemnation of bilingual education, but too many students who were in bilingual education, because there were over 160 languages spoken in the New York City public school system at the time, too many of them were ending up in special education, too many. And what we proposed was not the elimination of bilingual education or any of the resources given to bilingual education. What we proposed was offering parental choice, an alternative. Those parents who wanted English immersion could choose that. Those parents who wanted to stay in bilingual education could choose that. You couldn't have had a more Solomonic, responsible position. Harold Levy favored it. The New York Times said what we proposed was historic and could be groundbreaking, giving parents the choice of whether their children had English immersion or whether they had bilingual education. And guess what? You want to ask me what one of my biggest disappointments was from the Giuliani administration? It was not that. In fact, it was not the position of the mayor on bilingual education. It was that he didn't carry through and implement the recommendations of that commission, because it could have been historic for every community to give parental choice. What could be more empowering than giving parental choice? Funding both programs. But unfortunately, the chancellor and the mayor couldn't agree on the funding for the alternative program, so it didn't happen. And to this day, I wish parents had had that choice. I was pro students who needed bilingual education or preferred English immersion, and parents having that choice.
So in an appendix,
it was pro those students, Councilwoman. It was
Mr.
pro
Mastro,
those students.
I'm going to move to the next question. In the appendix to the 2000 Mayor's Report on Bilingual Education, you called for the city and the then Board of Education to move to vacate the then 26-year-old federal court Aspira consent decree. Such a vacator would have eliminated students' right to a bilingual education and the city's obligation to provide it. Why did you advocate for the vacator of the consent decree, and would you have the same position today?
Okay. It was a component of what we were proposing. You had to give them choice. So you had to have the ability to give parents choice. It was not that we had a problem with bilingual education. It was that we were trying to give parental choice. So please don't misunderstand what we were doing. What we were doing was supported across the board, and the New York Times said would have been historic.
Sure. I mean, although flexibility in the program's implementation and accelerated English language acquisitions are laudable goals, as you're saying, you're going towards parental choice. Vacating the consent decree would have eliminated students' right to a bilingual education and the city's obligation to provide it. I mean, that is a key component here. You called bilingual education a failure, and that's a quote.
It was failing too many students because too many of them ended up in special education. If you look at the report, you will see the percentage of students in bilingual education who were being dumped into special ed. That was a tragedy. These kids deserved choice.
The report will be in the record, so we'll make sure folks have access to that. Why should we trust that you wouldn't imperil the right of New York City's diverse student population to a bilingual education today?
because I championed the right of kids in bilingual education and their parents to have choice. I think that would be a good thing today. I want them to succeed. I wanted them to succeed then, and too many of our children were left behind in the old system. I hope it's improved today. I haven't been in government for the past 20 plus years, but back in 2000, too many of our kids were left behind. Too many of them were ending up in special education, and I wanted to do something to improve that, and the chancellor of the school system agreed with me, and the New York Times said, hooray, it's historic what you're trying to do.
So I want to pick up on the line of questioning from Deputy Speaker Ayala started related to your support of the gay community. You've invited Nympha Segarra to testify on your behalf later today. Mayor Giuliani's first appointment when he took office was the appointment of Nympha Segarra as Deputy Mayor for Education. As head of the mayor's transition team, there's no question, at least for me, that you were involved in that appointment as well as other appointments. Let's talk about how Ms. Segarra came to Mayor Giuliani's attention. In 1990, Bronx Borough President Fernando Ferrer appointed her to the Board of Education to fulfill a promise to appoint a Latina with children to the New York City schools. Once on the board, she proved to be one of the most conservative members. She voted with the conservatives on the board to mandate that New York City's AIDS education curriculum focused on abstinence. She opposed the distribution of condoms in high schools when teenagers were becoming infected and teen pregnancy rate was skyrocketing. And she opposed the rainbow curriculum, which was a curriculum to help teach first graders to develop positive attitudes and respect towards individuals from different racial, ethnic, religious, cultural, and diverse family backgrounds, including tolerance of gay and lesbian families. She sided with conservatives to cancel school chancellors Joseph Fernandez's contract in 1993, leading to Fernando Ferrer to ask her to resign. And then she endorsed Rudy Giuliani for mayor. Do you really believe that someone who used their position to so actively promote homophobia and combat medically sound AIDS education is the kind of person who is going to persuade this council to support you?
I don't think that's a fair characterization.
I'm not asking about the characterization of Ms. Segarra. I'm asking for you, representing folks to testify on your behalf here. Do you think that background, those facts that I stated, because all of that is factual information, is sound enough to convince this council?
I don't consider that to be factual information. I don't think the personal vilification of potential witnesses is constructive. I'm about building bridges. Folks are coming forward to talk about the work that I did in the Giuliani administration, and I just would add that I appreciate that they're willing to do that.
Sure.
And I appreciate that I also, among the people you mentioned, enjoy the support of Freddie Ferrer for this position. I enjoy the support of
Okay, we've heard a lot about your endorsements already, and they're all going to be here to testify. I'm solely asking if you believe that testimony specifically, with the history of facts that I just laid out, is going to persuade this council.
I'm simply pointing out the support that I enjoy, and I hope
Okay,
that
so
it
we
will
can move on.
resonate.
We can move on, Mr. Mastro. During your career in private practice, you have from time to time represented government officials and have been paid using taxpayer dollars. The work you've done in those contexts can tell us a great deal about how you would comport yourself as the most powerful attorney for the city. Let's talk about one of these instances, your work for the then Republican governor of New Jersey, Chris Christie, on Bridgegate scandal. Bridgegate was a political scandal that rocked New Jersey and national politics in 2013. In the scandal, Governor Christie was accused of deliberately creating a massive traffic problem on the George Washington Bridge in Fort Lee, New Jersey, as a retribution against the mayor of Fort Lee, a Democrat who had not supported Christie in his re-election campaign in 2013. When the scandal started to damage Governor Christie's political aspirations for higher office, he hired you. Since the taxpayers were footing the bill, which ended up being $8 million, Governor Christie promised that your work would be independent and transparent. The investigative report that you produced was neither of those things and was criticized for two main reasons. First, your report was widely derided as a whitewash designed to protect Governor Christie rather than to get to the truth. Some dubbed your report the Randy Mastro defense brief because it was so evidently one-sided. A crystal clear indication that your work failed the most basic test of credibility and transparency was your failure to retain contemporaneous notes from the interviews that you had conducted. In other investigations, your firm has taken contemporaneous notes during interviews and preserved them, as it is standard legal practice. However, for the Bridgegate investigation, you intentionally changed your approach and overwrote those notes as you were finalizing your report. A New Jersey federal judge, Susan Wigginton, sharply criticized your failure to preserve these notes, calling it distasteful and out of line with standard legal practice. Judge Wigginton added that New Jersey residents deserve better, and while the erasure of your notes may have been a clever tactic to help hide facts from the media and other investigators, when public investigations are involved, straightforward lawyering is superior to calculated strategy. Fundamentally, your report was not a serious piece of legal work, but instead political work attempting to clear your principal from wrongdoing. Mr. Mastro, why shouldn't New Yorkers be concerned that you'll do the same in our city and use taxpayer dollars as the guise of legal process to act as a political operative for the mayor?
Okay. Because that totally mischaracterizes the investigative work and defense of the governor's office, not the governor personally. And the report that we prepared, which dealt with two issues, Bridgegate and an accusation by the mayor of Hoboken, where her allegations were so thoroughly debunked and dropped by any investigators that no one mentions that anymore based on the work that we did. And let me just say this. The results of our investigation, where we acknowledged that there had been certain wrongdoing and who was responsible for it, but every subsequent investigation reached the same basic conclusions we did. The U.S. Attorney's Office, it charged two individuals. It didn't charge the governor. It didn't charge other members of his staff. The New Jersey Attorney General's Office, it reached the same conclusions. The Bergen County Prosecutor's Office, it reached the same conclusions.
So what is your response to the notes?
Please let me finish, because you said some very serious things, okay? As to the method in which we conducted our investigation, it was not standard operating procedure. Actually, the FBI, in conducting criminal investigations, produces one document, it's called a 302, of witness interviews. That's actually standard federal practice. And in complex investigations today that the law firms do on behalf of clients, it is common to work off of a central database, produce one final document, and interview memos. There was nothing that was concealed from the public. We did over 80 interviews. We produced thousands of pages of evidence based on the work that we did. And yes, I'm familiar with what the judge had to say, who didn't come from an investigative background. She had been a civil lawyer. The fact of the matter is that the way we conducted that investigation was not only responsible, it was in fact the conclusion reached by every other investigation.
So can you respond to my question?
Yes, so people should have confidence in my ability to do things the right way. And the fact of the matter is that I was, in that instance, representing a client which was the governor's office. And we said to the U.S. Attorney's Office at the time that there had been no federal crime committed by anyone, even if certain people engaged in wrongdoing. And ultimately, the U.S. Attorney, someone I have great respect for, I think he has great respect for me, decided to indict and prosecute anyway. And at the end of the day, the Supreme Court ruled 9-0 that there was no federal crime there. So people in New York should have confidence that I will stand up and I will speak truth to power. In this case, the truth to power was to the U.S. Attorney.
Okay. Your report also was widely criticized for its blatant sexism. The central conclusion of your report was that Bridget Ann Kelly, a former Christie aide, was responsible for the traffic jams and issues. And she took these actions because she was upset over being dumped by her former boss.
That was not what was concluded, but I'll be happy to explain when you're
Your
done.
report spent unnecessary time on the details of Ms. Kelly's romantic life and speculated wildly on her emotional well-being. In your report, you called her, quote, emotional, and claimed that she cried frequently and relied on men for approval. You also wrote, quote, events in Kelly's personal life may have some bearing on her subjective motivations and state of mind, end quote. You received Near universal condemnation for this sexist line of reasoning, New Jersey government officials called your work disgusting, sexist, anti-female. The press called it slut-shaming of Bridget Kelly, and others mentioned that there were no purpose in including these private details other than to shred her reputation and send a not-so-veiled message that she'd receive more such treatment if she decided to break her silence and reveal whatever she knows about others in the administration and their roles, if any, in the lane closure episode. Do you regret including gratuitous gossip about Ms. Kelly's romantic life in your report?
Thank you for asking that, because it's a total mischaracterization of the report and what we wrote about Ms. Kelly.
And the quotes that I stated?
Please let me finish. Please let me finish.
But the quotes that I stated, are you not regretful?
Please let me finish. You're quoting 2 or 3 snippets from a several hundred-page report, and the evidence that we uncovered was directly relevant to who might have been involved in the bridge closure, the lane closure. When the decision was made, and there really was no doubt that Bridget Kelly, from her emails, was involved in making that decision, along with David Wildstein at the Port Authority, both of whom were terminated and prosecuted. Bridget Kelly had replaced, as the mayor's deputy chief of staff, someone named Bill Stepien, who went on to run his campaign. Unbeknownst to others in the governor's office, they had a personal relationship, but the allegation after the bridge closure was that Bill Stepien, running the campaign, must have been involved in the decision to close the bridge.
Okay,
but at the time,
I want to get back to what I... Right, but I need you to understand that I asked about your words that you stated in the report, and if you are regretful of including...
You cannot ask a question like that and not let me please explain.
Yes, I can. I can be as direct and pointed to what I've brought up in my questioning.
Let me just finish.
I'm going to move on if you're not going to specifically answer if you regret including gossip about Ms. Kelly.
The fact of the matter is, the fact that they ceased to have a relationship and we're no longer speaking.
I'm moving on beyond this.
Well, the fact that we're no longer speaking.
Mr. Chairman, can you instruct the witness that he's out of order, and I said I was going to reclaim my
Mr.
time and
Mastro,
move
we'll
on?
give you an opportunity to continue to explain yourself, but let's
I'm sorry.
let the
Go
count.
ahead. Go ahead, please. All right. I just wanted to make clear that it was directly relevant to Stepien's
You can also
culpability.
supplement any of your testimony within 72 hours of this. I totally understand you want to add more. We have several members that still want to ask questions. You didn't want to ask my last question. I would like to move on because I have a few more.
Okay,
Mr.
I
Mastro.
did answer it. I had a reason for why that was important.
Okay, you can supplement it in your testimony, please, Mr. Mastro. I want to go back in time and discuss your work as an attorney for the 1993 Giuliani mayoral campaign. You were the outside counsel for that campaign. The public recently learned some troubling things about what took place during that campaign as a result of a YouTube show called America's Mayor Live. America's Mayor Live is a YouTube show hosted by your former principal, Rudy Giuliani, during an episode with former Donald Trump advisor Steve Bannon and failed Arizona gubernatorial candidate Kari Lake in April of last year. He gleefully shared an anecdote about the election day operations of that campaign. These are his words. And I quote, "So they went through East Harlem, which is all Hispanic, and they gave out little cards, and the card said, if you come to vote, make sure you have your green card because INS are picking up illegals," end quote. And so they went and spread these cards all over Latino communities of the city. To make matters worse, Giuliani had to hold back giggles while recounting the story. You were an attorney for that campaign, as you've stated previously. Were you aware of this scheme?
No.
A Department of Justice press release from that election day announced that the DOJ was aware that posters had been placed throughout New York City misinforming voters about the role of federal officials in that day's elections. The DOJ would go on to investigate these illegal activities along with other voter suppression tactics, including voter intimidation and poll site disruption, all neighborhoods of color. Mr. Mastro, should attorneys for an organization do everything they can to advise their client against discriminatory acts that violate constitutional law?
Yes, and again, my role was as the lawyer before the Campaign Finance Board. I was not involved in any other aspect of the campaign.
And as an attorney to the Giuliani campaign, though the election, the electoral part of it, did you advise against any of these vile discriminatory acts?
Having not been aware of what you were saying, or aware that any of that actually happened, I obviously did not advise in any way, shape, or form about it, but had such a thing occurred, hypothetically, or I'd been told that such a thing were going to occur, I would have expressed in no uncertain terms that that was not totally unacceptable and could not possibly happen.
Did you learn of it at any time period?
No.
While you were there?
No, I'm hearing this for the first time today. I haven't spoken to the former mayor in years. So what you're telling me today is not something I ever personally experienced, was ever personally aware of, or have any knowledge of.
Thank you for answering my questions. I look forward to this supplemental information that you're going to provide with your testimony. I really just want to reiterate what some of my colleagues have said. You know, at the end of all of this, we have to make a decision based off of your responses here, the track record that we've seen, both on who you've been a pro bono attorney to, but also the other side that you have taken on. And I think while you are stating that you have a track record of this and that historically some of the larger issues that's raised to us is the time that you served in an administration that was discriminatory, that was racist, that was sexist, and you either are against all of those things, which you haven't blatantly, admittedly, like stated yes or no to some of those questions, or you were complicit in that. And I think for a lot of us, you know, corporation counsel isn't a position of redemption, it's a position of trust. I will wrap my time there.
Thank you.
Can I please?
I'll give you 30 seconds to respond, and we're going to go to Councilmember Brown and Councilmember Brewer.
Thank you. It was factually relevant to whether Bill Stepien was involved in the decision to close the bridge, that he was no longer speaking to Bridget Kelly, who clearly was. But to be clear, so that was actually relevant to the investigation, and the U.S. Attorney's Office considered it relevant to the investigation. But again, we advocated on behalf of the governor's office that no one should have been federally charged by the U.S. Attorney's Office, and that's ultimately, including Bridget Kelly, because there was no federal crime, and ultimately the Supreme Court agreed 9-0 with us.
Thank you. Thank you. We're going to go to Councilmember Brannan, and we'll be followed by Councilmember Brewer.
Thank you, Chair Powers. Mr. Mastro, it's good to see you here today. Thank you for answering our questions.
Thank you.
What is your opinion of Rudy Giuliani circa 2024?
I'm not here today to testify about Rudy Giuliani. I haven't spoken to Rudy Giuliani in years. I find it heartbreaking, and my own personal views and values are reflected in the work I've done at Citizens Union for the past decade as its chair, where I have regularly spoken out about actions of the prior administration and that individual's lawyers, and that information has been provided to the council. So I'll let my public statements speak for themselves. I don't condone it.
Similar to Congress at the federal level, do you believe that the City Council is an equal branch of city government?
Absolutely. And I think you would see a level of service and responsiveness from Corp Counsel's office unlike anything you have ever seen before if I were to become the Corporation Counsel. Fortunate enough to become.
Okay, NBC News reported back in 2007 that Giuliani's City Hall was secretive to the point of being openly hostile toward open government, the First Amendment, and the public's access to simple facts and figures. You issued a statement for that campaign that said Giuliani ran an open and transparent administration. I've submitted that report for the record, and you added, quote, "There was probably no elected official in this country who made himself as available to the press and public as Rudy Giuliani did when he was mayor of New York City," unquote. At the time you made that statement, you were aware that when Giuliani left the mayor's office, he took 2,000 boxes of written, photographic, and electronic records, including your records, Mr. Mastro, which the city then had to spend years trying to get back. So was a mayor taking public records from City Hall that should go into the city archives appropriate?
I actually, at the time that happened, I don't recall being aware that he did that. I was no longer in City Hall. I'm glad that you got the records back because I understand you reviewed dozens of boxes here in preparation for these hearings. And the reason I said what I said that you're quoting is because every day the mayor would have a press conference. Every morning he would have a press conference, make himself available to the press. And then every afternoon when I was deputy mayor, there would be a gaggle of reporters able to ask me any questions at the end of the day. So I considered myself to be transparent. I spoke to any reporters who ever had questions for me. And I know that the mayor made himself available in ways that other mayors have not. And I just wanted to say one last thing because I didn't really get a chance to respond to all the points that were made earlier. I unequivocally, I'm 100% against any sexism, racism, discrimination of any form, and there's no evidence that I would ever condone any such thing. And there's plenty of evidence in my record of fighting for civil rights, constitutional rights, racial justice, and to promoting diversity. So I just wanted to make that crystal clear because we got a little off track in the back and forth, Councilwoman, but I just want that to be crystal clear. Thank you. Sorry, Councilman.
Okay, talking to your tenacity, and if maybe there's a time when tenacity has gone too far, you didn't list this in your responses to our pre-hearing questions about legal actions against the city, but in 2014, when you were still a partner at Gibson Dunn, you personally sued the city of New York and the FDNY over a $375 fine that you received for failing to prevent 2 unwarranted fire alarms at your residence. Do you remember this?
Short answer is obvious. I remember it, and I didn't list it because the question was when I represented a client. I actually was represented by someone else in that matter, and the reason why.
Okay, but let me just finish. So this is a $375 fine that you appealed the fine before oath. Then when oath ruled against you, you used firm resources at Gibson Dunn, namely a Gibson Dunn associate, to file your briefs and argue your case in the appellate division first in Supreme Court for a $375 fine. When you lost there, you appealed to the appellate division in the first department, where a 3-judge panel ruled against you in 2017. In addition to your own firm's resources, your lawsuit required the time of 4 law department attorneys to defend the city, taking their attention away from other work. This was litigation that you brought against the city that you should have disclosed. So why didn't you disclose this information in response to questions about your legal actions against the city?
It wasn't because you asked, the question from the council was litigations where I represented a client against the city. But to be clear, in that instance,
Wouldn't that be a technicality, though, to withhold information?
I understood the question to be where I was a lawyer representing clients, so I'm not resting on a technicality. But the fact of the matter is that the reason for that litigation, and the same articles you're probably quoting from, quoted me saying this, is that the fine was imposed because I was supposed to have corrected a false fire alarm. I did correct the false fire alarm. I put in the proof that I had corrected the false fire alarm, and the fire department didn't get around to acknowledging the correction until after the date when they imposed a new fine. And it was an example of the kind of thing that drives people in our city, New Yorkers, crazy about the bureaucracy of the city. I shouldn't have been fined. So the issue was
But let's
of
zoom out. Let's zoom out for a minute. Let's zoom out for a minute.
It was not a big deal.
Do you think it makes sense, and what does it speak to when you're going to such great lengths to fight a $375 fine? Certainly, most New Yorkers do not have the firepower and the resources that you were able to bring forth for a $375 fine.
I think that more is being made of this now than it was existed
Well, sure.
at the time. But the fact of the matter is that It was an example of how the city bureaucracy sometimes drives average New Yorkers nuts. And I thought it was an issue worth establishing. I'm surprised that we didn't win because the evidence showed that I shouldn't have been fined. But, you know, the fact of the matter is my colleagues were pleased to do it and get the experience. And it was an example of, you know, government having gone too far. I'm sure many of you have experienced the same thing and felt that frustration.
I'm sure people who were actually trying to fight fines that they, you know, trying to make ends meet, who weren't able to do that because the lawyers at the law department were focused on fighting your $375 fine.
It's actually standing up for New Yorkers against
You were standing up for
bureaucracy.
yourself.
It's standing up for New Yorkers against bureaucracy run amok. So it's not about me individually. It's about, you know, having sensible procedures and bureaucrats treating average New Yorkers the right way. It was not intended to offend. It was intended to vindicate the rights of average New Yorkers.
Okay, let's move on to the minimum wage and the fight for 15. As you know, in 2012, the Fight for 15 movement began when a group of fast food workers walked out of their jobs, demanding a $15 an hour wage and a union. At that time, fast food CEOs were among the highest paid corporate executives, averaging $23.8 million a year, while entry-level food service workers in New York State earned, on average, $16,920 per year. In 2015, Governor Cuomo convened a wage board to examine the minimum wage of the fast food industry. You were hired to fight that and contest that. In a July 21, 2015 article in the American Lawyer regarding your fight against the fast food workers' wage hike, you were described as having developed a reputation for challenging various government actions, or as you've apparently put it, who's better to know when government screws up than a former deputy mayor who's a litigator? So is raising the minimum wage for fast food workers a screw-up?
So you understand what that case was about. My clients, who are franchises of major national chains, the $15 minimum wage was only raised for those national food chain franchises. The franchisees are actually independent small businesses. They pay the big chains.
Understood.
Right.
But do you?
But let me.
No, I
finish,
understand the case. I was there. I understand the case.
I argued in favor of.
Do you
$15
believe that
minimum
fast
wage
food
for
workers?
everyone.
Do you believe that fast food workers deserve the raise?
Absolutely.
Then why did you fight against it?
Because a subset of them.
So only some of them
national
deserve the
chains.
raise, not all of them.
Absolutely right. Only the national chains.
Got it. Okay, let's move
were
on.
being raised. But please,
We-
let me
we gotta
explain.
keep moving. We
We
gotta keep-
argued for $15
I'm reclaiming my
minimum
time.
wage for
Reclaiming my
every
time.
fast food worker.
Chair? Mr. Mastro, you also represented the National Restaurant Association, the other NRA. The association has spent decades fighting increases to minimum wage at the federal and state levels, as well as a sub-minimum wage paid to tip workers like waiters. The NRA, the National Restaurant Association, also opposed New York State's proposed $15 minimum wage for fast food workers. You called it, without support in data, logic, or law, an arbitrary, capricious, irrational, and unreasonable. Thankfully, you lost, and the workers got a raise. The wage hike has since gone through, and this January, the minimum wage in New York City, Long Island, and Westchester went up to $16. Since 2018, fast food prices have generally increased at the same rate as inflation. Average weekly earnings for fast food workers increase in conjunction with the increases in the minimum wage, and fast food employment has continued to grow. So clearly, fast food workers got a raise, and the sky did not fall, and the world did not end. Even though you are well above an average earner, were you unable to see the benefit of an increased minimum wage for working people of New York City?
I did see the benefit. I said it was arbitrary and irrational and capricious because the $15 minimum wage should have applied to all fast food workers, the pizzeria, the deli. In fact, the $15 minimum wage should have applied to all workers. The challenge was very limited because the governor had cabined it to only national franchisees and not given it to the other workers. So those are the facts. I favored the $15 minimum wage. I argued in favor of across the board. That was fair. That was rational. Not just fast food
So
chains.
you're
Fortunately,
contending
later
that
the governor did it for everybody.
Mr. Mastro, you're contending that you were fighting to get more workers a raise and not to block the raise altogether?
We argued in court that the $15 minimum wage was irrational unless it was applied to all fast food workers. And you can find that in our court papers.
Okay, so giving workers a raise to you is irrational. Got it. Mr. Mastro,
No,
most
it was
senior
rational
partners,
to give it to all. To all.
most senior
Please.
partners at well-regarded law firms like the ones you've practiced in have their pick of clients. Their docket is so full that they can afford to turn away work they don't want. You chose to engage in a fight to suppress the wages of fast food workers. So should the fast food workers in the city be troubled that you might be the next corporation counsel?
I don't. The short answer is no, because I actually advocated that all fast food workers, not just from national franchisees, should get a $15 minimum wage. So I think fast food workers appreciate that I took that position with the local pizzeria and the deli.
Okay, thank you, Chair.
Thank you. Can I just have a follow-up question on that? Because I do feel like there's a characterization issue here with the case you're talking about. And the argument that you're saying that you argued for all fast food workers to make minimum wage feels a little disingenuous to me. A little may be the wrong word I'd use. I believe the argument you were making was that the franchise owners should not be part of that $15 wage because they're small business owners. Is that correct?
No. The argument was that Governor Cuomo, in the first instance, only sought to impose the $15 minimum wage on these franchisees on the misguided assumption that they were supported by the national chains, when in reality those franchisees pay for the right to be part of that national franchise, and they were going to be the only ones who had the obligation of the $15 minimum wage. So it's not disingenuous at all, Chair Powers, and I respect you tremendously, but I actually was arguing, and I'll be happy to pull up the old court papers, I was actually arguing that all fast food workers, not just the franchises of national chains, should be getting the $15 minimum wage, and that it wasn't right to just do it to those franchisees.
Who is your client in that issue?
They were several franchises. Some of them were McDonald's, but there were multiple franchises.
Understood. I think, just to characterize this correctly, I think there may be an argument, a policy argument, to discuss how franchise owners are discussed in a larger conversation about national chains. I think it would be a mischaracterization to say you were defending the pizza places and delis and other places who were not your client and similarly concerned about what the franchise owners were concerned about.
I didn't say that they were my clients. What I said was, in characterizing that limited $15 relief for that limited class of establishments, national franchisees, that what made it irrational and discriminatory was that it should have been across the board. Then we wouldn't have had a case. And by the way, Counsel Brennan, when it went broader, there was no lawsuit. We didn't challenge that. That's what we'd actually advocated, that there should be a $15 minimum wage across the board. So when that happened, that's actually something that the franchisees that I represented in that case thought was fair.
Okay. I also want to make sure we acknowledge that Councilmember Salamanca, Councilmember Narcisse were joining us virtually. We're now going to go to Councilmember Brewer.
Thank you. I'm going to ask a longer question and then some short ones about 9/11. The aftermath, as you know, of the 9/11 attacks has affected thousands of people, workers, and students who were there at Ground Zero. That fateful day, and many of the mistakes of that period have come home to roost, and we know why, because so many more people have died. Governor Whitman, then head of EPA in the Bush administration and the Giuliani administration, claimed the air was safe to breathe when it was not, as we all know. At least partially as a result, as of today, more people have died in the years since the attack than died on the day itself, from all of the respiratory issues, cancer, and other fatal diseases. And I think I'm particularly concerned about this and was responsible with Governor Cuomo for getting the extra memorial for these individuals. To her credit, Governor Whitman has since apologized for her statement. I don't know of any similar apology from Mayor Giuliani. The remaining residents and survivors of the attacks are interested deeply in what the city knew about the hazards of that period and when they knew it. Nadler, Maloney, and now Goldman, all members of Congress, have pressed the issue since those early days, but they've been rebuffed. And now, more than 2 decades later, as we're approaching the 23rd anniversary of the attacks, a group, as you may well know, 9/11 Health Watch, has filed an Freedom of Information FOIL requesting, among other documents, a copy of a memo to then Deputy Mayor Robert Harding from his assistant in early October saying that the city faced as many as 10,000 liability claims connected to 9/11, including toxic tort cases that might arise in the next few decades, which of course has come to bear. The Adams administration has thus far refused to release the memo. The law department, which you seek to head up, says that potential liability prevents release of the memo, and in response to the FOIL, the DEP and emergency management offices respond saying they actually have no relevant documents from that period. We don't believe them. And now there's an Article 78 lawsuit through 9/11 Health Watch against the administration seeking to overturn that FOIL denial. I realize that you can't comment on any current litigation, and I'm not asking you to. But I do want to list the reasons to deny a FOIL request, and I don't think any of them that I will list quickly fall under denial. So you obviously have those exempt from disclosure by state or federal statute, those which, if disclosed, would constitute an unwarranted invasion of privacy, those which, if disclosed, would impair contract awards or collective bargaining negotiations, those containing trade secrets, not the case, those compiled for law enforcement purposes, those which, if disclosed, would endanger life or safety, those containing examination questions or answers, interagency or interagency materials which are neither statistical nor factual, those which, if disclosed, would jeopardize the security of an agency's computer technology, traffic control signal photographs, none of the above. So my question to you, based on that list, do any of those statutory reasons to your practiced attorney's eye encompass using potential liability as a reason for denial of a FOIL request? And I think you can understand why families of those who volunteered to find victims' remains at Ground Zero, only later to die, might want to understand what those in charge, what those in government actually knew about the working conditions and living conditions in and around the pit of Ground Zero. And I think you know this is a very, very major issue.
I really appreciate the question. And it's true that I can't, and it wouldn't be responsible of me to opine on issues that are in active litigation. But if I'm fortunate to have this position, I commit to you, Councilwoman, that I will review that issue and thoroughly assess it and do what I think is the right thing to do, regardless of where the city has been right now. 9/11, I was not in the administration on 9/11, but so many friends died that day. And for me, what's happened to so many New Yorkers since, what happened to my friend Rudy Washington, who will be here, who was down there every day for a month and suffered near fatal health consequences that the Bloomberg administration refused to acknowledge.
Well, so's Adams.
I'm just trying to explain to you how this is personal. And we had to go public with his issues to get the Bloomberg administration at a point at which he was unemployed to give him the health care for that exposure when he was deputy mayor. So it's personal to me to look into this issue, and I commit to you that it will be highest priority if I'm fortunate enough to have this position.
Okay. How would you reduce the amount of money spent on private school tuition, the Carter cases?
Well, I think we have to assess.
People have been talking about this for 40 years,
I know we have.
and I've been listening to it for 40 years.
I know, and I appreciate the question, and I think that it is a question of reviewing those cases and trying to find both legal solutions, not just from a risk management standpoint, but also policy solutions, and working with the council and the administration to find alternative courses, because we have been talking about it for 40 years, and in some ways, there must be a better way to provide those services at a different cost structure for the city. So it's not just a legal issue, it's a policy issue, and I think it involves putting the best minds together from the council and the city administration to try and find some alternative approaches as a matter of policy.
All right. Is it acting in anyone's best interest to fight a civil case against a police officer if it enables the officer to cross the line again? How do you balance minimizing liability in the short term versus fulfilling the city's obligation to govern in a just manner? This is an ongoing issue.
Well, I think I alluded to this earlier, that the role of Corp Counsel, I think that we can do more than just take the incoming and have some dedicated resources to risk management and the financial consequences. I think that the great minds at Corp Counsel's office, we should have a larger dedicated team to reviewing those cases at inception, trying to figure out where the problems are systemically and individually.
Why do you think you can do it any differently than some of the great, Victor Kovner included, before you haven't been able to do that?
Well, I don't think it's a question of not being able to do it, and I stand on the shoulders of giants. I think we have seen an expansion of liability and cases,
Right.
to a new level, and I think
Higher this year than ever.
right, and that's why I think it requires a fresh perspective, not just to wait for the cases and try and figure out how to mitigate their cost to the city, but try to get to the root causes, who's causing them, and systemically, and that the law department can play more of a role in evaluating those cases on the front end and identifying to the police department where there need to be changes.
I know you answered this somewhat earlier, but should the mayor be represented by the law department in a sex assault case? You had a long answer, yes or no here?
Well, again, that depends. It's not a yes or no. I know there is a representation in this regard, and there has been outside counsel that has been brought in, but I'm not familiar with the circumstance or how the law department made that determination, and I've committed to review their protocols, how they made those decisions, and to review those decisions and call it as I see it after I've been fortunate enough to have the opportunity to do that.
Okay. I was at the Lucerne Hotel most of that situation. Did you speak to Mayor de Blasio privately to persuade him to move homeless out of the Lucerne Hotel? I have a different impression than you did. I think that the city moved people in there too quickly. There were no services. Project Renewal did provide services as time went on, but I think that the way in which it was handled from A to zero was wrong. But did you talk to the mayor about moving homeless out of Lucerne Hotel to go downtown?
I did not talk to the mayor personally. I did reach out to the city about the Lucerne issue. I did speak to Steve Banks personally, and I did speak to the Corporation Counsel personally. And I committed to work with the city to address the problem. And Mayor de Blasio, and a letter was sent to the city, including addressed to Mayor de Blasio, asking him to go to Lucerne and view the conditions himself. But I did not speak to him. The city decided to do that, and Mayor de Blasio did go there. And as you said, Councilwoman Brewer, the conditions in those early months were deplorable, and there needed to be a solution. And we worked shoulder to shoulder with that progressive mayor and his progressive team to try to find a better solution.
Well, I mean, the conditions in the hotel weren't bad. It was just there were no services. That was the problem.
Correct, and they were doubled
It
up.
wasn't
They
that,
were-
I mean, people did have their own private rooms in some cases. I just want to make it clear.
But they were mostly doubled up, Councilwoman,
but,
and that
you
was a
know.
problem. That was a problem.
Those rooms are quite nice. It's a lovely expensive hotel right now. It's not like it was a dump. So that has to be discussed differently.
I didn't say it was a dump. I said they were doubled up in single-room occupancy.
Okay. It's not an SRO in the traditional sense. June 1998, I know that you had moved on soon, but in terms of the budget was, I think that was the year when the council passed its own budget.
Yes.
Okay, so do you have some reason to think why that happened? Did you have anything to do with that? Because if everything was so rosy, that would not be an example of good relationships between the mayor and the city council. And I want to know what you would have done differently.
Okay. Well, of course, I was about to depart and
But you hadn't departed yet, and the scheduling of the budget starts earlier.
That's
As somebody who's been doing this for 30 years.
yes, and as somebody who did it then, yes, I was involved and I was disappointed at what happened. But you will recall the circumstances and where the meltdown occurred. The meltdown occurred over, and I have tremendous respect for him, but the speaker was running for governor, and the speaker wanted to block any provision of money going into the budget relating to a West Side Stadium. The mayor, thought that was inappropriate and the two fought on the budget. That's really where they stalemated. And there was a litigation over whether you'll recall there would be a referendum on that issue. And really, a line item in a budget is not something that you have a referendum over. So to me, while I was on the way out at that moment, that was a disappointment because that was the only time in my time, and we worked together on many things, council member. That was the only time we had a breakdown with the council, and I was sorry to see that happen. But on so many other occasions, we worked so constructively and got so much good legislation done and so much positive done, working my office and the council's office.
Okay. Why do you want this job so badly?
It seems like a fair question after the questioning today. Yes, and I'm sure this is.
I know 30 years ago you did not get it, so I didn't know if that's relevant.
Well, it is. I've said this. It's the only job in city government I ever aspired to do. I'm not a politician. I'm a lawyer, and as a lawyer, I have such respect for the law department and the power of the law department to do so much good. It's out of respect for that role. It's out of wanting to do more in civil rights, constitutional rights, social justice, public safety, things that when you are a subordinate in a mayor's office, you can do just so much on your own. But having the power of that wonderful 800 lawyer office and moving more of those resources into affirmative litigation, to me, there's the potential to do so much good. I would hope the council would realize that the reasons I want to do this job are for the public good and to improve people's lives and to promote civil rights, constitutional rights, social justice, and public safety. That's why I want to do this job. Okay. It's a calling, and I am called to that service.
Okay, we'll be a little bit more humble on that issue, I would suggest. My other question is, you mentioned to your credit that you would not accept that stupid piece of paper in order to meet with you, but would you get rid of it completely so that I do not have to listen to these commissioners who want me to sign papers, which I will not sign, before meeting with them? What would you do to get rid of that as a barrier to good government? Because government is all about people sharing, meeting, having discussions, and that's how you get things done.
It's not a question of humility, it's a question of passion, so please forgive me. I'm passionate about the job. And as the question you asked, I think the mayor's office is well aware of my views on that issue, and I have advised and told members of this council, many of you, that I will not be having anyone do anything on signing in for meetings with me.
I don't want them to sign. I don't want to sign with anybody. Can you make sure that I don't have to sign with anybody?
I understand, Gail, and you know what my views are on this, so you know what I will be saying on this subject.
All right. Thank you, Mr. Chair.
Do you still want the job? No, I'm just kidding. I'm kidding. I'm kidding.
I still want the job, and I hope this council will see the value, the passion, the commitment that I hope to bring to this. And it's not a question of humility, it's a question of public service.
Appreciate it. We're gonna go to the public advocate, and then we're gonna take just a very, very short few minutes to let people, Mr. Mastro, to use the bathroom and take a break, and then to come back. We'll be very quick and short in our break. We're gonna go to the public advocate before we do that.
Thank you, Mr. Chair.
Oh, God.
Thank you, Mr. Mastro, for being here,
I need it.
and to your wife and daughter for being here. I did want to at the outset just say, I would hire you personally as an attorney. I don't know if you'd have me as a client, but I would hire you personally as an attorney. I think you are very good at what
Thank you, and I respect you, and I think you know that. No matter what has ever been said before, I respect you.
I would also say, as I've said in the past, something that I personally would do or believe is not always the best for the public or for government to do. And I think there's a difference in what I would do as a private person and what this role needs as for public's attorney. I have a statement I'm going to read a little and then ask some questions. Good afternoon. My name is Jamani Williams, Public Advocate of the City of New York. Thank you, Chair Powers, Speaker, and the members of the Committees on Rules, Privileges, and Elections for holding this hearing today and give me the opportunity to testify. In 2019, the New York City Charter was amended by a public referendum to, among other things, require the advice and consent of the City Council for the appointment of the city's top lawyer, the Corporation Counsel. I'm here today to suggest that the members of this committee be concerned, and the council as a whole, about the mayor's nomination of Randy Mastro to be the next Corporation Counsel. New York City's Corporation Counsel has significant and unique responsibilities. They serve as both attorney and counsel for the city. As emphasized in our charter, Corporation Counsel is to be attorney and counsel for the city and every agency thereof, and shall have charge and conduct of all the law, business of the city and its agencies, and in which the city is interested. They are the sole person authorized to represent New York City in court. As chief legal officer of the city, they are charged with interpreting municipal law and providing independent analysis to the mayor, city agencies, and independent city offices. These duties should serve all New Yorkers, our constituents, in an ethical, balanced, and fair manner. I do have concerns that Mr. Mastro would impartially and ethically advance these goals, but I have been looking forward to this hearing to see if there's anything that would allay those concerns. Although everyone is entitled to legal representation in our system, the cases a lawyer argues and the strategy they employ to win may speak to their character, particularly if an attorney chooses those clients and they're not thrust on him. For much of his career, Mr. Mastro has too often not represented the interests of the people of New York. He represented fast food owners to attempt to block minimum wage increase for their workers, represented a group of landlords which led to partially blocking the eviction moratorium during the global pandemic. He's represented landlords to block a rent stabilization law. He also represented property owners to oppose enforcement of local Law 97 to create more sustainable buildings. In addition, he represented restaurants against enforcement of a polystyrene container ban. And in an ongoing case, he is arguing that Madison Square Garden should be allowed to continue using facial recognition software to block entry to lawyers litigating against the company that owns it. Finally, it is troubling that Mr. Mastro was involved in New York Jersey's litigation against New York City's congestion pricing plan, which could pose a significant conflict of interest should he become New York City's top lawyer. In addition to the cases he's chosen to represent, many against the interests of the City of New York, some of his tactics are also cause for concern. For example, in representing plaintiffs in the case to remove 283 homeless men staying in the Lucerne Hotel, as was mentioned, Mr. Mastro hired private investigators to spy on activists advocating for basic shelter for some of the most marginalized New Yorkers. As has been widely reported, Mr. Mastro oversaw the Bridgegate scandal of former New Jersey Governor Chris Christie. The federal judge overseeing the Bridgegate investigation harshly criticized Mastro's tactic of deliberately ensuring investigation notes were unavailable in the future, which I believe is a serious ethical concern. As the judge stated, the taxpayers of the state of New Jersey paid millions of dollars to conduct a transparent and thorough investigation. What they got instead was opacity and gamemanship. They deserve better. I believe New Yorkers do as well. Similarly, there are instances in the history of Mr. Mastro that do not espouse the professionalism the current council can endorse. For instance, during his tenure with the Giuliani administration, he was instrumental in dismantling the rights and privileges of many groups, including by removing necessary funding to a social services organization in the midst of the HIV/AIDS pandemic within New York City. It has been said by others that his past career should be reviewed beyond the surface. As deputy mayor under the Giuliani administration, he was with Giuliani as the former mayor went overboard many times to defend the police when black and brown individuals were murdered by NYPD. Not sure how you would treat the former and now disregard the mayor as a role model. New York City's top lawyer should promote public confidence in our city and in the legal profession. The people of New York City deserve an independent attorney who will protect the city and its people, defend the interests of all New Yorkers, and ensure the primacy of the public interest. I have concerns about moving forward with this nomination as corp counsel. My most cynical concern is that this administration has a record of obfuscating instances of, at worst, and about things like no-bid contracts, and at best, underpreparedness to a degree that can cause harm. As public advocate, I have to question whether the intended appointment of someone with a history of the type of theatrics I've described and questionable practice of law is simply a symptom of that same problem. Question is, are you here today as a favor from an administration or as the preferred choice of a mayor who would like every city council hearing to be an exercise in futility and prevent the people of New York City from getting real answers from the public agencies entrusted to provide services and keep our city running? With that, I do have a few questions. I do understand that you face death threats as very serious, and so thank you for the service that you did in addressing organized crime. I'm not sure if that alone is the qualification that should tip you over. I've heard a few cases mentioned that could have derailed things, like congestion pricing, rent stabilization, fast food. I will say, it seems like you've picked those cases and put them forward knowing what the result could be. And you have the ability, this is my opinion, you have the ability to tell people that, look what I did for you, I stopped rent stabilization, I stopped congestion pricing, I stopped fast food, and come before us at a hearing like this and say that's not what I was trying to do at all. I was actually trying to help congestion pricing, help rent stabilization, help fast food. That is a very interesting space to be in. I also want to acknowledge all of the pro bono work that you've done. I do think they're important, but I also want to ask if you are aware of the terms toxic charity and false generosity.
Well, they don't apply to me. They don't apply to me to the 10 years I served as vice chair and then as on a board member of legal aid.
But you are aware of the terms?
I'm aware what the terms are.
Okay. And I want to say this, I don't know if I know you enough to know they apply. I bring them up because just mentioning pro bono work could be toxic charity and false generosity, where people who benefit from bad structures and bad systems then go back to try to assist people who are harmed by them, even though they continue to promote the bad structure and bad things. And so that's a possibility.
So,
I'll let you answer my next question. You can respond to that, my
Sure.
first question.
Sure.
My second question, actually. So when I was a council member in December of 2014, when you testified on behalf of your client, Cablevision, at a hearing of the Zoning and Franchising Subcommittee, rather than answering questions directly, you accused the council of doing the bidding of the communications work of America and the Working Families Party. In particular, you accused me and others of asking questions directly from a WP memo that I have never seen. You're actually pretty demure today. Back then, it was pretty rough, pretty belligerent, and I think a disdain for the council that you're now asking to approve you. So did you think that was an appropriate way to respond to sincere questions from the legislative body of New York City?
well, I recall that hearing a little differently. I think you gave as good as you got, Councilman.
I gave
now you're
back.
the public advocate.
I didn't.
And I was there representing a client, Cablevision, involved in a private labor dispute with the CWA over organizing certain of its workers in certain counties, and the council was holding a hearing on that issue, on that private labor dispute. So I was making the point on behalf of my client that was that an appropriate subject for a council hearing. I have nothing but respect for the council. I have nothing but respect for you. And when we left the chamber that night, I shook your hand. And the fact of the matter is, responding to what you said earlier, my pro bono work, my community service, 20 years at Legal Aid, raising millions of dollars for that organization, chair of Citizens Union for the past 10 years, the gold standard of good government.
I've heard the list.
These are, and my pro bono work, these are my life's work over 40 years. And, you know, I just want to say this. I know you have said some harsh things about me My door is always going to be open to you. I want to represent each of you.
I appreciate that.
It doesn't
The only
matter
thing-
to me
the only
what
thing
you
I have
said
to
about
say,
me.
one, again, I don't know you enough. I just do know when it comes to toxic charity or forced generosity, people use that to try to hide the other things that they're actually doing. That's the only point I put out. I don't know you enough to say whether it falls in that category or not. I was just putting it out as a possibility. But I did, for my question, which was that an appropriate way to respond? I'm assuming that you're saying yes, that was an appropriate way to respond to the council's questions.
At that hearing, I was representing a client, and the client had a very clear view. But I will say
So wait,
this.
sorry. Yes, it was an appropriate way to respond to the council.
It was a contentious hearing, I acknowledge.
So yes, it was. That's what I'm going to put on the record.
I understand.
Okay.
And
Is there a difference between your approach as a private attorney versus being a public servant?
yes, as I've said before, I have more than one speed. Sometimes you are in, contentious circumstances and contentious litigation. Other times you are in a different context. As I've said before, I'm a bear in the courtroom and I'm a teddy bear in real life. It's not the case that representing the city is the same as representing private clients, sometimes in their most distressful matters. You have to have more than one speed. You have it, public advocate. I have it too. And I just want to say, there aren't that many lawyers in private practice who have the kind of demands on their time from private practice, who year after year make hundreds of hours for community service and pro bono. I always do. It's not, there's nothing toxic about it. It's good.
I think
It's
your
good and it
qualifications
feels
as an
good.
attorney are not what is at question here. I actually happen to think the previous corp counsel was just fine. And so I think there are other folks like her as well. I would say I was disturbed to hear, when I know you worked for Mayor Giuliani, and people work for different administrations, so I was trying not to hold that as much against you, but I will say I was disturbed to hear that you campaigned for him before he was mayor and then campaigned for him as president, because that says a whole lot more than just working for him as a mayor. That, again, doesn't necessarily disqualify. I just want to say from my thoughts about what ideals and values that you're bringing to here, and to hear you talk about broken windows, saying because of that, there were some cases that were cracked, for lack of a better word. I just want to make clear, any oppressive policy, you'll be able to find examples where it may have worked. The question is, where it had worked, is it worth all of the violations, and was there another way that you could have gotten to it? Unfortunately, when it comes to black and brown people, we never answered that question correctly. So your defense of not only the administration, but some of the policies that we already know, and have known then, by the way. Giuliani didn't just become Giuliani. We knew that he was who he was back then. But it's the continual defense of that causes a lot of concern for me.
I think what I said was, it's not a one-size-fits-all issue. There are certain circumstances where it's appropriate and certain circumstances where it isn't. And
What you described was the defense of broken windows because there were some cases that people were found to have done something.
Well, there were some instances where that's true. But I'm not here
If I searched
today.
everyone in this room right now, I
I'm
would
not-
probably find something that should not be here.
I'm-
That doesn't mean that I should do that.
I'm not.
But I'm going to move forward from broken windows because I don't think you're going to add anything else that you haven't already
Okay,
said.
can I please respond to what else?
Let me ask this question. You can answer how you would
Of
like.
course.
Do you think corp counsel should be subject to advice and consent of the council?
The short answer is yes. As chair of Citizens Union, we endorsed the council having advice and consent.
Do you think that other appointees, such as what the council is asking for, should be subject to advice and consent of the council?
I was asked this same question previously, and I explained the following, that those are policy questions, and the role of corp counsel is to help and defend the policies that are implemented for the city. As I explained to the speaker when she asked me the same question, it comes from a personal perspective that I understand you would like more authority on advice and consent. I get it.
It's yes, no, or maybe you don't have a decision.
It isn't a yes or no.
This one actually is.
But it isn't a yes or no, because my personal views on advice and consent, you know what my view was on this position because I supported it at Citizens Union. But my personal views on the issue are irrelevant to my ability to be your advocate as to the legality of what you want to do, which I would be able to do. But as I explained to the speaker, if you would please give me just this moment, okay, was that, I feel the council wants advice and consent. The mayor appoints a charter revision commission. Both parties say they had this in mind long before me. I feel like my nomination is stuck in that middle. I don't understand why my nomination has become so controversial, but I'm just here as a lawyer.
I'm going to get to some of that, why I think as well.
I'm just ready to serve, and I will, if you pass advice and consent and that becomes the law, I will defend it, and I will be your best advocate. But I don't. That's a policy question for you to make.
Move forward
not
on that.
me. Not me.
Sorry. What, if anything, would you do if you thought an executive order was not valid or legal?
I would advise the mayor that it was not valid or legal. And I've stood up to mayors and governors and presidents. I will tell the mayor when I think he's done something that's illegal, and I will tell you, council members, if I think you've done something.
In that order, would you defend that EO in court?
Not if I thought it was indefensible, public advocate. I would have to tell the mayor that I thought it was illegal.
Okay. The NYPD has been under fire for failing to adequately report its stops as designated level 3 by the Federal Monitor's 2024 February and April reports. As we follow the implementation of Local Law 20 in 2024, the How Many Stops Act, please explain what your legal strategy would be in the event of further lawsuits should NYPD officers fail to receive adequate training or deliberately fail to capture information now required by law.
Well, so much of that question depends upon how the facts unfold. But obviously I favor people having the proper training and all that. So, that's not really something to be debated, but it would depend upon the facts of the circumstance as they existed at that time.
So if the facts rule that they were not getting training or not complying with the law, you would help the council make sure that happens?
I would help the council and the administration. I represent both. I would represent both if I'm fortunate enough to have the opportunity.
The mayor at his press conference earlier discussed the want to get rid of some of the sanctuary laws. I believe the example he's using for that is a very horrific example where someone raped or sexually assaulted someone, was released, and then did it again, which is horrific. Unfortunately for the mayor and others who are reporting, the type of crime that individual was found admitted guilt for was actually the type of crime that you can work with ICE. And it seemed like agencies or parties didn't communicate with each other. Had nothing to do with sanctuary laws that the mayor has been opposed to for some time. What's your opinion on getting rid of the sanctuary laws?
First of all, those are policy issues to be determined by the council and the mayor, and I will advocate for supporting the law. In my own personal background, I think you know this, public advocate, the Charter Revision Commission that I chaired back in 2001 made the Mayor's Office of Immigrant Affairs a permanent charter agency and enshrined into our city's constitution the protection for immigrants to access all city services and not put themselves in any jeopardy because they access city services. So from that experience my personal views on the subject, but my personal
No, I got it. So if the mayor did try to change the sanctuary laws or move forward something opposition to what the sanctuary laws say now, you would not defend that in court should he be sued?
Again, these are policy questions.
No, that's not a policy question. I'm saying if he went afoul of the sanctuary laws now or tried to change it, say illegally, and he was sued, say, by another part of the government, would you defend that decision that he was making?
I'm not going to presume anyone is acting illegally or answer hypotheticals. I'm going to say that I will evaluate the law and what the law requires, and I will follow the law and advise the council and the mayor accordingly.
So you might defend...
So if the mayor violated the law or if the
No, I got it.
violated the law.
From that answer, you may possibly defend the mayor in doing
That's
this?
not my answer. My answer is I would have to evaluate the facts
I got
on
it.
the ground.
You said that a
what
few
the
times
law
when you didn't want to give a
requires,
straight answer. I got it. I
Consistent with the
understand.
law, and the best interest of the
Understand.
city, I would advise both the council and the mayor what I thought was legally required.
No, I asked you a specific question, and would you defend the mayor doing that? That's what I asked.
But yeah, it depends on the context in which the mayor is doing it. And
What
the law
context would you like?
requires.
Let me provide some more context for you.
I'm sorry?
What more context would you like for the example so that you can answer the question?
Again, you're saying that the mayor would be violating the law by doing something. I'm not sure what it is exactly.
Let's
If
just
the
say
mayor-
he did.
If the, you're a public advocate, if the mayor violated the law, I'm going to tell the mayor's violating the law. But I,
Would you defend him in court if myself or the council sued to try to get the law implemented?
if the mayor, again, you're asking a hypothetical, if the mayor were to do something illegal, and the council had a contrary position and the council position was legal, unlike probably any experience you've ever had before, I would tell the mayor he was wrong
Okay,
and
right
defend the
now,
council.
there's at least 3 pieces of legislation that the mayor is not following that's actually law, that the council has passed. Has to do with housing vouchers, has to do with solitary confinement.
Yes.
Has to do with How Many Stops Act. That is not hypothetical, that is happening right now.
And
Would you defend the mayor in court to support the position he has?
First of all, in each case, it would be irresponsible for me to opine on a pending case without studying the case and giving my views. But after I have studied the case and heard from both sides, but I have said, and I've said it unequivocally here, that if the council passes a law or overrides a mayoral veto, that's the law of the city, and that if the mayor thinks that's illegal, it's the obligation of the mayor to go to court, not wait to be sued
Would you
by
be the
council.
attorney
Not wait
that helps
to be
him go
sued
to
by the
court?
council.
Would you be the attorney that helps him go to court?
It would rest entirely on whether I believe the mayor's legal position was correct or not. But I would not recommend what I understand has happened in some of the cases you've talked about. The administration simply not, waiting to be sued by the council.
Yeah, I know. I'm just saying, I'm not talking about what you would recommend. I'm talking about what you would do as corp counsel.
Right, I just told you what I would do.
No, you didn't. So would you be the attorney that goes into court on behalf of the mayor to not implement these laws?
Only if I thought the mayor's legal position was the correct one. If not, I would be representing the council. But I would be telling the mayor he needs to go to court, not wait to be sued by the council. And when there are conflicts like that, I have to say, I think that there are so many disputes that could be avoided by more communication across the hall. So I hope to
I agree with that.
facilitate that. I hope to facilitate that and make sure we avoid
I agree.
litigation. But when there is litigation, I will evaluate the council's position, I will evaluate the mayor's position, and I will call the balls and strikes, and whoever I think is legally right, that's the party I will represent, and I will
I want to get to
tell
that. I
the
don't know
other
if
party
that's
that I will help them get
100% true,
independent
but
counsel.
I'll get to that.
and
But I have a couple more questions.
facilitate
and
them
I know
having independent
I'm
counsel.
running up against the
Sorry.
time I'm trying to set for myself. But a private property owner has a right to say, I don't want to do business with people who sue me. Those are the words those are your words when it came to defending the interests of Madison Square Garden owner James Dolan to use facial recognition technology to keep out 60 lawyers from his property. Now, I want to discuss public spaces. In the past, our office has asked to put pause on facial recognition technology use for surveillance in public spaces. Should you be appointed to corporate counsel, would you give the city the green light to use facial recognition technology to surveil people in public spaces? And if so, would that information be shared with corporations? I just want to make sure that I got that quote right. I don't want to do business with people who sue me.
What I literally said is true. When you are a private property owner and Madison Square Garden is a private venue, you have a right to determine not to do business with people who sue you. That's the law, and that's been the law in New York for over 100 years, and that's why I've won every court decision. But the fact of the matter is that you talk about facial recognition technology. There was a lawsuit about facial recognition technology at Madison Square Garden, and a federal court dismissed it at the outset. I was not Madison Square Garden's counsel, but it was dismissed because that technology is merely ancillary to a policy that is a legal policy. So you ask me the question, I give you the answer. You have a right not to do business with somebody who sues.
I will say that there is a point where the private ownership kind of merges with the public in Madison Square Garden. Although it's private, there's a lot of public things that happen there, and a lot, that line gets blurred when it comes to places like Madison Square Garden. But I think legally, what you're saying is correct. That doesn't mean that it's necessarily correct. And again, the right thing to do. Again, it's about the decisions you make and the clients you decide and the fights you decide, and why you decide those, to try to figure out what value system you use when you're making those decisions, and what value system will be applied as a corp counsel. I did want to ask, some of the tactics that were used,
Can I respond to that?
You can respond to this next question. Some of the tactics that were used, like was mentioned in the Lucerne Hotel, where you hired the private investigations and took pictures of folks. Is that a type of tactics you would use as corp counsel?
Again, there was a legal reason involving standing why it needed to establish that Shams was living.
I got it. There was a legal reason. Is that a tactic you would use as corp counsel?
It's not one that one would necessarily have to use in city government. But at the time, there was no confirmation he had moved. Shams knows why that was done, and I didn't tell someone to go there and use false pretenses. I asked for a photograph, and Shams knows that, and he respects me, I respect him, and he supports.
The question is, are those tactics you would use as the public attorney, as a corp counsel?
It shouldn't be necessary because the city should know that he's moved.
Is that,
so it wouldn't be necessary.
Yes, you would, or you wouldn't use those type of tactics?
I wouldn't have to do that as corporation counsel.
You wouldn't have to. I'm not sure if that's yes, you would, or you would not.
No.
But, okay. I do have some questions just about.
Can I answer the question about Madison Square Garden? I would.
In my next question, if you want, but I gotta move forward because I want to try to let some other folks speak.
I wouldn't do that if I were corporation counsel because the city would already know he'd moved. But go ahead.
The definition of the city, because we hear it is the mayor, the council, the public advocate, the comptroller, and the people. So is that your understanding of the city? And what the city defined, what the definition of the city is, when it says the corp counsel has to defend the city? What's your definition of that? So I just want to understand first.
Corp counsel's office represents the entire city. That's the administration, that's the city council, that's the independent offices, including yours, and that's also the many entities and authorities and corporations that make up the full breadth of the city, the many subdivisions that represent the city. So it's broader than just the four of you, meaning the administration, the council, the public advocate, and the controller.
Do you support the right of the New York City Public Advocate to receive timely information, regardless of the method of how it is requested, to fulfill New York City's charter mandated oversight and serve as an appropriate check on administration?
I do, and Betsy Gottbaum was here today, will tell you that I've represented her in advising her on such issues when she was public advocate.
So would you engage litigation to prevent the charter mandated work of the public advocate?
Of course, if the public advocate had a claim to bring against the city, and I believed the public advocate was legally right, evaluating, consistent with the law and the interests of the city, I would represent the public advocate.
So there are times when I, as a council member or as a public advocate, has tried to sue the city, and we were thrown off cases because the definition of the city in a legal dispute between that office and administration was found that I couldn't as a council, or I couldn't as a public advocate because I am the city. So I think that's more practice than what's actually in the charter. How would you navigate that if I am trying to sue the mayor or the council is trying to sue the mayor? Would you assist in that happening? And how would you get around that excuse that's always used when we try to do that?
I would make sure there was a team from the law department to evaluate your claim and your rights. I would try and facilitate dialogue with the administration to address the problem before it needed to go to court, which is what I will intend to do on all issues. And if it nevertheless was a breakdown, the Corp Counsel's office would have to make a determination which side to represent, and if the decision were made to represent one side or the other, I would facilitate getting independent counsel for the other side and facilitate the transfer of information and files to that party so that they would be fully represented in any event.
Who would pay for that?
Well, in retaining outside counsel, which happens in a lot of cases, including some of the ones that the city council is involved in right now, that is something that the city permits to be paid for by the city.
Well, in that
City
case,
law
it would come out
permits.
of one of our budgets, which we may not have that kind of money for, which is why corp counsel would be best, because we don't have to pay corp counsel.
I understand, and I am telling you that there,
But
for
the-
issues you have with the city, there will be a dedicated team
And
to
who
try
will
to
make the
help
decision
facilitate.
of which side the corp counsel represents?
I'm sorry?
Who would make the decision upon which side corp counsel represents?
Well, ultimately, corp counsel and the law department evaluating the issue, the facts, consistent with the law and in the best interest of the city, would make a determination of which party to represent.
Yeah. My concern is that in pattern and practice, that has meant the mayor gets corp counsel's support, gets corp counsel's advice, gets corp counsel's legal defense, and the rest of us are not able to benefit from that. And I will say my concern comes from some of the decisions you've made in the past. Some of it also comes from this particular administration that has shown they're not too keen on transparency or on accountability, and they are very keen on loyalty. And there's a huge concern, I haven't heard that allayed now, that the decisions that will be made will primarily be on behalf of the mayor. And I haven't really heard anything, even though I've tried to ask some questions and examples, to me that will lay up, okay, if this was the case, we would support the council, or we would support the public advocate, or comptroller for that example. And that is where my concern is, based on who you have been as a counsel, as an attorney, based on who this particular administration is, my biggest concern is that you as corp counsel would be primarily defending and doing the duty of the mayor. I will say what I'm about to say now is just pure hearsay, so it is what it is. But from folks I have spoken to, you've spoken to, I've also said that you'll be loyal to the mayor. And that just concerns me. So I just want to say it out loud. That is probably the biggest concern. I've added some based on some of your testimony here. But it is very concerning. I don't know that you've allayed any of it. I just want to make sure I didn't miss any questions.
Okay, can I respond?
Oh, sure. Sure.
Okay. Yeah, well, thank you. I've already told you that you'll always have an open door to me, and nobody, has to sign into anything for me. I've already told you that when it comes to issues between the mayor and the council that devolve into litigation, that my position is best practice, absolutely. The mayor's side, if they think something is illegal, that's the law of the city passed by the city council, the mayor has to initiate suit. And corp counsel will represent whichever side the corp counsel determines consistent with the law is, and in the best interest of the city, is right. And I've already told you that I will set up support groups
Can you,
to work
let me
with
just ask this. Can you think of any time where corp counsel has defended anyone except the mayor when it came to any other branch of government?
Well, isn't that interesting? I am telling you that I will call those.
Wait, before you get there, just can you think of any example when that happened?
Historically, I think corp counsel has represented the mayor's office, and I am telling you, as
But I would just say, I think
someone,
part of the reason that the former Judge Radix is no longer here is because she was keen on maybe not doing that every single time. And I believe that based on the things you've said today, based on the examples that I've given you, the opportunity to say, here is where I would defend you, public advocate. I would defend the council. I would defend comptroller. Here, on these examples, given very specific examples and not hypotheticals, to say on this particular case, I would not defend the mayor. Is there an example that you can think of right now? I don't want a hypothetical, because you can say anything, this may be illegal. Is there anything in you have just described your breadth of knowledge on the law. Can you think of any specific example where the mayor is not the person that you would defend?
I can think, you're asking me a hypothetical, but the
No, not hypothetical. There is a litany of things that are going on right now and that have gone on. And your breadth of knowledge of working with Giuliani to now.
I can't prejudge existing cases. I've already told you I'm not going to follow a rule about you having to sign in for meetings. I've already told you that I will make it a priority when I get into office
Understand.
to look at these cases where there's already in court.
I'm just being
and
clear.
Give my best advice.
The
on whose side to
decades
be on.
amount of work that you have said you have done, from Giuliani to now, the decades that you admittedly say, and I admittedly say you have a great experience, you can't think of one real-world example, whether it is something that's happening now or whether it's something that happened in the past, where you would say you as Corp Counsel would not have defended that mayor. That is a problem for someone who's saying you would do something different. You should have had examples of how you would do that difference so people would believe you. And the fact that you want to skirt around that means that you might be saying something that you think might help you get appointed as opposed to something that you would do.
I don't think that's right or fair. I will be as frank as I can be. We didn't have situations in the Giuliani administration where the mayor didn't take the advice to back off. We didn't have litigation with the city council other than that one referendum question, which I think all would agree was an inappropriate question for a referendum. So that issue didn't arise in my time in City Hall. But I am telling you,
I just want to close out by reiterating.
I know, please.
No, wait. I'm going to close out and then Chair can do what he would like to. I just want to reiterate that of the breadth of knowledge that you have on how government works, how the council, the public advocate, the comptroller, the borough presidents, how the mayor works, you do not have one example when the mayor was in court or the council, the public advocate, the comptroller, the borough presidents were litigating against the mayor, or some issue that the mayor brought to court that you would say you would not defend that mayor, you would defend another branch. You have enough knowledge, in my opinion, to have come up with some examples of that. Because what you have said today in the answers to the question, I don't think leads, at least me, to think that that would change even though you said it. And what would have been helpful is some examples. So in the next 72 hours, if you have had any examples that you can think of, I would actually love to hear them.
Okay.
Thank you.
Mr. Mastro, I'll let you, before we go to break, I'll let you answer that last point in question, give you an opportunity to respond, and then we'll go to break.
I am aware that you are in court on a number of issues where there's been a breakdown or that you have conflicts with the administration right now on a number of issues. I have said it wouldn't be responsible for me to opine on those until I've studied them and heard from both sides. But I have told you I will make it highest priority to do that, and I will call the balls and strikes. And if I agree the council is right, I will be representing the council based on my assessment of what's consistent with the law and in the best interests of the city. And I have told you that I do not believe that it is appropriate, and best practice should be that if the mayor disagrees with the law of the city council and feels it's illegal, the mayor should be going to court to sue. I haven't been in city government for 25 years, so thank you for your confidence in me, but I haven't been studying those issues. No responsible lawyer could sit here and answer your question. I'm a responsible lawyer.
That's just not true. You have enough experience. I'm sorry, Mr. Chair. He has enough experience in the breadth of knowledge.
Please, Mr. Williams.
And I know you think you're the smartest person in the room. I am sure of that.
Please, Mr. Williams.
So I'm going to give Mr. Mastro an opportunity to finish his thought, and then we're going to take a very short break.
Thank you. Unlike any Corp Counsel candidate in history, I've sued mayors, multiple mayors, including taking positions in court adverse to this mayor. I have sued governors. I have sued presidents. There is no doubt I will speak truth to power, unlike any Corp Counsel in history. I don't mean to say these things lacking a humility, Councilman Brewer. I'm saying them out of passion and a track record that you can depend on. I have stood up to mayors, governors, and presidents. And I will just say this. I don't think anyone expected we were going to go this long. Now, many of the dozens of witnesses who are here are having to leave. I don't know how we address that situation. Folks, we're about to take a break. I hope some folks, I understand there's some food and drink on the other side. I'm just saying that please hang in there. This council needs to hear from you and how much I appreciate you all
We're
being
here until we're not until it's over.
I understand, and I want to answer all of your questions, but I also want you to hear from these dozens of witnesses who've
We
come
have some more council members who have not had an opportunity to ask questions yet, and we want to hear from them, and we also want to hear from the public. We'll take a very short break to give everybody to use the bathroom and get a quick drink, and we'll be back. Oh, yes. It is 3:43 right now. We'll come back at 3:55.
Oh, okay, quick.
Ladies and gentlemen, please find your seats. Please ensure that all cell phones and electronic devices are placed on silent. We shall resume momentarily. Once again, please make sure all cell phones and electronic devices are placed to silent. We shall resume momentarily. Thank you for your cooperation.
It's not, but it's just like.
Once again, folks, please find your seats. Please ensure that all cell phones and electronic devices are placed to silent. We shall resume momentarily. Thank you for your cooperation.
Yeah. Okay, we are going to have council members, I think, filtering back in, but in the name of time and in respect for the public, I want to continue to move our hearing along. We wanted to jump back into council member questions. Mr. Mastro, I think you were asked at the end of the last series of questions to give an example of where you would have represented the council, I believe, over the mayor. I believe you wanted to provide an answer to that question. So we'll give you a quick, brief opportunity to do that before we jump into council member questions. Turn your microphone on.
I think I was asked for a situation where I wouldn't represent the mayor. I gave an example in real life that when I chaired a charter revision commission, I refused to do what the mayor wanted, which was to change the line of succession during his term, and I outright refused to do that. An example of a case, again, asking hypotheticals like that is very difficult, but if I had been Corp Counsel during the Bloomberg administration, I would not have represented the administration in a case that involved the Fulton Fish Market, where the law that the City Council passed required that there be an independent unloader of fish in the market because that was one of the organized crime pathways for shakedowns in the market. So we RFP'd and hired a union shop of independent unloaders from a company called Laro, and they were licensed to do that work. And the Bloomberg administration made a decision to ignore the law that the City Council passed and to cut a deal with the wholesalers at the Fulton Fish Market to move up to Hunts Point and get rid of the unloaders, the clean element in that market that was preventing organized crime from creeping back, because those unloaders were the shakedown, the endpoint for fish suppliers going to wholesalers. And the Bloomberg administration just decided to ignore the law and get rid of that linchpin to breaking organized crime stranglehold over the Fulton Fish Market. I had to sue on behalf of Laro. We won that lawsuit, but it really was an indefensible case for the city. And I would have told the mayor, Corp Counsel cannot represent you just because you want to do an economic development deal. That's a concrete example, but I know you have a number of issues like that right now, and I pledge to you I will study each of them and make it a priority to determine whether I think where Corp Counsel's office is right now is where I would be, and I will give it straight.
Appreciate that. Thank you for that example. We're now going to hop back into councilmember questions. We're going to hear from Councilmember Krishnan, followed by Councilmember Gennaro, and then we have a list of other council members here as well.
Thank you, Speaker Adams. Thank you, Chair Powers, and thank you, Mr. Mastro, for your testimony.
Thank you.
I want to recap where we are coming back from the break. You are a leading litigator. Your list of credentials is lengthy, but this position requires more. And I want to go through the principles, the basic principles that come with becoming the city's top lawyer. My first question is, Mr. Mastro, the mayor and city agencies are accountable to the public for their performance, correct?
Correct.
The public has a right to know how public money is spent, correct?
Correct.
City council hearings, the mayor's management report, and other such public reviews are all important tools for accountability and transparency. Is that right?
Correct.
You served as deputy mayor under Mayor Giuliani in 1997, correct?
I did.
And in that year, the state controller conducted an audit of city agencies, requesting information on city finances, agency budgets, program spending, and performance metrics. Is that correct?
There was a dispute with the state controller's office over certain subpoenas that had been issued and whether the scope of those subpoenas was excessive. So your question, the answer to your question is there was a dispute. As to whether the state controller was entitled to all of that information is a separate question that was very much in dispute.
In your role as deputy mayor to Rudy Giuliani, did you submit all of the requested documents and information for the state's audit?
There were issues between the state controller's office and the mayor's office about whether those subpoenas, the scope of them, was sufficient. That's something that happens in government.
Yeah,
So
it's Mr. Mastro, just a yes or no. Did you submit all the documents requested?
we submitted many, not all.
Thank you. In your role as deputy mayor to Rudy Giuliani, did you direct city employees to block state inspectors' access to city offices?
There were certain contested audits where some audits were conducted and some were not. These are sensitive issues of who has primacy and legal authority to do certain things. So these are not yes or no answers.
I'm going to read, that wasn't an answer to my question, but I'm going to read from the New York Times, March 29th, 1997. The headline was, Mayor Orders State Auditors to be Evicted. You are quoted extensively in the article, and the article says, quote, senior administration officials instructed state auditors at the Health Department and the Human Resources Administration to leave. In your role as deputy mayor to Rudy Giuliani, did you receive 17 separate subpoenas from the state that you did not comply with?
I don't recall the number, but there were issues about whether the state controller was exceeding the scope of his authority. We worked through those issues, and they ultimately were resolved. They were resolved ultimately consensually, Councilman.
Whether or not, Mr. Mastro,
I want to be clear. That's not uncommon.
Sorry, Mr. Mastro. I don't want to interrupt. I want to give you a chance to ask your question,
course,
but this is a factual question, right? Either you received the subpoenas or you didn't. And the public record is clear that you did receive them. Now, whether you thought they were legitimate or not is a different question. But I just want to let the record reflect that you did, in fact, receive 17 separate subpoenas, and you chose not to comply with them for your own reasons. Ultimately, however,
we
I'm sorry,
contested-
Mr. Mastro, ultimately, New York's highest court ruled that your failure to comply or to contest the state controller's audit was unlawful. Do you still believe that it is legal for the mayor's office to withhold information from the state controller when the state controller is requesting that information pursuant to the law?
I would follow the law. The authority of the state controller was to do certain types of audits. We complied with others. You're cherry-picking your facts, Councilman. The fact is that we thought that some of them exceeded the scope of the state controller's audit authority, and now that issue has since been defined by the New York Court of Appeals. So of course we would follow the law. But issues like this arise all the time between parallel or subordinate forms of government, and sometimes the courts resolve them. I know what the law is that came out of that case.
That's correct,
I would
Mr. Mastro.
follow the law.
Let me read to you what the law was as interpreted by the Court of Appeals in regards to this very issue.
I said I would
It said,
follow the law.
That's right. So the
Okay.
law said, we find the city's argument unpersuasive. The legislature has empowered the controller to conduct such audits of city agencies. It's great that after the fact, you have agreed to follow the law in the Court of Appeals. But it's also important, as the city's chief lawyer, to follow the law before it goes to court, as I'm sure you'd agree to. Do you still believe that the mayor's office can refuse to follow the law on sharing information with other government bodies if required to do so?
I believe the law is clear now about the breadth of the state controller's audit authority over the city. At the time, the position taken by the Giuliani administration was based on advice and working with Corp Counsel's office. Now the law is defined. I understand the law, but that was a legal question that was resolved in that case.
Right. Well, Mr. Mastro, let's be clear. The law was always the law. It was clear. Your administration and you personally also had a very different interpretation that was ultimately ruled incorrect.
It was.
Let me move on.
It was not. The law is established now that whether the state controller had that sweeping scope of authority was not clearly defined at that time.
Mr. Mastro, let's move on to the next topic. Councilmember Brewer touched on this, and I want to go a little bit deeper. In 1998, Mayor Giuliani proposed deep cuts. Sorry, let me back up for a second. You had testified earlier today that you believe you were critical in maintaining a collegial relationship between City Hall under the Giuliani administration and the City Council. Is that correct?
I don't just believe it. It's what people like Peter Vallone and his entire senior staff and others who will testify here, Ken Fisher and others will testify, was the case.
Sure.
And Mark Green felt that way too, even though we had our spats.
Just asking you, do you believe that it is critical to have a collegial relationship between the City Council and City Hall? Yes or no? That's a yes or no question.
I think we did. I did.
In 1998, Mayor Giuliani, as Councilmember Brewer mentioned, proposed deep cuts to public services that the City Council opposed. The Council passed its own budget to protect these vital services. Mayor Giuliani vetoed the budget. The City Council overrode his veto, as you know well. Did you, as Deputy Mayor to Rudy Giuliani, then authorize a publicly funded mail piece sent to nearly 1 million New York City residents attacking the City Council and claiming that the City Council illegally raised taxes on New Yorkers? Did you or did you not authorize that mail piece?
I don't recall the piece that you're referring to. But at the time, the administration and the council were in pitched battle over the budget on an issue that
So you don't recall. The answer is you don't recall. Let me refresh.
I don't recall.
Let me refresh your recollection. June 13th, 1998, there was an article titled "Mayor Ignores Council Over Property Tax." A mailer was sent to 900,000 property owners saying, "Dear taxpayer," accusing the council of setting rates in an invalid and improper manner. Peter Vallone, the Speaker of the Council at the time, who you mentioned, called it blatantly political, this mailer, unnecessarily alarming, and full of falsehoods. Randy Mastro, the Deputy Mayor of Operations, said the bills had been printed and sent to private mail-order houses and would be received by most taxpayers today or Monday. Quote, Mr. Mastro said, "The mailing is largely completed. There's nothing the City Council can do." In this role as Corporation Counsel, Mr. Mastro, where you represent not just City Hall, but the City Council, do you believe that such an action is an appropriate way for City Hall to respond to the City Council to maintain collegial relationships?
Again, I don't recall the specific instance you're talking about.
I've reminded you, though, so you could answer if you believe presently whether it's appropriate or not to act that way.
Please let me finish. And at the time, I was exiting City Hall and had already given my notice, so I wasn't heavily involved in those issues. But the fact of the matter is that it's not the way I, left to my own devices, would have conducted myself, and not the way I typically did with the council. And obviously, Peter Vallone and others on the council don't attribute that to me personally. That's why I enjoy so much support from him and his staff and council members from that generation.
Thank you. Stepping back for a second, the Corporation Counsel serves as the lawyer for New York City, correct?
Correct.
As well as the City Council and the mayor, correct?
Correct.
In other words, the Corporation Counsel, as the city's chief lawyer, represents the public interest, not the interests of one agency or one branch of government. Is that correct?
Correct.
Do you believe transparency and accountability are important in this position of Corporation Counsel?
I believe that transparency and accountability are important, more sensitive with the law department because of privilege issues. So there can't be complete transparency because so much involves privileged communications. But as a general principle, I personally believe in transparency and accountability. I chair a good government group, Citizens Union, that advocates for those principles in government at all times.
I know.
That doesn't mean that the principal I served necessarily shared those same views.
Sure.
But I am telling you that I understand that that is part of government and part of Corp Counsel's office, consistent with obligations to protect confidentiality and privilege.
And do you believe public officials should create and preserve a public record of their work?
I believe that when you make a public record, you should preserve the public record.
Thank you. Let's look carefully at that. You led an internal investigation on the Bridgegate matter, correct?
I led representation of the governor's office that included internal investigation that produced a several hundred-page report, over 80 interview memos, and hundreds, if not thousands, of pages of documents collected. And we followed the same procedure that the
I'm going to get to that, Mr. Mastro.
I'm sorry, that the FBI followed.
Mr. Mastro,
and
I haven't asked a single question about that yet.
Okay,
All
I
I've
just
asked
wanna-
you is a yes or no, and when there's a yes or no question, you can just give a yes or no answer. Did you lead an internal investigation? Were you hired by the office of Governor Christie to lead an internal investigation into the Bridgegate matter? Yes or no?
I and my law firm were hired to do that, and I answered questions earlier.
Correct. And we're going to go into a bit more detail about that, building on what Majority Leader Farias had said. In this matter, as you just said, you, quote, interviewed more than 70 witnesses and reviewed more than 250,000 documents, quote, through the course of your investigation, right? And I'm quoting from your own report.
Yes.
There was a separate prosecution of Governor Christie's staff over Bridgegate, as I'm sure you're well aware. The defendants in that case requested your notes from all of your interviews during the course of your investigation. In their criminal case, they filed a subpoena for those notes, correct?
Correct.
You opposed this subpoena, correct? And you opposed it on the grounds that, quote, no notes, transcripts, and recordings of the witness interviews existed, end quote, from your own report.
We produced all of the memos of the more than 70, I think more than 80 interviews. We produced all of those and said there were no other documents to produce.
Right. And I'd like to remind you, again, you interviewed more than 70 witnesses and reviewed more than 250,000 documents, and yet you represented to the court, and you can argue with your own report, but these are your own words, that, quote, no notes, transcripts, and recordings of the witness interviews existed.
That's correct.
You heard a bit more in the questioning earlier about how this was a substantial departure from the practices of Gibson Dunn, As someone who has worked at 2 large corporate law firms, as how lawyers practice law, both at law firms and generally. But I want to read to you,
That's actually
Mr.
not
Mastro,
true. That's
Mr.
actually not
Mastro,
true.
let me read to you the decision, because the judge had some strong words for your conduct. The court said, although Gibson Dunn acknowledged that it intentionally changed its approach in this investigation. Although your firm, Gibson Dunn, did not delete or shred documents, what you did in not preserving notes, quote, had the same effect, end quote. You were paid, again, although Gibson Dunn did not delete or shred documents, what you did had the same effect.
It did not.
Were you part of the FBI at that time, Mr. Mastro, in that investigation?
No, but it's not.
Yes or no? Were you part of the FBI?
I was not part of the FBI.
Were you a federal prosecutor on that case?
I was a federal prosecutor, not on that case.
Thank you. In fact, this was an internal investigation where you were producing a report and recommendations that included best practices. Is that correct?
But you are asking me whether I worked for the FBI because you know the FBI only does one memo of an interview and doesn't keep any other
That's
notes.
correct, as you testified
So
to
that's
before.
okay for the FBI.
And as I just recall you testifying, you were not part of the FBI. This wasn't a criminal investigation. You weren't a federal prosecutor. You were leading an internal investigation where you were creating a report and recommendation of best practices. And it's shocking that in a case where you were issuing a report of best practices, one of the most fundamental practices of lawyering, preserving records and notes, didn't apply in this case. You chose not to apply it. But I want to ask you this.
There were no records to preserve.
Mr. Mastro,
we didn't keep notes.
I'm sorry. After 70 witnesses and 250,000 documents, the fact that there were no records to produce
like me to answer?
just falls hollow. No, because I'm going to move on to the next question.
I
were
see,
paid.
so you don't want me to answer.
There wasn't a question in there.
Okay.
You were paid.
There's no question, but please
Mr.
let me
Mastro,
answer.
here's my question. You were paid $8 million in public money for this investigation, correct?
I don't recall the exact amount, but it was several $1 million.
Let me tell you, in the court records and papers, it was listed as $8 million. You billed for $10 million, you collected $8 million from the taxpayers of New Jersey. Do you think the public got their money's worth?
I believe that the work we did, which was confirmed in the results reached by the U.S. Attorney, the New Jersey AG, and the Bergen County Prosecutor's Office, that we did the work ahead of all those other investigations, that advanced those investigations, and got to the core of what happened on Bridgegate and what happened in connection with Hoboken, which no one even mentions, which was half our report.
But Mr. Mastro, I'm asking you a question. Do you believe the public got their money's worth in hiring you for this matter?
I think we represented the governor's office and the people of New Jersey in a professional, responsible, and ethical manner. And if you'd like me to explain that, I will. Because
I don't need an explanation. I just asked you if that's what you felt. And you sound like you felt like you did. The public did get their money's worth. Let me read to you what the federal judge said. Quote, the taxpayers of the state of New Jersey paid Gibson Dunn millions of dollars to conduct a transparent and thorough investigation. What they got instead was opacity and gamesmanship. They deserve better. End quote. Is it correct to say that your internal investigation found no evidence of wrongdoing by Governor Chris Christie?
It found that there was no evidence that he had directed the lane closure in advance, and it attributed to 2 individuals, and turned out the U.S. Attorney said a third, who were involved in making that decision and implementing that in advance. And our report reached the same conclusions as the U.S. Attorney, the New Jersey AG, and the Bergen County Prosecutor's Office as to who was ultimately responsible for making the decision on the lane closure. We didn't exonerate anyone per se. We said that there was something wrong that had happened, and we identified the individuals who were responsible for the decision, and that's exactly what the U.S. Attorney, the New Jersey AG, and the Bergen County Prosecutor, they reached the same conclusion.
I just asked if you found no evidence of wrongdoing by Governor Chris Christie, and it sounds like you didn't. But Mr. Mastro, as I mentioned before, you were one of the nation's leading litigators in one of the most high-profile public investigations of that time, when you were hired to serve the public interest at extraordinary taxpayer expense. You, quote, intentionally changed your practice and did not preserve any records or notes. And then you found no wrongdoing by Governor Christie. And the public had no chance to check your work because you kept no notes. My question is this how you intend to conduct yourself as corporation counsel?
The premise of your question is completely wrong. The practice at my law firm and among sophisticated law firms that do internal investigations now, in my own law firm, there had been an issue about notes where they had to be produced in a litigation. It was not actually best practice.
Got it.
And law firms today in sophisticated investigations, like the FBI in criminal investigations, they do not maintain notes. They make one memo of an interview, complete transparency on all our interviews and all of the documents that we reviewed, and all were produced. But sophisticated investigations today do not, have lots of note takers.
Mr.
They
Mastro,
they have memos.
Understood.
And
I'm not
individual
arguing.
reports.
I have to.
That is actually what sophisticated investigations do today.
Thank you. Mr. Mastro, I'm going to keep moving because I'm on a clock here. So I just
Please,
wanted
go
to add, as corporation counsel, you are once again hired by the public to once again represent the people of New York City, as well as the city council and the mayor. The public interest is paramount, and you must serve it with transparency, not personal interests, not political interests. So my question, rhetorically, is whose interest would you serve in this role? I don't need an answer to that question because I think your record speaks for itself. And I just conclude my questions by asking you, as you testified earlier, you worked under Giuliani at the U.S. Attorney's Office, you were his chief of staff, you were his deputy mayor, your professional relationship goes back a very long time. You have called him a role model and an inspiration. You have spoken up for his presidential campaign. As I mentioned, you called him a role model and an inspiration, someone who has now been indicted, disbarred, and is bankrupt because of his efforts to overturn the 2020 election for Donald Trump and to incite a violent insurrection against our country. Have you spoken out and denounced Rudy Giuliani for his efforts to overturn the 2020 election and incite a violent insurrection against the United States?
Yes.
When?
At Citizens Union, we've repeatedly taken positions about the actions that occurred around that election.
I'm asking if you personally, not
please,
Citizens Union.
Let me answer because you gave a
stick
speech,
to the question.
not a question. All right.
My question's not Citizens Union. My question is you personally.
I have submitted to this council the speech that I gave at Citizens Union's annual dinner, where I said that I hoped the lawyers for that campaign would come forward publicly and apologize for what they did. So please I don't need you to misunderstand in any way. I haven't spoken to Rudy Giuliani in years. And when I said he was a role model, it was because of the courage he showed standing up to the Reagan administration when I was a federal prosecutor, the courage he showed and backing me up when I put my life on the line against organized crime, and he supported those efforts. So there are things about Rudy Giuliani, the Rudy Giuliani of that period, that yes, I respect, but I have not had any contact with him in years.
And finally, my last question is, do you believe it was the right decision for the state of New York to disbar Rudy Giuliani for his actions?
I'm not here to pile on to someone. It's a heartbreaking situation for me. I believe in the law and the process and the bar took the action that it did.
But you're going to be the city's chief lawyer with a staff of several hundred lawyers. If a lawyer perjured himself or herself in front of the courts or in front of state agencies or legislatures, do you believe that that lawyer should be disciplined and disbarred for their conduct? Would you speak out if such actions happened under your watch?
Yes.
Thank you.
Thank you. We'll now go to Councilmember Gennaro.
Thank you, Mr. Chair. Good afternoon, Mr. Mastro. Thank you for your opening statement and the testimony you provided so far. I have some concerns about your nomination with regard to your record on the environment, so I'll probe that now. Let's start with your work for Chevron regarding the Lago Agrio oil field in Ecuador in the Amazon rainforest. I apologize that this question has a long ramp up. It's quite a celebrated case, and I have to, bring some people up to speed. The problems that I will lay out regarding Lago Agrio were conducted by Texaco, but Texaco was acquired by Chevron in 2001. From 1964 to 1990, Texaco deliberately and systematically dumped more than 16 billion with a B gallons of hazardous waste in the form of produced water in approximately 900 open waste pits dug into the floor of the Amazon forest. As many people know, produced water is something that's part of the drilling process. You drill, you get oil. You also get like a briny water from the earth that is laced with toxic chemicals and heavy metals. Produced water is as I said, a hazardous waste. It also dumped, Texaco did 17 million gallons of crude oil for road clearing activities in the rainforest. All of this Texaco admitted, but maintained that it had done so legally and according to industry standards. Texaco left behind a 1,500 square mile patch of environmental disaster causing an epidemic of cancer and other oil-related health problems for about 30,000 residents from indigenous cultures whose health, natural resources, and way of life has been decimated. This is considered one of the world's largest oil-related catastrophes and has been dubbed the Amazon Chernobyl. This is a well-known example of oil drilling malfeasance. I am a geologist myself with a subspecialty in petroleum geology, and people in this field know this case very well. Litigation for this catastrophe started in the U.S. in 1993. After years of effort to have the case relocated, litigation commenced in Ecuador in 2003. In 2011, Chevron, which took over Texaco in 2001, was found guilty and ordered to pay an $18 billion settlement, later reduced to $9 billion. You represented Chevron to fight the $9 billion settlement. And you prevailed, despite Texaco/Chevron admitting that it created that devastation, but arguing, as I said before, that it did so legally. In representing Chevron, you began a series of so-called slap lawsuits on Chevron's victims, on their lawyer, and on the Ecuadorian judicial system. Slap lawsuits, as many people know in this room, are strategic lawsuits against public participation, and their purpose is not necessarily to win, but to intimidate, harass, demonize, and bankrupt the weaker opponent, and prevent victims from speaking out against unethical and criminal activities. Many jurisdictions now ban slap lawsuits. Anyway, Chevron needed a win-at-all-cost lawyer, and they hired you. And you are proud of your success in that case, listing it first in your resume among your most significant legal accomplishments. I have your resume here that was provided to us. The first sentence in the part of the resume that talks about your best legal achievements. The first one, among many high-profile matters, Randy won a 2-month RICO trial barring the enforcement of a $9 billion fraudulent Ecuadorian judgment against Chevron. And let me continue with my long lead into my question. Once again, my apologies. So you did your job. You won on behalf of Chevron, which in 2003 yielded more than $200 billion in revenues worldwide. But the 30,000 indigenous people lost everything: their health, their water, their homes. There was a documentary film that was made titled Crude, as in crude oil, and was filmed at the Sundance Film Festival and received acclaim. So on one side there is Chevron, which has still not made the indigenous people whole, and why you highlight your victory in this case as your, I'm led to believe, your #1 legal achievement, according to your resume. New York City has many environmental justice challenges, and you have mentioned environmental justice 10 times in your responses so far in today's hearing by my count, and you mentioned environmental justice in your written statement. So finally we get to the question. How can the environmental justice community and this council trust you to champion EJ issues and defend EJ legislation when you tout as your #1 legal victory your triumph for Chevron in this case, which Chevron, in which Chevron perpetrated one of the worst episodes of environmental injustice on the planet, which is still going on today. Chevron perpetrated this environmental injustice, admitted it, and you got them a walk, and the indigenous people are still suffering from Chevron's environmental destruction. This council cannot get the city's activist EJ community to abide that. That is, I believe, a deal breaker, and the legal nuances of this case and your obligation towards your client, Chevron, are not going to create, that kind of description. It's not going to create any kind of baseline of trust of you on the part of the environmental justice community. I believe that is just a stone fact, and I invite your perspective on this matter.
Thank you for raising this, Councilman.
I also try to speak up. I don't hear so well, and so
Your recitation, respectfully, reads more like a press release from Steve Donziger, the New York lawyer who perpetrated a fraud on our judicial system, went to prison, and got disbarred for what he did in connection with the Ecuadorian litigation.
I was confident you were going to. I was confident you were going to bring up his name, but please continue.
Please. I did not represent Chevron in Ecuador and the litigation that occurred there. I represented Chevron not in slap suits. I won every aspect of the litigation that I brought to expose a litigation fraud, one that the Wall Street Journal called the litigation fraud of the century. And what we did there was to preserve and protect the integrity of the justice system and the judicial system. And when I go to that courthouse in the Southern District of New York, right across the street, judges still come up to me and say, thank you for what you did to protect the integrity of the justice system and the judicial system. And it was protecting that system from a New York lawyer who committed bribery, extortion, fraud, and was ultimately convicted of a crime and lost his bar license. And there is nothing about that that is a slap suit. There is nothing about that that is anti-environment. What it is about is protecting the integrity of the judicial system and the justice system. It's in the highest traditions of our justice system to expose litigation frauds, to see that justice is done, to see that the right result is reached.
Thank you, Mr. Mastro. Your answer is satisfactory. Let me just kind of revisit this. And I'm switching from my distance glasses to my reading glasses. But what is really central, I think, is the need for entities like Chevron, once they admit malfeasance, to be held accountable for that.
Chevron did not admit that, Councilman.
I mean, according to legal research done by the council, that was, this is the information that I have. But at the end of the day, let me just state that there's no way to deny that you were a big part of Chevron not having to pay this $9 billion settlement, which the legal process has deemed a fraud, and Stephen had his issues, and I get that, but here we are all these years later, and the people that live in that area are still suffering, and Chevron has not made it, has not made those people whole or done what they needed to do, and you were on the team, which involved many lawyers. It's my understanding that many firms were involved, but you were, part of the overall effort to get Chevron off the hook. So you were part of the team that did that at a very bare minimum. And we can talk about, Donziger and like what he did and why he went to jail, but he wasn't Chevron that did all this environmental destruction. And as I indicated in my lead up to this, I think the subtleties of the role that you played with regard to getting Chevron off the hook are not going to pass muster with New York City's activists, environmental justice community. This is one of the worst environmental injustices that has ever been perpetrated, and you stood with the parties that perpetrated that and worked to get them, Chevron, not to pay any judgment.
Councilman, I stood for the rule of law and our justice system. Chevron never admitted to any environmental disaster caused by Chevron, because as you said at the beginning of your recitation, it never even drilled in Ecuador itself. And every court, please, Councilman, every court up to the Supreme Court ruled the same thing. Steve Donziger committed litigation fraud, bribery, extortion, and Steve Donziger is the reason why that judgment didn't stand. And I assume you respect the rule of law as much as I do.
I certainly respect the rule of law, and I'm going to jump in. I certainly respect the rule of law. What I don't respect are companies like Chevron who put aside the fundamental tenets of the free market, which means you have to pay for the cost of production to bring your product to the marketplace. And whether it was Texaco or Chevron is a distinction without a difference, because Chevron was the entity that hired you, even though Texaco did it. And no amount of colloquy between you and I can change the fact that that area is still the Chernobyl of the rainforest.
That was Steve Donziger's characterization, not anybody else's. Please understand.
That is still, it's Chevron, Texaco, call it what you want. They made this happen. They put together a dream team of environmental experts in order to not have to answer or make restitution or pay a judgment for the environmental degradation that they caused, and you stood with them. And my practical point here is that your association with this case is going to be very difficult for New York City's environmental justice community to abide. And I think, as I said before, that is just a stone fact.
Okay, the stone fact is that I stood up for the integrity of the justice system. I exposed a litigation fraud
that doesn't help the indigenous people. Excuse me, I'm taking a little liberty here. That's just like that does not help the indigenous people who are still suffering at the hands of your client.
And that's because Steve Donziger committed litigation fraud. Why don't you ask him why he committed a crime?
Steve Donziger did not do the drilling.
A crime.
He did not create 900 pits of produced water. He did not destroy the habitat. He did not destroy these people's lives. He did not take away their livelihood, their culture, their health. He didn't do that. He was a bad lawyer. Okay, I get it. But
Okay.
somebody did that, and someone needs to be held account. I knew you were going to go that way, but
Go
at the
that
end
way,
of the
it's
day,
the truth.
But but at the end of the day, this environmental degradation did happen at the hands of your client, and you were central in getting that client off the hook
Did not-
by
did
standing up
not.
for justice. I'm
Did
going to move
not.
on to my next thing. I think
But it did not happen at the hands of Chevron, and the Ecuadorian oil company has been drilling ever since.
I could go on about the Ecuadorian
Please.
government, but but the purpose of this hearing is about you and your involvement with one entity, which is very much involved, and certainly like the government has its own story. It has its own problems, with regard to its people, but you did not represent them. You represented, Chevron / Texaco that did the drilling, and I think that's going to be a problem for the city's environmental justice community.
If standing up for the integrity of the judicial system is a problem, I'm sorry.
I'm going to move on to
I
my
stood
next
up for
question.
it.
I appreciate it. Anything that you want to submit for the record in the next 72 hours, but the hour's late, I'm going to move on to my next thing. I appreciate
please.
your comprehensive reply. This is about styrofoam. Mr. Mastro, you have represented companies who oppose important pro-environmental local laws passed by this council and pro-environmental rules passed by agencies. For example, in July 2015, former Mayor de Blasio announced a ban on single-use polystyrene foam articles, styrofoam, and fill packaging such as packing peanuts. The Restaurant Alliance, let me just go down to, let me just try to save time. And trying to move along here. And so let me jump to where you come in terms of an interview. With that said, about your opposition to the law and your representation of people who indicate styrofoam can be recycled easily, your comment was, with that said, you had an interview at New York One's Inside City Hall regarding that ban in 2015, and you were quoted as saying, quote, "This is a crazy decision by the city," close quote, and quote, "As a former deputy mayor, I've seen some pretty crazy ones over the years," close quote. Doesn't this record of adversity and ridicule of environmental laws undercut your ability to represent this council's environmental laws?
Well,
that's my question.
I'm very glad you asked that question, because the law in question that the city council passed said that if styrofoam could be, if it were this is the words of the council, that if styrofoam could be recycled in an economically feasible and environmentally sound way, that it should be recycled, because this council has supported recycling over and over again. And if it couldn't, the city could ban it. And what we proved in court, I believe, was consistent with the city council legislation, that styrofoam could be recycled in an economically feasible and environmentally sensitive way, because it was certainly capable of being collected for recycling. Clients involved in the case were willing to pay for a pilot program of the city, so the city would have lost nothing and potentially profited from the recycling. And the first judicial decision in that case affirmed my position that, in fact, it could be recycled.
Yeah, I don't think that
please,
really square. I will just follow up on like the central focus of my question, which is the ridicule. And I think the ridicule is of city laws and policies are a bad look for someone who needs to defend and advocate for city laws. With that, I'm getting the hook. I'm going to get one last question regarding Local Law 97. That's already been covered to some extent by Chair Powers and Councilmember Ressler, and Councilmember Ressler. So I'll forego the ramp up to the question. They kind of talked about that. Let me get to what I want to ask you about. You and your clients, those that are working with you on Local Law 97, you and your clients have refused to tell the press who is actually paying your bills for the lawsuit. In May, AM New York asked you and your clients who is financing this effort to undermine Local Law 97? Let's not say undermine, let's say challenge, okay? To challenge Local Law 97, and you and your clients refuse to say, and who finances a lawsuit is not information that is protected by attorney-client privilege. At the time you refused to comment, you had not been formally nominated by the mayor for this position. You are now before the council seeking to be the top lawyer in city government, and I think it is incumbent on you to be transparent about issues like this one. So can you be candid with the council and the public now? Who is financing your challenge to Local Law 97?
Well, it's not actually the case, Councilman, that
No one's paying the bills?
information relating to the financing of litigation when the individuals have an attorney-client relationship with you and request that, that's not necessarily the way you have characterized privilege. But the fact of the matter is that that party has not wanted to be disclosed publicly, but I will ask that party or parties if they consent to me disclosing that. But I, as a matter of client confidence and privilege, have not disclosed those issues. Other than the parties I am representing.
How about this? How about just take a sidebar with counsel to see if the counsel to this committee whether the counsel to this committee believes that what Mr. Mastro just stated about, because he's still claiming client confidentiality. I want to hear from our counsel whether or not that squares with his interpretation and or her interpretation, and if that's the case, I'm going to ask the question again. Is there anyone here any counsel sitting on the dais?
I'm not, and I'm not authorized to go into that, but I will ask that party or parties, and if I can disclose it to the council, I will. I would have thought you would have asked me about the case, why we brought the case.
Yeah, I know.
What I hope to do to help
I'm
the
trying to
council
move forward
pass
because that's already
climate
been
change legislation that will
the
pass
subject.
muster.
Hang on. What's that? What's that? Okay, counsel to the committee has just indicated to me that what I'm asking you is not shielded by attorney-client privilege. So I will ask you. So I will ask you again after being advised by counsel, who is paying the bill on the Local 97 litigation?
Right, and I will repeat that I honor client confidences, and I will speak to the client or clients about whether they waive.
When you say confidences, do you mean that they won't
Councilman-
like it, or this is like, oh, you'd be breaking the law by telling me?
Councilman, I will inquire of that party
No,
or parties.
we're going round and round here.
We're not
So-
going round and round, and I'm supposed to put
So-
in written
so-
submissions later, Mr.
So
Chair.
you are
I'll be
saying,
happy to
so
address that
you
in a
are
written
telling
submission
me,
later.
you
I am
are
telling
telling
you
me
that
that
you're not
you,
asking me about Local
you
Law
are telling me
97.
that you cannot tell me who's paying the bill for that lawsuit, because that would violate attorney-client privilege. Yes or no?
I am telling you that.
Yes or no?
Councilor Mastro, why don't I recommend, Councilor
Right.
Gennaro,
I don't
if
need
you
to
will.
be yelled at,
Why don't-
Councilman.
why
I'm
don't
not being I'm being respectful of you. Please don't yell
Councilor
at me.
Mastro,
Okay,
sorry,
thanks.
Councilmember and Mr. Mastro, in respect of time and also in respect of trying to keep this civil, we have asked, we offered 72 hours to amend your testimony,
Correct.
amend your statement. Take that time.
And I will let you
Please
know.
let us know if you're able to provide that information, if that
Thank you.
is a reasonable compromise.
Thank you. Thank you for your.
Thank you, and I'm
for-
sorry you raised your voice, but I'm just trying to be respectful of the council. And
Well, I just want to make sure
inquire
you
of
can
the
hear
council.
me. I want to make
will
sure you can
inquire-
hear me.
I
We're
will
going to keep moving.
I
We're
will
going to keep moving along
I will
because we
inquire.
are at 5 o'clock right now, and we have a lot of folks in the public who want to be heard and have a right to be heard. We are going to go to Councilmember Sanchez next.
Thank you, Chair, and good afternoon, Mr. Mastro. I'm going to start with some questions regarding your role in several charter revision commissions, and then end where our private conversation took place in the field of housing. So to start, after your departure from the Giuliani administration, Mayor Giuliani tapped you to serve as the chair of 2 charter revision commissions, in '99 and then in 2001.
Yes.
Today, I want to focus particularly on the 1999 Revision Commission
Yes.
in which Mayor Giuliani was concerned that in the event he won his campaign against Hillary Clinton for Senate, Public Advocate Mark Green would succeed him as mayor. It was well known that then Public Advocate Green was responsible for oversight of the mayor and had been critical. The chair of the most notable 1989 Charter Revision Commission and a former corporation counsel himself, Fritz Shorts, called the 1999 CRC overly politicized, profoundly undemocratic, while urging it to be disbanded because its composition was entirely political. You dismissed his criticisms at the time of a rushed process that seemed to mirror those of the current mayor's recent Charter Revision Commission, and that effort mirrored the same type of power grab and political retribution in trying to remove the public advocate from the mayoral line of succession. Question here is, do you think that attempting to amass executive power and take political retribution are appropriate ways to utilize a Charter Revision Commission, and do you stand by the actions that you held in that time?
I'll start with the second half of your question, which is that, in fact, that Charter Commission didn't do what the mayor wanted done. I stood up to the mayor. It should give you confidence as a council that I will stand up to authority when I disagree, because the mayor announced that he appointed that commission to try to change the line of mayoral succession during his term to deny Mark Green the opportunity to succeed him, and I refused to do that. I did not put that on the ballot, but I learned lessons from that Charter Revision Commission, and we built on that work when we reconvened in 2001. Anthony Crowell, the Dean of New York Law School, worked with me on both those commissions. We put the same individual propositions, but not changing the mayoral line of succession, on the ballot separately. Every one of them passed, including making the Mayor's Office of Immigrant Affairs a charter agency, banning guns and increasing penalties where they were possessed near schools, and making ACS, Mayor's Office to Combat Domestic Violence, so many other city agencies that hadn't been enshrined in our charter, making them permanent city agencies. So yes, I learned from that experience, and I built on it, and we achieved some quite extraordinary and positive things for the city as a result in 2001. And you asked me about charter commissions like the one that has been appointed. This is a matter of state law, and I know the council has its concerns. It's something that could be worked on as a matter of state law, but state law currently permits mayors to do charter commissions under these circumstances. That's something that really should be studied as a matter of state law and whether to amend state law. And if this council wanted to look into that question, I would help them with that type of legislation at the state level for the state legislature.
I'm just going to jump in because I want to move us along. I hear you on being proud of what you learned and how you took the lessons from that first commission, but the question is, right, maybe even divorce it from the experience. Do you think that attempting to amass executive power and take retribution are appropriate ways to utilize a Charter Revision Commission? Yes, no.
Well, that wasn't what happened there because I refused to do it.
Irrespective of what happened there,
I refused to do
today,
it.
do you believe that it is an appropriate use?
It's not what I would do. It's not what I did. It's not why I would call a charter commission. And I'm not saying that that's why any mayor called any charter commission, except Rudy Giuliani said publicly that he wanted to do that to Mark Green. I refused to do it. And today I have Mark Green's support.
Thank you, Mr. Mastro. I'm going to continue here on these lessons. So the chair of a Charter Revision Commission serves as the principal of that body and has predominant discretion in setting its agenda. At the outset of the 99 Revision Commission, you instructed the commission staff to make recommendations on specific charter issues. Among the recommendations that you instructed the staff to make were not only changes to the role of the public advocate, but also recommendations concerning the powers of the council. During the July 2022 public meeting of the 1999 Charter Revision Commission, the staff presented to the commission a number of preliminary proposals for changes to the charter that had been formulated pursuant to your instruction, and here's a summary. First, regarding the council's budget powers, your preliminary proposal sought to limit the council's plenary budget powers by putting a 4% cap on year-to-year increases in city funded spending. Of course, under this proposal, the mayor would have been able to waive this requirement by written determination. Another proposal would have raised the threshold requiring council approval for budget modifications to 5% or $100,000, whichever is greater, which was up from $50,000. In the area of land use, proposed changes would have eliminated the council review of special permits where the City Planning Commission approves an application by at least a 2/3 vote in a measure that purported to assure broad-based support, reasoning that cutting as much as 70 days, making the process shorter and more predictable for meritorious special permit applications was in the public interest. Additional proposed changes to the land use processes would have given the mayor the power to either veto council modifications to CPC-approved applications or limit council review only to portions of the applications approved by the CPC. And while these preliminary proposals did not make the commission's final cut, the proposed changes regarding council powers in the area of taxes did. The proposal that passed out of the commission required at least a 2/3 vote of the council to pass any local law or resolution imposing a new tax or increasing any existing tax on real property, and required a 4/5 vote to override a mayoral veto. Thankfully, when this recommendation was put to the voters of New York City by referendum in 1999, it was defeated. Questions. Why do you think this council should approve your nomination to be our attorney when historically you have been openly hostile to our powers and to our standing in city government? Second, given that voters overwhelmingly rejected these proposals, do you believe the effort was appropriate? Why did you believe the mayor should have more budgeting powers? Do you still believe the mayor should have more budget powers as Mayor Adams' recent commission has proposed to reduce budget transparency? And last, the good government group that you have touted, being on the board chair of Citizens Union, at the time strongly criticized your and Mayor Giuliani's inappropriate use of taxpayer dollars for the campaign to convince voters to support your proposals then. Do you believe that Citizens Union was wrong, or that you inappropriately used taxpayer dollars then?
Well, that's a lot to unpack. So let me start with the following, which is that, again, we learned from 99, and that was not put on the ballot. The proposition that you just described was not, put back on the ballot in 2001. But every other proposal was put on the ballot and passed overwhelmingly by the voters. It's also the case that the proposals you're describing were not an attack on the council or the council's powers. The changes in budget structure and the ability to pass tax increases, that was a restraint on both sides of the hall in terms of increasing taxes and in terms of increasing spending amounts. Right now, the mayor sets the amount of money available in a budget, and then that has to be negotiated and changed and agreed upon when the council adopts a budget. So that was not a measure that was hostile to the council. It was one that related to both sides of City Hall and their joint powers to do a budget and to pass a tax increase. And they didn't pass. And as I said, I learned from those things. And by the way, we went through a process to determine what proposals to put on the ballot. We modified that by 2001, and we put proposals, all of which passed overwhelmingly with the voters. But my personal views on these issues are not necessarily the ones that came out of a charter revision commission process. And at the end of the day, I represent the city, including the city council. You set the policy, I defend the policy. And if it's defensible, I have, argue professionally, responsibly, on a principled basis, zealously for the policy that you set. And that's what Corp Counsel does. Corp Counsel doesn't set the policy. Corp Counsel takes its guidance from both sides of City Hall on what policies both sides or each side of City Hall wants to implement, and then defends those policies in court.
Respectfully, Mr. Mastro, on the proposal to On the proposal regarding the council's budget powers, the mayor would have been able to waive the requirement. So that is not something that was equally affecting both
Just
sides.
like but
The hall at City Hall.
Councilwoman, the mayor sets the amount of revenue available to allocate and has to agree to change that. That wasn't changing the fundamental powers of either side of the whole, and that was not the intent of the proposals. But in any event, as I've said, learned from that experience. But it was not something that was intended to be a restraint on one side of the whole and not the other. It was intended to address some fundamental issues, and the voters rejected that, and I learned from that. Thank you.
Thank you, Mr. Mastro. So one more contour here. I've yet to mention the preliminary recommendations made on fiscal impact statements. It was recommended that the charter require fiscal impact statements to identify specific sources of funding in order to promote better informed and more accountable policymaking. The charter provides that mandates arising from local laws be binding only to the extent that funds are appropriated to it to implement that particular local law, and if no funds are allocated, then the execution of the local law would not be mandatory. This was billed as a truth in government measure, forcing the council to confront and resolve the hard choices represented by important or costly popular programs. The proposals even required that an FIS for a home rule message. Of course, this council is no stranger to recommendations to change FIS requirements in the charter. Just this summer, Mayor Adams impaneled the Charter Revision Commission, and one of the most problematic recommendations to come out of that commission involved fiscal impact statements. In fact, the preliminary recommendations from 2024's commission staff were uncannily similar to those made by your staff in 1999. Questions. Have you at any time advised or even discussed with the Adams administration your experience as chair to the Charter Revision Commissions in the past, or is it just coincidence that your recommendations reappeared?
I have not. I've had no involvement in the constitution of or effectuation of any proposals there. But each charter commission builds on the work of past charter commissions. You're talking about one of dozens and dozens of proposals on which we sought public comment. Very few of them reached the ballot. So a lot of good work was done. A lot of proposals you probably agree with, but you're only cherry picking.
The answer was no. Your answer was no. It's very clear.
All right. I just want to be clear that you probably would agree with a lot of the proposals that were on there.
Thank you, Mr. Mastro. This year, the council passed a bill that would require mayoral appointees for agency heads to go before the council for advice and consent. This was discussed a bit earlier. This measure is required to go before the voters in a referendum. Back in 1998, when you were still serving as the right hand to Mayor Giuliani, the council passed a local law that would have prevented the city from spending money on the development of a Yankee Stadium in Manhattan. Similarly, this measure was required to go before voters in a referendum. And in order to bump this referendum question from the ballot, the Giuliani administration, under your leadership, impaneled the 1998 Charter Revision Commission. Similarly, around the time that you were in discussions with the mayor for this nomination, the mayor, taking a play out of your playbook, also impaneled the Charter Revision Commission in order to bump your referendum question on advice and consent. Our referendum question on advice and consent. Have you at any time discussed with the mayor or members of his staff the Giuliani administration's use of charter revision commissions to bump referendum questions from the ballot?
Have not discussed the Giuliani administration's use of charter revision commissions, and the decision to create a charter revision commission was not the decision of the deputy mayor for operations. I had no involvement in that charter revision commission in 1998.
Thank you. Thank you. This council has deep concerns about the Adams Charter Commission proposals, which aim to consolidate legislative and fiscal powers within the office of the mayor. Separation of powers is a key component of a healthy democracy, and your history with similar charter proposals doesn't inspire confidence that you will protect those separations at the law department, is the line of questioning. And
Can I please respond to that? Can I please respond to that?
Can you let me finish, and then you can respond to whatever the chair allows you to?
Of course, council member.
Thank you, Mr. Mastro. So just in closing here, and to touch on, because my colleagues have asked, and you've had excellent exchanges with with them regarding some of your history on housing cases. In response to Chair Powers' earlier line of questioning this morning, very, very first line of questioning, I believe, regarding client motivations and congestion pricing and other lawsuits, you responded that you couldn't speak to the motivations of the governor in the New Jersey case. But you're too smart for that. You're too smart for that. Throughout your career, you have represented a roster of clients in litigation where the end goal was to void critical laws and policies and initiatives and that protect the public interests and the vulnerable. Said differently, you've been willing to allow your legal prowess as an attorney to be used to stymie the very causes that you are in some of the very same sentences claiming that you are a believer and champion of. Even if you were in private practice, a professional of your caliber has choice in the cases that you litigate, and especially so in more recent times. And the weapon that is the skill, that is your skill and your talent, how that is wielded, to me, has been problematic, saying that out loud here, and I'm sure many of my colleagues share. And so to me, the distinction that you've tried to draw between your actions in private practice and others is not truly a real one. Your actions against policies meant to protect the vulnerable speak to your boundaries and your character. And that applies to your exchange with Deputy Speaker Ayala on the Lucerne, your work on the eviction moratorium, something that hasn't been discussed today. You're defending LeFrak Realty against source of income victims, source of income discrimination victims of persons living with HIV and AIDS. And despite what you have claimed about defending the small landlord in the GMAX case regarding the HSTPA, in the very first paragraph of the SCOTUS, in the very first paragraph of your petition to SCOTUS in the GMAX case, you characterize the Housing Stability and Tenant Protection Act of 2019 as a permanent expropriation of vast swaths of private real estate. So this is my closing, and then you can have whatever time the chair allocates to you. Do you believe that rent regulation is essential to preserving housing affordability and preventing homelessness for low-income families? Are you committed to defending rent laws if we have to as a city against future challenges? And do you believe that the city and state can and should take emergency measures to prevent mass evictions during health and economic crises? Thank you, Chair, for the time.
I am committed to...
You are permitted to answer the question.
No, thank you very much. I appreciate it, because I wasn't sure there was a question. I am committed to those laws and supporting them. And the very paragraph that you cite and purport to quote says, this case is based on a substantially different record targeting only a specific set of amendments that I explained earlier are retroactive amendments applied to small landlords who couldn't even reoccupy a floor of their apartment building, who couldn't even, when they did the right thing and invested in tenant improvements, could no longer get any credit for that, even though they used to be able to get, over several years, a small amount of credit. So please understand when you ask this question, no one has ever questioned my character. In fact, I am a person who cares very much about my personal reputation. I am an effective advocate. I want to be your effective advocate and help you achieve your goals and your priorities. The fact that I have been successful in private practice, the fact that I have been successful in pro bono litigation for so many folks in civil rights cases, constitutional cases, social justice cases, these are skills that I can bring to bear for the city as a whole and this council. I want to be your champion. So the fact that I have had success, I want to have that success for you. That should be a positive. I appreciate your views. I hope you will understand when you look at the entirety of my record that there is so much good that we can do together to use the power of the law affirmatively to help the people of this city. And that's what why I'm offering my services now, and I thank you, Councilman.
Thank you, Mr. Mastro. We're gonna Speaker had a follow-up question, and then after that we'll go to Councilmember De La Rosa.
Thank you, Mr. Chair. Mr. Mastro, are you aware of the amendments put forth by the recent Charter Revision Commission?
Personally, I'm not. I haven't followed it closely.
You don't know any of the proposals that they have recommended be on the ballot in November?
I haven't followed it at all, other than as an issue I know between the council and the administration about the Charter Revision Commission affecting the legislative proposal to increase advise and consent that would have to go on the ballot. But I've not studied the proposals at all, I'm sorry.
Okay. As a commissioner of a former Charter Revision Commission some years ago, did you ever recommend any proposals that would actually expand the power of the council?
I don't recall whether any of the proposals expanded as opposed to modified, but they were not proposals, as I viewed them, intended to reduce the powers of one branch over another. They were intended to address mutual concerns about how to pass a budget and under what circumstances, and how to pass a tax increase and under what circumstances. So I didn't view them as affecting one side of the whole or the other. But I certainly didn't intend them to affect one side.
That was my other question. So then there would be no intention on your part then, back then, to make any such recommendation that the power of the council be expanded?
I did not understand myself to ever be doing that.
Thank you for your response. One more question. We disclosed today that you were or had advised the administration, the mayor, regarding the migrant crisis in 2023 pro bono.
Yes.
When did that cease?
I haven't.
It is still ongoing today. You are still advising the administration regarding the migrant crisis? Pro bono?
No, I don't think we've provided any advice since sometime in 2023. And again, the advice was limited, again, without waiving privilege. The advice was limited to questions of trying to see that asylum seekers got their asylum applications done in a timely fashion. Under federal law, it's supposed to happen in 180 days, but it doesn't. To see that they would get work permits, so they could start.
I understand the capacity.
Okay, right.
So this was before you were ever considered or thought to be a nominee for this particular.
Completely and detached in time.
If you were asked post that, would you take up tomorrow being advisement for the administration on any issue at this point?
I haven't been asked.
If.
Well, if you ask me to advise
I'm not
you,
going to
I'd be
ask
happy
you.
to.
I'm asking.
Your Honor, I'd be happy to advise you.
You were pro bono for the mayor. I'm asking if that were to happen again tomorrow, if that ask were to happen again tomorrow, would your response be the same in the affirmative?
My response to try to help asylum seekers get work permits? Yes, I would want to help them get work permits.
Okay.
I'd want to help them get legal status here. I think everybody in this room should want to see that.
I understand your response, so the answer would be yes then. Okay.
Thank you.
Thank you very much.
Thank you. We're now going to go to Councilmember De La Rosa, and we'll be followed by Councilmember Feliz.
Thank you. Good afternoon, Mr. Mastro.
Thank you.
I'm going to draw us into more recent history. In 2014, you appeared before the council to testify on behalf of Cablevision, and this is a follow-up to Public Advocate Williams' questions, digging in a little deeper. At the hearing on Cablevision's franchise agreement, with the city, and whether the company was respecting its workers' right to organize and collectively bargain, 2 regions of the National Labor Relations Board issued complaints against Cablevision for unfair practices. At the time, you asserted that the council had no role in oversight. The hearing was inappropriate use of council resources, and there had been no investigation into the charges. In fact, you specifically said you did your job already when you passed the authorizing resolution. You have no right in the administration of the franchise. However, you still appeared at the hearing on behalf of Cablevision. My first question to you is, why did you assert that there had been no investigation about Cablevision's unfair labor practice charges that the NLRB issued?
I don't think, again, you're asking me to go back 10 years ago. I don't think that accurately describes the state of play. I was not Cablevision's lawyer in connection with anything at the NLRB. There were subsequent issues resolved by the NLRB, and I knew that there were, issues percolating, but that was not what I was handling. And the point I was making was a simple, narrow one, which was that was a private labor dispute between a private company and a labor union. There had been It was surrounded by allegations that the labor union had, according to Department of Investigation report, improper communications with certain city officials. I was simply asserting for Cablevision that why were we having a hearing like that when it was a private labor dispute, but I was not involved at all in the NLRB proceedings or what happened after that. That's the place for that to be resolved.
I understand.
And I certainly intended no disrespect to the council. I was representing a client in private practice who had a principled position that it was a private labor dispute, so why were we having a hearing? That was all I was doing there.
I understand your role, and I
as the
had the
public advocate, and I
fortune
know.
or misfortune of watching that hearing twice this week in preparation for this hearing.
Okay.
And you did indeed assert that there were indeed no complaints issued against Cablevision, when we both know that in order for the NLRB to issue a complaint, there has to be an investigation that leads to that complaint. And you did indeed say that. But my next question is...
I don't think I misspoke, but go ahead. I was simply there to assert that this was a private labor dispute and it will be worked out at the NLRB.
Did you believe that there were no labor violations happening?
I did not assert one way or the other the ultimate outcome of whatever was going on with the NLRB. I asserted that the council holding a hearing on it,
I understand what you're
having hundreds of protesters from the CWA seemed like something that certainly Cablevision was concerned about why a private labor dispute would have generated that. But
Yeah,
this
Mr.
is
Mastro,
10 years
understand
ago,
what-
and I was appearing on behalf of a client,
I
and I
understand.
stated the client's position, and that was
I
the end
understand
of
what
it.
you asserted, Mr.
That was the end
Mastro.
of it.
I'm asking you if you believed, not if you asserted at the time, because trust me, I saw the hearing and I read the transcript. I know what you asserted. I'm asking, did you believe that there were no labor violations happening at the time?
I can only speak to, what I knew.
Yes or no would suffice.
What I knew personally, and I had no actual involvement in the underlying representation on the labor dispute.
Yes or no?
So I did not come to that hearing with a position on that issue.
Why do you believe that holding a decertification vote with a pending NLRB complaint of unfair labor practices is not union busting?
I didn't.
Do you believe that it's union busting?
I don't. There hadn't been a certification. And the NLRB was going to sort out what the legal rights of the parties were. That's why I was appearing for the very limited purpose of saying that why is the council holding a hearing on this when this is before the NLRB? And the NLRB will decide who's right and sort it out, and then it will get resolved. That's the only thing I did. And that's the only thing I said.
Could you explain the position you asserted when you argued that the council does not have a role when it comes to franchise agreements after it passed an authorizing resolution? Do you believe that to be true regardless of whether or not the franchisee is in compliance with the agreement?
I don't believe that it is typical. In my experience, it wasn't typical for the council to hold hearings on a labor dispute between a private employer and a labor union that was before the NLRB and would be sorted out there. Obviously, the council has some role in oversight of franchises and franchise policy, but it was unusual in my experience, and maybe the world has changed in more recent years, but it was unusual in my experience that the council would hold a hearing about a private labor dispute between a private employer and a labor union that was being handled at the NLRB.
As Corporation Counsel, would you maintain the same anti-labor views or a position that the City Council has no oversight role should a similar labor issue arise?
I don't have anti-labor views. I'm endorsed by the UFT, the AFT, the
We know the
UFA,
endorsement list. We have it.
Many unions have endorsed me, and I had great working relationships with the unions, including DC 37 when I was deputy mayor. So I am pro-union. I've always been pro-union. And in fact, I did groundbreaking litigation to make sure that members had direct rank and file voting over top union offices, setting precedents at federal law.
As Corporation Counsel, would you maintain that the council has no oversight role in similar labor issues today?
There's not one size fits all. And I'm there simply to advise and represent the council. So if you decide to have a hearing, and I think you have a principled position for doing it, I'm going to defend your position. In that instance, I'm representing a private client in a private labor dispute that's before the NLRB, so I question on behalf of a private client whether there should have been a hearing. But there's no one size fits all, and when I'm corp counsel, I'm representing you. You're my client. Cablevision was my client there. You're my client. And if you have a principled position, of course, I'm going to defend you to the hilt.
While I understand that and while I appreciate your passion for defending your clients, you are one person, you are not two people. You have choice in the matter of who you choose to defend and how you come before a body to defend that client. And at that time, you came before this body, and frankly, you dismissed the council's role as an independent checks and balance, as someone, as a body who did have a role in that process, you completely dismissed the council's role in oversight. I'm going to move on.
Okay, but council member, there seems to be some disconnect about the role of the lawyer in private practice. And maybe when we finally get to the dozens of people who came here to share their testimony with you, many of whom have left.
So then let's not hold them up. Let's not hold them up.
They will explain to you that you take your client's problems as you find them, and you zealously and ethically advocate for them as long as you have a principled basis for what you're advocating. That doesn't mean that they're your core values, or you can't represent another client, or that as corporation counsel, where your client is this body, you wouldn't just as zealously and ethically represent the principled positions of this body. I will do that, and I have a proven track record of doing it.
Well, thank you for describing that. We're gonna move on. I'm gonna talk to you about the use of technology. Recently, it seems Mayor Adams has relied on technology like drones and in high-stakes situations, including sending drones equipped with loudspeakers to nearly a dozen flood-prone neighborhoods to warn residents of possible flooding earlier this month. The talking drones that city officials deployed were supposed to warn residents about the night's storms in 2 languages. But a video of the drone on Staten Island showed the tech speaking an indecipherable language, and that was apparently intended to be Spanish. The Emergency Management Commissioner acknowledged the error, but said he was very proud of the work their team had done preparing for the storm. Do you believe that the use of drones with unvetted messaging in the place of in-language, culturally competent outreach led by city workers is an appropriate approach in an emergency?
I'm not familiar with the issue or the use you're talking about, and whether the factual premises of the question are in fact what's happening. I'm just not familiar with the issue, but I would study it, and the way you have described it, there would be questions that would need to be reviewed. But the fact of the matter is that I can't responsibly answer your question unless I know the actual facts and study the legal issues involved, and then I will call it as I see it. And if I think something wrong is going on, I'm going to tell the administration that. But you can't ask me as I sit here now when I don't know the facts, I haven't studied the issue, to have a firm position on the issue. I will responsibly and immediately review issues like this if I'm fortunate enough to have this job.
So let's move on to an issue that you do have some knowledge about. The drones are one recent example of surveillance technology in New York City. You represented Madison Square Garden in a lawsuit filed against the company over barring over 60 lawyers from David F. Hutcher and Cintrone LLP from entering the James Dolan's entertainment venue. Facial recognition technology was used to single out and ban the firm's attorneys who represented clients with pending litigation against MSG. During your last tenure in city government, there was an immense expansion of law enforcement power and a corresponding lack of accountability that severely harmed many New Yorkers, with a disproportionate impact on Black and Latino New Yorkers, as many of my colleagues have already outlined. Given that past record in city government and your pivotal legal work defending the controversial use of facial recognition technology, Why should we believe that you will safeguard New Yorkers' rights against the abusive use of this and similar technologies like facial recognition?
Because the people of New York City and city government as a whole would be my clients, and I would be advocating for their rights and their protections. And by the way, in the Madison Square Garden case, again, the issue there was not, in that case, about facial recognition. It was about whether a private property owner had the right to make decisions about who could use the premises or not. And Larry Hutcher is a fierce adversary who I respect, the Davidoff Hutcher firm, I respect. Larry Hutcher would tell you he respects me, because that's what good lawyers in private practice do. They do their cases zealously, and the outcome falls where it does. And in that case, I won the case, and Larry Hutcher ultimately acknowledged that our legal position was right.
So with the change of technology, we're learning that the use of facial recognition by law enforcement has found that it contributes to racial disparities in law enforcement outcomes and lacks the ability to equally distinguish darker faces. Given this and other concerns about protecting children from certain harmful technology, what place do you believe there is for the use of facial recognition in school facilities, if any?
I don't know how it's being used, or I'm not steeped in the issue. I haven't been in government for 25 years, but it's certainly an issue that I think warrants some examination. Again, in the MSG case, that was not the issue in the case. It wasn't a facial recognition case. There was a separate case about the facial recognition technology used there, and that case was thrown out of court, and Madison Square Garden won.
So thank you for answering the questions. I will express concerns as well as my colleagues have today, not only with our most recent history before the council and your ability to actually defend the council should it come to that, but also the fact that you seem to have distance between who your clients are and what is morally correct and what is your moral values. In this hearing, it has not been clear to me where you stand on certain issues.
My moral values have
That wasn't
existed.
a question. That was
Do
a
I get to
statement.
respond?
Mr. Mastro, I'll give you 30
When I finish.
Councilor, okay. I'm going to give him 30 seconds to respond, and we're going to go to Councilor
I
Feliz.
didn't ask a question. I was giving my closing statement.
Okay.
Okay, I appreciate your closing statement, and my moral values have never been questioned. My moral values are reflected in 40 years of pro bono and community service and in causes that I've championed for civil rights, racial justice, social justice, public safety, human rights. That's why so many people came here to support me, but unfortunately the crowd has thinned. At
Mr. Mastro, we're going to move on. We know there's a lot of public crowd. We're going to forego the second round of questions so we can give the people opportunity
Second
to
round
do
of
that.
questions.
The second round of questions are on. It's a long hearing. I think we all anticipated that. We appreciate everyone's patience for being here. There's folks from both sides who are sitting here waiting. So we are going to move on. We'll now go to Councilmember Feliz and followed by Councilmember Joseph, who I think is returning.
Thank you so much, Chair Powers, Speaker Adams, and all of my colleagues who have joined today. Mr. Mastro, good to see you today. Thank you for being here. As the public has learned during the course of today's hearing, you have a long and well-documented history and record representing large corporations with unsavory business practices, corporations with questionable reputations. You have a history of choosing—
I wouldn't agree with that, but please go ahead.
If I could just finish my statement, and then we'll get into the facts.
Sure.
You have a history of choosing to represent the powerful against the powerless. For instance, defending the real estate interests who sought to weaken our rent laws. I want to talk about another big corporation that you defended. You represented the Portfolio Recovery Associates, the PRA company, one of the largest debt collection agencies in the nation. You defended this corporation in a class action lawsuit with serious allegations which were then proven. A lawsuit which alleged that in connection with the debt collection efforts, the company and its debt collector law firm, Mallon Associates, submitted false or defective affidavits to state and local courts in order to fraudulently obtain default judgments against consumers for phantom debts that couldn't be legally recovered for many reasons. Just last year, the Consumer Financial Protection Bureau ordered that the PRA, your repeat offender client, to pay more than $24 million for having violated a 2015 consent order. This was after the company had already been ordered to pay more than $27 million in consumer refunds and penalties for its debt collection tactics. In the 2015 case, the CFPB, the Consumer Financial Protection Bureau, found that the company, the client that you defended, collected on unproven and inaccurate debts. They filed misleading affidavits in debt collection actions. They misrepresented that they intended to prove debts if customers contest them. They even misrepresented that the company had legally enforceable actions to debts that were clearly outside of the applicable statutes of limitations, basically telling consumers that you had claims to debts you knew you couldn't collect. I want to reiterate, these weren't just allegations, these were findings proven by a federal independent agency. After getting caught red-handed, the company you defended continued violating the law through intimidation, deception, and illegal debt collection tactics and lawsuits. Debt collection particularly affects vulnerable, disadvantaged communities. It affects low-income families that are struggling, draining resources from families who need them the most. So a few questions about this. You, as a lawyer, had countless options in terms of clients that you could have represented. You're obviously talented, there's no question about that. Why use your talent and your skills to defend powerful interests like the ones in this case, going after vulnerable people?
Council member, everything you have described about PRA happened after I represented PRA. Clients come to you in private practice with their worst problems. That doesn't mean that everything they did is what you would do, but you help them try to resolve their problems. And in that case, I'm sure you must realize after that recitation that we settled the cases that I represented. PRA paid money for what it did. We responsibly and ethically represented PRA, and I haven't represented PRA in years. And the fact of the matter is, if we're going to scrutinize private practice lawyers at major law firms applying those standards, that any client they've ever touched, you're going to attribute that former client's conduct forever to them, and that their clients have to have always been on the right side, and you can't represent them, even if you represent them ethically and responsibly, to settle matters and get, results that are fair to both sides because they result in a settlement. You're going to eliminate lawyers in private practice at major law firms ever being able to qualify for corp counsel again. And I stand on the shoulders of giants, if I'm fortunate enough to have this job, of individuals who have been some of the greatest lawyers in private practice in city history. And I'm glad they served, and I'm willing to serve.
I think the facts of that case show that this is not a case about lawyers hoping to resolve issues that their clients are facing.
I didn't represent them in the cases you cited.
The facts of that case show that this is a case about big corporations using high-powered lawyers to not only evade the truth, but also evade accountability. I think those are the facts of that case.
They didn't evade accountability. They paid lots of money.
Yeah,
and they agreed to structural reforms.
They entered into consent order,
on my watch.
They violated it, and then they were forced to pay an additional $20 million, $27 million. So
I didn't represent them then. Go ahead.
Yeah, but you represented them after they took those actions, and you defended them, right?
I represented them in connection with one set of lawsuits that were resolved with financial and remedial action. And I think there was a responsible resolution that all parties agreed to. I didn't represent them before. I didn't represent them after.
Okay, so just curious, what are factors that you consider when deciding who to represent? Obviously, you have many clients that want to use you as their lawyer. You're, again, very talented. What are factors that you consider when determining who you're going to represent? Any general principles that you follow?
First of all, when you are a partner in a law firm, you have fiduciary obligations to your law firm and your partners and your firm's clients. So when your firm's clients have issues, when you are introduced by other partners, in that case, it was introduced by another partner. You work with your partners and have fiduciary obligations to work for firm clients in a responsible and ethical way. In private practice, I think that it is fair to say that if I thought a client did something wrong and their position was indefensible, I would not represent them, even if presented by another partner. And I have turned down clients who I thought had an indefensible position. But it is also the case that sometimes—
So what are general principles that you follow?
Please let me finish, because you asked me the question, I want to give you a complete answer.
Right, but I'm just repeating the question because I think you're going on a different
sometimes
answer.
individuals do something wrong, and the representation is to try and help them find a path fairly, honestly, ethically, acknowledging that they've done something wrong, and you find a path. So that's how you see many cases settled. That's how you see in the area of criminal defense many cases resolved. The client's positions, the client's values are not your values. So to make moral judgments of me because I'm in a business to serve based on private clients of a private law firm where I have ethical obligations to the law, fiduciary obligations to the law firm to serve the firm and its clients and my partners, is to ignore that my values are reflected in what's my time, my pro bono, my community service, my public service for over a decade. So that's really fair ground. But what I did in private practice for clients and got successful results, I think that actually, and resolved issues with settlements, like the PRA case, I think that shows I'm a responsible lawyer, and I think it shows that I can be a responsible lawyer for you as your counsel.
What do you mean, though, by legally indefensible? Are you talking about a topic that you don't want to be associated with, or are you talking about a case where, the facts are not and the law are not on your side? What do you mean by legally indefensible?
I think if the client doesn't have a legal position, we have ethical obligations to only go to court and take positions in good faith. And if I don't believe I can take a position in good faith, I wouldn't represent the client. I wouldn't make that argument. And to be clear, right, if I thought the mayor took a position that wasn't defensible or in good faith, if I thought the council took such a position, I would tell you, and I would not go to court for anyone and never have. My integrity has never been questioned. I've never had a bar issue or a court issue, sanction, whatever, because I don't go to court on issues that aren't legally defensible. And I won't let you be in that position. I won't let anyone in city government be in that position.
Okay.
I give it straight.
All right. Yeah, I think
straight.
So why, if you are so committed to public service, did you not leave the mayor's office to become a civil rights lawyer?
Thank you for asking that, because I think back on my career. I loved public service. I was a new father. I got married. I had a kid. Okay, so don't question my commitment to public service or the public interest. I had to support my wife and my kid, and I was broke because I had been almost my entire career in public service up till that point in time. So please understand, if I could have done it, I would have stayed, and I want to come back now to do my first love.
If you're representing big corporations that are going after vulnerable people and communities, I think we have a lot of legitimate questions
Did not
about
go after
issues
vulnerable.
related to
Let the councilman finish his question, and then you'll have an opportunity to respond.
Another question. Given your track record of representing predatory companies, including the PRA, a classic example of a predatory company, why should we believe that you're now motivated to serve the public?
Okay. Again, there seems to be a fundamental disconnect that
there's a lot of questions about your commitment to public service.
Please, that so
and
many of the lawyers in this room who've been waiting 8 hours.
Yeah, I'm one of them, by the way. I'm one of the lawyers that has been waiting to ask these questions.
What lawyers do in private practice, we're in a service business where we serve our firm's clients. They come to us with their problems, and we try to responsibly, ethically represent them to address those problems. With PRA, I could not have acted more responsibly, reaching a settlement that worked for all sides, including AGs, financial settlement and remedial reforms. That's actually in the public interest. But the fact of the matter is, in private practice, you take your client's problems as you find them, and you serve ethically and responsibly, and if there is no defense, you do not, and you can't make a good faith defense,
So I just
don't represent them.
Yeah, so I just want to stick to the issues in the PRA case, because I think those allegations were serious. If a client,
I didn't say they weren't serious.
Let him finish the
Okay,
question.
I'm sorry,
if a
Mr. Chair,
client-
but I didn't say they weren't serious.
if a client with similar problems, as the PRA asked you to represent them today, would you represent them?
In private practice, we take our clients' problems as we find them, and if we think there's a path forward, a principled path forward, being a partner at a law firm, you represent the firm's clients. I have turned down many clients over the years. In that particular situation, I think we did something responsible that provided relief, financial and remedial relief. So we reached a settlement that all parties agreed to. That's not a bad thing. That's a good thing. And good lawyers in private practice help do that to get to good results, even if their client has done something that ultimately requires them to make financial restitution.
So I just want to go over some of the facts that were eventually proven in court on the PRA case. I just want to reiterate
It
or
didn't go,
restate
my
some of them.
case didn't go to court, so I'm not sure what case
if I
you're
could
referring
just
to.
finish, reclaim my time.
Okay, but I
So the
didn't do
PRA
that
Mr. Mastro,
case.
let him answer the question. You can respond and
I
state the facts of the case as you
I didn't
see
do
it.
that case, but go ahead.
In 2015, the CFPB, an independent federal agency, found that the company collected on unproven and inaccurate debts. They filed misleading affidavits in debt collection actions. They misrepresented that they intended to prove debts if consumers contested them. They misrepresented that the company had legally enforceable claims to debts outside of the applicable statutes of limitations. Again, telling consumers that you had claims to debts that you knew you couldn't recover. That, to me, personally, that sounds like a scam. So, but basically you're saying that you have no regrets taking on that PRA case.
I didn't do that case, so I don't know why you're raising it. That was not my case with the CFPB.
So you never defended the PRA?
I did defend PRA.
So what exactly did you defend them on?
They had claims and issues with certain AGs and private plaintiff class.
The ones that I just mentioned, right?
You mentioned some of them, and the cases that I was responsible for, which is a finite, my firm was responsible for, was a finite subset of what you've described, finite, and we resolved them. They were settled. They were settled. We didn't represent them on all litigation issues across the board. We did not.
Okay.
But I appreciate your questions, and I'm trying to give you the best answer I can, which is that we settled those cases.
But can we agree that after they did everything that I just described, you defended them in their lawsuit, right?
We didn't actually end up, litigating.
Cases are generally settled. Generally, there's a stipulation where the two parties agree on something. But after they engaged in those abusive practices, you defended them in that case, right?
No, that's not what I would
So what
say.
exactly did you do with it?
That's not what I would say.
What exactly
I would
did
say
you?
there were certain allegations made, certain class action allegations and AG involvement, and we settled those cases. They never went to trial.
But you defended them in the court. They didn't go to trial. Eventually, the case was.
His question is, did you represent them?
I think where you're
I already
saying
said that I represented them on some small subset of what you're talking about, and we resolved the cases. And they resolved in a settlement. They never went to trial.
All right, I think we're playing word games. At the end of the
I'm
day,
not
you
playing word games.
were the lawyer on the case, defending them when they were.
Mr. Mastro, I think
by
the question is
CFPB.
straightforward. I think his question is whether you represented that client in those matters, whether you settled or went to court. I think it's a little bit of semantics. I think you understand the
It's
general.
not semantics. I represented, Gibson Dunn represented that client on some matters, not all the ones you're talking about. Okay? You're talking about every case they had. before and after me, I was involved in particular matters that got settled. So that's the answer.
And I'm actually describing the terms of that settlement, the case that you represented them on.
Okay.
So for those that are watching, that case is easily obtainable. You just got to Google it.
It absolutely is. It's a matter of
easily
public record, and we
obtainable
settled.
on Google.
We
so
settled.
You could learn the details of the consent order.
We definitely settled.
That the
No
PRA
question.
violated. So let's change the topic a little bit. The Giuliani administration, including during your tenure, was well known for using government as an instrument for political revenge against those who spoke out against it, as some of my colleagues mentioned earlier today. According to a New York Times article of 2008, a former longtime attorney in the Corporation Counsel's office, Joel Berger, who left the Giuliani administration to privately represent victims of police brutality, also taught at NYU Law. He led a legal apprenticeship for his students with the Office of Corporation Counsel. After he publicly criticized the Giuliani administration's record on police brutality, a city official called the NYU Law School to threaten ending the legal apprenticeship until that professor was removed. Were you aware of that incident?
I have no recollection of that. I have no recollection of that.
So you played no role in that incident as deputy mayor of operations?
I have no recollection of that.
No recollection. Okay, cool. So that concludes my questions. To close, the question everyone in this room is thinking about is, who is the best person to serve as the top lawyer of the city of New York? And what are factors that we should think about when determining who is that best lawyer who should serve as the next corporation counsel? Mr. Mastro, I don't think anybody could correctly dispute that you're a talented lawyer. I don't think anybody in this room disputes that. But there's a lot of questions related to your values, legitimate questions due to the types of clients that you've represented and defended. There's a lot of talented lawyers in our city, and talent is something that should carry a lot of weight in terms of who becomes the next corporation counsel, but that is not the only factor. It's also important that the next corporation counsel shares similar values, someone who has a history, someone who's used their talent and their power to fight for the best interests of everyday New Yorkers. So I'll leave it at that. Thank you so much.
Thank you, Councilmember Feliz. We're going to go to Councilmember Joseph, followed by Areola and Palladino.
Thank you. I have a couple of questions on education. Earlier you spoke about the policies you made around education. Have you ever taught? Were you ever an educator in any capacity?
I have taught law school at Fordham Law School and at Penn Law School, and I'm on the
specifically on
board of
bilingual education.
And I'm on the board of advisors of the Penn Law School. And as deputy mayor, I oversaw the budget and interacted with the Board of Education and the chancellor on a regular basis. And if they ever get a chance to testify, you will hear from people, and you've already heard from Billy Thompson, who was president of the Board of Education. You would have heard from the former general counsel of the Board of Education, who served under multiple chancellors, how constructive I was in working with the Board of Education and the chancellor in support of the school system. So yes, I spent a lot of time as deputy mayor on issues relating to the public school system.
You were under Harold Levy, none with educators. Remember, he had to get a waiver from the state to become the chancellor because he had no education background.
Actually, that's not true.
Yeah, he did. We can reference it in the article.
I'm not.
I was a teacher at the time in 2000 when he became the chancellor. I was a brand new teacher in New York City public schools.
Council member, I respect that. I worked with Rudy Crew. I worked with Harold Levy.
Harold Levy was not an educator.
I didn't say he was an educator.
Well, that's what I was referencing. He was not an educator.
I said it wasn't true that I only worked with Harold Levy. I worked with Rudy Crew.
So let's move on. So during your time, you served on the task force on bilingual education, correct?
Yes.
You were emphasizing on intense English instruction for students who are not fluent in English, right? How do you think your work on the task force shaped the perspective on education today?
Well, unfortunately, it didn't shape the perspective on education today because a proposal the New York Times called historic and loud.
And what was that proposal?
Did not happen.
Can you please share that proposal with us?
Yes, I think I did earlier, and I'm happy to share it again.
We would love to hear it again.
Which was with the support of the chancellor, we were going to create parental choice, where parents would choose whether they wanted their children to have English immersion or continue in traditional bilingual education. So there would be.
But that exists already.
choice.
When you do the home language survey and when you enter the school system, that option is given to you as you register your child.
It didn't exist then.
So nice, the home language, you're sure? The home language survey, the Hills form.
There was, council member.
Remember, this was a class action lawsuit. That's exactly how we wind up having bilingual education.
Council member.
Yes, sir.
We did not have widespread availability and parental choice back in 2000, and that was the proposal.
PS 189, who's a bilingual education school, has been around for 50 years doing exactly the work that you wanted to do. Exactly for 50 years.
I wanted to do it for the entire city and give all parents that choice.
PS 189 has been doing that work for 50 years.
That's one PS.
One PS, then the model is across the city. And at the time, historically,
Do
you
like
also
that
had a
model?
shortage.
You like that model?
The model is an excellent model, still stands today.
Good,
Matter of fact,
good.
with our influx of migrants, they went to that school to copy that exact model across the city.
That's fantastic, because that's what I urged the mayor and the chancellor
So it's being
to do
done.
back in 2000 citywide, and unfortunately they couldn't get it together to provide.
We
the
had a
funding.
shortage of 8,000 teachers at the time, if you
couldn't get
remember.
it would've-
A salary for an educator at the time was $31,000. And we couldn't recruit education, remember? And they had to change the licensing formula.
Council member, I respect you. I don't know why, if you're saying you think that proposal was a good one and there are examples of it in the system, why?
It already existed.
Why we're having a debate? It was.
No,
what
we're not
the-
having a debate. I
Wait,
just
wait,
wanted to clarify some of the stuff that it already existed. We were trying here to reinvent the wheel.
It didn't exist citywide. It did not exist citywide, and it would have taken hiring more teachers, and it
But
would
you
have
had a
empowered
shortage.
parents.
We had a shortage in 2000 of 8,000 teachers, and if you recall, they had to change the licensing, which allowed more teachers to come and teach because there was a shortage. And historically, we still have a shortage in bilingual education, ESL teachers. Prior to becoming council member, that's what I was, an ESL teacher. And I taught up until the very last day because there was no one to take my position.
I appreciate you. I appreciate your service. I respect you. I wanted to bring that program citywide. It's what came out of it.
I'm just a little
Wait,
curious
we
as to
weren't
why
able to do it.
non-educators was leading that fight into bringing bilingual education. So my question to you again today is, how do you think your work on the task force would shape the perspective on education policy in New York today? Not back then, but today, because you are going to be the corporate counsel, and these things will come before you.
I don't think anyone has a monopoly on good ideas. And I think that that was a good idea that was lauded at the time by the New York Times and others, and universally hailed. And I am saddened that the mayor and the chancellor didn't get their act together to do that. And I have since served on the CUNY board. I've served on the Literacy Design Collaborative, YMCA Board of Greater New York, Children's Museum Manhattan, Jewish Children's Museum, Hale House. I have devoted a lot of time and energy, pro bono, community service to education and educational institutions. So how do I think that shaped where we are today? Unfortunately, it didn't get adopted. So I wish it had. I think you're saying it's a good idea. And where it exists, it has some profoundly positive effects. I wish it had
Actually,
been a
Mayor
citywide.
Bloomberg referenced 189, front page of the New York Times, as the greatest model in the city, and that's where he would go to look at bilingual programs. So
Well, we're
again,
agreeing, except I would have brought it citywide.
but you didn't. But like I said,
I didn't have a check.
It's always
to write the 20 million.
non-educators that are leading education fights. So given your involvement in this task force, we're going to focus back on the bilingual education. You wanted to do bilingual education reform. How do you think the principles of fairness, equity should apply in current education policies, especially in a diverse city like New York City, where we speak over more than 160 languages with a new influx of new New Yorkers in our schools?
They absolutely have to apply, and that's why it's more important than ever that we have a commitment to bilingual education. and creative approaches to make sure that our kids get educated and have the best opportunity to succeed in life. That's what that commission was about, because too many kids were ending up in special ed and giving
And how
parental
are they ending?
choice.
How are they ending up there? Because they don't just get there. You have to write a letter. SBSC team. They have to be screened. How do we get there? How do we get them into special education?
The outcomes in bilingual education programs were resulting in too many children being diverted into special education.
Because it was a cultural thing, and there was no one there to be cultural. And we had students that were also SIFE, right? We have a lot of students that enter the system that is with interrupted formal education.
I agree with you.
And we were screening them as special education, but you said they ended up there.
I wasn't
How did they
screening
end up
anybody.
there?
I wasn't screening anybody.
Well, that's how they
But-
get screened. It's not an overnight process to get into special education.
No, but
correct?
we're in violent agreement that that was happening too often, and I was simply suggesting that more choice for parents might actually improve outcomes.
But we have
That's all.
choices. We have standalone, we have push-in, we have immersion, we have bilingual programs. So there's different varieties. Because when you take the hills, you have to sit, and the family has to sit and watch a video and decide which type of setting they want for their children, whether it's a push-in, pull-out, immersion, bilingual, or standalone.
Okay, I hear you. I haven't been involved in this for 25 years.
I've been involved for 22 years before I became a council member.
I think that's fantastic. And I applaud your service, and it's the highest calling. My father was a teacher too.
Well, thank you. So how would your, looking back, do you know how language is acquired? Language acquisition for English language learners.
Again, you've already pointed out.
So that's why I'm calling out the method that you guys were using back in the task force was not the right method.
Okay.
Okay, thank
Well,
you.
I won't, as Corp Counsel, I'll not be responsible for establishing the policy.
You
I'll
were
be responsible
you
for
were on it,
defending
and
the
you
policy.
said you had resolutions, you had solutions as to how our children can get, how we should be looking at bilingual education. It has to come with a holistic approach, not just like, let's move our children. There's a process, right?
I appreciate what you're saying, and the work of that task force was more complex than the bottom line of parental choice, and it was working with the Board of Education on sophisticated models like you're talking about. I just gave the overall bottom line, and it was in fact applauded at the time and called historic on a lead story in the New York Times.
And it was also a lawsuit. Okay, the Task Force on Bilingual
my
Education
proposals were not a lawsuit.
It was a lawsuit as to why the bilingual education was
Not-
created.
not-
The
not
Task Force
me.
on Bilingual Education aimed to ensure student transition to English fluency. Looking back, do you believe that the approach taken was the best for students for long-term success? And how would you apply those lessons learned to your role as corporate counsel?
Well, I obviously,
Like I always tell everyone who comes before me, you have homework to do.
I don't doubt, council member, that I have lots of homework to do. I'm a very good student, and I'm a fast learner, and I could learn a lot from you. So if I had the opportunity to work with you, I'm sure I would learn from you. And you know something else? I'd learn what your priorities are and how we could achieve them using affirmative litigation. That would be so exciting. And it's not being done now, because the law department isn't doing that. So I could learn a lot from you, and I could do a lot with the law and the resources of the law to help improve student outcomes. Learning from you and each council member in their districts, that's what I want to do in this job if afforded this opportunity.
And how would you address, as the corporate counsel, address legal challenges that might arise from policies intended to support English language learners in public schools?
Well, we have to support them and improve outcomes. They're our future. So to the extent that involves legal issues, I'd look forward to working together with you and others steeped in these issues on ways we could use the law to help achieve more positive outcomes for our children.
And earlier, Councilmember Brewer talked about Carter cases. How are you How are we going to resolve Carter and Connor cases?
Again, there's got to be a better way. The council member raised what has been an issue for 40 years. There's got to be a better way of approaching these issues more systemically as a matter of policy. I think the law department can support on what is legal and what is legal within existing law and consent decrees and the like. But ultimately, it's a policy question about how we provide better systems and outcomes, and I think there's just been a tendency to let it roll over year after year.
Do you currently know our bill for Carter cases right now? It's at $2.2 billion.
It's not right. It's not right. So I commit that that would be a priority to try to work with the council and the administration to find better ways to address the needs and the issues that also should achieve efficiencies.
Thank you, Chair.
Thank you very much, Council.
Thank you, Councilmember. We have three more council members. We have Councilmember Ariola, and followed by Palladino, and followed by Aviles.
Thank you, Chair. First, I want to thank you for your patience in answering all the questions. It's been a long time.
Thank you.
And you've taken it with grace. Thank you.
Appreciate it.
So you're known as a tenacious litigator, a fearless advocate for the city in your capacity as deputy mayor and chief of staff, and a staunch advocate for the disadvantaged. You've been a civil rights activist. You've combated for people to get their constitutional rights, and you fought for racial justice. And for that, I want to thank you.
Thank you.
So I'm interested in what you would do with the current law department and how they have been deciding on cases to litigate, appeal, and deny. In October of 2021, the de Blasio administration instituted a vaccine mandate for all New York City municipal workers, a mandate that has now been deemed arbitrary and capricious by judges across the city, state, and country. The workers affected had worked selflessly and tirelessly all through 2020 in the height of the pandemic. Firefighters, EMS workers, nurses, doctors with little to no PPE saved lives of thousands of New Yorkers. Police officers who worked triple shifts, teachers who had to figure out a way to educate through a computer screen. At no point did our sanitation workers fear coming to work and that our garbage was picked up. But in October of 2021, all of the applause became silent, and that silence was deafening. The same city workers who faced the dangers of the COVID ahead of them with no protection had been tossed to the side if they would not agree to take a vaccine for valid reasons. Religious beliefs were not being valued, and the opinion of medical doctors who knew their patients and their bodies were being questioned. Thousands of city workers were terminated for not complying with the COVID-19 vaccine, and a slew of lawsuits were rightfully brought against the city because of it. Almost 3 years later, many of those lawsuits have been won, and the city has appealed and kept city workers that judges have ordered back to work and given back pay away from the jobs that they love. Eventually, the city is losing those appeals and spending hundreds of thousands of taxpayer dollars on what they know is going to lose. And you spoke about you would take cases that you knew were prosecutorial, and that could be won. These cases are guaranteed losses, but yet they're all still appealed. We now have homeless firefighters, teachers who cannot get a job even outside of the city because of problem codes that have been placed on their records for not complying with the mandate. There were also the workers who didn't have enough money to have representation in court or go on in Article 78. On October 24th, 2022, Judge Ralph Porzo ruled on Garvey v. City of New York that the COVID vaccine mandates for public employees that private employees is arbitrary and capricious. The city that appealed that ruling, and 16 sanitation workers have still not been allowed to return to work because of this stay. In the meantime, the Article 78 were being won by other city employees, and they were being reinstated. So you see, there is a discrepancy in how it's being held. In the Article 78 cases, for instance, Rivici versus the City of New York and Bonomi versus the City of New York, municipal workers were ordered back to work with back pay. Other city workers who were similarly situated and won their cases and they were waiting for a ruling are not allowed back to work. Some municipal workers are requesting reinstatement by being asked to sign a waiver that other employees have just been reinstated and they are similarly situated and they do not have to sign a waiver. So I'll begin my questioning with, will you drop these appeals in all of these mandated cases that have been won and allow these workers to return to their jobs with the back pay that the judge ordered? Will you end the arbitrary, unlawful, and unfair practice that has been going on? And will you drop the waiver for all city employees so that they may return to work?
I have to give the same answer to start that I've given to others who've asked me about pending legal matters. Responsibly, ethically, I should study them myself. You've laid out cases and precedents, judges' opinions, judges I know and respect who've made rulings against the city. And this is a class of cases like Council Member Brewer referred to earlier about 9/11 health consequences, where representing Rudy Washington, a former deputy mayor who suffered life-threatening health consequences from 9/11, opened up for the first time health benefits to those who were down at 9/11, and we're very proud of that, and he's very proud of that, although his life has been hell since 9/11. You're talking about a life of hell from people who asserted rights, and now we're seeing some courts vindicate their rights, but I would have to study those cases, study the body of cases, and see if they overlap and whether the city's policy now, those court cases, whether they are defensible or not. I pledge to you that I will do that, but I can't responsibly and ethically tell you what I will conclude, because I have to study the issue, I have to study the body of cases, I have to hear from people in the law department on these issues, and then make decisions. But when I do that, and I will make it a priority, because it sounds like the city is paying out a lot of money, I will call it as I see it, and tell that to the administration and to the council.
So you'll be leaving, if you are approved, you'll be leaving a tremendous job, and it will be a great financial sacrifice, and you'll be giving up your law practice to take this job. I know what that feels like, to go from city and go from a government job to private job and then come back, because it is a calling, and I believe that you have that calling. But you've been put through the ringer today, and you've been asked questions, and you've answered them from my colleagues in the process. So the big question I have is, from what you've heard today, why would you want this job?
Well, I must really want this job,
Yes.
given how obviously there have been so many questions raised, one council member after another, in quite an organized fashion. The fact of the matter is, I respect this council. I respect each and every one of you, despite some of the things that have been said here or before that are hurtful, that are not true, that do not reflect my character and my values and my lifetime's work. But I want to do this job. I want to return to public service because I have a deep commitment to the city and to using the power of the law to do a public good and improve people's lives. I believe we can do so much. We can do so much when it comes to the issues that we were just talking about with the council member, using the power of the law for good. I am at times mystified how this opportunity to do something innovative and transformative with the law department that will serve the city council and the administration and the people of the city of New York devoting more resources to cases to protect and promote public safety, to protect and promote civil rights, constitutional rights, social justice, workers' rights, tenants' rights, consumer protection, environmental protection. This would be transformative for our city, and it's never happened before. It takes a lot to move the city government. It takes a lot to change for the better. I know, I've been there. It ain't my first rodeo, but you know something? We have to do it for the good of all New Yorkers. And if you give me this opportunity, I say this humbly, if you give me this opportunity, I will do everything I can to make this a better city through the power of the law. And we can do so much more on public safety, so much more on civil rights and constitutional rights and social justice. The potential is there with that great 800-person law department. It's never happened before because it is so hard. When somebody has been there, knows how city government works, knows how to press the levers, knows how hard it is to change, but has a track record of motivating people to change and inspiring that, to devote more resources to those things, that should be as exciting for this council as it is for me. Whatever happens in this process, I will still love this city. I will still love the experience I had in the public sector, and I will always answer the call to serve. I hope you will see on reflection, just as the speaker said the other day, to look at my entire record and see that it is a record and values committed, the kinds of values that so many of you told me you share, that you want to see more of in city government. I will deliver. I have delivered in every phase of my career. I don't say that other than humbly. The opportunity to serve here, I'm honored. I'm obviously putting myself through quite an ordeal. I doubt you have ever in the history of this city had a confirmation hearing that looked anything like this and kept these dozens of people.
Mr. Mastro, we're going to
please let me finish.
Keep moving.
Please, a former governor, other elected officials, former corp counsel, judges, sitting in an audience for 8 hours. I pray that you hear them. I respect you. I want to answer every one of your questions. I'll stay here till the wee hours.
We appreciate
but
that.
I want to serve you. Please understand that.
Okay, and I do appreciate that, and I'm glad that you did say what you did, because I think we all needed to hear that. We're a body that respects due process, legal representation, and second chances. We also need the law department to understand that they have been going against what the judge and the courts have decided upon and appealed and lost. There are no set policies. Everybody is taken as an individual. They are decided upon arbitrarily. What I'm saying to you, Mr. Mastro, is if you are approved, you are walking into a labyrinth of a mess. And you need to really use your intelligence, your knowledge, your experience to really unravel that, because these people deserve better than what they're getting. And, you know, there has been an issue in this body today with trust in you. So, you know, and that has been voiced almost unanimously. But again, I will say to you that I believe in you. I know your history. I know what you did for this city during 9/11 and before. I know what you did in the private sector. And what you've always done was fight for what was right, whether it was your private client or the city of New York. And I believe that you can be fair and you can make the separation. And I'm hoping you do, because the people I spoke about really need that. Thank you for the time.
Okay, I appreciate you saying that, council member, and you know, the problems when I served in city government before were also immense. It's a 24/7 job. I'm committed to doing it, and I'm committing to serving this council with distinction because I respect this body and I respect the role.
Thank you. We'll now go to Councilmember Palladino, followed by Councilmember, I think the last one, Councilmember Vilas. And then we'll move on to the public.
Good evening. Can't say good afternoon anymore, can we? Can't say good morning, can't say good afternoon, but we'll say good evening. Let me start off by saying this. Never be afraid or embarrassed that you were chief of staff to one of the best mayors this city has ever seen in Rudolph Giuliani. This body here today has done everything they possibly could to tear him to shreds, because that's what they do. See, half of the people who are now gone, because they can't sit here, weren't even born in 1993 or 1994, so they have no real remembrance of what that was like to live back in those days. We are now in 2024, where we exist in a city of no laws, no rules. Welcome to the City Council. You have been put through the ringer, Mr. Mastro, and I am very sorry for that. You have got a reputation that precedes itself, and yet you sat through absolute and sometimes very ignorant questions from people who were 7 years old, 10 years old, 12 years old. You lived through when the World Trade Centers were bombed. We talked about people dying. My brother was one of those people who died during a related illness to 9/11. He lived down there. We're talking about kids in school. Well, kids in school in 1994 and 1993, which they keep wanting to talk to you about, things were very different. How much was the city budget? Was it $102 billion or $102.6 billion that it is today? No, it was somewhere around 20 or 13 billion, something like that.
Maybe 25.
Maybe 25 billion, give or take. What's a billion here or there? Okay, now we have several things here that I want to go over with you, but first I do want to reiterate once again, thank you to every single person here that sat here on Randy's behalf, because this was not a hearing. Once again, this was not a hearing. He's not going out for Supreme Court judge. This was an inquisition, an assassination of a good man's character. I despise that. We talk about building bridges. That's what I do. So when you said it, I understood it. Because in order to reach a common ground, differences of opinion, we must build a bridge so that we can come together and discuss those differences. And in the middle, we will find our answers. And yet, if you say this to this body, they get crazy because there's only one way to see things. It's their way or it's the highway. I pray to God that Randy Mastro brings what we need to this city council. And that is common sense. His opening statement was mind-blowing. I loved every word he said. I hung on every word that he said because he was able to show us, the people of the city council, and the people of the city of New York, which I really wish this was being televised, so that the people of the city could actually see the city council at work and how they actually operate this city. It's a disgrace. Now I want to get to my questions. Okay, here we go. Let's start with Local Law 97. I come from District 19, and you were on the PCCC. So I want to talk about Local 97 because in my district it impacted probably more than any other. I hear from my constituents every single day who are concerned and worried about not being able to afford their condo or co-op anymore due to this law. These are often elderly, retired, working-class people who don't live in expensive homes by any standard. In fact, I introduced legislation to delay the crippling fines of Local Law 97, which would have bankrupted several middle-class buildings in my district. Unfortunately, this council didn't care enough about the elderly, working-class constituents in Queens. They passed on my bill to save these people from bankruptcy. Some here seem to think they're saving the planet by bankrupting the elderly poor who cannot afford their electric bills anymore. I heard you mention your work on behalf of improving Local Law 97. Would you please explain what it would look like and what the protections you can include for my constituents who simply cannot bear any further increase to their cost of living?
Wow, after all that, she asked me a really tough question. Let me just say this. I appreciate that someone has better silver hair in the chamber than I do. And I just want to say how much I respect the entire council, and I will stay here all night to answer any of your questions. I just feel for the folks who came here and have been here all day. On your question, council member, the issue in the lawsuit, and we said it in the first paragraph of our complaint, is not that we don't favor reducing carbon emissions and we don't support global warming initiatives. It's that there was a comprehensive package, state law, that had certain parameters that left some flexibility for localities, but that Governor Cuomo himself described as comprehensive. And it was a system of goals and aspirations and targets. And the city used to have laws like that, and some of them pushed the city to achieve targets sooner. In fact, by 2030, there was supposed to be, under local law, aspirationally, hitting 30%. Well, in just a few years, without artificial caps and mandates, and really one-size-fits-all, no matter what the use of the property, how much density, whatever was done there, there's still, in just a few years, well short of 2030, carbon emissions had been reduced by 19% in the city. So the initiative that the state started and the additional layers that the city included, which my clients, small co-ops and small condos in Queens and other boroughs, they were complying with spending money and reducing carbon emissions. The plan was working. Now, the problem with what was well-intentioned legislation, don't get me wrong, but there's a comprehensive state law. And there are things that the city can do to try to accelerate the process, to make the aspirations kick in sooner or the targets sooner. But by imposing, no, you've got one size fits all, even if you're a dense condo or you are a luxury building on Fifth Avenue, you have the same carbon emissions, even if you have many more people living in that same square footage than you do in the luxury co-ops on Park Avenue. That was inconsistent with state law and took the city too far. I would work with this council, and perhaps at the end of the day, the courts will agree that legislation should survive, although the appellate division agreed with our position that we had stated a viable preemption claim. That issue will go to the New York Court of Appeals. But if the New York Court of Appeals agrees with our legal position and that the state law covers the landscape and that the city has to act within that landscape, I will help you here on the council figure out how to push the envelope to encourage and incentivize New York property owners, businesses and residential, to accelerate reduction of carbon emissions consistent with state law. But it's the artificial caps, the one-size-fits-all, as well-intended as it is, that creates the conflict. This is not a criticism of anyone. This is a principled legal position on behalf of small condo owners who are suffering and who have complied with the law, have reduced carbon emissions, spent money to do so consistent with city law, and now they find themselves going bankrupt and facing draconian penalties for not hitting the arbitrary caps.
Thank you very much. I'm just going to shift it a little bit also to a public safety issue. What do you believe to be the greatest threat to public safety today, and how would you use the position of corporation counsel to address it? What specific legal strategies would you employ to address this issue?
We're talking legal strategies now.
Yeah, I shifted gears.
And I take, again, as Corp Counsel, you take your direction on policy from the council. You take your direction on policy from the administration, and hopefully on policies that the two agree to, and Corp Counsel can help facilitate communication. In terms of potential legal remedies for public safety issues, you have guns, you have drugs, you have gang violence, you have organized crime, still a problem in certain industries in our city. You have the potential to forfeit the ill-gotten gains of crime, which actually adds to the city's coffers. The feds do it all the time with the federal forfeiture laws, and the state has analogs, racketeering statute and similar statutes. I think when it comes to drugs, I know there's already affirmative litigation that the city has joined on the opioid crisis. How about fentanyl? How about going after the countries and the parties responsible for the influx of fentanyl in our city and trying to sanction them, trying to fine them billions of dollars? We have to get creative. We have to get illegal guns off the street. We have to get illegal drugs off the street. And my God, we have to do something about the illegal smoke shops. And state law has been reformed recently to do that. It gives us the tools. I want to have a task force at Corp Counsel's office to do that instead of the problems that folks have had so far. And I've read about Council Member Brewer's problems trying to close an illegal smoke shop in her neighborhood. It shouldn't be that hard. And now that state law has changed, Corp Counsel should play a role in doing that. That's what I mean about working with individual council members. The problems you have with drugs, violent gangs, gun violence, illegal smoke shops. I want to work with each one of you to identify what are the problems in your district and to help through affirmative litigation, like we did when I was at the U.S. Attorney's Office, and we used the racketeering law to go after organized crime and illegal business enterprises, like we used the forfeiture laws to forfeit illegal drug proceeds and tenancies in public housing of drug dealers when the city couldn't even get them evicted under local law. So these are all things, imagine how much good we could do if we did this together. That's what I'm asking this council for the opportunity to do.
Randy, I just want to say, Mr. Mastro, I just want to say thank you very, very much for your patience, your time, and I look at you and I see a plus because I really see level ground with you and sense and sensibility through you, with you, and I really think that that's what this needs, this Board of Governing needs. We just need a level head, and I think you, and you're going to be in charge of what, how many lawyers, 800?
It has a potential to be up to 800. There have been some,
Well, there's plenty of work
some
for-
depletion
there's-
in the ranks.
There's plenty of work for 800 of them. So all I'm saying is I think what this city needs is balance. I think it's been off balance for quite some time. And I think you would bring the balance to this council through your understanding, through your open door policy, through your past experience and your present experience. I think you are the complete package. And I, sir, for one, speak on behalf of myself, my colleagues in the Common Sense Caucus. We truly do believe that you are the man for the job. And I really hope that this council and this committee seriously takes all your assets and everything that you've given of yourself, both privately and publicly, into a great deal of consideration, and does not, see you go down in a ball of flames and this was a waste of time. Thank you very much, everybody. Have a
Thank you.
wonderful evening. I've got to get back to Queens.
Thank you, Councilmember. We'll now go to Councilmember Aviles, and then we'll be headed into the public testimony.
Saving the best for last. Thank you, Mr. Mastro.
It's a pleasure to see you.
The true heroes in the room are your wife and your daughter,
Yes, they are.
who are dutifully here the entire time.
And they haven't even begun to cry.
I'm going to have to talk with them so they can talk with my husband. On to the business at hand. I have a couple of quick questions just for clarification. In terms of your work on the task force for bilingual education, you advocated for the complete elimination of bilingual education. Is that correct?
I didn't, no.
Did not.
No,
Okay.
to be clear, so the council.
Let's keep it just super short. You didn't.
I will keep it super short.
That's why I'm asking, just
I
to clarify.
advocated for improving existing bilingual education and giving parents a choice of traditional bilingual education, which we were going to improve, and put more resources into that, but also to give them a choice of English immersion, which would have to be funded and staffed, and let parents make that choice. To me, that's ultimately what we should be doing, giving parents more choice.
But calling to vacate a 26-year-old federal court Aspira consent decree would have eliminated bilingual education. And that was what you were advocating for. That seems in direct contradiction to choice.
But
I'm a product of that bilingual education.
I understand that, and of course, as you know, I have great respect for you. But I was not advocating, we were not advocating for elimination of bilingual education. You needed relief from the consent decree to be able to impose the reforms and the parental choice we were talking about. We were not talking about eliminating the legal obligation to provide bilingual education. We were talking about improving it. So please, council members, don't misunderstand. We were talking about a better system of parental choice where bilingual education would be available and hopefully improved, and parents would have a choice as well of English immersion, which would have to be funded and staffed. And the New York Times didn't often say of the Giuliani administration that it did anything historic and it praised its efforts. This was something that still, for me, is sad that it didn't get done, because I wanted to give parents that choice.
The New York Times has often been wrong, actually, for the record. Let's move on to I just wanted to clarify that, too.
Thank you.
As you know, I'm the chair of the Council's Committee on Immigration, so
Yes.
Bear with me. I am going to make a statement here, and as you are aware, it is not only the questions that we are asking and your response, but also an opportunity to correct the record when there has been misinformation. So as you are aware, immigrant New Yorkers comprise nearly 40% of New Yorkers, according to the 2020 census. And as the chair of immigration, it's my responsibility to oversee the city's relations with important segment of our community. New York City's sanctuary policies began in 1989, as you are well aware, when Mayor Ed Koch issued an executive order that barred city officials from sharing information about immigrants with federal agencies in most circumstances so that immigrants could access city services without fear. This policy was actively reissued and respected by every subsequent mayor, including Republicans, independents, and Democrats. And despite their varying ideologies, each recognized that in order for the city to thrive, there needed to be trust between immigrant communities and city agencies, and particularly law enforcement. For decades, the city has upheld the belief that everyone, regardless of immigration status, should be treated equally under the law. Studies, such as one done by the Center for American Progress from 2017, has shown us that counties with these policies have stronger economies and are safer than those that do not have these policies. Public safety experts, including hundreds of police officers across the country, have found that sanctuary policies improve law enforcement's ability to investigate and respond to crime. These policies ensure that immigrants who have witnessed or have been subjected to criminal acts are willing to cooperate with law enforcement, and thus that persons who have committed crimes are successfully prosecuted. This ensures that all New Yorkers are safer. Absent such laws, persons fearful of deportation will be unwilling to cooperate with the law enforcement or with other city agencies charged with enforcing the city's laws. They may also be unwilling to take such necessary actions as seeking medical attention for fear of deportation. In essence, sanctuary policies help prevent the emergence of a completely unprotected, marginalized, and exploited class of persons in New York City. Recently, some have depicted sanctuary laws as a loophole for accountability. Nothing is further from the truth. If a court finds a person guilty of a crime, those individuals are still held accountable because of sanctuary policies are not a get-out-of-jail-free card or policy. After hearing some of my colleagues speak mistruths about so-called sanctuary laws that perpetrate significant misinformation about the issue, I just would like to ask you a few questions to help provide clarity on the fact. History shows that Rudy Giuliani, like every other mayor, defended the right for the city to prohibit municipal workers from being involved in immigration enforcement on the basis that it ran counter to public safety if the city's immigrant communities believe accessing services and reporting to local authorities risk their immigration status. Mr. Giuliani reissued an executive order that had started under Mayor Koch and continued and became vocal about this importance to the city. So is the rationale that Mr. Giuliani gave for involving city workers in federal immigration enforcement activities consistent with how you remember the reason for such a position? And I understand this is a long time ago.
I recall that the administration I served supported the policy that you just described. And as I explained earlier in my testimony, I chaired a mayoral charter commission that enshrined that into the city charter, and the voters approved it overwhelmingly.
Which we are happy for. I want to help clarify also some misinformation because there seems to be an overgeneralization occurring today about the laws that may have also been the case when Giuliani's policies were being attacked. Is it true that the Giuliani executive order that prohibited undocumented immigrants from being reported to ICE while using city services did not completely cut off all cooperation by the city and cooperation with ICE officials?
I don't recall what the limitations of that were, but I think there were some narrow provisions.
But it did not cut off cooperation with ICE officials 100%.
I don't believe that the policy that existed in our administration was any different than the policy that existed in the Dinkins administration or the Koch administration.
Right, so it's fair to say that that it created guardrails that sought to prevent our city's workforce from being placed in a position of doing the federal government's work with public safety exceptions.
I think that would be correct, but you're asking me to go back 25, 30 years. I don't remember the specific provisions, but it was the same policy, and then it was enshrined in the city constitution as a result of a city charter amendment that Charter Commission I chaired proposed to be put on the ballot and was passed overwhelmingly by the voters.
So it is in fact the case that the law allows for cooperation with ICE officials and provides guardrails for safety. So today there's similar conversation happening with, again, inaccurate claims being made that the city cannot cooperate, but rather establish a process, that the city cannot cooperate with the federal government. In reality, the current laws, as I just said, do not prohibit cooperation, but rather establish a process and guardrails for public safety exceptions. As I'm sure you are well aware about what an immigrant detainer request is in this context.
I am aware of what that is.
Yes, okay. And the reason why we go down this path is because we have an administration who has been talking about rolling back a steadfast, proven policy that has been replicated across the country. And you have talked on a variety of issues of how you will work to bring two elements together to discussion.
Yes.
Can you walk me through, in the case that these two sides cannot be brought to a compromise, how will you pick which side to represent? And then what is the processes that will be put in place in the law department in order to ensure that there is sufficient resources and independence in order to represent one of those sides?
I know that there are issues of policy and interpretation right now between the council and the administration, but there are legal requirements, laws that exist that define the scope of the legal obligation. I would facilitate communication between the two sides of the hall and study the issue, understand the law, make recommendations consistent with the law in the best interest of the city, but following the law. And what I conclude is the state of the law. You set the policy. The law that exists is the policy, and it's a question of whether there is compliance with the law. And I would bring and encourage dialogue between the two sides of the hall. You're describing guardrails. I understand that there are issues about what that entails and what can be done. I would have to, again, responsibly steep myself in the issue, but the law is the law. Whatever the law is the advice I am going to give to both of you. And when I responsibly and professionally sit down to do that analysis, I will hear from all sides. I will try and bring all sides together to find a way to make sure that everyone is complying with the law. But you will get my straight answer on what the law is. And if there is an aspect where there isn't compliance with the law, I'm going to say that. And I'm going to give that advice. But I can't prejudge that issue. You all set the policy in the laws that you pass, or that the voters pass in a charter referendum. Our job at Corp Counsel's office is to figure out what the law is and requires, and tell both sides of the whole what the law requires, and to try to bring the two sides of the whole. I will be proactive in this way, in a way that past Corp Counsel haven't necessarily been, to bring the two sides of the whole together, to go through our conclusions of what the law requires, and to see if there is common ground. Because I don't want to see, if I'm fortunate enough to have this role, I don't want to see litigation between the two sides of the whole. I want to find common ground. And this is an area where constructive dialogue would help a lot. But I need to study the law and then give you responsible professional advice.
Thank you for that response. So So the current law allows federal immigration officials to request the detainment of someone and permits city officials to honor that request in cases where someone is convicted of a serious crime. Is that also your understanding of our detainer laws?
I haven't been involved in these issues in 20 plus
It
years.
hasn't changed, so I'm
understand.
sure you're aware of it.
Don't be sure I'm aware of 25 years ago. I've got quite a memory, but I do know that there are aspects of the law that talk about, detainers and the like. I just would have to steep myself in that again and study, what the law requires at this point.
So in terms of, the city just can't take the role of federal authorities in all cases by broadly denying freedom to someone who would otherwise should not be detained unless they are convicted of a serious crime and federal authorities take the steps to request their detainment. Is this also your understanding?
The law, as in a more general sense, as I recall it, and what became enshrined in the city's constitution, was one that protected immigrants' status and right to access city services without fear of reprisal or reporting. And there were, again, I don't recall the specifics, but there were some guardrails there about circumstances that would be exceptions. I would have to steep myself in it. I want to be professional and responsible, but I am telling you, you know where I'm coming from the Charter Commission that I had that adopted by the voters. But I would have to professionally and responsibly study the law again, talk to other lawyers at Corp Counsel, talk to your lawyers, and on both sides of the hall, and I will give you my best assessment, and whatever I conclude is what I'm going to tell both of you and try and bring it together to make sure that the law that exists, laws you've passed and laws that are enshrined in the Charter, are followed.
Correct, and that the administration actually read the law before they make claims that are incorrect. So I have heard you say many times today, respecting the rule of law, which we hold very dear here. Do you believe in due process?
Of course I believe in due process.
It's a simple question. It's a simple question, and I think you do. And that is what we have in the laws currently. And so I guess what I'm asking in short is, in an administration that is ready to roll back or at least put forward some incredibly misinformed and xenophobic rhetoric against sanctuary policy, would you vigorously commit to upholding sanctuary policy and in particular upholding due process?
I'm council member.
You could say yes.
I know, council member.
And we can get to the folks, or you can talk for a long time.
Council, I most definitely don't want to talk for a long time. Respectfully, I can't accept the characterization. It's the premise of the question, but I can say,
it is
it
is the fact.
Yes.
The law as it currently stands affords due process and affords cooperation with ICE. It is very clear.
I can.
There is no politics here. So either you can vigorously protect the law as noted, or you can go against it.
I will vigorously protect the law and determine what the law requires and respect due process. Of course, I will do that. And I've already said that repeatedly. I'm just saying I can't characterize the current positions or the facts because I'm not familiar with them.
Sure, and unlike many of the other policy issues which have changed significantly over the 30 to 25 years you have been in private practice, this policy has only been strengthened and reiterated. So this one should not be so distinct or unique. This one you know intimately and has not changed, has only gotten better. So one more last question.
Please.
One more last question.
Thank you.
So this is in terms of emergency authority and shelters. So the city uses its emergency authority to site shelters when capacity is needed to comply with the law. Sometimes this must happen in the face of neighborhood opposition. Are you committed to the idea that every neighborhood must contribute to providing shelter for homeless individuals?
I believe that is the policy of the city, but I think that is a fair policy, but my role as Corp Counsel isn't to set the policy. My role as Corp Counsel is to legally defend the policy. You and the administration working together set the policy. So, I certainly would understand that policy and would be honored to defend whatever the policy is that the City Council and the administration determine is the city's policy, or whatever the law requires.
That has been the policy, and your actions has suggested that you don't think certain neighborhoods have that obligation.
I'm sorry?
Despite the fact that the city hasn't had enough beds, and it was a violation of the law not to offer beds to individuals.
Are you referring to something in my background?
No,
Oh.
other cases fighting against siting of shelters
Oh, well,
in the city,
okay.
which continues to be a major issue.
I understand what you're saying. As Corporation Counsel, I would be defending the city's policies zealously, and about the location of shelters as a matter of policy that would be determined by the administration and this council.
So you believe personally that the fair share proposal is an appropriate and just proposal?
Short answer is yes, and I've litigated that issue many times. But that's the law, and that's the law that should be enforced and followed, and would be, if I were Corporation Counsel, fair share.
That's a tall order. You have an administration who is currently violating it, and on a daily basis. So I will, in closing, Mr. Mastro, I thank you for your time, for your patience. Obviously, we all take this very, very seriously, as do you, as does everyone in the public who has been waiting for many, many hours. This is not, it's an important moment for our city, and this is a critically important role, particularly when we have an administration who has abutted, refuses, does not acknowledge, is uncooperative, and really has a penchant for a lack of transparency and accountability. And so, as you find yourself here looking for this job, I will say, we all take this seriously and we respect what you have done in your life, and clearly you are a very skilled litigator. And you are rigorous and you have more energy than most 20-year-olds. I do question your choices of administration in representing Giuliani 1 and Giuliani 2.0. It is of grave concern because of the negative impacts, both then and now, administrations have had on people of color and marginalized people in this city. And I will just say, I am concerned because history has a way of repeating itself if, in fact, we have not learned the full load of lessons that we should have learned from then. So I thank you for my time, and thank you, I yield.
Thank you, Council Member.
Can I?
It's 7 o'clock. We've been here for hours. I think we have the information we need.
Well, I want to thank the council. I'm here to answer any question. I'm here to serve. You're called to serve. And while I don't engage in the kind of rhetoric that some have used in this hearing, I'm honored to serve, and I'm honored to serve this council. And I hope to make a public contribution. I will leave the stage to, there were 40, 50 people here to testify, and now so many of them have left. So I'm going to leave the stage.
We know.
But I'm just
we know.
going to say this. Please, please look at my entire record. Please understand what hopefully I can do working with you to innovate, to transform, to bring a whole new direction to how the law department works. And when you think about that and you look at my entire career and how I've used the power of the law to innovate and transform, we could do so much good together. Open your hearts and your minds. Give me a chance. And if you do what we do together,
Mr. Mastro,
we will succeed.
I'm going to open up.
Thank you.
I'm going to mostly open up the public hearing now.
Thank you.
Thank you. Thank you. Thank you for your patience. And I know it's been a long day, so thank you for answering all the questions and sitting with us. And certainly, I'm sure there'll be follow-ups as well. The way the process is going to work now, we have received appearance slips. We're going to put panels up based on how you have marked your support or opposition. We're going to do that in alternate panels. So we will call. We'll both call the first panel up, with the second panel be waiting to be able to get up quickly. There'll be an opportunity for members to ask questions after you testify. I think you'll have a few minutes to testify each, and then we'll have an opportunity to ask questions. Just want to deeply thank everyone for being here. I know it's been a very long day, and we thank you guys who have stayed for being here and being part of this process. We're going to do, like I said, an alternating panels, so we'll get one up for each, as you marked yourself and indicated, in alternating order, and try to move through this quickly. I will have the council call them as they've been organized.
The first panel is Bertha Lewis of the Black Institute and Gabrielle Semmel of CWA, and then that will be followed by Ken Fisher, Governor Patterson, Assembly Member David Weprin, and Betsy Gotbaum.
Hi there. You can, we'll start here on my left, your right. We'll give you, I think we're going to have a clock going. We'll give you an opportunity to read your testimony. We'll do the whole panel, and then we'll offer an opportunity if people have questions, ask questions. And please introduce yourself before you testify.
Is this thing on? Yeah, okay.
It is on.
Thank you, Chairperson of this committee, and to all the City Council members present and absent. My name is Bertha Lewis, and I am the president of the Black Institute, the Black Leadership Action Coalition, and Black Institute Group. And I am vehemently opposed to the appointment of Randy Mastro to the position of Corp Counsel to this body. We need to remember some history. Yes, in 1993, there was a riot on the steps of City Hall led by the NYPD and then candidate Rudolph Giuliani. It was racist, it was vicious, and violent. Well, Councilmember Palladino isn't here, but I was not 12 years old. I was there. I witnessed it, and I was assaulted in it. Upon the election of Mr. Giuliani to be mayor of New York City, despite this despicable display, Mr. Mastro made a decision to join that administration as first deputy and deputy mayor of operations. In his position with the Giuliani administration, he was one of the architects and consultants on the stop and frisk and broken windows policy. He and then Mayor Giuliani systematically dismantled affirmative action from the Dinkins administration. He tried to eliminate all MWBE programs. And yes, he was part of vacancy decontrol. And is that one of the people who would have been testifying here today, he worked with Democrats and Speaker Vallone. Listen, he went on, I'm going on. And I was here. In 1998, after the vicious attack by the NYPD on Abner Louima, he was assigned to the policing task force set up by Giuliani, and he defended the mayor when he dismissed all of the recommendations of the task force. In 1999, he headed the Mayor's Charter Revision Commission to limit the powers of the city council, just the same as the current mayor is doing now. He represented the Republican Party of Staten Island to challenge the election of Debbie Rose to this council and destroy the Working Families Party in the process, but he lost that battle. He likes to toot his chairmanship of Citizens Union as proof that he is a progressive and that he is for good government, but he has used Citizen Union to promote himself and to defend one of his private commercial clients. Even today, his law firm has a case representing big landlords and the Rent Stabilization Association to gut provisions of the rent stabilization law. Members of the council reject this revisionist lawyer. The job of court counsel is to represent the people of New York City. He is not and has never been for the people of this great city. When considering this appointment, ask yourselves one important question. Why, of all the thousands of competent and accomplished lawyers in this city, would he be the only one that the mayor has put forth? I urge you to reject him and to use your power of advice and consent to just say no. Thank you.
Good afternoon, Speaker Adams, Chair Powers, and members of the council who are here, not here. My name is Gabrielle Semmel. I've testified before, and the papers say Gay Semmel. That's also my name, just want to be clear about that. I am a retired union-side labor lawyer who previously worked as district counsel for the Communication Workers of America for more than 30 years. Before that, I worked as a field attorney for the National Labor Relations Board in Manhattan. I was the main attorney for CWA in the 5+ year battle by workers to hold on to a union and get a contract at Cablevision in Brooklyn. And that case has come up a couple of times in some of the questions by the council. That labor fight was quite infamous in the city, and the council's subcommittee on zoning and franchises held a hearing in December 2014 where Randy Mastro testified on behalf of the council. I am here today on behalf of the Communication Workers of America to state its opposition to the appointment of Mr. Mastro as corporation counsel and to explain why. During the council hearing in 2014, Mr. Mastro exhibited contempt for unions, contempt for workers, contempt for CWA, contempt for the National Labor Relations Board, and also contempt for the council. He also misrepresented the facts regarding Cablevision's many unfair labor practices and NLRB procedures. He actually misrepresented what he said again here. 2 New York City regions of the NLRB issued sweeping complaints against Cablevision regarding its unlawful behavior in both the Bronx and Brooklyn. Mr. Mastro falsely claimed that Cablevision CEO James Dolan, this was at the hearing, did not threaten the workers before conducting an illegal vote on September 10th, 2014. That was untrue. Mr. Dolan threatened workers that if they voted for the union a second time, contrary to what Mr. Mastro said, the union was certified. If they voted for the union this second time, he would never give them wage parity and with the non-union workers in the company. All workers elsewhere in the company were making 14% more on average than the Brooklyn workers. That is a threat, and that is the truth. I have a transcript.
Thank you. We're going to,
I have
we'll let you finish now, and then we're going to ask questions.
2 more sentences. Mr. Mastro represented the facts, sought to justify anti-union behavior, and attacked recognized protections of organized labor. I'd be happy to expand on any of this in response to questions. Thank you.
Thank you. I'm going to forego my questions. Do we have any colleagues who want to ask questions? Go ahead.
In your testimony, you referenced, sorry, Ms. Semmel. In your testimony, you referenced Mr. Mastro misrepresenting the facts and process related to Cablevision's unfair labor practices and NLRB's procedures. Can you just elaborate a little bit more on that misrepresentation?
Yeah. At the hearing, he claimed or he implied that that the trial of the NLRB was part of the investigatory process, as would be the as would be the appeal to the NLRB, and it was really the courts that would decide it. At the NLRB, before a complaint is issued, it is the NLRB that issues the complaint, not the charging party. They do a thorough investigation, which means that they have sufficient evidence to believe that a trial is warranted. The next step is the trial level with an ALJ. Most cases settle before they get to the ALJ stage, and very few cases are appealed beyond the ALJ stage. So usually the ALJ is the decision maker. The agency, in 2012, the agency won about 90% of its cases before the ALJ. So at the time of the hearing with Mr. Mastro, the agency had already held one trial for 20 days. That means they had investigated it and believed that these violations had occurred and had issued a second comprehensive complaint that would then also be tried for another 20 days. At the hearing, Mr. Mastro, contrary to what he said here, said that the union's charges were frivolous, and he believed that ultimately Cablevision would be completely vindicated. It was not. The union won most of the issues that were tried.
I was a community person organizing in Brooklyn. I lived in Brooklyn. I knew these workers. I saw firsthand the tactics that were used in these closed meetings with threats, firings, in which we had to get workers reinstated. Mr. Dolan, who at the time owned Cablevision, just coincidentally, same client for Madison Square Garden, Mr. James Dolan. I was there, I witnessed it, and again, it is a decision of any lawyer to take on a client or not to take on a client, and to do his homework on that client prior to taking that client.
Thank you for both of your responses.
Thank you. Any other colleagues? Okay. Thank you for your testimony. Thanks for your patience as well. Call the next panel.
We'll next hear from Betsy Gottbaum, Assemblymember David Weprin, Governor Patterson, and Ken Fisher.
I think the former public advocate has left. I saw Ken Fisher here. I'm not sure if he's still here. He left, I believe. Nope. We'll hear from Assemblymember Weprin and our former governor, David Patterson. And we'll give you an opportunity to testify, and then we'll obviously have potentially have member questions as well.
Is this on? Okay. We have the same problem in Albany, by the way.
You remember being on this side of the table?
We can never figure out whether the light's on or not. I've been on that side many times. As a matter of fact, this has been nostalgia for me because I was chair of the Finance Committee, as you may know, for 8 years, and I actually sat through all the budget hearings, and we often went, till midnight or 1 or 2, but usually the testimony was very quick at that point, and the audience was less and less as we went through. So we actually have more people than I expected right now. I hope this isn't coming off my time.
Keep going.
Speaker Adams, Chair Powers, I want to thank you for the opportunity to speak in support of Randy Mastro's confirmation to be the next Corporation Counsel of the City of New York. I'm Assemblyman David Weprin. I represent the 24th District in Queens. I currently chair the Assembly Insurance Committee and have previously served as chair of the Correction Committee. I proudly represent my neighbors from 2002 to 2009 in the New York City Council, where, as I mentioned, I was chair of the Finance Committee. Randy Mastro has been a friend and someone who I've worked with in different capacities, but more in an advisory role. He is a real outstanding individual. When I first got elected to the City Council and became chair of the Finance Committee, Randy was someone I sought advice from and somebody that I respected. He is a real bridge builder. He is a type of person that can work with anyone and everyone and really tries to work for the benefit of the mission as opposed to the individuals. I worked with Randy when I was on Wall Street, which I was on for 25 years in different positions. I chaired the Securities Industry Association, New York District, for a number of years, and I've worked with Randy. I want to state, since I've been in this hearing almost the whole day, and I'm not a Rudy Giuliani fan by any means. And you'd think at one point that, as we're sitting here, that Rudy Giuliani was up for confirmation. He's not, and Randy Mastro is. And I just want to say that the experience I've had with Randy in different capacities has been, I've found him to be not only a brilliant lawyer and advocate, but also a great individual, someone that I feel I can trust and you should be able to trust. And if I had to define him, I would say he's a real mensch.
Thank you. Thanks, Assemblyman. Nice to see you. Governor Preston.
Madam Speaker, Mr. Chairman, members of the council.
I think your microphone is off. There you go.
How about now? Oh. They won't mind hearing their names again. Madam Speaker, Chairman Powers, members of the City Council, and all of you who've come here today. I'm David Patterson. I'm a recovering governor, and I am very happy to be here in support of Randy Mastro's appointment to become Corporation Counsel. I've listened to a lot of conversation today, but there was just one part of the conversation that stuck in my head, and it came from the dynamic and articulate speaker of the New York City Council, Adrienne Adams. She delineated the difference between appointing a counsel in-house and appointing a corporation counsel. For years, the corporation counsel was really the mayor's lawyer and it responded only to the mayor. Some very good government action in the past few years has changed that. Now the corporation counsel's duty is to represent not just the mayor, but the city council, the independent elected officials like the public advocate, and the agencies or subsidiaries of the New York City government. And so that's a much greater demand on a lawyer, but I don't think it is beyond the reach of Randy Mastro. Anybody who could sit here for 8.5 hours, and every time someone asked him a question, he said he's glad to hear the question, probably needs to rethink whether or not he really wants to have this job. But I think it was an exhibition of his concerns and his true love for the actual city. He happens to be a Democrat. He has always registered and voted as a Democrat. And he stood for the democratic principles, trying to eradicate the ills of our society: poor housing, drug abuse, crime, unemployment and underemployment, poor and inadequate health care facilities, and often, and too often, a failed educational system. So having someone that has that breadth of interest representing us in the Corporation Counsel's office, I think would be a tremendous idea. Now, many of you have elicited concerns about him and gone into his previous life as a very well-paid lawyer, and that is interesting enough as it is, but we would not want to actually state that we don't like people who represent large businesses, large corporations. A lot of that is what generates the revenues of our society. At the same time, some of you have raised some issues about things that went on when he was really not in position to change them. But the one time he did, I didn't think he got any credit for it, and it was in 1999 when the mayor knew that he'd be leaving in 2001, that Mark Green was the odds-on favorite to become the new mayor. And so he thought at that point that he would have a commission to set up to basically eliminate the position of public advocate, and Randy Mastro stopped him. Now, when you're working for the type of personality that Rudolph Giuliani is, and it's no surprise that he went to hang out with Donald Trump, because he was trying to affect and actually eliminate an election in New York City, and Donald Trump was trying to steal an election in the United States of America. So I see why they hang out together. But the point is that Randy Mastro used that opportunity to stop what would have been a tremendous downgrade of legislative and executive power in allowing that to go through. So,
Thank you, Governor.
You're welcome.
Thank you. Do we have questions from council members? Panel?
I'll just say that I tremendously respect the both of you very much, as I did the first panel, and I appreciate you hanging out with us today. Assemblymember Weprin, who shares a district with me, thank you for being here, and our beloved former Governor David Patterson, you already know. Thank you both for hanging out with us all day.
Thank you, Madam Speaker.
Thank you both for your patience and your testimony.
There's no charge for this testimony.
By the way, we were in the same law school class at Hofstra Law.
All right. A little history lesson. All right, we're going to call the next panel, and we'll prep the panel after that.
The next person testifying is Bridget Kelly, followed by Fran Reiter, Ninfa Segarra, and Rudy Washington.
Thank you. You can just state your name and title, affiliation, and we'll be on the clock, and then we'll have an opportunity to ask questions as well.
I appreciate that. My name is Bridget Ann Kelly, and I am a victim of Randy Mastro's sexism attacks in New Jersey. Distinguished members of the Rules Committee, good evening. Thank you for hearing my testimony today regarding Randy Mastro's nomination. I am not a resident of your city, but I am your neighbor, and I visit often. I am proud of my 20 years working hand-in-hand with New York City during my time in New Jersey state government. I'm also someone that lost that career in government, in large part due to the underhanded and unethical actions of Randy Mastro. As you heard today, Randy Mastro was hired by Governor Chris Christie to the tune of more than $9 million to manufacture what has become known as the Mastro Report that lied about me, slut-shamed me, scapegoated me, and I eventually took the fall for what is known as Bridgegate. In listening to Mr. Mastro's opening statement and hours of chatter of self-serving adjectives, I wanted to make sure I added one of my own to describe him: sexist. Council Member Farias, thank you for raising the issue of the irresponsible work product of this witness in the Bridgegate matter. To correct his testimony, I was the Deputy Chief of Staff to the Governor of New Jersey, not the Mayor. And yes, Mr. Mastro and his whitewash report was chastised by a federal judge in New Jersey. And Mr. Mastro's response was that she had not been an investigator. She was just a civil attorney before sitting on the bench. I think that was downplaying Judge Wigginton's role prior to being nominated to the bench. And that's another Randy Mastro tactic, sexism at its best. Mr. Mastro stated that he conducted his Bridgegate investigation just like the FBI. You, Mr. Mastro, are not the FBI, and with the FBI, I got to see their 302s. You are accountable to the taxpayers of New Jersey to retain your notes and, as you say, perform standard or best practices. You did not. Your investigation led to the destruction of not only my career, but my reputation. And today, you were given the opportunity to express regret, and he's not even in the room, for the depiction of my character and my reputation. You chose to be silent, and that silence is deafening to me, my 4 children, and to the city of New York. What a shame. Randy Mastro is a conniving and ruthless politician and political operative who happens to be an attorney. When would somebody hire Randy Mastro? Perhaps you hire him when you need to threaten or scare someone, or when you need to take someone down for your own political security, or when you need a scapegoat to get you out of trouble. He's really good at what he does. He'll do whatever he needs to and goes after anyone that stands in the way of his principle, at whatever cost. In my case, it was Governor Chris Christie. Someone needed to have him take the fall for him. Randy Mastro embodies something that both Democrats and Republicans need to rid from our system. He will try to embarrass us all, including the members of this committee and the City Council, and that is guaranteed if any of you stand in his way. Confirming Randy Mastro to serve as Corporation Counsel to the City of New York will send a very strong and direct message to every woman who has ever been scapegoated or slut-shamed to protect a man in power. And unfortunately, there are far too many of us to whom that resonates. And while many citizens of the City of New York will not follow this appointment process or understand the work of the Corporation Counsel, it will reek of the same old, same old. And I know you are all smart enough to know that things like that are why people lose faith in our government. At some point, this division that we have in politics, this sort of win-at-all-costs mentality, must end. We interact as enemies at the expense of others, and the common goal of a better and honest system is lost. Good people don't want to run for office, much less work in government anymore. This distrust is destroying the core of our democracy. Members of this committee, I am respectfully asking and strongly suggesting that you take a step to end that distrust and send the right message to the people of the City of New York and to your neighbors in New Jersey by opposing the nomination of Randy Mastro as Corporation Counsel. And to be clear, and to use Mr. Mastro's words before he does, my testimony is not an unfair characterization. Thank you.
Thank you.
Thank you so much, Ms. Kelly, for being here.
Thank you.
We certainly feel your pain. We watched your ordeal, as I'm sure a lot of the nation watched your ordeal through Bridgegate. And your courage is admirable. I'd just like for this panel and those who are still here in the chamber to know and hear from you specifically the impact of Bridgegate on your life then and where you are now in 2024.
Well, for the record, I'm in severe PTSD therapy. I thought that at the time, the worst thing when this all unfolded in 2014, that the worst thing that was going to happen was a committee investigation, and I truly believed and was told to believe and assigned an attorney by the former governor that was going to protect me, that the worst was going to be a committee hearing. And as you all know, you have committee hearings to investigate and whatnot. And then, what happened was my attorney, once I downloaded to him, he dropped me because I told him what I knew. And I wound up having to get one of the best criminal defense attorneys in the state, if not the country. But funny thing was, the committee hearing wasn't really going to be the worst thing. There was the hiring of Randy Mastro and his team of former U.S. attorneys, some of which worked with Chris Christie, some of which who had fundraisers for Mr. Christie when he was running for president, some of which whose children worked for me in the governor's office. Mr. Mastro, I mean, it was amazing. He had a full investigation of all the things in Chris Christie's office done in like 6 weeks to the tune of $9 million. And he solved the whole thing, gave the U.S. attorney his little script, and then they went about it. Prior to, Madam Speaker, Me Too hadn't come to a head, if we're going to talk about things. Me Too was not something that people were talking about in 2014 yet. It hadn't come to the forefront and hadn't come to be an issue whereby women were comfortable speaking out. The Mastro report came out. I was at my attorney's office watching it. Mr. Mastro had, I think, a press conference that lasted about an hour and a half, holding up his documentation, his however many page Word report with all these interviews of people that were my friends. And very interesting, my romantic life and my personal life became the subject of the Mastro report. And that I was an unstable, I looked for approval from men for things. I worked in government for 20 years for some pretty powerful men and women. I had respect from both sides of the aisle, and I was damn good at what I did. And so I didn't need any approval from any man. I joke with people that he gave Bill Stepien, who, apparently I was so brokenhearted, I closed the George Washington Bridge when he broke my heart. Crazy. He gave Bill Stepien much too much credit. I didn't close the lanes of the bridge. The bridge was never closed, but we're not debating Bridgegate. His personal attacks on my state of mind, on my work product, was all reliant on almost like office gossip, or what do they call that? Coffee around the water cooler chatter. And he sat and his team of attorneys interviewed people, but with no notes. And they went back to their offices and wrote up their own little Harlequin novel, but it's almost like they had a script. And this came out, and Madam Speaker, I was so floored, and I was so hurt. I have 2 daughters. One is with me today, Mary Kate. At the time, they were much younger. They were 17 and 7. And the first person that came out to fight was the chair of the Joint Committee on Bridgegate, and it was Senator Loretta Weinberg, who no longer is in the Senate. But let me tell you something. She told Randy Mastro where to go with that report, and she said it was sexist, she said it was slut-shaming, and she was right. But I have to tell you, at the time, things were just getting worse legally, and it was almost like I had to put that behind me to deal with the fact that I was now going to be, I was under federal investigation, I was then indicted, I was then went to trial, I was then convicted on 9 counts, 2 of which were thrown out, sentenced to prison twice, once for 18 months, once for 13 months. And then the United Supreme Court took my case. And they get 10,000 requests a year, and they take 75 cases. I was 9 days away from leaving for prison. 9. Leaving my kids. My ex-husband was moving in. My girlfriends had packed me all up, and I was going to West Virginia. So talking to your kids about going to prison for something you didn't do, that's someone. It was really hard. And so fighting that battle for a good 7 years, I knew my reputation was so tarnished. But then I win at the highest level. I went to the United States Supreme Court, and my case was, and he touted it today, unanimously overturned, like he played a part in it. Do you know I can't get a job in government? Nobody will talk to me. I worked in government for 20 years. It's the only job I ever had, and I loved it. And I miss it every day. I walk into the chambers and I'm like a nerd. I'm so excited to be here, but for the worst reasons. So I lost my career. My kids lost a part of their mom. It taught my kids something that they always say what doesn't kill you makes you stronger. I joked with the kids it was a good college essay subject, but it's not funny. It's my life, and it's their life. So he had an opportunity today when Councilwoman Farias asked if he regretted his depiction of me. He has a daughter and a wife sitting here, and he was silent. And I would tell you right now, I am so impressed that you have a majority of women on your council. That speaks volumes. I don't care if you're Democrat or Republican. The issue is women. The issue is being treated differently, and the issue is decency. And I'm sorry, that was loud. I have so many trust issues. I have so many, and I'm airing my dirty laundry, but it's really true. The trauma from this has almost killed me. And he kicked it off, and he's supportive of it. And he could have said something today. Not that it would have made it better, but to show maybe some of you that he has a soul. But I'm not sure he does.
Thank you very much, Ms. Kelly. Thank you for your testimony. Thank you for your strength.
Thank you.
Thank you for testifying today, Ms. Kelly. Just a couple thoughts run through my head. One, I do want to double down on what the speaker said. Thank you for being here. We applaud you for being here. It's brave. If this incident occurred a few years before the Me Too movement, do you think your experience would have been viewed differently if it happened today?
I do, and I'd only say that because, unfortunately, I think situations where there is sexism or slut-shaming happens probably every day in the office. And it's not just women, it's now happening women and men. It's discrimination, it's everything. But I think because famous people started doing it, people felt more comfortable to talk about it. And so for me, when it happened, it was kind of like, and again, there are a lot of people afraid of Chris Christie. So a lot of people that I know who claim to be all these women's rights, and all my Republican friends all forgot to say something when the report came out, and they still have forgotten to say things. That report was blatantly sexist, and the silence was deafening then too, and I think it was I think people are still threatened. So I give any woman that comes forward so much credit, because it's not easy. And I never felt, what's so funny, and I think back, I never felt that intimidated in the office, because I was so confident at my job. I really was very good at my job, and I'm not a confident person. I'm not an egomaniac. I loved what I did, and I worked with both sides of the aisle. I never felt, there's legislators, there's this, there's always something, but I never needed anybody's approval because I was good at what I did. And so I think that because really big stars started to come out, and it came out that really big names were being abusive to women, I think it gave women the confidence. So I'm not saying that I wish this would have happened a year or two later. I wish it never happened, because it really did ruin my life, and I hope he can sleep at night. But, because I can't. But at the end of the day, I think it would have been handled differently, but I would hope no attorney or anybody would ever go there again. It's none of anybody's business. And my personal relationship had zero to do. And he said it again today, oh, it was her state of mind. Who is he to talk about my state of mind? Right now? Yeah, sure, you can talk about my state of mind. I am in PTSD therapy. I should be billing him for it.
And so thank you for that response. You answered a couple of the questions that I have listed. No. I appreciate you just being open. The last question I have, Mr. Mastro claimed no one had been found to do any wrongdoing, and that his report and the Supreme Court's decision came to the same conclusion. Would you like to respond to that?
I'm sure that the taxpayers of the state of New Jersey would have liked Mr. Mastro to be the arbiter of all the truths in the world, but, and for 7 years I had to fight this battle. I don't know that Mr. Mastro knows exactly what happened because I think he talked to the wrong people. Mr. Mastro did ask to interview me, and that would be like, you know, probably one of the stupider things I would ever do because he was hired by the exact man by whom I worked for, and it came to light during the trial many times who knew what and when. So I find it unfortunate, and somebody, I think, the woman who was sitting here before talked about revisionist history. We have a lot of people, unfortunately, in government that do that. And it's unfortunate, it's sad, and I'm just disappointed. My dad always says to me, it's worse to be disappointed than mad. And to be disappointed by the government for whom I worked, and then the people with whom I worked, and then furthermore by somebody who doesn't even know me, and then to cast me in that light, it hurts.
Thank you for your response.
Thank you.
Thank you. Do you have any other questions or comments? Okay. Thank you for your testimony.
Thank you all
for
very,
being
very
here.
much.
The next panel is Fran Reiter, Ninfa Segarra, and Rudy Washington. And that panel will be followed by Seth Pollack from Housing Works, and Darius Gordon from Met Counsel.
Thank you. I think you're all alone. You can state your name and title affiliation, and we'll put you on the 2 minutes and ask questions.
I'm all alone. Good evening, Mr. Chairman, Madam Speaker. I'd first like to start out by simply saying, Madam Speaker, I grew up in your district, and my family, we migrated from the South, fleeing the Klan. And as a result of that, I grew up with the suspicion of white folks. And I give that backdrop because I first met Randy in 1993. And at that time, I had nobody in my circle that was white. I had no white friends. I didn't know anybody from the white community. And I met Randy, and I consider myself a fairly good judge of character. We instantly bonded in '93. And little did I know, a year and a half later, he would be somebody I'm counting on to cover my back when organized crime was coming after us. I too lived under, my kids lived under, my wife lived under for 2.5 years of police protection, from the Fulton Fish Market. And it got messy, and I won't bother you with the details. But after that fight, Randy dragged me into another fight, and that was with the carting industry, which was the Genovese crime family. And once again, we lived through that. I want to correct the record on something that I think was deliberately distorted back in the day by the New York Times. The minority program, I've heard it from the counselor, I've heard people speak about it. That program was built upon the antidote of my company. I was 60% of what made Mayor Dinkins' program. I testified, I submitted written testimony, and unfortunately, at the end of Mayor Dinkins' administration, when he was prepared to roll it out, the lawsuits flew, and it was from the General Contractors Association. They stopped the program, and it was Randy Mastro who I went to and devised another way of tackling that issue, and that was to put me on the Policy Procurement Board, where I changed the rules so that commissioners could now do sole source purchasing. I planted, Madam Speaker, on 168th Street in Jamaica, a business development center. I also put one in Harlem on 116th Street at the Malcolm Sabaz Mosque, a business development center. And it escapes me now, we put one in Brooklyn. And there we work with minority firms, and we had our commissioners do sole source procurement and got numbers larger than anybody had gotten before, but the Times wouldn't print that. They wouldn't put it out there, all right? When I wanted to transform and do work in Harlem, I wanted to compete against 7 cities. I needed $100 million to submit my proposal to reform 125th Street. Those bean counters at OMB, which you guys are familiar with, wasn't going to give me $100 million up front to show the federal government that it's in place and nobody could pull it back. It was Randy who went to bat with me to fight OMB and convince the mayor that $300 million would be a good investment in Harlem, starting with Home Depot on the east and all the way to the west, from river to river, reform in Harlem. I mean, we did some good work together. And I'd just like to say, I watched and was at his wedding. I was with him when his child was born. My daughter calls him her godfather. We have dinner probably twice a month, once every 2 months. And when we're not having dinner, we touching base, and he's checking on me. Lastly, I'll leave you with this. Very few people notice, but I was the person that did the first rescue and search operation, 9/11. And yes, I remember, because I had major concerns when Christy Whitman said, the air was fine. All that equipment, that was me, up front. 3 days later, I was in intensive care at Beth Israel.
I just want to stop you there because we have a few people who have to leave very soon who want to also have an opportunity to testify.
Okay, well.
We're going to call.
All right, let me just say this.
Yeah, you can go ahead, sorry.
Chairman, and I'll wrap it. When leaving government in '02, I wind up being sick a number of times. And when I applied to have my medical, I was just looking for medical coverage. The city denied me. And I found out the city was denying every first responder, firemen, policemen, construction workers. And I went to Randy, and he vetted my legal team, went after the city, and we won for every first responder that's receiving health care today. And as Randy said, he's been through this with me. I lost track of the operations. My last one was in February of this year, and I'm still recovering. And he's been there for me. His family's been there for me. So thank you for giving me this time.
Thank you.
Thank you. You can stay. We might have questions as well. You can stay. I think we might call one other. Do we have any councilors have questions? Okay. Thank you for your testimony. Thank you for your patience as well.
We'll hear from Veronica Moya next.
Thank you for those of you who are willing to stay this long. I know it's been a long, exhausting day, and I have sat here patiently because I was so anxious to speak to you. My name is Veronica Moyer. I'm a partner at King & Spalding. I was previously a partner at Gibson Dunn, and at both law firms have worked closely with Randy Mastro. We started out as colleagues and became dear friends over the years. And I have listened to the proceedings today, and I think the most I can offer to you now is an answer to the question that was raised early on. Randy was asked, how can we be sure that you will run a diverse and equitable organization if your corporation counsel? And I want to share that from my personal experience, you can absolutely be sure. Randy mentioned multiple times his record from Gibson Dunn, how he grew from 0 to 30% of women partners in the New York office alone. That same commitment to diversity and inclusion was repeated around the law firm, not just in the New York office. And the one thing I wanted to point out is Randy is not a person who just makes statements about the importance of diversity. He does the hard work, the daily sustaining work of promoting diverse lawyers. I'll just give you one small example of the personal sacrifices that he has made to support me. Randy once flew to Dallas to help me secure retention in a high-profile case with billions of dollars in exposure, a case that was very important to my career for me to lead. We ended up getting that case, and it ultimately led to novel, precedent-setting case law. What I found out probably a year after Randy did that was that he had actually flown to Dallas on his birthday and was late for his own birthday party because he wanted to support me. He wanted us to get this case. He was invested in my success. I have now repeatedly been recognized by Benchmark Litigation as one of the top 100 trial lawyers in America, along with Randy. Randy was instrumental to my success. And I say that despite the fact that I have strong academic credentials. I have an undergraduate degree from the Massachusetts Institute of Technology, and Speaker Adams, I have to say, where I pledged my cherished sorority, Alpha Kappa Alpha. I have been admiring your cup all day. I have a law degree from Harvard Law School, but I did not come from a place where there was exposure to the practice of law. Neither of my parents went to college. My grandparents did not have the opportunity to graduate from high school. So what I needed was what I call a door opener, someone who could help me open the doors to help me succeed in what remains a predominantly white, predominantly male law firm world. People who can get you in the room to even be considered for the important opportunities. Randy was a door opener for me, and he was for many others, and that's how we got to that 30%, that sustained commitment. This is a man of the highest integrity that I have trusted on so many matters, and I just want you to know that you can be absolutely certain that his commitment to diversity and inclusion is absolutely real.
Thank you for your testimony. Thank you for your patience here as well. A long day. Do we have questions from any council members? Okay, well, thank you for being with us, and thank you for your patience.
The next panel will be Darius Gordon, Seth Pollack, Victor Pate, Natalie Druce, Pavone Tavares, and Darren Mack.
Good evening, council
Just
members.
give us 1 second. We'll have folks come up and sit with you, and then we'll go. All right, you can go ahead. Thanks.
Thank you. Good evening, and thank you all for your patience. My name is Darius Clow Gordon. I'm the Executive Director for Met Counsel and Housing, and I'm here to tell you exactly why we're vehemently opposed Randy Mastro being appointed Corporation Counsel. Let's not mince words. Randy Mastro has spent the last 30 years as a relentless enemy of tenants. His legacy is destruction, starting with his crucial role in 1994 under the Giuliani administration, where he was instrumental in pushing vacancy decontrol. His disastrous policies gutted rent-stabilized housing across New York City, allowing landlords to jack up rents and displace countless working-class New Yorkers. And what did Mastro do? He stood by while the city lost the power to protect its tenants, ensuring that the damage was irreversible. After his stint at the mayor's office, Mastro didn't stop there. He returned to private practice, becoming the go-to guy for landlords and the Rent Stabilization Association. Time and time again, he's taken up arms against tenants, fighting tooth and nail to destroy rent regulations and strip away tenant protections. During COVID-19 pandemic, when tenants struggled to survive, Mastro led a heartless crusade to overturn eviction protections, taking it all the way to the U.S. Supreme Court. And now, as if his past betrayals weren't enough, he's at it again, this time trying to dismantle New York's Housing Stability and Tenant Protection Act of 2019. This man has a long history of siding with landlords, pushing for policies that make it easier to evict, displace, and exploit tenants. He's not a champion for renters, he's a hired gun for the highest bidder. Make no mistake, Randy Mastro isn't about creating a better New York for all of us. He is about lining the pockets of landlords and developers at the expense of those who live here. Mayor Adams' suggestion for Mastro's involvement is a red flag, a sign that his housing plan, including the City of Yes, is designed to trample over tenants' rights and dismantle the progress that we have fought to achieve. Met Counsel will not stand for this. I repeat, Met Counsel will not stand for this. We're here to say no to Randy Mastro becoming the corporation counsel and to any initiative or person that puts profit over people. We will fight tooth and nail to protect tenants, preserve affordable housing, and ensure that the city remains a place we all, not just for the wealthy, can call home. Thank you.
Thank you. Yeah, thank you. Thank you, Chair Powers and members of the Rules Committee, for the opportunity to testify before you today. My name is Natalie Druce, and I'm a staff attorney at the Safety Net Project at the Urban Justice Center. For over 40 years, the Safety Net Project, or SMP, has provided free legal services to thousands of low and no-income New Yorkers citywide. Our services include helping tenants avoid eviction, address repairs and landlord harassment, securing crucial public benefits, and enforcing the rights of homeless New Yorkers. SMP encompasses an organized member base with lived experience of poverty and homelessness, the Safety Net activists, who organize campaigns to address homelessness and welfare issues. We work extensively on homelessness issues, including advocacy around the rights of homeless New Yorkers in the shelter system and in the streets. We were one of the organizations that led the Homeless Can't Stay Home campaign during the pandemic, advocating for safe shelter for homeless New Yorkers when COVID was at its peak. I'm here today to voice our organization's concerns regarding the nomination of Randy Mastro as Corporation Counsel. Mr. Mastro has a history of anti-homeless and anti-tenant activity, including engaging in litigation to oppose homeless shelters in wealthy neighborhoods. He has previously represented groups trying to prevent the opening of shelters on the Upper East Side and Billionaires Row. As we have heard today, Mr. Mastro represented a group of Upper West Side residents who, after publicly expressing virulent anti-homeless views, sought to shut down a de-densification shelter at the Lucerne Hotel where over 200 homeless men were residing. These men had been transferred from unsafe congregate shelters where the risk of infection from COVID-19 was unacceptably high, in part due to advocacy from groups like ours. Mr. Mastro deployed unscrupulous tactics during this case, including hiring former police officers to masquerade as plumbers, gain access to a former Lucerne resident's new home, and take photographs of him shirtless. Regardless of his legal objectives, the unethical manner in which he pursued them is what concerns us. Mr. Mastro has also repeatedly represented landlords seeking to undo legal protections for tenants. This includes the Supreme Court challenge to the HSTPA and a 2021 lawsuit in which he represented landlords opposed to the pandemic-era eviction moratorium. New York City is experiencing an acute housing affordability and homelessness crisis. The city claims that the shelter system does not have the capacity to accommodate everyone, and as a result, it has set up a separate and unequal shelter system for recent immigrants and is evicting those residents into street homelessness after their stays expire. There is clearly a need for expanded shelter capacity, and yet in some neighborhoods, aided by attorneys like Mr. Mastro, residents oppose shelters and seek to keep homeless New Yorkers away entirely. Against this backdrop, it is deeply concerning that the administration would seek to appoint an individual with a track record of attacking the rights and interests of tenants and unhoused people to be the city's top lawyer. Given Corporation Counsel's role in defending lawsuits involving allegations of governmental misconduct, Mr. Mastro's history of engaging in unscrupulous conduct during litigation is also a cause for grave concern. For these reasons, our organization has serious doubts that Mr. Mastro's appointment as Corporation Counsel is in the best interests of New Yorkers at large, and in particular the interests of low-income and homeless New Yorkers. Thank you for your time today.
Thanks.
Good evening, and thank you, Speaker Adams, Chairman Powers, and members of the City Council who are still here. My name is Donovan Tavares. I was born and raised in Bushwick, Brooklyn, and I'm the Community Safety Coordinator for the Justice Committee, a 40-year-old grassroots organization that is dedicated to building a movement against police violence and systemic racism in New York City. It is through this lens and this expertise that the Justice Committee strongly opposes the appointment of Randy Mastro for Corp Counsel. Given Mr. Mastro's long history of supporting racist policing and other racist policies as part of the Giuliani administration, his return to New York City government as Corp Counsel will only serve to further Mayor Adams' agenda to erode police accountability and build New York City as a police state. Mastro played an essential role in the Giuliani administration, under which the NYPD murdered Anthony Baez, Antonio Rosario, Hilton Vega, Yongxin Huang, Amadou Diallo, Annabel Carrasquillo, Frankie Arzuaga, and Nicholas Hayward Jr., along with joining Giuliani in ridiculing police accountability recommendations. Mastro defended Giuliani's violent broken windows policing that plagued Black and Latinx communities and set the stage for further ballooning of unconstitutional stop and frisk under Mayor Bloomberg, which is resurging under Eric Adams. Since he took office as mayor, Eric Adams has been working to expand the NYPD's power and role in New Yorkers' lives and shield abusive officers from accountability. Mayor Adams' charter revision proposal to complicate the process for passing public safety legislation is case in point, as is the systemic burying of police misconduct complaints during his tenure as mayor and his refusal to ensure accountability for the officers who killed Kowalski Trewick. With the families of Win Rosario and Alan Felice, Delron Small, and Antonio Williams in the midst of fighting for the officers who killed their loved ones to be fired, we're deeply concerned about what a Mastro Corp Counsel appointment would mean, especially given that this position represents the CCRB when police union attorneys use bogus legal maneuvers to delay administrative trials. If his appointment is confirmed, Mastro would be at the legal helm as the Adams administration continues to erode police accountability while working to expand the NYPD's power to use force against, involuntary remove from public spaces, and hospitalize New Yorkers without suspicion of criminality. As an organization dedicated to true safety for all New Yorkers, the Justice Committee urges the City Council to reject Mastro's nomination. Thank you.
Thank you. I think no questions. Thank you, guys. Thanks for your patience. Thanks for being here.
Our next panel will be from Zoom. We will have Iris Baez and Kelly Grace Price.
Your time has begun. You may begin.
What? While we're figuring out the Zoom, we're going to move on to an in-person panel.
Hello?
Are you there on Zoom?
Hello?
Yes, hello.
Yes.
You can go ahead.
Okay. As someone who lived through Giuliani, I'm here today to tell the City Council you must reject Mayor Adams' appointee to Randy Mastros. Back then, Mastro was rightfully called Giuliani's pit bull. He spent years defending racist, abusive policing by Giuliani NYPD. Mastro's Giuliani's chief of staff when my son was, and Nicholas Haywood and Anthony Rosario and Hilton Vega was murdered by NYPD. He defended Giuliani's broken window policing and target Black and Latino communities like mine, the South Bronx. The deputy mayor, he joined Giuliani in marking and dismissing nearly all of the 1998 commissioners of the task force for police community relations. Already Randy Mastro to become core counsel in change. 800 lawyers could be disaster for New York City. It would mean changing the legal regime and support NYPD excessive force, racial profiling, and citizenship of poor and low community of color. I urge the City Council to reject Mayor Adams' appointee of Randy Mastro to Court Counsel. Thank you.
Your time has expired.
Thank you. We have one question for you. I think Speaker is going to ask a question if you can hear her.
Ms. Baez, can you hear me?
Yes, I can.
Okay, thank you so much for your testimony. This is Speaker Adams. I just have one question for you. What is your main concern about Mr. Mastro possibly being the city's top lawyer? Your main concern?
My main concern would be he would go with the mayor. Whatever the mayor says, he will do. That's my main concern. Because don't forget, he was Giuliani's pit bull back then. Whatever Giuliani said, he would bow. And now he's older, so now he's going to do the same thing with the mayor.
So you believe that Mr. Mastro would side with the mayor and not
Yes.
not be equally balanced as a representative for the city?
No, he won't
the
be
council.
a representative for the city. He'll be for the mayor. And we can't keep on going back.
Thank you, Ms. Baez.
Thank you.
The next panel will be Janet Morgan, Beth Hatton, Muzzy Rosenblatt, and Devorah Halberstam. And while we're at it, we'll call Victor Kovner, Justice David Sachs, and Judge Rolando Acosta.
Good evening, Honorable Speaker Adams, Chairperson of the proceedings, the members of the City Council who are still here. My name is Janet Morgan, and I'm here to testify to my support for Randy Mastro. I have to say, though, I feel kind of like Barack Obama, who didn't want to come after, speak after Michelle, and I'm speaking after a host of people today. I have to say also that sadly, Rudy Giuliani has loomed over these proceedings like a Shakespearean apparition, a specter, Banquo's ghost, to which I would say, in the words of Lady Macbeth, out damned spot. We're here to talk about someone who isn't one iota like Rudy Giuliani. Randy Mastro, who was my attorney in the greatest crisis I ever faced in my life. On a morning in the spring of 1990, my phone rang. On the other end of the line was the voice of someone I did not know, Randy Mastro. Having followed my case, my suspension for now 2 years from my social studies teaching position in the Malvern School District on Long Island, suspended because of an essay I had assigned my students on racism. Randy was calling to offer to represent me pro bono. Randy Mastro's call came the morning after a brutal examination before trial regarding the civil rights lawsuit I had. By then, I was suspended in 1988, I had filed against Malvern. I was so nauseous, I was praying I would not throw up while Mr. Mastro was on the phone. Divine providence intervened, I believe, and I do believe that. Because of that, I was able to continue with the call. The reason the school superintendent involved himself in the matter of an assignment a teacher makes, which is unusual, was that a parent, a white parent, had called the superintendent and complained about my essay assignment. A week or so after the essays had been graded and returned to students, my chairperson informed me that the superintendent wanted me to rescind the assignment. Unable, of course, to rescind an assignment, my chairperson returned with the order now, discount the students' grades, the grades that they had made on the essay. Absurd an order, unthinkable to even consider such, I refused. On the Friday of the beginning of the Memorial Day weekend, the superintendent's secretary came to me at the end of the day with a letter informing me of my suspension. My students, 5 classes, would return to class on Monday, their teacher gone. 1990, 2 years into the suspension, the State Commissioner of Education made his ruling that Malvern had made an impermissible intrusion into my classroom and ordered my reinstatement to my teaching position. That would not be the end for Malvern. Appeal the commissioner's ruling to the Supreme Court of the state of New York. This was when Randy Mastro assumed all matters related to my cases with a passion for right and a consummate zeal for social justice and the skill of one of the nation's best. Randy Mastro traveled to Albany to argue my case before the Supreme Court there. Consider that 3.5 decades before what is branded and besmirched now as DEI hiring of blacks, me, and CRT critical race teaching, a time when across this nation my essay may likewise be banned. It is deja vu. My case, a precursor 3.5 decades ago before. There's no doubting, certainly in my mind, that Randy Mastro, had he not come into my life, I would have had no more career. I was financially destitute. When I mortgaged my home, I was single at that point. I had a mortgage. I mortgaged my home again. Had he not come into my life and taken my cases over, I would not have had a career at age 48, still a few years at that point before retirement. I would have remained financially destitute. In addition to the fact that the fight for me, he won the case before the Supreme Court. And he also represented me on my civil rights case and managed won a settlement for me that restored me to, financial health. I hope, in spite of some of the things that have been said here today, you will seriously consider people like me, people of color. I mean, this is a man who fights for people of color. I believe you can entrust into him the position. I believe he will fight for all people, certainly fighting for people of color, racial justice, social justice. And thank you very much for your consideration.
Thank you. Thanks for sharing your story as well. Thank you. We're going to move on. So hold your applause, please. You can go ahead.
Thank you. Okay. Am I done?
You can stay there. We might have questions. But
okay.
We'll come back. Microphone.
Good evening, Speaker Adams, and all council members that are here today. Thanks for hearing from me. First, I have to say, for me, it's deja vu sitting in these chambers. I've sat here many a day, and I don't want to begin to cry, but I will. But I have to stand up for the speaker because she is very special. My name is Devorah Halberstam. It was a Tuesday morning, March 1st, 1994, 10:21 to be exact. My teenage son, Ari, who was traveling in a van with his schoolmates, were attacked by a terrorist with a barrage of bullets and an arsenal of weapons. My son, Ari, was shot in the head with the Uzi machine gun and died in the worst anti-Semitic attack fueled by hate the city has ever seen to date. Please just look out the window and be with me in the moment he was murdered on the Brooklyn Bridge. On that day, at that moment, my life was changed forever. We became victims of hate and terrorism. Being a victim is not a state of mind. It takes courage to survive the death of your child. And I speak for all moms whose children were taken from them. There is no freedom for us. Our loss informs our decisions in life going forward. And there were many, beginning with the burial, the long road ahead through the criminal justice system, the emotional toll this takes on a family, the domino effect in our home life while keeping the memory of our Ari remembered. This is why I am here today, you know. They say it takes a village. We are here today to talk about the appointment of Randy Mastro for the position of Corporation Counsel. It is not just a position to be filled. It is crucial that the person who fills this spot is a man of integrity, a man of wisdom, a man of compassion, and a man who knows how to get things done. I am here to talk about Randy, that person. I am witness to who Randy Mastro is and was. You cannot rewrite history. Randy was with us right from the day Ari was shot. He stood by us with strength and helped us through some of the most grueling days and agony, which none of you should ever know. He walked me through the criminal justice system. He was there with strength, advice, and knowledge, and guidance. He supported my vision for the Jewish Children's Museum that this council carries on, memorializing Ari forever as a living and breathing space for children. He was there from the groundbreaking and contributed constantly until this very day, that has served 3 million children and families, teaching them to respect and understand, to love and not to hate, to accept each other no matter who we are and where we come from. In over 30 years, Randy has never asked me for anything, but he has always stood by me and my family until this very day. 30 years has shown me who he is. Now is the time to speak the truth and give gratitude. I have learned the workings of our city and government. I recommend to you a man with such vast knowledge and wisdom for the position of Corporation Counsel at this time in history. For this position, you have to be wise, not just have wisdom, sometimes even Solomonic wisdom. You have to have integrity and leadership. Randy has those qualities. He is consistent and trustworthy. He will be an asset to this city. I know that this council is looking out for the people of the city. I am the people of this city. Randy will never fail you or the people of the city. I am sure of that. Thank you so much.
Thank you.
My name is Muzzy Rosenblatt. For 24 years, I have led BRC, one of New York City's largest, most effective nonprofit organizations serving people experiencing homelessness. For over a decade prior to that, I served in city government under Mayors Koch, Dinkins, and Giuliani. I speak today in support of the nomination of Randy Mastro to be the city's next corporation counsel. I've known Randy professionally for over 30 years and cannot imagine a better person to serve in this role. I say this based on years of experience working directly with Randy in his capacity as BRC's attorney and years of working with him in city government. Randy defended BRC against a wealthy, well-organized, not-in-my-backyard coalition suing to stop us from siting, developing, and operating a shelter and treatment program in Manhattan's Chelsea neighborhood. Using their deep pockets, our opponents left no stone unturned in their efforts to destroy a project that would, and now does, deliver critical services for New Yorkers in need. His passion for justice would not let them stop us, and his brilliance as a lawyer stopped them. He provided wise counsel, a comprehensive strategy, vast knowledge of every aspect of state and local law, and a heartfelt conviction to ensure that the right to quality care of our city's most vulnerable would not be denied. Not only did Randy protect BRC's interests, he set new legal precedents that continue to protect the entirety of New York City's homeless shelter system. As this litigation went on for years, not once did Randy hesitate, tire, or back down. Simply put, BRC and people experiencing homelessness in our city could not have had a more dedicated or capable advocate. I also worked with Randy when we were served together in city government. He championed the effort to implement the recommendations of the New York City Commission on Homelessness, a commission empowered by the previous mayor, leading to a transformation of how homeless services are provided. Together, we turned a failing shelter system into one that was robust and service-rich, operated by a diverse array of New York City's best community-based nonprofits, delivering results for the people it served. Randy worked tirelessly to ensure more resources were spent on supportive and low-income housing, helped achieve a new level of commitment between the city and state in the New York housing program, and worked with the Clinton administration to secure the largest federal commitment of resources to addressing homelessness in New York City at the time. Throughout his career, Randy has been a fighter for the most vulnerable, willing to take on the most powerful, even if it meant risking his life. There could be no greater advocate for the city of New York or its residents than Randy Mastro. And I do just want to add, it's not in my written testimony, really how incredible it was to sit and listen to testimony from representatives of Met Council and Urban Justice Center. Not that they were present at the time, but at the time that the legislation that undid rent-regulated housing or minimized rent protections in the 90s, Met Council was led by somebody who went to prison for corruption, and its greatest benefactor, Speaker Silver, also went to prison for corruption, and he's the one that undid that law.
Thanks.
Similarly,
Thanks,
the
Leslie.
Urban Justice Center, who we worked with closely, or their clients, regularly undermined our efforts to work with unhoused New Yorkers who had been placed in hotels during the COVID pandemic to find permanent housing.
Thank you.
Thank you.
Thank you, guys. Thanks for being here so much.
We're next going to have our Zoom people. We have Matt Douse. Matt Douse on Zoom.
Hi.
And we're also going to have James Innes from New York Communities for Change in person.
Okay, Matt, you can go ahead. 2 minutes.
Thank you. Can you hear me?
Yes.
Everyone hear me? Okay, great. Well, first of all, good evening, Speaker Adams, Chair Powers, members of the Rules and Privileges Committee. For those of you who are left, I've been watching this testimony from the very beginning. It's over 10 hours now. I'm trying to be as brief as I can. I'm here to testify on behalf of Randy Mastro to become the next corporation counsel in my individual capacity. I know some of the members, or actually a lot of the members of the committee, I don't know who's left, but I've already been in touch with some of them, to voice my support, and I'm here to answer any questions after the testimony as well. I served as, for those of you who don't know me, from the entry level on up to the top of New York City government for over 20 years. Left about 14 years ago. I was a government lawyer when I started, and my tenure included service, as first of all as a human rights prosecutor for the Commission on Human Rights. I was special counsel to the New York City Trade Waste Commission, where Randy was at the helm, and I worked for him. He and for Rudy Washington. It's now known as BIC, as you know. I was also general counsel for the Taxi and Limousine Commission, as well as the New York City Community Development Agency, which is now known as DYCD. I'm the longest serving former taxi commissioner. That's how many people know me. And I'm also a former commissioner for the Civil Service Commission for New York City. I'm now back to practicing law. I'm an active member of the New York City Bar Association, where I chair and co-chair committees and task forces. I've known Randy for over 30 years as a friend, mentor, and colleague whom I greatly respect and admire. Not only is he one of the best litigators in the United States, but he's a person of impeccable moral character and a former public servant who has improved the lives of millions of New Yorkers.
Your time has expired.
I would respectfully request that I continue with my testimony.
You can continue, but you did use a lot of time on your resume. Mr. Doss, I'm hearing you. You can make your statement, but we also are on a clock, so I need you to go ahead.
I have to. Can I just say something? I mean, I really think it's kind of unfair to let the public go last on a meeting like this, where all.
Mr. Doss, you can litigate this if you want to litigate this with me, or you can make your statement. You can choose.
Could I have, as someone who served the city for 20 years, a minute to sum this up, please?
You can go ahead and sum it up.
Yeah, I know it sounds like it may not matter anyway, but I mean, honestly, he put his life on the line. I'm there because he's a friend, but he is, honestly, I think after you listen to all the testimony that you heard here today, and I urge you to read my written testimony and all people who testified here today, he represents the people like the district attorney does. He's going to be independent. I know this. I know his character. I've known him for so many years. And, look, you can't do good things in life without having people criticize you, every once in a while. This is what happened today. I still think he's going to do an amazing job. I think you should give him a chance. And I refer to my testimony that's previous. And I really think the council, really should, I don't think the members of the council here truly reflect the opinions of everybody in this city. And there's a lot of people I know who are here to testify that had to leave, and that's just not fair. I respectfully request that you have a separate public hearing tomorrow or some other time where you hear from people from the public, because we're taxpayers, and I want Randy in there. And you could see he withstood.
Mr. Doss, thank you. We'll take that into consideration on the recommendation for a second hearing, and we'll call up our next panel. Thank you.
The next person we'll hear from, if you don't mind, we have one more person on Zoom, is Kelly Grace Price.
Your time has begun.
Hi, good evening. It's Kelly Grace Price from Close Rosie's. I've already turned in my written testimony, and I'm not going to repeat what I said verbatim. It's been a long day, and no one wants to listen to Zoom testimony. But sitting here today, listening to this hearing, it's clear that the City Council cannot approve the appointment of Randy Mastro to Corporation Counsel. Doing so would be an act of deliberate indifference that could open the city up to large-scale civil rights liability. There are tens of thousands of cases pending against the city And we have heard Mr. Mastro already say that he will recuse himself from any case involving prior clients. But instead of providing a complete list of who those previous clients he has represented, he claims to have so little pull with his former law firm that they won't even provide him a list of people and entities that he has represented on behalf of that firm. This is at the same time that a recovering governor appeared to testify on his behalf today. These statements strain credulity. I cannot believe that Mr. Mastro cannot get a list of his previous clients from his previous law firm. But back to deliberate indifference and Mastro's clients, because Mastro will have to recuse himself from any case involving a former client, the majority of his time will be tied up in debates about what case he can or can't participate in or manage. And we're not talking about insignificant clients. I already mentioned in my written testimony that I've already filed that the Child Victim Act cases that the law department is having to wrangle right now are a major boondoggle that the law department is failing to properly address. Many of those cases name the Roman Catholic Archdiocese of Brooklyn, along with the city and the ACS or the previous child welfare agencies under the Human Services Association as defendants. There are thousands of them. So for Mastro to have to recuse him from this huge pack of cases along with others just creates so many problems and in fact opens the city up for liability because
Your time has expired.
okay, thank you very much. I don't want to go on, but I just filed my written testimony.
Thanks so much. Nice to hear from you. Go ahead.
Hello, my name is James Ennis. I run the public safety work at New York Communities for Change. We're an organization that represents and organizes people of low income and color communities from the Bronx to Brooklyn to homeowners in Queens. I just want to say we reject the nomination of this gentleman today. We see his nomination, or if he was confirmed, as the same as being a bloodthirsty fox guarding a hen house. A lot's been said about the gentleman today. I'm not going to go get into all of it, but I do have to, for my members, speak to a couple of the lowlights of his career, right? The gentleman abused the legal system on behalf of Chevron to persecute Stephen Donzier, who successfully represented the indigenous communities of Ecuador and got billions of dollar settlement. Stephen had to spend 995 days on house arrest because of the legal abuses this gentleman did against him in the courts. This gentleman also is suing the city to overthrow our landmark climate and jobs law, Local Law 97. And he's saying that the law is superseded by state law. So his argument is state law supersedes all municipality law on climate, which is an absurd statement in itself. And these are things that affect us, my members, I just want to point out. Mr. Maestro was behind the long-running abusive investigation into the New York State Working Families Party that made it harder for them to keep their ballot line. The gentleman is also Chris Christie and Phil Murphy's top lawyer to stop congestion pricing here in New York City. He is also James Dolan's lawyer, as we all heard, keeping other lawyers out of New York City, out of Madison Square Garden. And these are all the people or the clients he had while he was broke and newly married, leaving public service. I just want to point that out. We've heard a lot about the gentleman's housing and his representation of the Rent Stabilization Association. I'm just going to add, as recently as May of this year, he filed a writ with the Supreme Court to overthrow New York's Housing Stability and Tenant Protections Acts. We're in the middle of a housing crisis. Our members find this totally unacceptable. And with that, I'll yield the rest of my time. Have a good one, y'all.
God bless you for taking your time. Thank you.
I'm going to call these names again just to make sure they're not here. Victor Kovner, Justice David Sachs, Justice Rolando Acosta, Beth Hatton, Roger B. Adler, Esquire, Georgia Winston, Mara Binney,
Ms. Mastro, please sit down. We'll take care of the hearing. Thanks. Okay.
He can go ahead of me if he wants.
Okay, you can come up.
Mark Rosenblum.
But please, for now on, please sit down, and we will conduct the hearing. Thank you.
Louis Coletti.
Okay, I don't know if he was taking my place. We got a place at the table. Okay.
They want to switch out people. They need to talk to us beforehand. He can't come forward and do that shit. No, he cannot.
You can go ahead. Please introduce yourself, name and title, affiliation.
Good evening. My name is Mark Beanie, and Randy Mastro inspired me to work in the public service. As a young lawyer, I spent 4 years working with Randy very closely, and frankly, his words, but his deeds and his actions, his commitment to the public service inspired me. And so after working at Gibson, Dunn and Crutcher with these folks and with Randy, I spent the next 15 years of my career as a prosecutor, first in the Manhattan DA's office down the street, and then across the bridge in the U.S. Attorney's Office for the Eastern District of New York. And now I work at a law firm in Midtown, but I have to tell you that Randy shaped so many young lawyers like me to be committed to the public interest. Randy is a fantastic lawyer who is committed to the public good and has done it throughout his career. You know many of his famous acts in the public good, such as taking on President Trump with respect to what he did in 2020 with the violent clearing of peaceful racial justice demonstrators for a photo op. But I want to tell you about some of the acts of good that Randy has done that you may not be aware of. My younger brother is developmentally disabled. And when I was at Gibson Dunn, I wanted to do something on behalf of developmentally disabled New Yorkers. Randy Mastro did that with me. He helped me do that. And we got 50 attorneys to provide legal services on behalf of loved ones of developmentally disabled people who needed pro bono services. And so he is literally a legal Robin Hood for the developmentally disabled. He's a fantastic attorney, he is committed to the public good, and he would be a fantastic corporation counsel. So I please urge you to confirm him.
Thank you. Thanks for your patience of being here.
Thank you. Can you hear me?
Microphone on.
Thank you. My name is Georgia Winston, and I'm here to voice my support for Randy Mastro to serve as Corporation Counsel. I worked with Randy for nearly 20 years. He was my mentor and then my partner at Gibson Dunn, and I think there's no doubt that he's an extraordinary lawyer and a fierce advocate. He goes all in for his clients and would do the same for the city. But I just wanted to focus on a couple of Randy's specific qualities. Throughout the time that I've known him, he's been dedicated to pro bono work and committed to public service and dedicated to mentoring junior lawyers and to fostering diversity. With respect to pro bono work, Randy's been a passionate advocate for all types of causes and has been devoted to helping people in need. He did a lot of that work despite how busy he was because he cares about those causes and issues and about doing good. And this matters. The fact is that private practice, we have lots of different types of clients. They don't always align with our own personal values. It's a business. That's the bottom line. And that's the nature of it. But Randy has put in countless hours outside of that paid work, hours that could have been spent with his family or friends or sitting on the couch watching Grey's Anatomy, but instead he spent it helping people and causes that could use his help. And I think if you're looking at how to determine his values, that's something that you should look at. Madam Speaker, you spoke in your opening remarks about entitlement and specifically of women and people of color understanding that there's no entitlement to any particular position, and that those words resonated with me. And I think in that regard, it's especially important that people who are in a position to do so act as allies, and where they're able, go out of their way to help make opportunities for women and people of color. And that is what Randy does and has done. And Veronica, who's testified earlier, spoke to this and to the need for people to open doors. I'll just be another minute. Randy did that. He went out of his way to give me opportunities that I wouldn't otherwise have had, guided me throughout my career to help me become the first female litigation partner of color in Gibson Dunn's New York office. And I saw him take the time to give that same kind of guidance and mentorship to other junior lawyers, especially women and people of color. and the litigation department became significantly more diverse as a result of those efforts. And I just add on one more thing on a slightly more personal note, because there was some discussion about whether Randy's respected by his colleagues, how he'd be to work with. He was a terrific colleague. I've worked with lots of different lawyers in my career, and Randy was one of the best to work with. He was always committed and passionate, always respectful of my ideas and input, even when I was a very junior associate. He's a person with strong opinions, but he values and respects those of others. So at bottom, Randy is devoted to serving the public interest and would do a terrific job. Thank you.
Madam Speaker and Mr. Chair, members of the council, my name is Jim Walden. I count myself as a lot of things, but primarily these days, I'm an opponent of Mayor Adams. I've sued him twice. I've spoken out against him. And I have that voice because of Randy Mastro. When I became a litigation partner at Gibson, Dunn & Crutcher, I was lost. I'm a survivor of horrible physical abuse from an alcoholic father, and I went to a law firm and I had no idea what to do. And Randy took me under his wing. And Randy showed me what a legal career could be, where you're a private lawyer being able to afford New York, which I could not with 3 small children, and yet do good in the world. And what good did I do under Randy's tutelage? I didn't serve big corporations. I didn't bring lawsuits on behalf of oil companies. I protected transgender rights with the first lawsuit ever on behalf of a transgender man who had experienced discrimination in New Jersey. I brought a lawsuit with Randy's help to keep open a hospital for a marginalized community in Brooklyn that was being shut by Mayor Bloomberg. I brought a lawsuit with Randy's help against President Obama's administration for denying hearings to tens of thousands of mentally ill New Yorkers. And I sit here during a 10-hour hearing and think to myself, there is one question, and only one question, that this council should be asking itself. Do you want Derek Jeter to be the captain of your team? And instead, we're hearing misinformation, disrespectful questions, and old stories about things that Randy had nothing to do with. If you had heard from the people that filled these rooms, there were dozens of people like me whose careers were changed forever by Randy Mastro, and yet you will not hear from them. That is a shame.
Thank you. And this public testimony is an opportunity to certainly hear from those folks. We have people who are here. I know it's been a long day and certainly a long hearing, and we appreciate everyone's patience, but there is a public part of that testimony you're participating in right now, which is that opportunity. We'll go to Luke Coletti. Thanks.
Is it on?
May I just say one more thing?
Sir, we're going to move. We moved on.
And then I'll be done.
Sir, your time is up. We're going to keep. I understand you want to keep talking,
May I
sir. We are going to move on to the panel. Thanks.
Okay, Mr. Chairman, Madam Speaker, members of the council, thank you for enduring your responsibilities through this, and thank you for the opportunity to provide some testimony on today's confirmation hearings. My name is Louis Coletti. I work for the law firm and government relations firm of Davidoff, Hutcher, and Cintron. I want to clarify something, if you'll allow me, since earlier today it was mentioned that many of Randy Mastro's supporters were just lobbyists. Number one, I don't know if you've ever seen the what do you call it, the Netflix show Suits. Well, if you have, I'm Harvey's Mike Ross. I'm not an attorney. And until September, I'm not a registered lobbyist until September 1st, because one of our clients, National Minority Contractors Association, insisted that I get involved, so I'll be involved with them. I'm here to discuss and recommend that you adopt and confirm Randy Mastro as the Corporation Counsel for the City of New York. At the beginning of the hearings today, I was very impressed, Madam Speaker, as you outlined characteristics that this council would be looking for: character, integrity, and competence. But as I sat here during the day, I began to think about what my grandmother had once told me. Don't hold the children responsible for the sins of the parents. And I hope in your deliberations, you do not hold Randy Mastro guilty for the sins of Rudy Giuliani. He doesn't deserve that. Over the years, in his roles as deputy mayor, I had numerous opportunities to work with Randy. And I'll be the first to admit that we didn't always start out on the same page. But we kept at it. We worked. You heard him mention communication several times today, and it's pretty obvious that that's something that has to be done today. I'll close by saying this. Here are the characteristics of the man, Randy Mastro, that I know and I worked with. We all know he's an outstanding lawyer with an incredible knowledge of the law. He's a man of impeccable character. He's trustworthy. He's a man of his word. He's someone who will forcefully advocate, yet understand and have good listening and to try to find common ground. That's the man that I know, and I hope that that's the man that you will confirm as a Corporation Counsel for the City of New York. Thank you.
Thank you. Thank you. Speaker, go ahead.
Yeah, I just want to correct the record. Thank you so much. Thank you all for your testimony. I know it's frustrating, it's late, and we understand very much that Mr. Mastro has huge support. That is not an issue at all. I do want to correct the record. It was not stated, and I'm paraphrasing, it was not stated that everyone that was speaking in behalf of Mr. Mastro were lobbyists. I'm going to paraphrase. What was said was that there are some who are supporting Mr. Mastro, perhaps speaking today, who are lobbyists and are doing business with the city. That is what was said today.
Okay, I just wanted to make it clear in defining who I
Understood.
was, that I was not one of those people.
Understood.
Understood.
Understood, and I thank you very much.
Thank you.
Thank you.
Thanks so much. Thanks for being here.
The next panel is Jennifer Rabb. She gone? Avi Weitzman, not here. Ross Sandler. Jim Walden. Oh, thank you. Adam Offenhartz. Mark Kirsch. Steve Gradman.
Thank you. We'll start over here and we'll work our way down. Thanks.
Thank you very much, Madam Chair, council members. Thank you for being here. My name is Ross Sandler. I am a former commissioner and a law professor, and I come to speak in favor of voting for Randy Mastro. I've been in government many times, and I was thinking back that the first corporation counsel that I knew well was Norman Redlick, who was corporation counsel for John Lindsay. I've known everyone since then. And I can say about Randy Mastro that not a single one of them had the experience, knowledge of government, or the ability that he has shown now, and would hit the ground running as a corporation counsel. He would be the best I would have ever seen. And I've been listening to the testimony, which I found pretty interesting all day long, and I thought the council questions were very interesting. I also teach professional responsibility, and one of the rules of the canons, one of the rules of the ABA is that a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views. And that's a very important rule because that protects the people who are representing the very unpopular groups that, in certain places, civil rights groups, racial groups, gender. That says that we have to have those lawyers doing that work. But the rule isn't as narrow as that. It really is about lawyers generally, and that we want lawyers to be independent, to exercise judgment, and to take on clients so that the entire justice system works. And when I heard a lot of this discussion about Randy's clients, I thought about that, and I thought about this rule and how important it is as part of the professional canons and the rules of professional conduct. And I just suggest that it applies in this situation in many, many ways, and that you should think about what it would be like if there were, say, a lawyer for a civil rights group, and people said about that person, we don't like him because of that representation. I think it would be useful to put yourself in that place and to think over how to think about his representations, and can you associate, do you have to associate his views, his social views with that? And
Okay.
the answer
Thank you.
to that has come from all the testimony you heard, and I suggest you just work that way.
Thank you. We'll go next, sir.
Yes, good evening. My name is Steve Gradman. I am president of Pride Democrats of New York City, which in the year of Stonewall 25 in 1998, we had the largest candidates forum in the history of New York. And that was also the year that Randy Mastro created the Domestic Partnership Bill, which was signed into law by Mayor Giuliani. Randy greatly legitimized support and protected all gay people. I myself am a domestic partner. And I also want to bring out that his firm, Gibson Dunn, successfully convinced the U.S. Supreme Court to recognize same-sex marriage in the Proposition 8 case. Mr. Mastro has deep breadth of legal experience, and I think he'd be an excellent person for this position. Thank you very much.
Succinct. We like that. Thank you.
Thank you. It's a privilege to appear before the City Council. And to speak for my dear friend, Randy Mastro. We've known each other and worked together as partners for 15 years. You've heard enough about his legal skills. I'll only note that Randy has been described today as a happy warrior. That's an incomplete picture. He's a warrior diplomat. The warrior gets the headlines, the diplomat gets the results. Randy knows how to keep temperatures down in very fraught situations, helping both parties get to something they can both live with. That combination of skills, warrior diplomat, is rarer than you'd think, and I think it can be useful to you. All lawyers are agents, not principals. As your lawyer, Randy will never forget you're the principals. He's the agent, and he will fight for your agenda to the fullest extent the law permits. I'll briefly address Randy's character. He's revered for his uncompromising integrity. I've been in tight spots in cases with him many times. I've never seen him suggest doing anything that even got close to the line in ethics, much less over it. At two leading law firms, he's been a destination for advice. He puts ethics and integrity as his foremost concerns. I've never seen him depart from those principles. A couple of quick examples. At Gibson Dunn during COVID, he created and led an effort to raise money from partners for all employees who needed support, who might have had COVID or had a spouse who lost a job or a child who was in the hospital. He got 100% participation from the partners, raising hundreds of thousands of dollars. And trust me, in a large law firm, getting 100% agreement on anything, difficult. Strong voiced, I think in New York, the largest office of Gibson Dunn, the strongest voice for doing pro bono work and making sure all the associates and all the partners were committed to it. Again, not an easy thing to do. He's also a strong voice for diversity, as you've heard. One thing I'll just say, it's great to hire women, people of color, and make sure they've got work to do. It's a different thing to get them in front of clients so that they can build relationships where they become the relationship partners. Randy was a master of doing that. Committed. Thank you.
Thank you.
Good evening. I'm Adam Offenhartz. I've had the privilege of knowing Randy Mastro for over 25 years, and I've seen him in a variety of points of time in my life that I think go to some of the issues that have been raised today. I believe it was Speaker Adams who asked, how will you handle the Corporation Counsel Department? How will you lead? How will you deal with the vast number of lawyers you'll be in charge of? What kind of leader are you? I can tell you that as a brand new baby lawyer, Randy Mastro was the person everyone wanted to work with. And for me, that was a long, long time ago, in the early 1990s. Randy was the person that gave young lawyers the opportunity to go to court, to take depositions, to get in front of clients. When you had questions about what was appropriate, how to deal with a gnarly issue, how to deal with a difficult adversary or even client, you went to Randy. But more importantly, as one's career grew, and this is true for me as well as for so many other people you've heard from, Randy always stressed the importance of public service. There are so many lawyers, some of whom you've heard from today, probably many more you would have heard from had things, schedules worked differently, became turned to public service because of Randy. Randy also pushed many of us to become involved in the community. He stressed the importance of being on boards. He, despite being the busiest lawyer I know, always found time to teach. Many of us, myself among them, have also brought teaching into our lives because of Randy Mastro. The number of lawyers that Randy has a positive impact on, who he has affected, who he has made better citizens, is countless. And I'll very quickly end with the thought that it's very important we remember the most important thing today is what is best for our city. I've lived in the city for close to 30 years. I've lived in the village, the West Village. I ride the subway. I work now near Ground Zero. The city has a labyrinth of problems. It does. It's a tough place. You all, the mayor, all of us, need the best people who can help the city. Randy Mastro is the best person I know to serve as corporate counsel. I urge the council to support Randy Mastro.
Thank you. Thank you, guys. Thanks for being here for so late. Your patience. Thanks.
The next panel is Marla Alhadeff, Joseph Rose, Federico Varela, Ann Champion, David Lewis, Chad Vignola, Christopher Perino, Frederick Jacobs, Christopher Leon Johnson. Nope, I misspoke. Not Christopher Leon Johnson. We'll call you later. Neil Getnick. And Jessica Benvenista.
Thank you. We'll start over here, and you can spy your 2 minutes, and if we have questions, we'll...
Am I on?
You're
Yeah.
on.
Hi, my name is Ann Champion. Randy was my partner at Gibson Dunn, where I was also an associate under him. I've known him for almost 20 years. I'm here to speak on behalf of myself, not my law firm. But I want to say that Randy is one of the most ethical, best lawyers in the country. He's got a long and distinguished record of public service as an AUSA, former deputy mayor, and in private practice, representing clients in some of the most groundbreaking litigations, literally, of the past few decades. And he wants to go back to public service and run the law department. He's highly qualified to do so, and I hope that you confirm him. He's a great manager. He's able to listen to all views. He does listen. He's a great listener, and he takes everything into account. He's able to drive consensus and synthesize diverse viewpoints. He has tremendous respect for diversity, and as you've heard from so many others, he is a great champion of diversity. He's a great manager, as I said, and he will be a great manager for the law department. As others have said, I have also personally witnessed Randy's high ethical standards, his high moral character over the entire time that I've known him. I understand the criticisms of the Giuliani administration, but I think that Randy's record shows that he was a force for good in the roles he played in that administration. As lawyers, we are required to zealously represent our clients. It is not about our personal views, as the law professor has so aptly testified today. Randy is the epitome of a zealous advocate, whether he's representing a pro bono client trying to get a homeless shelter opened or exposing litigation fraud on behalf of a major corporation. As corporation counsel, he will use those skills to represent the city. I have no doubt that if he is confirmed, it will be transformative for the better, and every single one of you will be happy that you voted to confirm him, and I hope that you do so. Perfect timing.
Go ahead. You can go ahead.
Good evening. My name is Chris Perino. I was the 60th Attorney General of New Jersey. Today I'm chair of the litigation department at Lowenstein Sandler, and I live here in New York City with my family. I'm apolitical. I'm not a Republican. I'm not a Democrat. I'm unaffiliated. I've represented the Democratic administration of New Jersey Governor Phil Murphy. I served in the Republican administration of New Jersey Governor Chris Christie. And that's where I first met Randy Mastro. It was 2014. I had only just started as chief counsel to the governor when the Bridgegate scandal broke in the media. We hired Randy and his firm less than a week later on behalf of the Office of the Governor. And as chief counsel to the governor, I was Randy's client. I asked Randy and his team to do a top-to-bottom investigation regarding Bridgegate, to follow the facts and the law wherever they led, and to report on who was responsible. And that's exactly what he did. Randy and his team reached the conclusions that now, 10 years later, have stood the test of time. Bridget Kelly, who was here earlier, her story is a tragic one. But she was prosecuted by the Department of Justice, not by Randy Mastro. Look at the report itself. I think it's pages 114 or 115, around there. Take a look at it. It recites the facts. And the one thing I didn't hear Ms. Kelly say tonight was that the report misstated the facts. The Department of Justice reached the same key factual conclusions as the Mastro team did, and in 2020, the United States Supreme Court reached the same legal conclusions that Randy had reached 6 years earlier. Now, Ms. Kelly didn't know a key fact when she presented to you this evening. Randy Mastro made...
Sir, you're out of time.
I'm sorry. I've been here for 10 hours.
You're still out of
and
time.
I'm going to finish my comments.
No, you're not.
Listen,
Sir,
I have
you're not.
watched.
I'm
I have
sorry.
watched.
We've also been sitting here for 10 hours, sir. Thank you. Next.
Speaker Adams, thank you so much for staying throughout this hearing. Council members who are here, we appreciate that. And I'm particularly pleased that Councilmember Brewer, you're back. I think we've known each other for 30 years. I'm Neil Getnick. I'm the managing partner of Getnick Law, a Manhattan-based boutique law firm focusing on business integrity counseling and anti-fraud and corruption investigation and litigation. And that's as much as I plan to say about myself when I came here today. But I do want to say some more things, which is that I think that you probably should love me as an attorney. I'm not an AmLaw 100 lawyer. I'm not a corporate defense lawyer. I'm not a lobbyist. I've spent my life in social and economic justice. When I was in the Manhattan DA's office, I led an investigation that resulted in proving the wrongful conviction of an African-American defendant who was 3 years into a 6 to 12-year sentence. I've used the False Claims Act to recover $750 million against GSK, 23 million of which came back to New York. I've used the False Claims Act of the New York State and New York City to recover $70 million in taxes from a hedge fund guy based in Midtown Manhattan who was sending all his taxes to Alabama. And earlier this year, I received the Southern Christian Leadership Conference Beloved Community Award in resolving a labor dispute by bringing management and labor and the SCLC into an alliance for economic and social justice, in addition to achieving a collective bargaining agreement. So why am I saying all of that for you? Which is that I think I'm your type of guy, and I'm telling you that Randy Mastro is your type of guy. He is the real thing. And how do I know that? In the early and mid-1990s, I worked with public advocate
You're out
Mark
of
Green.
time. I'm so sorry.
No, I'm sorry. I don't think it's fair, but I will abide by your decision.
I appreciate that. Thank you.
Good evening. My name is Jessica Benvenisti, and I'm a brand new partner at Randy's law firm, King & Spalding. I think I'm the youngest lawyer to testify tonight, so perhaps I offer a little bit different perspective. I've worked under and with Randy for the 12 years that I've been a lawyer. I'd like to share a bit about what it's like to train with him and what he is like as a person at work. I hope the City Council appreciates what an amazing opportunity Randy's nomination is, not just for him, but also for the 850 lawyers at the law department who would benefit from his unparalleled leadership. First, Randy is an unbelievably giving mentor. He has an open door policy any time of day or night. Randy does not tell anyone that he is too busy for them. And his door is open not just for the hard questions. When Randy gives advice, he gives it to you straight. He actively listens to junior attorneys and believes that everyone on a team, from paralegals to junior attorneys to the most senior lawyers, can and do make critical contributions. And he gives credit where it is due. He works as hard as anyone, encouraging everyone to give it their all too. Second, Randy is very open and reflective. Given his reputation and years of experience, you may assume that he thinks he's always right or even that he's stubborn, but the opposite is true. Randy thrives when there is a diversity of opinion and when he is challenged by others, even and sometimes especially by the most junior lawyers on his teams. I remember helping to prepare Randy for an argument in front of a judge when I was a first year out of law school, probably 23 or 24 years old. And he pushed everyone, including me, to challenge what he planned to say. And then once it was over, he asked the team what we thought of his response to every single question. Randy is never satisfied. He always wants to do better, which makes everyone around him want the same for their own work. Third, Randy is supportive of all attorneys, no matter their gender or identity. And I realize I'm running out of time, so I'm going to skip to the end. Randy might not have the same background or lived experiences as the council, or certainly not all New Yorkers, and certainly not me. But I have seen time and again that he is remarkably empathic, and that is the corporation counsel he would be. Thank you.
Thank you. Next panel.
The next panel will be Mark Kirsch.
Wait, give me a second. Are there any questions for this panel? No.
Just quick, I'll do you the favor, but really make it quick. 1 or 2 sentences. What was your last final word that you wanted? You got to put your mic on, sir, but quick.
It will be very quick. What I was going to tell you was that Bridget Kelly didn't know a key fact, and that is that Randy Mastro presented the legal arguments to the Department of Justice in 2014 that the Supreme Court adopted in 2020 when the case was dismissed against her. Randy has got some really unique qualities. He's a great lawyer, we know that. He's a leader. Don't let him go. Don't miss this opportunity.
Thank you very much.
Thanks a lot.
Thank you.
Mark Kirsch. Elaine Wood. We heard from Matthew Doss. Bob Avlatroni. Pina Carnival.
Okay, you may begin.
Yes, good evening, and thank you, Madam Speaker, for staying so late, and I appreciate what you do. I was going to say hi to Chairman Powers, but he's not here. I've known him for a long time. This is my first time testifying as a private citizen. I testified many times through the years before the City Council. As first a member of the Koch administration, when I was part of the team that cleaned up the Parking Violations Bureau scandal, which seems like 100 years ago was the largest municipal scandal in history. Then I went on to serve Mayor Dinkins, Mayor Giuliani, and 2 terms with Mayor Bloomberg. Let me talk about Randy Mastro. And I'm a little bit, feeling pressure only because of the way I feel about this guy. I've heard a lot of people speak about him today. This is a man with character, integrity, compassion for people, and plain out guts. I was with him as part of the team that set up the Trade Waste Commission when his life was threatened, and his family paid a big price for that. And we were one of the most popular guys in town, to say the least, because we took away hundreds of millions of dollars from mob tax that was being used by La Cosa Nostra, I'll say it. And it was a shame what was happening then. Randy never blinked. We stayed the course, and it's all about the city of New York, all about the people of this city. That's what I've spent my entire career on, and there's no one I admire that has more moral conviction, compassion, and straight-out character than Randy Mastro, more than anybody I've ever worked with in my entire life, and I had a private sector career. I went on to be Sobro with South Bronx Overall Economic Development Corporation. I served pro bono for 6 years with them to make a difference in that community.
You're out of time, sorry.
I thank you for allowing me to testify, and I'm sorry, I'm a little emotional about this. It's
fine.
late.
Thank you. Do you want to stay in case there's any questions? Do you want to stay until we're done with the next panelist so that maybe if there's a question, you don't have to. It's okay. Go ahead.
Okay. Good evening. My name is Peter Carnival. I'm a board member of the New Era Democrats, which is also known as NED, a non-profit independent political association that supports good government. NED was established over 40 years ago, and its motto is justice, equality, and opportunity for the whole human family. Our advocacy organization supports not just registered Democratic candidates for office, but often reaches across the aisle to support the person who is running or being appointed based on the criteria of honesty, accomplishment, independence, and character. NED is not only in favor of simply always towing the political party line and believes that democracy is best served by allowing people to have differences of opinion and to affiliate with whoever they wish. I'm here today on behalf of NED to voice our support for the appointment of Randy Mastro as Corporation Counsel for the City of New York. NED has known and worked with Randy for over 30 years, and not only was he honored by our group for his commitment to public service, but he has been a true friend and ally known for supporting causes that we care about, such as ethics in government. As you know, his life was threatened by organized crime leaders when he served as deputy mayor for his role in cleaning up several industries in the city that fleeced New Yorkers and the city government alike. We've had the utmost confidence he would represent the city well and do an incredible job for all New Yorkers. Randy Mastro is a man of an unimpeachable character, and we are speaking out today as our members, who, by the way, vote and organize others to vote, are concerned by the nature of the statements made about him in advance of the nomination by Mayor Adams. These criticisms are not directed towards his impeccable qualifications and extensive experience as one of the nation's leading litigators and lawyers, but instead focuses on political disagreements with clients he has represented over his long career, or the people he has worked in his prior role as deputy mayor. Trying to limit or harm a lawyer's reputation for these reasons is not fair to the measure of his abilities as a corporation counsel.
Your time, sir.
We consider
Sir.
these issues. Thank you
Sir,
for your time and
you're out of time.
consideration.
Thank you. If you want to submit your testimony for the record, you may do so within the next
Thank you.
72 hours. Thank you.
I wasn't sure if you wanted me to come back and
I
answer a
wasn't
question.
sure if anybody had any questions for you, so I was
I'm
hoping.
sorry I departed quickly.
It's okay. It's okay. No worries.
Everybody satisfied?
No worries. Are there any questions for this panel?
Thank you.
No. Okay. Thank you, gentlemen, so much.
Our last panel is Christopher Leon Johnson, William Lee Henderson, and Tawaki Komatsu.
Can I go?
Wait for everyone.
All right, no problem.
Well, we have one more. We have one more panel after this. Yep.
Okay. I'm sorry. So we do have one more panel after this. You may go.
All right. Hello. Good evening, Speaker Adams, for having this hearing. I want to speak on behalf of Mr. Randy Mastro. I support his appointment by the mayor of the New York City, Mayor Adams. What's going on here is that these nonprofits like Vocal New York, Housing Works, the Urban Justice Center, Freedom Agenda, like Darren Mack, and New York Community Change, which is led by Mr. James Ennis, they're getting paid off and threatened by the Speaker of the City Council, you, Speaker Adrian Adams, with tanking up discretionary funding and removal of projects if they don't support your agenda of making sure that this man behind me doesn't get appointed as the mayor's committee council. All you guys want in the city council is nothing but WP-owned, DSA-owned, Marxist lawyers to defend Eric Adams, because if you have a Marxist lawyer, you can control them. And we all know, Mr. Speaker, you're trying to run for state senate or state assembly against Cook or Sanders, so you're doing whatever you got to do to get support from the WP, and that's the reason why you don't want this guy to become the committee counsel, because the WP and the DSA don't want this guy here. So you got to give this guy a chance. I believe in giving this guy a chance. It doesn't matter what Giuliani does. Giuliani and Randy Mastro are two different men. Okay, Giuliani made a lot of mistakes. Does that mean Mastro should pay? No, don't make people pay because what another man does. So I want to support this man for being appointed by the city council. You should give this guy a chance. You gave Yusuf Salam a chance, as much as he got convicted for beating a woman with a pipe. You could easily not put this guy in the city council. So if you can give Yusuf Salam a second chance, and give this guy a second chance, okay? Thank you, and I gotta go. Thank you.
Hi, I'm Tawaki Komatsu, Ms. Ayala. I've testified to you many times. I think the last time I was here was on March 11th. I had a laptop in front of me then.